Hello.
What is sitting and reading the files for? Hello, yeah, what pronouncement of the Why? Pakka.
My lords,
Wait. Fresh matters ಕೊಡಿ. ಎಲ್ಲ ಕೊಡಿ. ಯಾವ್ದಾದ್ರೂ ಸರಿ ಕೊಡಿ. ಅಲಿಗೇಷನ್ ಕೇಳಿದ್ನ ಈಗ. ಕಸ್ಟಡಿ. You are in custody for 354. Bail ತಗೊಳ್ಳಿಲ್ವಾ? Bail is rejected. Anyway, give it. 230. ನಾಳೆ ಯಾವತ್ತು ಕ್ರೈಮ್ ಆಗಿರೋದು? Why you did not move the other court? ಯಾಕೆ ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇರೋದು ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ? ಇರಿ ಒಂದ್ ನಿಮಿಷ. ಎಸ್, ಕೊಡಿ. Atrocities tomorrow. Am I not coming here? Market. Wait. What is connected? It's a fresh matter. How is it listed tomorrow? Yes. Good. ಕೊಡಿ. Tomorrow. 27ನೇ ತಾರೀಕು. ಅಯ್ಯೋ, ಮುಂದಿನ 27 ಆದ್ಮೇಲೆ ತಗೋಣ. ಕೊಡಿ. ಏನು ಸ್ಟೇ ಇಲ್ವಾ? ಕೊಡಿ. ನೋ ಸ್ಟೇ ಮ್ಯಾಟರ್ಸ್ ಕೊಡಿ. ಅದು ಲಕ್ಷ್ಮಣ್, ಅದು ಸಪ್ರೇಟ್ ಇಟ್ಕೊಳ್ಳಿ. ನೋ ಸ್ಟೇ ಅಂತ ರೇಖಾ ಮೇಡಮ್ ಹೇಳ್ತೀನಿ. ವೈ? ಅಯ್ಯೋ, ಕೊಡಿ ಪರವಾಗಿ. ಅದು ಕೊಡಿ, ಚೇಂಬರ್ ಕಳಿಸಿ ಮಾಡಿ. ಮೀನ್ಸ್ ಪಕ್ಕಂತ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ನೇಮ್ ಚೇಂಜ್ ಅಷ್ಟೇ ಅಂತ. ನೋ ಸ್ಟೇ ಮ್ಯಾಟರ್ಗಳು ಕೊಡಿ. ನೋ ಸ್ಟೇ ಅಂತ ಮೇಲ್ ಬರೆದು ಕೊಡಿ. ಎಸ್, ಅದು ಬರೆದು ಕೊಡಿ ಸರ್. ಸಾರಿ, ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ತಾನೆ. ಸ್ವಲ್ಪ ಜೋರಾಗಿ ಹೇಳಿ ನೀವು, ಅವ್ರಿಗೆ ಗೊತ್ತಾಗೋದೇ ಇಲ್ಲ ಅಂದ್ರೆ ಹೆಂಗೆ? ಯಾವುದು? ಅದು ಫ್ರೈಡೇ ಬರುತ್ತೆ ಹೇಳಿದ್ನ. ಸೂರ್ಯನಾರಾಯಣ್ ಸರ್ ತಾನೆ? ಫ್ರೈಡೇ ಬರುತ್ತೆ. ಏಜ್ಡ್ ಇನ್ ಲಾಸ್ ಪೆಂಡಿಂಗ್ ಫ್ರೆಶ್ ಮಂಡೇ. ಏನಾಗಲ್ಲ ಕೊಡಿ, ಮಂಡೇ. ಎಸ್, ಮಂಡೇ ಸರ್. ಫ್ರೆಶ್ ತಾನೆ? ಯಾಕೆ ಅದಕ್ಕೆ ಅರ್ಜೆನ್ಸಿ? ದಟ್ಸ್ ನಾಟ್ ದಿ ಅರ್ಜೆನ್ಸಿ. ಏನು ಲಾಲ್ಬಾಗ, ಕಬ್ಬನ್ ಪಾರ್ಕ? ಕೊಡಿ ಸುಮ್ಮನೆ, ಕೊಡ್ರಿ ಸುಮ್ಮನೆ. ಎಲ್ಲ ಹೇಳಕ್ ಲಿಮಿಟ್ ಇರ್ಬೇಕು. ಕೊಡಿ. ಎಸ್, ಸಾರಿ, ಗಿವ್ ಇಟ್. ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ಅಲ್ವಾ ಅದು? ಮಂಡೇ ಸರ್. ಯು ವಾಂಟ್ ಇಟ್ ಆನ್ ಮಂಡೇ ಆರ್ ನೆಕ್ಸ್ಟ್ ಮಂಡೇ? You want it on 10th or 17th? Choice is yours. Anyway, you decide and tell me. Yes. Vacating stay applications ಯಾರ್ಯಾರ್ದಿದೆ ಅದು ಕೊಡಿ ಎಲ್ಲ. ಆಲ್ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಕೊಟ್ಬಿಡಿ. ನೀವು ನಾನೇ ಕೊಡ್ತೀನಿ ಸರ್, ಡೇಟ್ ಕೊಡಿ ಸರ್. Wait, end of the list, wait. Give all other fresh matters ಕೊಡಿ. 498 ಎಲ್ಲ ಯಾಕೆ ಸರ್? ತುಂಬಾ ಎಫರ್ಟ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ. ಬೇಲ್ ತಗೊಳ್ಳಿಲ್ವಾ? ತಗೊಂಡ್ಬಿಡಿ. ಪೇರೆಂಟ್ಸಾ ಹಸ್ಬೆಂಡಾ? ಬೇಲ್ ತಗೊಂಡ್ಬಿಡಿ. ಬೇಲ್ ಕೊಟ್ಟಿರ್ತಾರೆ ಕೇಳಿ. ಎಸ್, ಮಂಡೇ ಅದು. Please keep. Gundas, bank is coming with Gundas. ಯಾವ್ದು ಟೈಟ್ಲ್ ಇದೆಯಾ ಗುಂಡಾ ಬ್ಯಾಂಕ್ ಅಂತ? ಇಲ್ಲ ತಾನೆ? ಕೊಡಿ. ಏನಕ್ಕಾದ್ರೂ ಸರಿ. ಎಸ್, ಅಟ್ರಾಸಿಟೀಸ್ 2:30 tomorrow. 2:30. Coming from? Why Chennai? Gundas are from Chennai. Then ಇರ್ಲಿ ಬಿಡಿ ಕೊಡಿ ಮಂಡೇ. ನೋ ಸ್ಟೇ ಬರ್ತ್ ಕೊಡಿ, ನೋ ಸ್ಟೇ ಅಂತ. ಅದು ಸಪ್ರೇಟ್ ಇಟ್ಕೊಳ್ಳಿ, ನೋ ಸ್ಟೇ ಇಲ್ಲ ಲಕ್ಷ್ಮಣ್. ಮೇಡಮ್ ಕೊಡಿ. ಕಸ್ಟಮ್ ಅಫಿಷಿಯಲ್. ಸೊ ವಾಟ್ ಫ್ರೆಶ್ ಅಪ್ ಪೆಂಡಿಂಗ್ ಕೊಡಿ. ಸ್ಟೇ ಇಲ್ಲ, ನೋ ಸ್ಟೇ ಅಂತ ಬರ್, ನೋ ಸ್ಟೇ ಇದೆಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮೆಮೊಗಳೆಲ್ಲ. ಡೋಂಟ್ ಮೇಕ್ ಅ ಮೆನ್ಷನ್. ಯಾವ್ಯಾವ್ದ್ರಲ್ಲಿ ಸ್ಟೇ ಇಲ್ಲ ಎಲ್ಲ ಕೊಡಿ. ಫ್ರೆಶ್ ಎಲ್ಲ ಮಂಡೇ 498 ಮಂಡೇ. ಎಸ್. Why he practicing advocate should not marry, is it? All right, ಕೊಡಿ. Give it. No stay. ನಾಳೆ ಯಾಕೆ? ನೀವು ಥರ್ಡ್ ಪೆಟಿಷನರ್ ಶೋಲ್ಡರ್ ಇಂದ ಎಲ್ಲ ಪೆಟಿಷನರ್ಸ್ ರಿಲೀಫ್ ತಗೋಬೇಡಿ, ಕೊಡಿ. ವಿಲ್ ಸಿ ಗಿವ್ ಇಟ್. ಎಸ್ ಕೊಡಿ. ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ವಾ? ಸಾರಿ, ಸ್ಟೇ ಇದೆಯಾ ಇಲ್ವಾ? 2027 ಮೂವ್ ಮಾಡಿ. ಎಸ್ ಗಿವ್ ಇಟ್. ಫ್ರೆಶರ್ ಪೆಂಡಿಂಗ್ ಮಂಡೇ. ಏನು ಅಫೆನ್ಸ್ ಸರ್? ಕೊಡಿ. 230 ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಸರ್. ಮಂಡೇ ಕೊಡಿ. ಮಂಡೇವರೆಗೂ ಆಗ್ಬೋದು ತಾನೆ, ಏನಾಗಲ್ಲ. ಮಂಡೇವರೆಗೂ ಆಗುವಂತ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಗಳೆಲ್ಲ ಕೊಟ್ಬಿಡಿ. 230 ನಿಜವಾಗ್ಲೂ ಅರ್ಜೆನ್ಸಿ ಇದ್ರೆ ಹೇಳಿ. ಫ್ರೈಡೇ ಇವತ್ತಿದೆಯಾ? ಸೀರಿಯಲ್ ನಂಬರ್ 101 ವಿಡ್ರಾಯಲ್ ಅಂತ ಬರ್ಕೊಳ್ಳಿ. ಲಿಬರ್ಟಿ. ಎಸ್.
ಈ ಕಡೆ ಬರ್ತಾನೆ ಇಲ್ಲ.
ಪೆಂಡಿಂಗ್ ಮ್ಯಾಟರ್ ನೋ ಸ್ಟೇ ಇದ್ರೆ ಮಾತ್ರ ಕೊಡಿ. ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಇದ್ರೆ ಕೊಡಿ, ನೋ ಸ್ಟೇ ಇದ್ರೆ ಕೊಡಿ. ಸರಿ, ಹಾಕಿದೀರಾ ಈಗ? ಇವತ್ತಿದೆಯಾ? ವಿಡ್ರಾ ಆಗಿದೆಯಾ? 230 ನಾಳೆಗ? ನಾಳೆ ಮಂಡೇ, ಎಲ್ಲ ಮಂಡೇ.
APSC candidates, because my lords have granted a stay, they are unable to obtain bail also. They are successful candidates, my lords, meritorious students. Kindly be taken up at the end of this.
ನಾಳೆ ತಗೋಣ. Tomorrow.
The offense under section 69, my lord, is in custody since 14/7. Relationship for 5 years, my lord. End of the list.
230. ನಾಳೆಗೆ ಬೇಕಾ? ನಾಳೆ. ಎಸ್.
One matter for 230. Yesterday, my lord, the India police took up our manager and detained him up to 11 o'clock in the.
Our manager?
Yes, my lord.
Which bank, sir?
My lord, IndusInd Bank. They say the police officers are asking the manager to reverse 1.5 crores at midnight at 12 o'clock. Then we went and told, my lord, there is no allegation against us. You cannot detain us like this.
ಇದೆಲ್ಲ midnight ಅಲ್ಲಿ ಹೇಳಿದ್ರಾ?
ಹೌದು, 11 ಬಿಟ್ಟು ಕಳಿಸಿದ್ದಾರೆ. Without our, we are not even named in the FIR. Then, my lord, we were made to sit in the police station up to 11:30. And thereafter, my lord, we requested the officer, please furnish the copy of the FIR at least.
You have told the bank and come now?
No, my lord, he was detained, my lord, 2:30. There is a real threat.
230.
So great.
ಅಲ್ಲ, ನೀವು ಹೇಳ್ತಿರೋದು ನೋಡಿದ್ರೆ 10:00 ಬೇಕೇನೋ ಅನ್ಕೊಂಡೆ.
ಇಲ್ಲ, I'm sorry, I was.
ಪರವಾಗಿಲ್ಲ.
I'm
Don't be
extremely sorry
sorry.
if the court is.
No worries. Yes.
Madam, maintenance recovery petition, madam.
ಕೊಡಿ, fresh matter ಕೊಡಿ.
Already civil prison
ನೀವು
ಹೋಗಿದ್ದಾರೆ.
ಕೊಡಿ ಸರ್.
Same execution.
Monday.
Madam, 230 madam. ತಿರ್ಗಾ ಸಿವಿಲ್ ಪ್ರಿಸನ್ ಹೋಗಿದ್ರೆ ತಿರ್ಗಾ ಅದೇ ಕೇಸಲ್ಲಿ ವಾರೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಏನ್ ಮಾಡಕ್ಕಾಗುತ್ತೆ? ಮೇಂಟೆನೆನ್ಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂದ್ರೆ ಅದೇನೆ.
ಸಫರಿಂಗ್ ಫ್ರಮ್ ಕ್ಯಾನ್ಸರ್ madam.
ಯಾರು?
ಪೆಟಿಷನರ್.
ಆಯ್ತು, ನಾಳೆಗೆ ತಗೊಳ್ಳಿ.
230 madam.
ಫ್ರೆಶ್ ಇದ್ರೆ ಕೊಟ್ಬಿಡಿ ಸರ್. ಎಲ್ಲರೂ ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ ಒಂದ್ ಮೆಮೊನು ತಗೊಳಲ್ಲ. ವೇಟ್. ಎಸ್, ಪ್ಲೀಸ್ ವೇಟ್ ದಟ್ ಸೈಡ್. ನೋ ಸ್ಟೇನಾ? To 2027. Yes.
Lord,
No, don't move.
Lord,
No stay ಇದ್ರೆ ಮಾತ್ರ. ಸ್ಟೇ ಇದ್ರೆ ಮೂವ್ ಮಾಡಬೇಡಿ.
tomorrow.
ನೋ ಸ್ಟೇ ಬರ್ಕೊಡಿ ಅಲ್ಲಿ. ನಾನೇ ಹಾಕಿಸ್ತೀನಿ. ನಾಳೆ ನಾಡಿದ್ದು ಯಾವಾಗ ಹಾಕ್ಸ್ತೀನಿ. ನೋ ಸ್ಟೇ ಮ್ಯಾಟರ್.
Tomorrow.
Blanket complaint my lord is given against all the.
ಸಾರಿ,
Blanket complaint is
ಬ್ಲಾಂಕೆಟ್ ಕಂಪ್ಲೇಂಟ್.
against all the teachers of this school.
ಹಂಗ ಬ್ಲಾಂಕೆಟ್ ತಗೊಂಡೋಗಿದ್ದು ಕಂಪ್ಲೇಂಟ್ ಅನ್ಕೊಂಡೆ. ಎಸ್.
230 my lord. All the teachers have been.
ಸ್ವಲ್ಪ ಅಲ್ಲಿ ಹೇಳ್ತಾ ಇರೋದು ಕೇಳಿಸ್ತಾ ಇಲ್ವಾ? Yes.
Hitting complaint against all the teachers on the ground my lord. The building which the school is.
Tomorrow.
Foreign ಹೋಗ್ತಾ ಇದ್ದಾರೆ.
ಫಾರಿನ್ ಹೋಗ್ತದೆ, ಹೋಗಿ.
Graduation 420 cases.
ಇರ್ಲಿ ಮಂಡೇ. ಏನ್ ಪೆಂಡಿಂಗ್ ಅದು? Monday.
That's pending matter. Magistrate has rejected the application for release of money, my lords. ITR file ಮಾಡ್ಬೇಕು, my lords. Tomorrow.
No. Yes.
My lords, the date may be given.
On 20th, it is set out for.
Tuesday. Nivek, you can come this side. Both of you come this. All of you come this side. Wait. Yes.
A patient of dementia. I'm a patient of dementia, my lord. I've been dropped from the charge sheet as accused number 2. Despite that, my lord, there's continued freezing of my accounts. I need the funds for my own medical treatment, my lord. I'm literally on my deathbed, and that's why I'm moving.
Deathbed.
Yes, I'm moving
Alright,
for
good.
230.
2:30 ತೊಗೊಳ್ಳಿ.
Grateful.
My lords, 498 matter, my lords. Neighbors have been falsely implicated. There was a stay of further investigation.
Can it be on Monday?
In spite of that, they have filed charge sheet, my lords.
Monday?
My lords, Monday it's listed, my lords.
For
before the
what?
honorable court. For appearance of the parties.
ಆಯ್ತು, ಫ್ರೈಡೆ ಕೊಡಿ.
Applies.
ನೀವ್ ಯಾರು? ಏನು? ಏನ್ ಬೇಕು? ಡೇಟ್ ಬೇಕಾ? ಅದು ತಗೊಳ್ಳಿ ಮೇಡಮ್. ಫ್ರೆಶ್ ಪೆಂಡಿಂಗ್ ಮಂಡೇ. ಮಂಡೇ ಮೇಡಮ್. 2:30 498 ಏನ? ಏನಿಲ್ಲ ಕೊಡಿ. ಎಸ್ ಮಂಡೇ. Sorry? Where is the order sheet? Order sheet ಇಲ್ಲ ಅಂದ್ರೆ ಕಾಸ್ಟ್ ಇಂಪೋಸ್ ಮಾಡ್ತೀನಿ. ಆರ್ಡರ್ ಶೀಟ್ ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಕ್ಕೆ ಅಂತ ಲಿಸ್ಟ್ ಆಗಿದ್ರೆ ಮಾತ್ರ. ನಾಡಿದ್ದಕ್ಕಿದೆಯಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಅಲ್ಲ. ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಇದ್ರೆ 2:30 ತಗೊಳ್ಳಿ ಅದು. ನಾಳೆಗೆ. 498 ಸ್ಟೇ ಕೊಟ್ಟಿದೀವಾ? ಹಸ್ಬೆಂಡಿಗೂ ಸ್ಟೇ ಆಗಿದೆಯಾ? ವೈ ವೇಸ್ಟ್ ಎಫರ್ಟ್? ಏನ್ ಸರ್? ವಿಲ್ ಸಿ. ಎಸ್ ಕೊಡಿ. ಮಂಡೇ ಆಗಲ್ಲ. ಟ್ಯೂಸ್ಡೇ ಆರ್ ಬಿಟ್ವೀನ್ ಟ್ಯೂಸ್ಡೇ ಟು ಥರ್ಸ್ಡೇ ನೆಕ್ಸ್ಟ್. Drugging and trafficking the child, his own daughter. ಅದು ತೊಳೆದು ಅದು ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್. ಮಂಡೇ ಆಗ್ಬೋದಾ? ವೇಟ್. ಎಸ್ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ನೋ ಸ್ಟೇ ಕೊಟ್ಬಿಡಿ ಮೆಮೋ. ಆಪರೇಟಿಂಗ್ 2027 ಜನವರಿಲಿ ಕೊಡಿ ಮೆಮೋ. ಎಸ್ ನೆಕ್ಸ್ಟ್. How do you know? How do you know? ಏನು ಆಗಿಲ್ಲ ಅಂತಾನ? ಮತ್ತೆ ಯಾಕೆ ಅರ್ಜೆನ್ಸಿ ಬಿಡಿ. ನಾಳೆ ಓಲ್ಡ್ ಮ್ಯಾಟರ್ಸ್ ಕೊಟ್ಬಿಡಿ ಸರ್. ನೋ ಸ್ಟೇ ಈಗ ಕೊಡ್ತೀರಾ ಇಲ್ವಾ ನೋ ಸ್ಟೇನ? ಬರುತ್ತೆ ಕೊಡಿ. ಮಂಡೇ. No problem, Monday. Monday, I remember that case. Yes, Monday, yes. Monday. ಏನ್ ಫ್ರೆಶ್ ಅಪ್ ಪೆಂಡಿಂಗ್? ಏನ್ ಅರ್ಜೆನ್ಸಿ ಏನು? ಯಾವ್ದ್ರಲ್ಲಿ ಸರ್? ಟುಮಾರೋ. ಮಂಡೇ. 498 ಎಲ್ಲ ಮಂಡೇ ಕೊಡಿ. NDPS ಮಂಡೇನೆ. ನೋ ಪ್ರಾಬ್ಲಮ್ ಮಂಡೇ.
498 ಮಂಡೇ ಅಂತ ನೋಡಿ.
ಎಲ್ಲ ಫ್ರೆಶ್ ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ ಮಿಕ್ಕಿದೆಲ್ಲ. ಎಲ್ಲಾರು ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ರು. ನಿಮ್ಮಲ್ಲಿ ಕೋಆಪರೇಟ್ ಮಾಡ್ಕೊಂಡು ಒಬ್ರು ಹೇಳಿದ್ರೆ ಸರಿ. ಇಬ್ರು ಒಟ್ಟಿಗೆ ಹೇಳಿದ್ರೆ ಯಾವ ಮೆಮೊನು ತಗೊಳಲ್ಲ. ಕೊಡಿ. ಆರ್ಡರ್ ಶೀಟ್ ಎಲ್ಲಿದೆ? ಮೆಮೋಗೆ ಅಪೆಂಡ್ ಮಾಡ್ಬೇಕು ಆರ್ಡರ್ ಶೀಟ್ನ. ಕೊಡಿ. ನಾಳೆಗೆ ಹಾಕ್ತೀನಿ. ಅಕಸ್ಮಾತ್ ಫ್ರೇಮಿಂಗ್ ಆಫ್ ಚಾರ್ಜ್ ಇಲ್ಲ ಅಂದ್ರೆ ಕಾಸ್ಟ್. ಎಸ್. ಅಡ್ವೊಕೇಟ್ ಅರೆಸ್ಟಾ? ವೈ ಸರ್? ಅಫೆನ್ಸ್ ಏನ್ ಸರ್? 118 ಅಡ್ವೊಕೇಟ್ ಮೇಲೆ ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ? ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದಾರಾ? ಪರವಾಗಿಲ್ಲ. ಮಂಡೇ. ಎಸ್ ಮಂಡೇ. ನೀವು ಹೇಳೋದ್ರಲ್ಲಿ ಕ್ಲಾರಿಟಿನೇ ಇಲ್ಲ. ಮಂಡೇ. ಎಸ್ ವೆರಿ ಗುಡ್. ಮಂಡೇ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ತಾನೆ? ಅಫ್ಕೋರ್ಸ್ ಆನ್ ಸೀನಿಯಾರಿಟಿನೇ. ನಿಮ್ಗಿಂತ ಮುಂಚೆ ಕೊಟ್ಟಿರೋ ಮೆಮೊಗಳಿದಾವಲ್ಲ. ಎಸ್ ಆರ್ಡರ್ ಶೀಟ್ ಇದೆಯಾ? ಎಲ್ಲಿದೆ? ಹಿಯರಿಂಗ್ ಬಿಫೋರ್ ಚಾರ್ಜ್ ಅದು. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಮಾಡಕ್ಕಲ್ಲ. HBC ಅಷ್ಟೇ. ಹಿಯರ್ ಆರ್ಗ್ಯೂ ಮಾಡಿ ಕೊಡಿ. ಗಿವ್ ಇಟ್ ಸರ್. ಯು ವಾಂಟ್ ಟು ವಿಡ್ರಾ? ಹಾ ತಗೊಳ್ಳಿ, ವಿಡ್ರಾಲ್ ಮೆಮೋ ತಗೊಳ್ಳಿ. ಕೊಡಿ. ಮಂಡೇ ಸರ್, ಅದ್ರಲ್ಲಿ ಏನು ಅರ್ಜೆನ್ಸಿ?
Also offense, there are 8 to 10 girls, not
8 to 10?
victims,
ಹಾ.
all of which are suppressed in the charge sheet. That has filed a petition for further hearing.
ಫರ್ದರ್ ಹಿಯರಿಂಗ್
Sorry, further investigation. Date was not set.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ.
Cause of the
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಬರುತ್ತೆ ಕೊಡಿ ಸರ್.
For tomorrow, my lord.
ಗಿವ್ ಆಲ್ ದಿ ಅದರ್ ಮೆಮೋಸ್. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ 498 ಅವೆಲ್ಲ ಐಲಿಡ್ ಅಫೆನ್ಸಸ್ ಎಲ್ಲ ಮಂಡೇ ಕೊಡಿ. ಮಂಡೇ ಎವ್ರಿಥಿಂಗ್ ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಕೊಡಿ. ನೋ ಪ್ರಾಬ್ಲಮ್ ಕೊಡಿ ಸರ್. ಮೇಡಮ್ ಈಗ ಇನ್ ಮಿಕ್ಕಿದ ಮೆಮೋ ಎಲ್ಲ 17th ತಗೊಂಡ್ಬಿಡಿ.
End of list.
ಈಗ ತುಂಬಾ ಇದ್ ಮಾಡಿದ್ರೆ 17th ಹಾಕ್ತೀನಿ. ಇಲ್ಲದ ಮೆಮೋ ಕೊಡಿ ಸ್ವಲ್ಪ. ವೈ ಇಸ್ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ? ವೈ ಇನ್ ಜುಡಿಷಿಯಲ್ ಕಸ್ಟಡಿ? ವಾಟ್ ಅಫೆನ್ಸ್? ಹಾ, NDPS offense ಅಲ್ಲಿ ಮತ್ತೆ ಬೇರೆ ಎಲ್ಲಿರ್ಬೇಕು ಅನ್ಕೊಂಡ್ರಿ? We'll see tomorrow.
All other court.
Wait, who is that shouting? Who is that shouting?
Sorry, sorry.
Lower your voice.
That's for.
Wait. When? On 13th. ಅಂದ್ರೆ ಮಂಡೇ ಬರುತ್ತೆ. ಮಂಡೇ ಟ್ಯೂಸ್ಡೇ ಬರುತ್ತೆ ಕೊಡಿ.
All.
ನಿಮ್ದೇನು? ವಿಚ್ ಡಾಕ್ಯುಮೆಂಟ್ಸ್? ಹೌದು, ಇಟ್ ಇಸ್ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಇದೆ. ಅದನ್ನ ಈಗ ಕೊಡಕ್ಕಾಗಲ್ಲ. ಅವೆಲ್ಲ ಪ್ರೊನೌನ್ಸ್ಮೆಂಟ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ ಅವೆಲ್ಲ ಮಾಡಕ್ಕಾಗಲ್ಲ. ನೋ ಸರ್, ಯು ಕಾಂಟ್ ಡೂ ಎನಿಥಿಂಗ್ ಯು ವಾಂಟ್ ಜಸ್ಟ್ ಬಿಕಾಸ್ ಯುವರ್ ಪಾರ್ಟಿ ಇನ್ ಪರ್ಸನ್ ಬಿಹೇವ್. ಎಸ್, ಸೆಟಲ್ಡಾ? ಯಾವಾಗ ಬೇಕು ಸೆಟಲ್ಮೆಂಟಿಗೆ? ಕೊಡಿ. ಅಷ್ಟೇ ಸಾಕು. ನೋ, ನಥಿಂಗ್ ಡೂಯಿಂಗ್. ಎಸ್, ನೆಕ್ಸ್ಟ್. ಮಂಡೇ ಆರ್ ಟ್ಯೂಸ್ಡೇ ಲೆಟ್ ಕಮ್. ಅದು ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಕೊಡಿ, ಡೇಟ್ ಕೊಡಿ ಫಾಸ್ಟ್. 11 ಗಂಟೆವರೆಗೂ ಇವತ್ತು ಮೆಮೊಲ ಇದಿರಲ್ಲ, ಕೊಡಿ ಈಗ ಕೊಡಿ ಜಲ್ದಿ. Yes, why are you all waiting now?
An application has been rejected before
All
the
of you
session.
can't say it. One same rule applies here also. Wait. Yes, why are you waiting?
For all other accused.
No, wait, you wait.
And
Yes,
Your Lordship, the case is listed tomorrow only, but the trial.
for what?
High Court only it was yesterday, it is listed tomorrow, but in trial court, the case is tomorrow only. For
No
NBW
problem.
has been
I
issued.
can't fix my dates according to trial court. Take adjournment there.
2:30 cannot.
No,
be taken.
give it, yes.
Udupi Bar
Tomorrow ideyalla bidi adu. Yes.
Bar Association has passed a resolution. They filed a defamation case against me, advocates.
Monday.
End of list, my
No,
lord.
end of.
Tomorrow is the date for notice.
ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
6th.
Defamation ಏನಾಗೋಗ್ಬಿಡುತ್ತೆ?
But they're both advocates, that's it.
Nothing, no problem.
Date may begin for Monday, ma'am.
Give it, yes.
Respondent number 2, IA was given in the year 2025, Your Lordship.
For what?
In-
Vacating,
IA was
ಕೊಡಿ.
stay,
Yes. Stay or vacating stay?
IA was given 2025. Your
No
Lordship,
stay
we
matter
filed
ಹಾಕಿ
for-
madam. Yes.
Have it listed tomorrow, Your Lordship.
Stay ಇಲ್ವಾ ಅದ್ರಲ್ಲಿ?
ಇಲ್ಲ.
ಕೊಡಿ.
Account freeze ಆಗಿದೆ, my lord.
ತೊಂದ್ರೆ ಇಲ್ಲ, no stay matter ಅದು ಕೊಡಿ.
Monday, kindly post
Yes,
Monday.
what happened? Not come?
For Monday, maybe kindly taken either this
What's the urgency?
urgency is the trial date is coming up next.
I had given a date for Monday. It was not listed?
It wasn't listed.
Tomorrow.
My lord, kindly
Your
check on
Lordship.
Monday, my lord. Should be taken on Friday.
Why Friday?
I have an unavoidable travel that I have to do in the afternoon.
All-
Your Lordship.
No, tomorrow, let it be in tomorrow. No problem. Morning itself, yes.
My lord, kindly give it.
Sorry? Against the husband it is stayed? All right, give it.
Yeah.
ಕೊಡಿ Monday.
Your Lordship.
Monday. Yes.
Your Lordship.
ಬೇಕಿದ್ ಕೊಟ್ಬಿಡಿ ಅಲ್ಲ ಸಾಕು.
Your Lordship, there's
ಸಾಕು,
one.
ಸಾಕು,
Your Lordship,
311 has been rejected.
Give all the memos, sir.
A date may be given
ಕೊಟ್ಬಿಡಿ ಎಲ್ಲ memos.
for withdrawal of prosecution.
Memos, fresh matters ಎಲ್ಲ ಕೊಟ್ಬಿಡಿ. Give all the memos, please. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಸರ್. ಪರವಾಗಿಲ್ಲ ಕೊಡಿ ಮಂಡೇ ಎಲ್ಲ ಮಂಡೇ ಮೇಲೆ ಕೊಡಿ ಎಲ್ಲ.
Your lordship, 311 has.
ಮಂಡೇ ಮೇಲೆ ಕೊಡಿ ಸರ್. Give.
311 has been.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಸರ್. ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. 138 138 ಅಲ್ಲ. ಏನಾಗಿದೆ? ಯಾವತ್ತಿದೆ? ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತು? ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತು? ಪರವಾಗಿಲ್ಲ ಕೊಡಿ.
Your lords,
ಏನಾಗಲ್ಲ ಕೊಡಿ ಸರ್.
Milord's date was given back. There was.
Wait. Yes. ನೀವೆಲ್ಲ ಕೊಡಿ.
your lords,
ಈಗ 10:55 ಆಯ್ತು. In 1 minute ಅಲ್ಲಿ ನೀವು ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಎಲ್ಲ 17th ಹಾಕ್ಬಿಡಿ.
Milords.
All 17th. 17th, yes.
Judgment ಇದೆ 12.
ಕೊಡಿ. ಯಾವ್ದು ರಿಸರ್ವ್ ಆಗಿರೋದು? ಈಗ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದ್ಯಾ? ಅದೇನ್ ಚಾಲೆಂಜ್ ಮಾಡ್ತಿದ್ದೀರಾ? ಅಷ್ಟೇ ಕೊಡಿ. ಅವ್ರಿಗೆ ಒಂದು ಕಾಪಿ ಕೊಟ್ಬಿಡಿ.
My lord,
Your lordship,
covered by judge.
ಹಾ, ಕೊಟ್ಬಿಡಿ.
My lord,
Yes, all
covered
the
by
cases.
judge.
Your lordship, 311 has been rejected.
Give it.
Friday is the date, your lordship.
Give it.
Friday is the date.
No problem, give it, madam.
your lords, the matter was, the subsequent matter was
Monday.
ಆಗ್ಲಿ, ಏನಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಸರ್? ಏನಕ್ಕೆ ಲಿಸ್ಟ್ ಆಗಿದೆ ಸರ್? ಕನ್ವಿಕ್ಷನ್ಗ ಕೊಡಿ ಸುಮ್ನೆ. ಎಸ್
your lords,
Milord's date.
ಕೊಡಿ ಪ್ಲೀಸ್. You don't give a memo.
My lord.
I'll not take your memo.
your lords, if
You should know how to behave in the court.
Sorry, my lord.
your lords, if I
Monday
may, your
judge.
lords,
Please give, madam.
My lord,
your lords says,
ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ.
Trial court ಅಲ್ಲಿ judgment.
ನೀವು ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ.
my lord, Supreme Court covered by.
ನೀವು ಕೊಡಂಗಿದ್ರೆ ಕೊಡಿ. Yes.
Sir, judgment ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ
ಯಾವತ್ತಿದೆ?
ಸರ್ ಮಂಡೇ ಇದೆ ಸರ್.
Friday.
1:30.
Friday.
I'm sorry.
2:30 ಬೇಕಾಗಿತ್ತು.
Last,
2:30 ಬೇಕಾಗಿತ್ತು, ಹಂಗ್ ಕೊಡಕ್ಕಾಗಲ್ಲ.
Sir, please.
Yes.
My lordship.
ನಾಳೆಗೆ ಹಾಕಿ ಮೇಡಮ್.
Sir,
ನಾಳೆ.
Sir, I'm really sorry for my behavior.
No,
sir.
wait.
Sir.
Yes, give it.
last 15 years, my lordship, the 498 case is pending, my lordship.
Last 15 days ಇಂದ.
15 years, my lordship.
ಅದನ್ನ September 7th ಹಾಕಿ ಮೇಡಮ್.
Sir.
Another 15 days let it be pending.
The matter is posted for
ಸುಮ್ನೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಂದ್ರೆ ಬರುತ್ತೆ. ಇದ್ರ ಎಕ್ಸ್ಟ್ರಾ ಡೈಲಾಗ್ ಎಲ್ಲ ಹೊಡೆದ್ರೆ ಇಲ್ಲಿ ನಾನ್ ತಗೊಳ್ಳೋದೇ ಇಲ್ಲ ಮೆಮೋನ.
Order has been.
10ನೇ ಮೆಮೋ 15 ದಿವಸದಿಂದ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದಿದೆ ಇದಿದೆ, ಅವೆಲ್ಲ ಇಲ್ಲ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಅಂತ ಹೇಳಿ ವಿಲ್ ಗೆಟ್ ಇಟ್. Don't embellish anything in while moving a memo. Yes.
Sir, the matter is posted for judgment, my lord. Matter is
When?
posted for judgment. Monday.
ಎಲ್ಲ ಕೋರ್ಟ್ ಮುಗಿಸ್ಕೊಂಡ್ ಬಂದ್ರ ಮೆಮೋ ಎಲ್ಲ? ಬೇರೆ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇರ್ಲಿಲ್ವಾ ಮೆಮೋ ಮಾಡೋದು? ಕಾಣ್ಲಿಲ್ಲ ನೀವು ಮತ್ತೆ?
I've been standing here.
1:15 ಬನ್ನಿ.
Sir, my lord.
ಹಾ? ನೀವ್ ಎಲ್ಲಿದ್ರಿ? ಕೊಡಿ. Come at 1:30. Come and move at 1:30. You should know how to move a memo. Yes.
this to serial number 20.
No adjournment, direct or indirect, mention when it is called.
This one fresh matter, still number 1.
Discharge is rejected in 2025. What is the stage today?
Evidence is, evidence coming.
Yes. The petitioner is before the, when was it, when was the petition filed? Nodi madam.
24 June 25.
Charge frame agide yavattu?
Charges in 2019.
2023. The petitioner is before the court seeking the following prayer. The petitioner files an application seeking his discharge from the area of accused, which comes to be rejected about 2 years ago. The learned counsel for the petitioner submits that the trial has commenced after framing of charges. There is no warrant of interference once charges have framed prior to the filing of the petition itself. In that light, they are reserving liberty to the petitioner to urge all the contentions before the concerned court. The petition stands disposed in the light of the judgment of the apex court in the case of Meenakshi Bala. Yes, next.
Number 2.
Covered ಕೊಡಿ ಅದು 171E. ಎರಡು ಇದೆಯಲ್ಲ ನಿಮ್ದು? ಇನ್ನೊಂದು ಯಾವ್ದು 171E ನಿಮ್ದಾ? ಹಾ ಕೊಡಿ ಅದು.
ಇದರಲ್ಲಿ
Same,
evidence
JY.
comments.
171E. Yes, next.
3.
Petition, sir. Got the offense under section
498 304B. You are the sister of the husband.
Please,
Huh?
the case of the prosecution is that.
Mic ತಗೊಳ್ಳಿ sir.
Please. Well, the marriage has taken place in the year 2021. The deceased has committed suicide.
Correct.
But thereafter, my lord, case was registered against.
ಅದೆಲ್ಲ ಆಯ್ತು sir, sister ಅದೇನ್ role
Lord, the
ಹೇಳಿ.
specific allegation is that these petitioners, when they were frequently visiting the house of A1, at that time they used to harass this deceased to fetch dowry from the complainant. That is the specific allegation. That apart, my lord, there is specific allegation in 161 statement that on 8/5/2021, when they had been to a marriage of the relatives of one of the complainant, these petitioners picked up quarrel and created a scene. That is what the main allegation. But my lord, in fact, I have produced invitation card. That is the marriage of accused number 3, my lord. Therefore, they have projected as if the marriage has taken place with respect to their relatives and created scene, my lord.
Yes, Vaida madam.
Allegations is there against this petitioner, my lordship, as per.
No, which can become the offences under section 304B,
Yes, my lordship.
498A, all right.
But some allegations are there.
Allegations are there, I'm not on that. One HCGP, 2 emergent notice, returnable by 28th of August.
My lord, it is posted for framing of charge on 11th of August, my lord.
Insofar as the petitioner is concerned, the framing of charges shall be deferred. It is made clear, the concerned, it is only against the petitioner accused number 2. Yes.
My lord, this petitioner 2 and
2,
4,
3,
my lord. 2 to 4,
is
my
there.
lord.
2 to 4 and 2 to 4, we'll see on that day.
Please, oblige.
Number 4.
My lord, husband petitioner. Lord, the petitioner is the resident of Shingenahalli of Channarayapatna Taluk. The respondent wife is the resident of Bangalore as a sole daughter of.
ಯಾಕೆ ಜೊತೆಗೆ ಇರ್ಲಿಲ್ವಾ ಇಬ್ರು?
ಇಲ್ಲ ಸ್ವಾಮಿ, ಒಂದು 15 days ಇದ್ರು ಊರ್ನಲ್ಲಿ ಇರ್ತೀನಿ ಅಂತ ಮದ್ವೆ ಆಗಿದ್ದು. ಏನು ಅಲಿಗೇಷನ್ ಇಲ್ಲ ಸ್ವಾಮಿ. ನಾನು ಕರ್ಕೊಂಡು ಹೋಗಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ 498 ಪ್ರೈವೇಟ್ ಕಂಪ್ಲೇಂಟ್ ಹಾಕಿ. ಬೇರೆ ಏನೂ ಅಲಿಗೇಷನ್ ಇಲ್ಲ.
Private complaint.
ಒಂದು ಹೆಣ್ಮಗಳಿದ್ದಾಳೆ ಸ್ವಾಮಿ.
Private complaint is the suspicion, yes. The petitioner is the husband. Is alleged of the offence punishable under section 498A. The wife complainant does not directly register a complaint before the jurisdictional police, nor has produced any effort being made for registration of a complaint before the police as obtaining under section 154 of the CRPC. 154(1) or 154(3) of the CRPC, has directly chosen to file a private complaint in an offence under section 498A. In the light of the 498, the learned magistrate refers the matter. A reference has led to the impugned proceedings. The complaint, the narration in the complaint is bereft of any material that would become the ingredients of 498A. Minor skirmishes or vicissitudes that happen in the family between the husband and the wife is sought to be projected to become a crime. In permitting further proceedings against the husband would run foul of the judgment of the apex court in the case of Abhishek versus State of Uttar Pradesh, 2023 SCC online SC page 1083. Therefore, there shall be 1 HCGP 2 emergent notice.
5.
Entry model.
Kottaಯ್ತು sir. ಕೊಟ್ಟಾಯ್ತು.
Grateful.
Yes sir.
For the petitioner in this case, Lordship.
Still number 5. 2, 3, 4, 498A. Yes, next.
6.
States. Yes.
Lordship, six appear for the petitioner in this matter, my lordships. My lordships, this is a.
In the meantime, yes, next. Bhargav, heard the learned senior counsel Gopal Swamy appearing for the petitioner. Plethora of revenue proceedings pending between the parties is sought to be dressed with the color of crime by setting the criminal law into motion. In that light, there shall be an interim order of stay of further proceedings. Charge sheet ಆಗಿದೆಯಾ?
ಇಲ್ಲ.
Further investigation with the petitioner to the next date of hearing. Still number 8, 2 to 585. Yes, next.
9.
OS number, Naveen. OS number.
OS number,
ಇಲ್ಲ ಅಂದ್ರೆ no stay.
OS number 384 of 2018.
Yes, on the same set of facts. Yes, next.
10.
Who is in possession? ನಿಮ್ದೆ ಮೇಡಮ್ 10. ಪೊಸೆಷನ್ ಯಾರಿದ್ದಾರೆ?
ಪೊಸೆಷನ್ ಅಲ್ಲಿ ಅಲ್ಲ ಸ್ವಾಮಿ.
447 ತಾನೆ offense.
Yes, my lord.
Trespass ಎಲ್ಲಿ ಮಾಡಿದ್ರಿ?
Trespass while going on the road.
Road trespass.
ಅದನ್ನೇ ಹಾಕಿದ್ದಾರೆ ಸ್ವಾಮಿ. While going on the road, the complainant has attacked on the petitioners because the petitioners village is
on the road.
Golratti, my lord. And the complainant is in Kittadal. In Kittadal
village.
Yes,
next. Yes.
11. 11.
Is it a split charge? Split
Split up ಅಲ್ಲ.
ಹಂಗಾದ್ರೆ no chance. Yes. No, nothing.
ಅಲ್ಲ 10 years ಇಂದನೂ ಕೋರ್ಟಿಗೆ ಹೋಗ್ತಾನೆ ಇದ್ದಾರೆ. ಅದರ ಒಂದು ಡಿಸ್ಪೋಸಲ್ ಆದರೂ ಆಗಬೇಕು.
ಅದ್ಮ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಕೊಡ್ತೀನಿ ಬೇಕಾರೆ. No problem. I'll direct speedy disposal of the case. Not a problem. The petitioner is before the court seeking the following prayer. The learned counsel appearing for the petitioner would restrict the prayer for one of a direction to the concerned court seeking speedy disposal of the matter. In the light of the said submission, the examination gets narrowed to the fact as to the registration of the crime and the pending proceedings before the concerned court. The crime is of the year 2017, and the matter for offences punishable under so and so, and the matter is languishing before the concerned court. The perusal at the order sheet would indicate adjournments being granted without rhyme or reason ad nauseum. In that, ad nauseum. In that light, I deem it appropriate to infuse finality into the proceedings by with a direction to the concerned court to conclude the proceedings with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier, ordered accordingly.
12.
Mat bartare extension ge. Yes.
498A, my lord. Husband,
Accused number 1.
accused number 1, husband, father-in-law and mother-in-law, my lord.
Husband horrible. Very bad offense. Husband, you will dismiss it straight away.
My lord.
You know,
Earlier, she has filed one.
no problem. Husband horrible offenses. If you stick on to the husband, we will permit discharge.
My lord, 2 and 3.
2 and 3. The petitioners are accused 1, 2 and 3. The summary of the charge sheet clearly indicates that the offences against the husband, accused number 1, are horrendous. Therefore, there is no question of entertainment of the petition qua husband, the accused number 1. The petitioner would seek leave of this court to avail the remedy as available in law qua accused number 1, the husband. Insofar as the other accused 2 and 3 are concerned, that shall finding no allegations that would touch upon the ingredients of section 85.
Yes, my lord.
Of section 85, there shall be an interim order of stay of further proceedings qua the pursuant till the next date of 1 HCGP to emergent notice.
13.
498A, please, my lord. The husband has not filed.
A2 to A6, 85. Husband is not before the court.
Please.
14.
My lord, I beg to appeal for the petitioner. It
Well,
is covered by my lordship's judgment, my lord.
Page 38 covered.
Yes, my lord.
Correct? Huh? Yes. Heard
Yes,
the
ma'am.
learned counsel. A. Valen. Valen, senior counsel? Huh?
No, my lord.
Not yet. All right. Yes. A. Valen. Heard so and so. Covered by page 38. Amale, 2 other judgments are there following that same. Correct? Yes.
Apply, my lord.
Next.
15.
Petitioner, your lordship. Lordship, it's a commercial dispute.
Correct. Page 50, 51. But look at the charges.
Your lordship, we have gone through the charges. There is a lot of dispute. The relationship was from 2019. Your lordship, may I humbly request you to refer the page number, the very affair of this complaint. What is the page number? 41, your lordship.
Not necessary. Go to page 50 and 51.
Yes, your lordship. The charge.
41 is the complaint.
Yes.
50 and 51 is the charge sheet. The complaint is merged into the charge sheet.
Your lordship, the respondent number 1 failed to investigate. The respondent number 2 was running the business of the petitioner from his premises. Your lordship, I wanted to just bring it to your knowledge. In the FIR, your lordship, if you look into the address
Yes,
of
Devti
the
madam.
There's a records of transaction also, somewhere around 1 crore 87 lakhs.
No,
has
that is
been-
there, but
involvement is
we'll
there,
see.
Your Lordship.
1 HCG, what's the stage now?
charges, your lordship, 13-8.
Charges are framed.
No, it's pending for charges.
The 1 HCGP 2 emergent notice. The charges shall not be framed against these petitioners without the leave of the court.
Much obliged.
16.
In the meantime,
17. 18.
split charge.
Please, ma'am.
Appear before the court. Next date, ಏನು?
Next, 7/1/2027.
27 ನಾ?
Please,
ಹಂಗಾರೆ ಸ್ಟೇ ಮಾಡಕ್ಕಾಗಲ್ಲ. ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಪ್ರೊಕ್ಲಮೇಶನ್ ಈಗ.
proclamation. Kindly,
Why have you not appeared?
please, summons has been not served, my lord.
Huh?
Kaveri Galati case, my lord. Kaveri Galati,
Kaveri Galati.
16 crime, my lord. Summons has been not served, my lord.
In the
Hence, he couldn't
meantime,
appear.
yes. Stayed.
Please, my lord.
ಆ ಕಾವೇರಿ ಗಲಾಟೆ ನಾನೇ ಕ್ವಾಶ್ ಮಾಡಿದ್ದೀನಿ ಎಲ್ಲ ಕೊಡಿಯಲ್ಲಿ.
Please, my lord.
ನೀವು ತರದೆ ಹೋದ್ರೆ ಹೆಂಗೆ?
Please, my
ಒಂದ್
lord.
20 ಕ್ವಾಶ್ ಮಾಡಿರ್ಬೇಕು.
I will
List
bring
the
the
matter,
state.
stay ಮಾಡಿ, list the matter on 25th. ಅವತ್ತರದೇ dismiss ಮಾಡ್ಬಿಡ್ತೀವಿ.
Please, please.
Yes.
19,
This is a petitioner is an impanel advocate of the bank.
In the meantime,
20,
As a remit tagged along to the petition of the co-accused.
number, yes.
20,
A4. No serious allegation against petitioner.
But there are
He has not-
seriousness ಇಲ್ಲ ಬಿಡಿ ಅದ್ರಲ್ಲಿ. ಅದಕ್ಕೆ ಸ್ಟೇ ಕೊಡ್ಬೇಕು ಅಂತ.
He has not issued any amount and the money was recovered from A3. It is a honey trap, my lord, by
Honey trap,
A1. A1 is a,
honey trap ಅಲ್ಲಿ money trap ಹೆಂಗಾಯ್ತು?
A1, my lord, invited, my lord, the complainant to a service apartment.
What did you do?
Well, I went there, that's all, my lord.
Why?
I went there. And our allegation is that I video recorded the complainant and accused one, A1. A1 involved, my lord, not serious.
ವಿಡಿಯೋ ಯಾಕೆ ತೆಗೆದ್ರೆ?
Allegation is that to upload in the social media.
Come after charge sheet. The petitioner is before the court seeking the following prayer. The learned counsel would submit. ನಾನೇ ಬರಿಲ್ಲ, ನೀವೇ ಮಾಡ್ತೀರಾ?
ಅಲ್ಲ.
The learned counsel would submit that he would reproach this court in the event a final report is filed and the final report would go against him. That light, preserving such liberty, the petition stands disposed. All contentions remain open. Yes, next.
21,
Petitioners. The accused number 3 and 5. The accused number 4, 6 and 7 granted with stay granted.
ಯಾರು ಕೊಟ್ಟಿರೋದು ಕೊಡಿ 13 ನಲ್ಲಿ ಕೊಡಿ ಇಲ್ಲಿ. Prevention Corruption Act ತಾನೇ ಇದೆ ಮತ್ತೆ?
The allegation only after lapse of 10 years they filed the complaint. The earlier B report has been filed by the CBI, same was accepted in the very same set of facts.
Tag along with so and so, same order. Next.
Stay.
Same order ಅಂದ್ರೆ ಏನು?
22,
22 minutes of petition. Offense minute 352, minute 353.
Misappropriations. 1 HCGP to emergent notice. 22, sorry.
22.
Sorry. In the meantime, yes, next.
23,
23 misappropriations. 1 HCGP to emergent notice. Next.
24,
24 and 29 same. Tag ಮಾಡಿ ಕೊಡಿ.
5293/25.
ಆರ್ಡರ್ ಇಲ್ವಾ? ಕೊಡಿ. ಎಲ್ಲಿದೆ? ಅಷ್ಟು ಹೇಳಿ ಸಾಕು. Tag with 62 same order. Next. 24 and 29 same ಇದ್ದಾವೆ.
25,
My lord, I appear for the petitioner in this case, my lord. My lord, DV proceedings.
R8, who are you, sir?
My lord, the allegation is I'm in illicit relationship with the husband of the respondent, my lord. I'm not even a member of the family,
The
my lord.
petitioner is respondent number 8 in a proceeding instituted by the wife of the first respondent, alleging that the petitioner is the husband's paramour. The domestic violence proceedings could not have been initiated against the present petitioner as present petitioner in the light of the said relation and settled principle of law. In that light, there shall be an interim order of stay of further proceedings, sway the petition to the next date of hearing. Next.
Grateful, obliged, my lord.
26,
Counterblast to my complaint.
Meantime,
27,
detail order ಬರಿಬೇಕು, ಟೈಮ್ ಇಲ್ಲ, ಇರ್ಲಿ. Yes.
64 BNS.
6, ಇದು 27 rightly withdrawn, withdrawal ಹಾಕಿದ್ದಾರೆ. Otherwise dismissal ಅದು. Yes, 28.
28,
Petitioner, your lordship.
Yes, sir, A8 to A10,
Yes.
395.
The lordship, we are not even present in the scene.
He is the supplier of ganja to other accused.
That is matter of different case altogether, your
Correct, sir,
lordship.
that's a matter of trial, sir.
Your lordship, what I was trying to pray, your lordship, that they are giving a statement, the accused giving a statement. After that, police should have investigated and file the reports.
No problem.
This much ganja was recovered, this was taken, this something would have been there. There is nothing on record, your
We'll
lordship.
see, we'll see.
Your lordship, please, your lordship. It is-
Please, there is no
it
please jurisdiction. Yes.
He's a dentist by profession.
Dentist, ah?
Yes, your lordship. The accused number 8 is working as a real estate management.
Who is a dentist here?
Accused number 9, Akhil.
Accused number 9.
Yes, your lordship.
Perhaps he would need a root canal.
Lordship.
Anyway, No chance of interference.
Accused number 10, your lordship, is MBA degree holder. All are educated, 26, 27 years old.
No problem.
Just
Correct.
for-
That is the age when they supply.
Your lordship, they are not at all involved with the crime.
No,
It's just a
that-
personal
that's-
enemy.
no,
your lordship.
no, sir.
Lordship. Your lordship is just accused, 5 comes up and give this statement. Your lordship, after
Where
the
do you supply? In the clinic, is it?
your lordship,
Then?
there is no such cases, your lordship. Your lordship, I humbly pray that that can be deferred and give a opportunity to
No,
have the
sir,
matter in brief.
nothing.
Your lordship,
If I entertain petitioners who are alleged of supplying ganja,
your lordship, he has a blank statement saying that 8, 9, 10 has supplied. Should have been some kind of credential
voluntary statement
information.
will see, corroboration will see what is there.
Your lordship, there should have been, like a specific statement on this day, on this time, this person came and supplied to us.
Oh, you should
Lordship,
say
your
time, minute, second, they supplied this many grams of ganja.
It-
No, sir,
is a
it doesn't
blank
work, it doesn't work like that.
It was a blank statement by the
No,
accused,
no,
your
statements
lordship.
are always blank, corroboration comes in the evidence, we'll see.
But there is no evidence put up in the charge sheet, your lordship.
We'll
Nothing
see.
is put up,
We'll
your
see.
lordship.
The learned counsel for the petitioner submits that accused number 8, 9 and 10 are dragged into the dragnet of crime on the voluntary statements of the co-accused. The learned HCGP Nageshwarappa is directed to secure instructions with regard to the corroborative material qua the accused number 8 to 10 by the next date of hearing. List the matter on 25th.
Your lordship, the matter is for the charges. We are
Very good,
facing,
let
your
it be, sir. Yes, 25th next. Not in this case.
25th of August. Much.
You're doing, practicing dentistry or stopped?
Keep practicing then.
Practicing. Continues. Yes.
29 and 30.
Petitioners are father, mother.
A2
and,
to A4,
sister.
85. Next.
31.
I'm calling for the petition.
You are public servants.
Yes, my lords.
Where is the order of taking of cognizance?
My lords, page number, my lords.
Cognizance order ಎಲ್ಲಿದೆ? ಇಲ್ಲಿ ಹುಡುಕಿದ್ರೆ ಡಿಸ್ಮಿಸ್ ಮಾಡ್ತೀನಿ.
No, my lords.
One HCGP, two emergent notice.
32.
Connected matters are stayed, my
ಇದು
lords.
ನಾವು ಕೊಡಲ್ಲ. Where is the cognizance?
Sorry, my lords, sorry.
Where is the cognizance order?
I'll show that, my lords.
Yes. I tag along with same order. You should.
My lords, 41, my lords. Page number.
ಅದು ನೋಡಿ ಫ್ಲಾಗ್ ಹಾಕೊಂಡ್ ಬರ್ಬೇಕು ತಾನೆ. ಅದು ಕಷ್ಟನಾ?
No, my lords, I'll.
Yes.
Page number 41 is.
All right. Same order. Next.
32.
Settlement.
Yes, my lord, both the parties are here.
Yes. Offense ಏನು?
My lords, 279, 338 IPC and A187 of M.
Yes, yes. ಕೊಡಿ.
Lords, with your permission, I'll be filing my wakalat, Lords.
Yes.
Joint affidavit we have already given.
Yes, sir. Sign here. Yes, next.
Odd sheets in this. 33.
For petitioner, my lords, there's a delay of 1 year in lodging the complaint. The entire allegation is against A2. My lords, the only allegation against A1 is that he has assisted in filling the form. And my lords, there is an agreement between A2 and the complainant. And with respect to the 10%, they tell that cash deposit has been made. And it has been deposited in the cooperative society, in the cooperative bank. My lords, after 1 year, my lords, and with respect to the remaining 90%, that is 9 crores, my lords, there is not even a single averment with respect to the remaining 90%.
One HCGP, two emergent notice.
My lords.
Seriously? You're seeking stay? Next.
34.
Bail bond cancelled.
ಕ್ಯಾನ್ಸಲ್ ಮಾಡಿ ನೋಟಿಸು ಕೊಟ್ಟಿಲ್ಲ, ಡಾಕ್ಯುಮೆಂಟ್ಸು ಕೊಡೋದಿಲ್ಲ.
ಈಗ are you taken back into custody?
ಇಲ್ಲ, ಕಸ್ಟಡಿಗೆ ಇನ್ನೂ ತಗೊಂಡಿಲ್ಲ.
There shall be an interim order of stay of the order cancelling the bail bond till the next date of hearing. Yes, next. 7.
ಫೇಲ್ ಟ್ರ್ಯಾಪ್.
ಎಷ್ಟನೇ ಸರ್ತಿ ಫೇಲ್ ಆಯ್ತು?
ಎರಡನೇ ಸರಿನೂ ಫೇಲ್. ರೆಸ್ಪಾನ್ಸೇ ಇಲ್ಲ ಅವ್ರ ಸೈಡ್ ಇಂದ.
ರೆಸ್ಪಾನ್ಸ್ ಇಲ್ವಾ?
ಅಕ್ಯೂಸ್ ಸೈಡ್ ಇಂದ. Still they made because I've shown the enmity also.
ಈ ಫೇಲ್ ಟ್ರ್ಯಾಪ್ ಎಲ್ಲ ಒಂದ್ 2-3 ಕೇಸಲ್ಲಿ 4 ಸರಿ ಫೇಲ್ ಆಗಿದೆ ಟ್ರ್ಯಾಪ್. ಅದನ್ನೆಲ್ಲ ಸ್ವಲ್ಪ ವಿಲ್ ಟೇಕ್ ಇಟ್. List this matter on Tuesday. Serve on Baby Patil. Counsel to serve on Baby Patil. List the matter on Tuesday next. In the fresh matters list. Yes.
36.
My lord, it's
36
check bounce
and-
proceeding. 36 and 39, my lord.
36 and 39 both allowed. Restore to file. Will pass ಒಂದು ವಾರ ಸುಮ್ಮನೆ ಇರಿ, ಆರ್ಡರ್ ಆಮೇಲೆ ಕೊಡ್ತೀನಿ. Yes. Next.
7.
My lord, 109 on 11, it's not attractive.
Yes, sir. ಹೌದಾ? Arms Act.
There is no recovery against S16 and 20, my lord.
Come after charge. No question of interference now.
My lord, and the 109 and 111 ಆದ್ರೂ ಸ್ವಾಮಿ ಅದು ನಮ್ಗೆ ಅಟ್ರಾಕ್ಟ್ ಆಗಲ್ಲ. There is no injury, there is no.
ಆಯ್ತು, ಇನ್ನು FIR ಇದೆ ಈಗ.
ಸ್ವಾಮಿ,
ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಆಗ್ಲಿ.
ನಿಮ್ದೇ ಒಂದು ಜಜ್ಮೆಂಟ್ ಇದೆ ಸ್ವಾಮಿ. ಅನರ್ಘ ಗೋಸ್ವಾಮಿ ಹೊಸದ್ರಲ್ಲಿ ಹೇಳಿದ್ರು.
ಏನದ್ರಲ್ಲಿ? FIR ಚಾರ್ಜ್ ಶೀಟಾ?
FIR ಅಲ್ಲೇ ಹೇಳಿದಿರಿ.
ಅದು FIR ಚಾರ್ಜ್ ಶೀಟಾ?
FIR ಸ್ಟೇಜ್ ಅಲ್ಲಿ ಹೇಳಿದಿರ ಸ್ವಾಮಿ.
ಅದನ್ನ ತಪ್ಪರ್ದು ಬಿಡಿದೀನಿ ಬಿಡಿ.
Even to the remote.
ಅದು ಸೆಟಲ್ಮೆಂಟ್ ಸರ್.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಅನರ್ಘ ಗೋಸ್ವಾಮಿ ಹೊಸ ಸ್ಟೇಟ್ ಆಫ್ ಕರ್ನಾಟಕ ಕ್ವಾಶ್ ಆಗಿದೆ.
I don't know. Yes, we'll see.
In meanwhile,
One HCGP to emergent notice. ಅದಕ್ಕೆ ಏನೋ ಹೇಳಿದ್ರಲ್ಲ, ಅದಕ್ಕೆ ಅದನ್ನ ಡಿಸ್ಟಿಂಗ್ವಿಶ್ ಮಾಡಕ್ ನೋಟಿಸ್ ಮಾಡ್ತೇವೆ. Yes.
38.
Failed
7A,
trap.
failed trap.
Failed trap.
Tuesday I'll take it.
Please.
Heard the learned senior counsel Srimati Lakshmi Iyengar. ಎಷ್ಟನೇ ಸರ್ತಿ ಫೇಲ್ ಆಗಿರೋದು ಇದು?
2 attempts failed. Even third attempt, they've not been able to. No demand, no acceptance.
ಹಾಗಾದ್ರೆ ಪಾಸ್ ಆಗಲ್ಲ ಬಿಡಿ ಅವರು. Yes. Heard the learned senior counsel Srimati Lakshmi Iyengar appearing for the petitioner. List the matter on Tuesday in the fresh matters list. Sarvan Baby Patil. Counsel Baby Patil is directed to accept notice for the respondent.
Obliged.
40.
It's a concocted
What is concocted in
series
this
of
matter?
FIRs.
ಏನ್ series of
against men.
FIRs?
Initially, I'm an informant to the police. I have given an information.
ಏನ್ ಇನ್ಫಾರ್ಮೇಶನ್? ಎಲ್ಲ ಇಲ್ಲಿಗಲ್
Cattle-
ಇಮಿಗ್ರೆಂಟ್ಸ್ ಇದಾರೆ ಅಂತನಾ?
No, my lords.
Then?
ಗಾಡಿಯಲ್ಲಿ ಕ್ಯಾಟಲ್ ತಗೊಂಡು ಹೋಗ್ತಿದ್ದಾರೆ. It was an election time.
ಕ್ಯಾಟಲ್ ಆಕ್ಟ್.
Election time. ಚೆಕ್ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಗಾಡಿ
ಎಲೆಕ್ಷನ್ ಟೈಮ್ ಅಲ್ಲಿ ಕ್ಯಾಟಲ್ ತಗೊಂಡೋದ್ರೆ ಏನ್ ತಪ್ಪು?
ಚೆಕ್ ಪೋಸ್ಟ್ ಇತ್ತು. ಚೆಕ್ ಪೋಸ್ಟ್ ಅಲ್ಲಿ ಗಾಡಿ ಸ್ಟಾಪ್ ಮಾಡ್ಲಿಲ್ಲ. Just 100 meter after the check post, the vehicle has been stopped right in front of the police station. Exactly right in front of the police station.
One HCGP accepts notice. Who is the complainant?
In this private
One HCGP
fourth
to
FIR ali, it's a suhamoto complaint.
emergent notice in the meantime. Yes.
Grateful.
Next.
41.
Disproportionate asset. Lords, 34 years, my lords, is the check period. My admitted.
Karmadi will take it.
Lords, your lordships have passed, my lords, in order to not to file the charge sheet till the leave of the.
ಎಲ್ಲದರಲ್ಲೂ ಅದೇ.
Your
Not
lordship
to
may
file
kindly-
it only. The event charge sheet is not filed, the same shall not be filed without the leave of the court. Tag with madam ಒಂದು ಲಿಸ್ಟ್ ಇದೆಯಲ್ಲ, ಅದ್ರ
There is one.
ಸೇಮ್ ನಂಬರ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅದೇ order.
ಇನ್ನೊಂದು ಇದೆಯಲ್ಲ,
45 minutes.
ಇನ್ನೂ ಒಂದು ಇದೆಯಲ್ಲ.
45 also. Serial number.
ಸೇಮ್ ಎರಡು, ಅದು ಸೇಮ್ ಆರ್ಡರ್. 41, 45 ಎರಡು ಕೇಸ್.
42.
The meantime
43.
Petitioners.
ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಾ? ಯಾವುದು? 40?
42.
ಹೌದಾ? ಸರಿ ಬಿಡಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿದೆ.
ಹಂಗೆ ಸರಿ ಆಯ್ತು. ಎಸ್.
43.
Appearing for the petitioner.
74 and 79. No chance of stay. Yes. One HCGP to emergent notice. Next.
44.
Meantime
45.
45 ಆಯ್ತಲ್ಲ ಮೇಡಮ್? ಅದೇ ಪ್ರಸನ್ನ ಕುಮಾರ್ ಸೇಮ್ ಟ್ಯಾಗ್ ವಿತ್.
46.
My
In the
lord,
meantime,
appear-
next.
appear on behalf of petitioner, my lord. 46, my lord.
ಆಮೇಲೆ
Yes, my lord, the affair was registered under section.
I have stayed it, madam. Yes.
Much
Reserve for next time.
Much.
Yes.
47.
47, my lords.
MMD.
Freezing. Freezing of the account.
No, my lords, regarding theft and MMDR Act.
MMDR.
MMDR. Yes.
I'll take notice.
One HCGP accepts notice for the respondent. Learned SPP is directed to appear in the matter list on 22nd. Sorry. 20th.
48.
Petitioners in this case.
OS number.
788 of 2026. my lord.
Same. Yes. Stayed. Next.
Obliged.
49.
ಆಯ್ತಲ್ಲ ಅದು.
49.
Complaint dismissed for non-prosecution.
Yes, my lord.
Same.
For
My lord.
default, my lord.
Kudi. Same order. Much obliged.
50,
Chauri.
Yes, please.
In the meantime. Yes, next. Next list, yes.
list number 2 being spoken to, still number 1.
I'm for the petition.
Yeah.
In this case, in fact, an order was passed that the stay has been, if the issue is not framed as on the date of the petition,
Date of the order antagide.
yes, Your Honor.
This court passed the following order. The learned counsel for the petitioner has moved the matter for being spoken to on this score that an inadvertent error has crept in with regard to the manner in which the order is granted. This court had opined that the interim order should operate from if the charges are not framed as on the date of filing of the petition, but is mentioned as on the day of grant of the interim order. Therefore, it requires to be corrected to read as on the date of filing of the petition. Adanna ಮಾಡ್ತೀರಾ ಜೀವ?
Still number 2.
In this petition, you are seeking the quash of the charge sheet filed before the filed in CC number, my lordship. In the order updated on the website, my lordship.
ಏನಾಗಿದೆ?
ಅದು FIR quash withdrawal ಅಂತ ಬಂದ್ಬಿಟ್ಟಿದೆ ಬೇರೆ ಅದು. But instead of staying the my lordship has granted.
Disposed it.
Allowed by directing the time bound direction 4 months directions ಕೊಟ್ಟಿದೆ.
ಅದಲ್ವಾ ಕೇಳಿದ್ದು?
ಅದು ಅದ್ಯಾವುದು ಬಂದಿಲ್ಲ ಬೇರೆ.
Offense ಏನ್ ಹೇಳಿ?
Offense 304A. Government officers ಇದ್ದಾರೆ ಅಂದ್ರೆ 4 months speedy disposal ಆರ್ಡರ್ ಆಗಿದೆ.
ಸ್ಪಿಡಿ ಡಿಸ್ಪೋಸಲ್ ಕೊಟ್ಟಿರ್ಬೇಕು ಅದರಲ್ಲಿ.
ಬಟ್ ಇದ್ರ ಆರ್ಡರ್ ಅಲ್ಲಿ ಬೇರೆ ವಿಡ್ರಾಲ್ ಅಂತ
ನೀವು ಕೇಳಿದ್ ಸ್ಪಿಡಿ ಡಿಸ್ಪೋಸಲ್ ಅಲ್ಲ?
ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್.
ಅದು ಮಾಡ್ಬಿಡಿ ಕರೆಕ್ಷನ್. ದಿಸ್ ಕೋರ್ಟ್ ಸೊ ಅಂಡ್ ಸೊ ಅದನ್ನ ಕೊಡ್ತೀನಿ. ಸ್ಪಿಡಿ ಡಿಸ್ಪೋಸಲ್.
ವಿತಿನ್ 4 months ಅಂತ ಹೇಳಿ.
ಎಷ್ಟು ದಿನ ಬೇಕು?
4 months ಅಂತ ಹೇಳಿದ್ರಿ ಅಂತ.
ಆಯ್ತು, ಅದೇ ಮೇಂಟೈನ್ ಮಾಡೋಣ ಬಿಡಿ.
Oblige.
Yes.
Still number 3, fresh matters.
I appear for the petitioner in this case, ma'am. There is a monetary transaction between petitioner and respondent.
Respondents.
ವಕಾಲತ್ ಹಾಕಿದ್ದೀರಾ? ಯಾವತ್ತು ಹಾಕಿದ್ರಿ?
ಕೋರ್ಟ್ ಡೇಟ್ ಅಲ್ಲಿ ಹಾಕಿದ್ವಿ. ಕೌಂಟರ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ.
ಹಾ ಸರಿ. Learned registered to print the name of ನಿಮ್ಮ ಹೆಸರೇನು?
ರಂಗೇಗೌಡ.
ರಂಗೇಗೌಡ
MK.
ಹಾ ಸರಿ. Print the name of so and so is appearing for the respondent complainant. Lest the matter for admission interim order subsisting will continue till the next date of hearing. ಅವರು ಕೇಳೋಣ.
Please, ma'am.
ಇಲ್ಲಿವರೆಗೂ ಸರ್ ರೆಪ್ರೆಸೆಂಟ್ ಮಾಡಿರಲಿಲ್ವಲ್ಲ?
ಅಲ್ಲ, in fact, parties are compromised the issue. We would. Hakadvi, but since it's 376, my lords, the allegation is 376.
376.
My lords had posted the matter for today.
He was there, is it?
He was there on that.
But registry ತೋರಿಸಲಿಲ್ಲ. We'll close it. ಎಲ್ಲ ಸೆಟ್ಲ್ ಆಗಿ ಹೋಗ್ಬಿಟ್ಟಿದ್ಯಾ? 376 ಯಾಕೆ ಹಾಕಿದ್ರಿ ಮತ್ತೆ?
ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಇದ್ರದ್ದು.
ಸ್ವಲ್ಪ ಅಮೌಂಟ್ ಇತ್ತು ಅಂತ ರೇಪ್ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾರ ಯಾರಾದ್ರೂ? ಏನ್ ಮಿಸ್ಅಂಡರ್ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಅಲ್ಲಿ ರೇಪ್ ಅಲಿಗೇಷನ್ ಮಾಡ್ತಾರ? You know what is the impact on the man whom you allege rape? 376 is easy like this. ದುಡ್ಡು ಬರ್ಬೇಕಾಗಿತ್ತು, ಅದಕ್ಕೆ 376. Now he has returned the money, is it? So rape is returned. What is this? You can't use rape for all these monetary transactions. Yeah. It's a very serious offense. Serious offense is treated like this by complainants. Promise to marry and rape, either monetary transaction rape. Rape is used for everything. The petitioner is before the court calling in question the proceedings in CC 2436 of 2024 registered for offences punishable under section so and so. Heard so and so. The petitioner and the respondent are known to each other. They involve in a financial transaction with regard to purchase of a property. The sale consideration and the amount that had to reach the hands of the complainant became the subject matter of a dispute. The complainant, ಎಷ್ಟು ಕೊಡಬೇಕಾಗಿತ್ತು? 2 ಲಕ್ಷನಾ?
6 lakhs.
The complainant had to get 6 lakhs from the hands of the petitioner.
ನನ್ನಿಂದಲ್ಲ sir. I helped her to purchase the property by paying 6 lakhs.
Correct. Dispute ಯಾಕೆ?
When I asked refund, she filed a complaint.
The petitioner is said to have facilitated the purchase of a property by the complainant by helping her with an amount of rupees 6 lakhs. The petitioner demanded the said amount back from the complainant. A serious offense like that of rape is used by the complainant for settling the score with regard to monetary transactions. This is an admitted fact in the light of the complainant herself submitting that in the petitioner has returned. ಅಲ್ಲ, ವಾಪಸ್ ಕೊಟ್ರಾ?
ಅಲ್ಲ, ಆಗ್ಲೇ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ ಸರ್. It is
The
paid on-
petitioner has left the 6 lakhs with the complainant herself and is not wanting to seek any refund. Therefore, the offense of rape is now vanished and a settlement has sprung before this court. There cannot be any other classic illustration of abuse and misuse of the provisions of the penal provisions of heinous offences under the IPC as the complainant, for the sake of avoiding a refund of rupees 6 lakhs, alleges rape against the complainant, against the petitioner. And since the petitioner has now given up the claim for the refund of 6 lakhs, has come before the court seeking settlement of the dispute. In that light, the permitting further trial against this petitioner would become an abuse of the process of the law and result in miscarriage of justice. Allowed, quashed.
Number 4.
Settlement, my lord.
Settlement.
Married.
Pokso.
ಹಾ, my lord.
Marriage.
Register ಆಗಿದೆ ಸರ್.
ಎಲ್ಲಿದೆ? ಕೊಡಿ.
Serial number 162 also.
But child marriage restraint act ಇದೆ.
Subsequently, there's one more FIR registered, that serial number 162, reporting settlement.
ಅದೇನಕ್ಕೆ?
ಅದು same party, sir.
Child marriage I will not quash.
My lord, both the parties, even the family
Maybe
members, sir.
Child marriage ಯಾರು ಮದುವೆ ಯಾರು ಮಾಡ್ಕೊಂಡಿದ್ದು?
ಅಪ್ಪ ಅಮ್ಮ ಮದುವೆ ಮಾಡಿದ್ದು ಅವರು ಇದ್ದಾರೆ.
ಅಪ್ಪ ಅಮ್ಮನೇ ಮದುವೆ ಮಾಡಿದ್ರಲ್ವಾ?
ಹೌದು, ಅವರು
ಬಹಳ ಸಂತೋಷ. ಅವ್ರ ಮೇಲೆ ಬಿಡೋದೇ ಇಲ್ಲ ನಾನು.
Already settled.
No, ನೀವೇನಾದ್ರು ಸೆಟಲ್ ಮಾಡ್ಕೊಳ್ಳಿ. Father and mother will not. Parents who indulge in getting the children married at a underage will not be spared.
Illiterate, my lord.
Will not. No, sir.
Knowledge
That is
about
child
that,
marriage restraint act ಇಲ್ವೇ ಇಲ್ಲ. ಎಲ್ಲಿ ಮದುವೆ ಆದ್ರಿ?
ಊರಲ್ಲಾಗಿದೆ, ದೇವಸ್ಥಾನ ಹತ್ರ.
ಆ ದೇವಸ್ಥಾನದಲ್ಲಿ SPP ಅವರೇ, ಆ ದೇವಸ್ಥಾನದಲ್ಲಿ ಪೂಜಾರಿ ಯಾರಿದ್ರು ಮದುವೆ ಮಾಡಿಸಿದ ಅವ್ರನ್ನ ಇಟ್ಕೊಳ್ಳಿ.
We will include him also, my lord.
Literate, my lord. Okay.
I will spare the boy and the girl, not a problem, not the parents.
They are present.
Both
are ladies.
So
ಗೊತ್ತಿಲ್ಲ ಅವರು.
nothing doing. ಏನು ಕೇಳಿದ್ನ ನಿಮಗೆ ಇದನ್ನ?
ಇಲ್ಲ ಸರ್, just women are there.
So nothing. Child marriage restraint act, except that the petitioner is before petitioners ಯಾರ್ಯಾರು?
In first petition, serial number 4, husband, mother and mother-in-law.
Serial number 4 ಅದರಲ್ಲಿ husband,
mother-in-law.
Husband ಗೆ cost, mother and mother-in-law both proceedings shall continue qua the child marriage restraint act ಅನ್ನೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಅದನ್ನ ಕೋಟ್ ಮಾಡಿ. ಇನ್ನೊಂದು ಯಾವುದು? ನೋ ಸರ್, ಲಿಟ್ರಸಿ ಅವೆಲ್ಲ ನಡೆಯೋದೇ ಇಲ್ಲ. Nothing doing. ಇನ್ನೊಂದು ಯಾವುದು?
Serial number 160.
ಅದೇನು?
ಬರೀ petitioner, same POCSO.
ಬರೀ husband and
husband, that's all.
ಅದು ಅದ್ ಮಾತ್ರ ಕಾಸ್ಟ್ ಮಾಡಿ. ಇದೆಲ್ಲಿದೆ ರಿಜಿಸ್ಟ್ರೇಷನ್?
ಆಗಿದೆ ಸ್ವಾಮಿ, I'll produce. It is there in the joint, along with joint affair produce. ಮಗುನು ಆಗಿದೆ ಸ್ವಾಮಿ, there.
ಆಯ್ತಾಯ್ತು. ನೋ ಪೇರೆಂಟ್ಸ್ ವಿಲ್ ನಾಟ್. ಯಾರು ಮದುವೆ ಮಾಡೋದು 18 ವರ್ಷದ ಕೆಳಗೆ? ಅವ್ರ ಹಿಂಗ ಮೆಸೇಜ್ ಶುಡ್ ಗೋ ಸರ್. ನಥಿಂಗ್ ಡೂಯಿಂಗ್.
Not even aware, my lord.
No sir. ಏನಾಗಲ್ಲ, ತೊಂದ್ರೆ ಇಲ್ಲ, ನಡೀಲಿ.
ಕಡೆ ಗೊತ್ತಾಗಲ್ಲ ಸರ್.
ನೋ ಸರ್, ಊರ್ ಕಡೆ ಗೊತ್ತಾಗ್ಲಿ ಅಂತಾನೆ ಇದ್ ಮಾಡ್ತಾ ಇರೋದು. ಆ ದೇವಸ್ಥಾನದ SPP ಅವರೇ, ಆ ಯಾವ ದೇವಸ್ಥಾನದಲ್ಲಿ ಆಗಿದೆ ನೋಡ್ಬಿಟ್ಟು ಡ್ರ್ಯಾಗ್ ದಟ್ ಪೂಜಾರಿ ಆಲ್ಸೋ ಇಂಟು ಇಟ್.
Yes, man, we'll ask them to file additional charge sheet.
That is the complaint says the marriage ಆಯ್ತು ಅಂತ, but subsequently there was no proof of marriage. Once she attained the majority, the marriage was solemnized, my lord.
ಆ ತರ ಇದ್ರೆ we will leave it. ಮದುವೆ ಆಗಿದ್ದು ಯಾವಾಗ?
This is later, my lord. It's mentioned in the joint.
When?
I'll mention.
When?
After she became a major, my lord.
ಏಟ್ ಹೇಳಿ ಸರ್.
It is on 10th October 2023, my lord. I mentioned in my joint affidavit, my lord.
10th October
2023, my lord. When she became a major.
What's her age then?
At the time of FIR, it was 16. But at the time of marriage.
Date of the FIR.
My lord, date of the FIR was 17/8/2021, my lord.
Marriage is on 10/10/23, yeah?
Yes, my lord.
What is the date of birth of the victim?
My lord, it's 20. I produce all the documents in it.
ಬರ್ಕೊಂಡಿಲ್ವಾ?
The FIR itself was registered in 2021. And the
At that
marriage
time
is 2023, we would not have registered Child Marriage Act, my lord. Child Marriage Act seems to have happened.
ಈಗ FIR ಅಲ್ಲಿ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಆಕ್ಟ್ ಇದೆಯಾ ಇಲ್ವಾ?
ಇದೆ ಸ್ವಾಮಿ.
ಮತ್ತೆ ಹೆಂಗ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು? ಮದುವೆ ಆಗ್ದೇನೆ?
ಸ್ವಾಮಿ ಅದೇ ಕನ್ಫ್ಯೂಷನ್ ಆಗಿ ಮಾಡಿದ್ದಾರೆ.
ಕನ್ಫ್ಯೂಷನ್?
ಮ್ಯಾರೇಜ್ ಪ್ರೂಫ್ ಇಲ್ಲ ಸ್ವಾಮಿ. 3rd July 2025 ಡೇಟ್ ಆಫ್ ಬರ್ತ್, my lord. 2005.
2005.
Yes, my lord.
Then 17/8/21 ಗೆ she was 16 years.
My lord. But that time the marriage was not performed. ಮಗುನು ಆಗಿದೆ.
ಅಯ್ಯೋ ಇರ್ಲಿ, ಅದು ಫಾದರ್ ಅಂಡ್ ಮದರ್ ವಿಲ್ ನಾಟ್, ಬಟ್ ದಿ ಪೇರೆಂಟ್ಸ್ ಮಸ್ಟ್.
Both side are mothers, my lord, no father.
ನೋ ಪ್ರಾಬ್ಲಮ್ಸ್. ಇವ್ರದ್ದಾಯ್ತು, ಬಟ್ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗಿರೋದು ಯಾವಾಗ?
First crime registered on 17/8/2021.
ಅವಾಗ ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ರೆಸ್ಟ್ರೇಂಟ್ ಆಕ್ಟ್ ಇತ್ತೋ ಇಲ್ವಾ?
ಇತ್ತು ಸ್ವಾಮಿ.
ಮತ್ತೆ ಹೆಂಗ್ ಮಾಡಿದ್ರು?
ಸ್ವಾಮಿ ಅದು ಆಗಿರಲಿಲ್ಲ ಮದ್ವೆ ಅವಾಗ. ಊರ್ ಕಡೆ ಹೇಳಿದಾರೆ ಅಂತ ಹೋಗಿ ವೆರಿಫೈ ಮಾಡಿದ್ದಾರೆ. ಸಬ್ಸಿಕ್ವೆಂಟ್ಲಿ ರಿಲೀಸ್ ಆದ್ಮೇಲೆ ಮದ್ವೆ ಮಾಡಿಸಿರೋದು. ಈ ಕೇಸಲ್ಲಿ ರಿಲೀಸ್ ಆದ್ಮೇಲೆ ಮದ್ವೆ.
We'll see. Wait. Let's the matter on Friday. ಅವ್ರು ಬರದೇನ್ ಬೇಡ. Friday. Yes.
For petitioner, my lord, 1 and 2 days.
We'll see. Yes. ಅವತ್ತೇ ಏನು ಕಸ್ಟಡಿಲಿ ಇದಾರಾ?
ಇಲ್ಲ ಸರ್.
ಮತ್ತೆ wait sir. Yes. ಎಲ್ಲ both 162 and ಇದು ಎರಡು Friday.
My lord, sign can be taken.
ಅವತ್ತೇ. Yes.
They have to confirm on 18.
ಚಾಮರಾಜನಗರದಿಂದ. So what?
ಚಾಮರಾಜನಗರ.
ಅದೇ ಚಾಮರಾಜನಗರನೇ. Yes. ಅವ್ರು ಬರದೇನ್ ಬೇಡ. We'll see. Yes. Next.
5.
ವಕಾಲತ್ ಅಲ್ಲಾಕಿ. Registry ಹಾಕಿ.
Lord, appear for the petitioner in this matter, my lord. Lord, similar matter.
ಕೊಡಿ ಟ್ಯಾಗ್ all the cases.
My lord, all the cases are.
ಎಷ್ಟಿದೆ ಟೋಟಲ್ ಟ್ಯಾಗ್ ಆಗಿದೆಯಾ?
Tag, there is a direction, but my lord, all the matters are not being listed
together. Tag this petition along with so and so. List them all on ಯಾವತ್ ಬೇಕು? 25th ತಗೊಳ್ಳಿ. ಎಲ್ಲಾದ್ರಲ್ಲೂ ಸ್ಟೇಟ್ ತಾನೆ ಪಾರ್ಟಿ.
Please, my lord.
Tag all so and so. We'll dispose on that day. Get ready in whatever matter it is. Yes.
Lord, in this also interim order may be.
Interim order. ಅದಕ್ಕೆ ಅಲ್ಲ, ಅದರಲ್ಲೆಲ್ಲ interim order ಇದೆ, same order.
Please.
Numbers list ಕೊಡಿ.
Please, my lord, I will provide it, my lord. Along with the matter.
If you don't provide, then no interim order in this.
My lord, I'll provide it now itself.
Yes.
Obliged.
Bill number 6.
Petition.
Husband.
Also, the respondent number 2, my lord, from the DLSA, have appeared in recently. I'll file my detailed objection.
Objections ಹಾಕಿ. List the matter on 25th for admission. Objections if any by then. In the event no objections are filed, this court would be constrained to stay against the husband as well. Allegations ಇದೆ.
498.
Huh?
498.
Sorry?
498.
ಅದನ್ನೇ ಹೇಳಿದ್ದು. Yes sir. On
Lord,
25th.
kindly, there is another connected matter where A22.
In-laws stay ಮಾಡಿರೋದು.
ಅದು ಇದೆ. Kindly it may be tagged along.
Tag along with so and
criminal
so.
petition number 3738 of.
Stay already ಇದೆ.
ಅವ್ರಿಗೆ ಇದು ಹೋಗುತ್ತೆ. Yes. Next.
3738 of
23.
8, 7, 2 weeks IO. Next. ಅದೇನು ಎಲ್ಲೋ ಹೋಗ್ಬೇಕು ಅಂತಿದ್ರಾ? ಎಲ್ಲಿಗೆ?
ಕೆನಡಾಗೆ ಸರ್. ಮ್ಯಾಟರ್ ಸೆಟಲ್ ಮಾಡಿದೀವಿ, ಅಮೌಂಟ್ ಕೊಟ್ಬಿಟ್ಟಿದೀವಿ, ಪ್ರಾಪರ್ಟಿ ಟ್ರಾನ್ಸ್ಫರ್ ಮಾಡಿದೀವಿ. ಸಬ್ಸಿಕ್ವೆಂಟ್ ಆ ಪ್ರಾಪರ್ಟಿನ ಇನ್ನೊಬ್ರಿಗೂ ಅವ್ರು ಮಾರಿದ್ದಾರೆ. ಟು ದಟ್ ಎಫೆಕ್ಟ್ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಅಫಿಡವಿಟ್ ಸರ್.
ಇದೇ ಇದೆಯಲ್ಲ.
ಸ್ಟೇ ಇದೆ ಕರೆಕ್ಟ್. ನನಗೆ ಅವಕೇಶನ್ ನಾನು ಕೆಲಸ
ರೆಸ್ಪಾಂಡೆಂಟ್ ಬರೋಕ್ ಮುಂಚೆ ಹೆಂಗ್ ಕ್ವಾಶ್ ಮಾಡಕ್ಕಾಗತ್ತೆ?
ಅವ್ರು ಬರ್ತಾ ಇಲ್ಲ. ಇನ್ಸ್ಪೈರ್ಟ್ ಆಫ್
ಎಲ್ಲಿ ನೋಟಿಸ್ awaiting service. Yes.
ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಇಂದ ನೋಟಿಸ್ ಹೋಗಿದ್ದು, ಲೋಕ ಅದಾಲತ್ಗೆ ಬಂದಿಲ್ಲ.
Post immediately after service of notice upon the respondent or on 24th, whichever is earlier.
Yes. Much.
Interim order continues. Next.
Bill number 8.
I appear for petitioner in this case. I'm a proxy counsel, your lordship. Kindly have the matter tomorrow or next week.
Order ಕೊಡಿ. Order 27/7 ಏನಿದೆ ನೋಡಿ. ನಿಮಗೆ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ ತಗೊಳಕ್ ಹೇಳಿರೋದು. ಸ್ಯಾಂಕ್ಷನ್ ಇದೆಯಾ ಇಲ್ವಾ ಅಂತ.
Sanction is not taken.
Not taken. This court on 27/7/2026 had passed the following order. The learned HCGP on instructions would submit that there is no sanction taken to prosecute the petitioners. The petitioners are admittedly public servants. The order of taking of cognizance is what is called in question. Cognizance could not have been taken without a sanction being obtained and placed before the concerned court. In that light, there shall be an interim order of stay of further proceedings before the concerned court, qua these petitioners till the next date of hearing.
Number 9.
Let's, my application seeking
Right, 17.40.
17.40. Only on two heads I am questioning.
We'll take it on Yavat Madam 14th. 10th, list
Okay.
on 10th.
Please.
We'll serve on VV Patel there.
Either.
My apologies.
17.40.
Please. My lords, charges have been framed.
Frame ಆಗೋಗಿದೆ.
Evidence ನಡೀತಾ ಇದೆ. ತಮ್ಮದೇ judgment covered ಇದೆ.
ಅವರಿಗೆ ಅದೇ ನಾನು ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೆ, my application seeking my discharge application has been dismissed. That is
No,
a
my lords,
challenge.
my only
Charge ಯಾವಾಗ
respectful.
frame ಆಯ್ತು?
Evidence ನಡೀತಾ ಇದೆ
Then-
already.
ಅಲ್ಲ ಯಾವಾಗ frame ಆಯ್ತು?
Date
Let's,
happened.
the dismissal on 17th January 26.
Charge ಯಾವಾಗ frame ಆಯ್ತು sir?
Let's,
31/1/2026. I put the date.
Petition ಹಾಕಿರೋದು ಯಾವತ್ತು?
Petition ಹಾಕಿರೋದು ಅದಾದ್ಮೇಲೆನೆ.
24/3/26.
ಅಲ್ಲೇ.
2 ತಿಂಗಳು ಆದ್ಮೇಲೆ ಹಾಕಿರ್ಸಿ.
ಅಲ್ಲೇ.
Only sanctioning authority has been examined, even cross examination ಆಗಿಲ್ಲ, only one witness.
ಪರವಾಗಿಲ್ಲ. ಅದೇ ನಿಮಗೆ ಸಪರೇಟ್ ರೂಲ್.
Swami?
ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಆದ್ಮೇಲೆ ಮುಗೀತು.
Let's, Lordship may kindly appreciate.
No
In case
appreciation.
If I am able to convince this
No
court.
sir, not at all.
Able to convince
No,
this
no,
court
sir.
on this point.
No, on whatever point it is, ಅಲ್ಲೇ ಎಲ್ಲ. ಚಾರ್ಜ್ ಫ್ರೇಮ್ ಯಾಕೆ ನಿಮಗೊಂದು ರೂಲ್ ಬೇರೆಯವ್ರಿಗೊಂದು ರೂಲ್?
Let's, it is not, it will not curtail my rights, my lords.
Absolutely sir. Then
Definitely.
ಅಲ್ಲೇ ತಗೊಂಡೋಗಿ sir.
Let's, it will not curtail
No
my rights.
problem sir. The
I will
petitioner.
convince- I will convince my lords.
No,
I will
sir.
convince on that point.
No,
My lords,
nothing doing.
this petition is maintainable.
No sir, I will not. It is discretionary. I will not. The
My lords,
petitioner is before the court seeking
my
the
kindly-
following prayer.
My lords may kindly.
The learned counsel appearing for the petitioner would submit that the learned counsel B.B. Patil would submit that charges have already been framed and the evidence is on. The learned counsel would further submit that charges are framed and the evidence is on in the case at hand long before the filing of the petition itself. The discharge application of the petitioner has been rejected and thus the matter was proceeded to frame the concerned court proceeded to frame the charges and the matter is at the stage of evidence. There is no warrant of interference at this stage in the case at hand in the light of the judgment of the apex court in the case of Meenakshi Bala and subsequent judgments following the judgment of the apex court in the case of Meenakshi Bala. Leaving open all the contentions to the to urge before the concerned court at the appropriate time, the petition stands disposed.
Deeply obliged.
May I request, my lords? Lords, I'm not now, they asking for this court to reconsider, my lords. My only
Nothing
request
else,
is
sir.
this. My only request is this, my lords. I have disputed only few items on the head of the assets, expenditure and income. My lords, to consider that, my lords, all the 100 witnesses need not be examined before the court.
ಆಯ್ತು ನಿಮ್ಗೆ ಯಾರು ಬೇಕು ಹೇಳಿ ಅವ್ರಿಗೆ ಹೇಳೋಣ.
My lords, I will file a 294 application.
Okay.
294 application. I will not dispute wherever I have absolutely no qualm.
I will direct
Let
the court to
the-
consider
let-
it.
Let the
Yes.
trial court to dispose of the matter in 6 months' time.
The petitioner at this juncture would submit that the disproportionate assets in the case at hand is pegged at 17.40%. Therefore, it is only where the petitioner can prove it by an application under section 294 of the BNSS. Therefore, the learned counsel would submit that if an application is filed under section 294 of the BNSS, the concerned court.
94 of CRP.
CRPC, the concerned court be directed to consider the same and dispose the main matter itself with an outer limit of 6 months. In the light of the issue boiling down to number of witness, to the fact that all the witnesses need not be examined in the case at hand, I deem it appropriate to direct the concerned court to conclude the proceedings itself with an outer limit of 6 months from the date of receipt of the copy of the order, of this order, keeping open all the contentions, ordered accordingly.
Please.
Deeply obliged. Deeply obliged.
Sense of both the parties.
Deeply obliged.
Yes.
Number 10.
Once, my lord,
Yes, my lord.
under
Charges has
section,
been framed, my lord.
NDPS. The only allegation against accused number 2,
Maybe,
the
sir.
petitioner is that he sold the seats.
Prior to filing of the petition, after.
My lord, the allegation is that he
Charge
sold
frame ಆಗಿರೋದು ಯಾವಾಗ?
11/9.
11.
11/9/25. Yes, same Meenakshi Bala disposed, leaving open all the contents to be urged before the
My lord,
consent.
I only seek for to expedite the trial because
the
pertaining
trial-
to this
trial ಯಾವ
petitioner,
ವರ್ಷದ್ದು?
split up, the case has been split up pertaining to this petitioner.
ಬೇರೆಯವ್ರು acquit ಆಗಿದ್ದಾರಾ?
ಇಲ್ಲ.
ಇಲ್ಲ.
Accused number 1 grown the ganja. Allegation against
No
this
problem.
petitioner, accused number 2 that he supplied ganja
ಯಾವ
seeds.
ವರ್ಷದ್ದು?
My lord, this is of the year 2025, 4 my lords, 2024.
Yes. Meenakshi Bala.
Already 16 witnesses have been examined out of 26
In an
witnesses, my
NDPS
lords.
case, I will not, sir. Anyway. Yes, next.
My lord, I represent the petitioner in the matter, my lords.
Yes,
My
sir.
lords, allegation under 406, 420, 465 and 506, my lords. My lords, the petitioners are directors of a company which is scanning on chit business. The company is not arrayed as an accused, my lords. The petitioners are directors.
I will direct it to
Covered
be,
by the,
I will direct them to implead, sir. ಬೇಕಂತ
my lords,
ಮಾಡ್ತಾರೆ.
on the merits of the case,
ಬೇಕಂತ
my lords,
ಮಾಡ್ತಾರೆ.
and so far as the merits of the case are concerned, my lords, the accused number 1 is the person who has taken the check from the respondent number 2, and he has handed over the check in favor of the petitioner company, my lords.
Get the complainants. The
My lords,
one
until
HCGP to emergent notice returnable by 21st.
my
Just
lords, the
not-
trial court may proceed to frame charges, my
No
lords.
problem,
That's the
sir.
issue.
Chit fund, yes, sir.
My-
Next. No, sir. Yes, next. Madam. Green ಇದೆ ಅಂದ್ರೆ 24th ಹಾಕಿ ಅಷ್ಟೇ. Yes.
For petitioner, my lords.
Hmm.
Serial number 12. 311 application came to be rejected for recall of cross-examination, my lord. PW, I have filed application for recalling the
Pokso
cross.
na?
Yes, my lord. 4, 6 and 10, my lord.
64 also.
60? ಇಲ್ಲ ಅದಾಯ್ತು ಅಪ್ಲಿಕೇಶನ್ ತಾನೆ. Whom do you want to recall, sir?
PW 4, 2, 3 and 6, my lord.
2 is the victim?
Yes, my lord.
No, will not permit. What's the age of the victim now?
The present age is around 17 years, 4 months.
At the time of the incident?
At the time of incident, 15 years, 6 months, my lord.
Will never permit. Any ಬೇರೆ ಯಾರಾದ್ರೆ ಹೇಳಿ. You can't recall the victim at all.
PW 3 and 6, my lord.
Three
Father and mother, my lord.
3 and 6 you can take. The petitioner is before the court calling in question an order of the concerned court dated 15/4/2026 passed in special case 99 of 2025 by which the concerned court rejects the application of the petitioner seeking filed under section 311 of the CRPC seeking recall of PW 2, 3 and 6 of for further cross examination. The ಒಂದ್ಸರಿ ಮಾಡಿದೀರಾ PW 2 ನ?
ಮಾಡಿದ್ದೀವಿ.
Yes. The petitioner heard so and so. The petitioner gets embroiled in a crime in a crime for offences punishable under the under so and so illide alla page 7. The issue in the list is not with regard to the merit of the claim of the petitioner before the concerned court or the defence. The petitioner files an application under section 311 of the CRPC seeking recall of PW 2, 3 and 6 for further cross examination. The concerned court rejects it. The learned counsel for the petitioner submits that would not press the petition insofar as the recall of PW2 the victim is concerned. Insofar as 3 and 6 who are the mother and father of the victim should be permitted to be cross-examined. In the light of the said submission, the issue is whether the order that rejects the further cross-examination of PW 3 and 6 is tenable in law or otherwise. The learned tenable law, the order of the concerned court reads as follows. If the order so passed by the concerned court is considered on the bedrock of the principles laid down by the apex court in the case of Varsha Garg, so the order would fly foul or run foul of the principles so laid down in the said judgment. In that light, the concerned court shall now permit further cross-examination of PW 3 and 6 and not PW 2 the victim. The concerned court shall oversee that the petitioner should not be permitted to drag the proceedings on the score of further cross-examination of PW 3 and 6. For said reasons, petition is allowed, so and so quashed. The application filed by the petitioner is partly allowed. PW 2 is PW2 shall not be called for further PW2 victim shall not be called for further cross-examination. 3 and 6 be permitted to be cross-examined on the date fixed by the concerned court, and the concerned court shall regulate its procedure to take the issue to its logical conclusion. Ordered according.
Please vote.
13.
376 and 376 2N, my lord. Complaint was given after 8 months when she was found to be pregnant, my lord.
Sorry?
Complaint was given after 8 months of pregnancy, my lord.
So what?
The DNA test shows that he is not the father, my lord. Page number 90. And even in the complaint
You are
allegation,
not the father.
I'm not the father.
Don't bother. Now other things heli.
Other things, my lord, in the complaint, it is stated that he gave her some gifts of cloth and some items and then took her to his house, my lord. There is no allegation of rape in the complaint.
How many years, sir?
23 years. Victim.
ನಿಮ್ಗಲ್ಲ sir. ಎಷ್ಟು ವರ್ಷ relationship?
No relationship, my lord. He is actually the distant relative of the, but there is no relationship.
No relation,
They are
but only
living
relative.
close to each other in the house, 2 houses away. And the child belongs to somebody else, my lord.
ಎಲ್ಲಿದೆ DNA?
DNA is at page 90, my lord.
Page 9. It's not matched. Not matched.
Not
DNA is not
matching.
matched. But 183 statement, she has narrated all the incidents.
DNA ಮ್ಯಾಚ್ ಆಗ್ಬೇಕಲ್ಲ ಹಂಗಿದ್ರೆ. But 376 2 ಏನಿದೆ repeated rape.
Repeated, she says at the complaint is given at the time of pregnancy, she says we did not know about the pregnancy, my lord. So that they are saying 10 months before these repeated rapes happened.
ಎಲ್ಲ 24 ಲೇ ಆಗಿರೋದು. The main time. Yes. Next.
14.
States.
14.2, my lords, I appear for the petitioner.
Respondent.
My lords, is a matter where respondent number 2, father, my lords, had filed.
ಗೊತ್ತಾಯ್ತು ಇದೆಲ್ಲ
That's
synopsis ಹಾಕಿ
before-
ಕೇಳಿದೆ last time.
My lords, before my learned friend begins, my lords, the mediation reports that your lordship had sought, my lords, on the last day. We'll just produce the same.
What
my
is the
lords.
mediation report?
My lords, now what has happened is,
What's the mediation report really?
my lords, the interim mediation report has been filed before the Supreme Court saying that, my lords, the mediation is, the proposal is also filed. There might be a settlement finalized very soon, my lords.
My lords, mediation, my lords, is with respect to the trust.
My lords, kindly have the look at, my lords.
This, my lords, the
No,
order of.
Nishant, would not the mediation put an end to all the litigation?
My lords, they are using this criminal litigation to forcibly settle the matter. My lords may kindly see the order of mediation by the Honorable Apex
No,
Court
when
was
Apex
3-3.
Court is seized of the matter, where am I staying it now?
That order only I have produced, my lords, which basically says civil and criminal matters both.
3-3-25, my lords, is the order passed by the Apex Court appointing the mediator, my lord.
Page number 10, my lords.
Subsequently, the protest petition is filed.
One ನಿಮಿಷ.
3-3-25 is the order of
One
the Apex Court.
moment, one moment. Where is the order of the Apex
Page
Court?
number 10, my lords, para number 3, my lords. Yes.
3-3-25 is the order of the Apex Court.
One ನಿಮಿಷ.
Nimsha. Lords, para number 2, last 3 lines, my lords, basically says, my lords, should put an end to all the dispute, including criminal proceedings which have been
Pursuant to
instituted
this,
against.
my lords, protest petition is lodged by the
ಯಾವ್ದು
respondent.
protest petition ಹಾಕಿದ್ದೆ ಅವತ್ತು?
10-6-25. After this.
Why, sir?
No, my lords, now I'm coming
No,
before your
therefore,
lordship saying
this
the
is-
same thing.
Wait, wait.
My lords,
Who filed the protest petition?
I filed the protest
Respondent
petition.
2 filed the protest petition on 10-6-25.
I will observe that you are acting contrary to what the Apex Court has
No,
said.
no, my lords.
And stay everything now.
No, it is already stayed, my
There is
lords.
an
They
interim
already
order.
have a stay here. All I am seeking
Then I
is,
will
my lords-
observe that you are acting contrary to the Apex
No, no, no,
Court.
not at all, my
Why
lords.
did you file protest petition?
My lords, when the protest petition was like filed, my lords, the mediation has not had commenced yet, my lords.
Why do you want to intimidate the mediation?
No, no, my lords, now we
Why
are
do you
not,
want to
my lords.
frustrate the mediation by filing protest petition?
No, no, my lords, I go down to that now, my lords.
I will straight away observe that you're acting contrary to the Apex Court's direction,
there
and that
is-
settlement also will go now.
No, 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 my lords, there is already a stay granted by this court, my lords.
That's
We
all
don't-
right, but why did you file a protest petition after the order of the Apex Court? Yes, Arjun?
My lord's permission, Lord, because I'm appearing before the Honorable Supreme Court and in the mediation, I'll just make.
All
one-
right, Supreme Court says
Yes, Lord,
criminal
one
proceedings
respectful
also
clarification.
will
Yes, yes.
conclude. Why
One-
did you file protest petition?
Just 2 facts on what happened.
Yes.
The first order 3-3-2025, my lord, mediation was instituted and we were referred to the Supreme Court Mediation Center, my
All
lord.
right.
I'll just complete. That mediation, my lord, could not be successful because at that time we were in judicial custody. Subsequently, my lord, the Honorable Supreme Court, noticing the nature of the disputes, appointed Justice Bopanna, my lord, as the mediator.
All right.
In that interregnum, my lord, this may have been filed, my lord, but
Interregnum illa ille.
my lord, because that mediation was returned. First mediation was returned as unsuccessful.
No problem. Now, I'll record that you are not going to proceed further in the protest petition.
No, my lord.
Lordships have stayed it, my lord.
It's already stayed, my lords.
Everything is stayed, my lord. And my lord,
Indian
just say-
ಮತ್ತೇನೀಗ?
My
lords, may just one
Directing
fact
us
may
that
just
there is
the
a
lordships
criminal
notice.
case.
Quash ಅಂತೂ ಮಾಡಲ್ಲ ನಾನು. ಬೇರೆ ಏನಾರು ಬೇಕಾ?
There is in fact, my lords,
One
one more
fact-
thing. There is one more criminal case that they themselves file an SLP during the time of mediation, my lords.
Why, sir? Why?
My lords, in their criminal SLP, they take time before the Honorable Supreme Court saying mediation
Anyway,
is
I'll
going
record
on.
now.
Day before yesterday, matter comes up before Supreme Court, they say mediation is going on, give us 12 weeks. Day before yesterday, that's also placed, my lord. Day before yesterday,
My
my
lords,
lord.
kindly.
Now,
have
what
a
is the
look
crime
at
registered by them against you?
My
My
lord,
lords, misappropriation, my lords, in Sheshatripuram.
In crime, when was that registered?
Lords, and that is not placed before this, my lords. It's
Date
handled by a
ಗೊತ್ತಿಲ್ವಾ?
different-
You don't
That's
know the
handled by
date?
a different
It's an
council.
older one.
It's an older one.
Older one.
Older one, my lord. we were
Not
in
after, not after the
Not after
mediation
this.
process began. Yes.
But my lords, the
But they sought-
cancellation.
So it's only you who has sought to
cancellation,
frustrate the
my lord.
proceedings.
Sought cancellation
I'll come.
after, my lord, during the period of the mediation, they sought cancellation. And then before the Honorable Supreme Court, they take time saying this
Now,
mediation.
both of
that's
you,
late.
till the mediation process is off, hold your hands.
Please,
Yes,
my
my
lords,
lord.
we are ready for that.
That's all we are saying.
Quash ಮಾಡಕ್ Supreme Court pending ಇರ್ಬೇಕಾದ್ರೆ we can't quash it.
In August, we get a bail, my lords, before
They are
before this
using
court
this-
itself, and then
They are using the
in November,
pendency
they
of this
file for a
criminal
cancellation
matter,
of bail.
Are you
asking us
not,
to settle.
are you not before the Supreme Court?
We are also before this.
Then, sir, you should have made that submission there. When the matter is seized by the apex court, where am I interfering in this now? Anyway, stay ಅಂತೂ ಇದೆ to facilitate mediation. You mediate
Yes.
or whatever you want and report it to the apex court.
In fact, my lords, on the last day of hearing, my lords, my learned friend said there is mediation, my lords. And we sought time to produce all these orders before your
All
lordship.
right. The heard so and so. ಏನ್ ನಿಮ್ದು ಇದೆಯಾ ಹೇಳೋದು? ಅಷ್ಟೇ. Heard so and so. The petitioners are before the court calling in question certain crimes, charge sheet.
This is the crime, my lords.
Certain crimes registered against them by the complainant respondent. Both the parties are before the apex court in SLP 5391 of 2025, arising out of an MFA, in MFA number 6815 of 2024, dated 5/2/2025. The apex court has passed the following order. The parties to the list are referred to mediation and are in the process of mediation. The learned counsel for the petitioner submits that after the apex court directed mediation and during the course of mediation, a protest petition has been filed by the respondents to arm twist these petitioners to enter into a settlement in these cases. The protest petition is admittedly filed on 10/6/2026 after the order of the apex court 10/6/2025, after the order of the apex court on 3/3/2025. Therefore, the parties to the list shall hold their hands till the mediation would be taken to its logical conclusion, and the said mediation is placed before the concerned court, before the apex court as is directed. The learned counsel would submit that the matter was listed before the apex court even on 20th July 2026, on which date?
3/8, my lord.
On 3/8/2026, and the matter is adjourned on the score that the matter, that the mediation between the two is in progress. In that light, if mediation is in progress, there cannot be any act either by the petitioners or by the respondents that would frustrate mediation, which is directed pursuant to the order of the apex court. In that light, the interim orders subsisting in these cases shall continue till the next date of hearing. The parties to the list are at liberty to file a memo before this court with regard to, in the event of any closure of mediation that is placed before the concerned court.
Grateful.
Grateful.
Yes. ಅಷ್ಟೇ, ಎಲ್ಲರದು ಹಾಕ್ಬಿಡಿ ಹರ್ಡ್ ಅಂತ.
Please.
Yes.
Ashok Raj.
Filed IA, my lords.
Stay application ಇರಲಿಲ್ಲ ಅವತ್ತು. In the meantime, order on IA. Next.
16.
My lord, in the previous date of hearing, my lord, a submission was made that I was absconding. My lord, that is not the case, my lord. Accused number 3 and 4 are absconding.
ನೀವ್ ಯಾರು sir?
My lord, I am accused number 1 and 2. My lord, latest order sheet, my lord, shows that, my lord, accused number 3 and 4 are absconding.
ಏನಿದೆ split ಆ?
No, my lord.
Then?
My lord, cow slaughter, my lord, based on the confession and statement of accused number 4, have been dragged into the proceedings. Your lordship may kindly see, my lord, page number 136 for a moment. 136, my lord, shows the Mahajar.
CDR.
Entire seizure, my lord, is by accused number 4.
Disclose that he was present on the scene of offense.
Sorry?
CDR discloses that he was present on the scene of offense. And he was in
You
contact.
better face trial. Yes.
My lord, CDR, my lord, was not the part of the charge sheet, my lord. I was not
And
provided.
164 statement speaks about the accused number 2's presence.
I'll let them provide a copy, my lord. I don't have that copies, my lord.
ಆಯ್ತು ಬರ್ಲಿ ಬಿಡಿ. ಏನ್ ಸ್ಟೇ ಮಾಡಿಲ್ವಲ್ಲ?
There is no stay, my lord.
List the matter on 14th. Yes.
I'll let them provide the copy,
No,
my lord. That is not the part of the charge sheet, my lord. That is the reason, my lord, I'm making this
Let
submission.
him produce.
CDR there. Charge,
Yes,
part of
next,
charge
next.
17.
The dispute only related to partial withdrawal, my lord. There's
Yeah.
For investment, my lord. Investment clause says, my lord, her complaint, it says that partial withdrawal is not allowing.
3183. Yes. One HCGP to emergent notice in the meantime. Next.
18.
Lordship, the petitioner, all three society na party ಮಾಡಿದೆ ಅಂತ ಹೇಳಿದ್ರ
Society is part. Yes.
And my lordship, the last date of hearing, my lordship, the matter mediation report set aside ಆಗಿದೆ ಅಂತ submitted. But as per my client instructions, set aside ಆಗಿಲ್ಲ. So I produce the.
Let objections come about.
Yes.
File your objections. The learned counsel, Srimati Kirti Reddy, appearing for respond number 3 society, seeks 10 days time?
A week is
A week's time. A week's time to file statement of objections. List the matter on 18th. Objections, if any, by then. Yes. Entry modern ಕೊಟ್ಟಿಲ್ಲ.
Yes.
ಇದೆಯಾ?
Yes, my lordship.
ಏನಿದೆ? No entry matters.
Further proceeding, as per mediation report, my lordship. The mediation report.
In the light of settlement arrived at between
Yes,
the
my
parties.
lordship.
Settlement
ಆಗಿದೆ.
ಆಗಿಲ್ವಾ?
I have no instructions. my lord.
See, that person is dead.
Which is
Person
why
Yes, sir.
114, my lordship, the mediation
ಯಾವ್ದು
report.
settlement ಯಾವ್ದು ತೋರಿಸಿ?
114, my lordship. 114.
Page.
114.
ಯಾವತ್ತಾಗಿದೆ? 2010 ಅಲ್ಲ?
13 also. As per mediation, if all condition is already fulfilled, my lordship, the amount deposit agide sale deed ಬರ್ಕೊಟ್ಟಿದ್ದಾರೆ.
compromise before in the OS, the compromise, if that's what they're referring to. my
That
lord,
is the OS compromise 2010.
That itself, my lord, is, my instructions are that itself was done under collusion and fraud.
That's fraudulent.
Please, my lord.
ಯಾವ ಸತ್ತೋಗಿದ್ ಯಾವಾಗ?
May I bring
Before this, is it?
No, subsequently.
You file your objections. Let's, there's already an interim order granted. They list the matter on 18th, fresh matters. Yes.
Interim order.
That will continue. Yes. Interim order subsisting will continue to the next date of hearing. ಯಾರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿದಿರ ಸೊಸೈಟಿ?
The respondent.
ನೀವು ಮಾಡಿದ್ದು ಸರ್?
Is the director, Pankaj.
ಸೊಸೈಟಿನ ಪಾರ್ಟಿ ಮಾಡಿ. By name director ಯಾಕೆ ಮಾಡಿದ್ದೀರಾ?
As per instruction.
I had filed an impleading application.
Second
You had
respondent.
filed impleading application in her name, is it?
Because I'm the director and the one that they had made a party is not, he's dead.
All right.
I'm the de facto
Impleading
complainant.
application ಅದೇ ಇದ್ರ ಪರವಾಗಿಲ್ಲ.
But I'm the de facto complainant. That's why I have filed.
Correct. In the other case also you were the de facto complainant. Yes. All right.
19.
Please, my lord. The matter was earlier listed on 27/7, my lord. There was a folly on our part, as your lordship mentioned, that we could not file the charge sheet, my lord. But we're also kind enough to take the charge sheet on record, my lord. There is a entire charge sheet that is filed, my lord, which only reflect that there was a suicide, my lord. But subsequently, based on a private complaint, as far as petition number 1 and 2 are concerned, my lord, except the name is name in the cause title that is being mentioned in the PCR, my lord. There is no allegations against petitioner number 2, my lord. But as far as petition number 1 is concerned, except call record, there are no other allegations at all, my lord. 302, 201, 120A,
Mate?
120B.
Then how are you before the court, sir?
My lord, in fact, as far as petition number 2 is concerned, my lord, except her name being in the, mentioned in the cause title, my lord, there are actually literally zero allegations against her, my lord. The only allegations are that she had,
Not in a case of murder, sir.
my lord, but UDR report was filed and entire charge sheet also reflects.
See, UD unnatural death report was filed, later it is converted to 302 and all of you are dragged into the proceedings.
Please, my lord,
All right.
please. But mainly the allegations are against accused number 3 and 4, my lord. They are the ones who took him to the hospital, my lord, the deceased. And subsequently kept him in ambulance for for some time, my lord. Later he was transferred to some other hospital.
Then madam, stay marna.
No, my lordship.
ಏನು ಇಲ್ಲ ಅಂತೇವೆ.
Alla, in the PCR itself, it has been clearly mentioned, my lordship.
If your lordship may kindly have a look at PCR, my lord, if I may be
All
permitted to show
right,
PCR.
in a 302 case, filing 482 confidence, okay. Over confidence yake?
I'm not relying on overconfidence, but literally against petition number 2, there are
No, sir, nothing.
even if entire PCR is also produced, my lord, there are no allegations. They're only saying that there were certain call records pertaining to petition number 1 and others, my lord.
Saku, sir, it's a matter of evidence. It's a case of murder.
But as far as accused number 2, my lord, petition number 2, there is nothing, my lord,
You're
nothing.
accused number 1 and 2.
Accused number 1 and 2, my lord.
Yes.
In fact, I mean, I was made accused number 1 and 2. Whereas in fact, entire PCR allegations are against accused number 3 and 5, my lord.
That's the charge sheet. That's the result of the investigation.
But charge sheet was filed on 21/7/2023, my lord.
Oh, no problem, sir.
Very detailed charge
What's
sheet.
the stage?
Appearance of the accused.
Where, sir? Seek discharge. If they do it, don't find. I am not going to interfere.
At least if I may request for stay, as far as petition number 2 is concerned, my lord.
No, sir, nothing. File discharge, we'll see. Nothing doing. Please go, allowed, please.
21.
Petitioner is accused number 1.
ಯಾರು acquit ಆಗಿದ್ದಾರೆ?
Accused number 2 is a
Page.
498.
She is a palmer of A1, your lordship.
Paramarra.
498 A.
None of the witness has been examined.
Acquittal ಯಾರ್ದಾಗಿದೆ?
Accused number 2.
2 ಯಾರು?
2 ಅವರು ಏನೋ ಅಫೇರ್ ಇದ್ದು ಇವರಿಬ್ರು ಬಂದು ಹರಾಸ್ಮೆಂಟ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ ಕೇಸ್.
ಹಸ್ಬೆಂಡ್ acquit ಆಗಿದ್ದಾರಾ?
ಇಲ್ಲ.
ಮತ್ತೆ?
Accused number 2, none of the witness has been examined in spite of.
The paramour could not have been drawn at all. ಎಲ್ಲಿಂದ ಟ್ರಯಲ್ ನಡೆಸಬೇಕು?
That point,
On that point, we'll do it. The petitioner is before the court seeking the following prayer. The learned counsel appearing for the petitioner submits that the petitioner is drawn as accused number
1.
Accused number 1 and the other accused number 2 has been acquitted of the offence and therefore further proceedings against the petitioner accused number
1.
A1 na ನೀವು?
One is husband, your lordship. A1 is the husband, 498 A offense.
ನೀವ್ ಯಾರು ಸರ್?
Husband, accused number 1.
ಹಸ್ಬೆಂಡ್ ಬಂದಿದ್ದೀರಾ ಇಲ್ಲಿ? ಯಾಕೆ?
ಅಲ್ಲ, none of the witness has been examined in spite of the issuance of the proclamation.
Paramour ಅಂದ್ರೆ ಮತ್ತೆ?
A2 is the palmer who is acquitted.
A2 is paramour. Anything else, sir?
Like, one more complaint is that is also closed. 498 ಕೊಟ್ಟಿದ್ದಾರೆ. ಅದು ಕ್ಲೋಸ್ ಆಗಿದೆ. ಅದರಲ್ಲಿ
Husband ಗೆ split charge sheet apply ಆಗಲ್ಲ, sir.
ಯಾಕಂದ್ರೆ ಇದು
Husband is unique, allegations are unique.
2012 is the complaint
Maybe,
and
sir.
they are separated. 10
ತೊಂದ್ರೆ ಇಲ್ಲ.
ವರ್ಷದಿಂದ
ಈಗ ಸ್ಪೀಡಿ ಡಿಸ್ಪೋಸಲ್ ಬೇಕಾದ್ರೆ 3 ತಿಂಗಳಲ್ಲಿ ಕ್ಲೋಸ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ.
they are separated. One more complaint 498 ಕೊಟ್ಟರೆ ಅದು ಇವರು ಅಪಿಯರ್ ಆಗಿಲ್ಲ ಅಂತ ಅದು ಕ್ಲೋಸ್ ಆಗಿದೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ.
And it's,
ಆಯ್ತು,
page number
ಇದನ್ನ
30.
2 months ಅಲ್ಲಿ ಕನ್ಕ್ಲೂಡ್ ಮಾಡಕ್ ಹೇಳ್ತೀನಿ.
Page number 30 ಅಲ್ಲಿ
We can't quash it on split charge sheet.
in spite
Yes.
of issuance of the
The
proclamation.
petitioner is before the court, calling in question the proceedings in so and so, registered for offence punishable under so and so. Petitioner is the accused number 1 husband. The matter is pending before the concerned court for the last 14 years, as the crime is registered in the year 2012. In the light of the proceedings of the year 2012 and the second crime so registered by the same complainant against this petitioner, ending in acquittal on this score that the complainant has not appeared before the concerned court, I deem it appropriate to direct the concerned court to conclude the proceedings with an outer limit of 2 months from the date of receipt of the copy of this order. In the event the complainant would not appear before the court to cooperate with the proceedings, the concerned court shall pass necessary orders in accordance with law. ಅಷ್ಟೇ, ಇದು ಕ್ಲೋಸ್ ಆಗುತ್ತೆ ಬಿಡಿ. Yes.
22.
498.
Husband.
Husband.
ಬೇರೆ ಇದಾರಾ? ಬರೀ ಹಸ್ಬೆಂಡ್.
Only husband.
ನೋಟಿಸ್ ಮಾಡಿದ್ದೀನಲ್ಲ, ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ. 2011 Lord marriage. She was living with me, Lord, in America. After she came back, Lord, she files 4 complaints against me.
4?
Yes, my Lord. 1, 2, Lord, last time, your Lordship,
ಎಲ್ಲಿದೆ ಕೊಡಿ?
produce, along with the memo, Lord, I produced.
4 ಕಂಪ್ಲೇಂಟ್ ಎಲ್ಲಿದೆ ಸರ್?
ಇದು ಸೇರಿ.
ಅಲ್ಲೇ
ಎರಡು ಮೇಂಟೆನೆನ್ಸ್, ಇನ್ನೊಂದು ಡಿವೋರ್ಸ್ ಪಿಟಿಷನ್.
ಅದು ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲ ಸರ್. ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಎಷ್ಟನೇದು?
ಅಲ್ಲ, ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇದು.
ಅದು ಪ್ಯಾಕೇಜ್. ಒಂದ್ಸರಿ ವೈಫ್ ಸ್ಟಾರ್ಟ್ಸ್ ಫೈಲಿಂಗ್ ಅಂದ್ರೆ ಒಂದು 5 ಆಗೇ ಆಗುತ್ತೆ. ಹಂಗಂತ ಇದ್ರಲ್ಲಿ ಯಾವ್ದು?
Not in this, in the complaint she says, not, I was not ready for the divorce. Therefore, not, she narrates in, from 2011, she narrates everything, not till 2025. She was living with me in America, not after she came back here, she files a complaint. ಆಮೇಲೆ ಡಿವೋರ್ಸ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡಿದ್ದಾರೆ ಬಂದ ಮೇಲೆ.
Get her, we'll see. M1 HGP2 emergent notice returnable by the 19th. In the event the petitioner would serve ಮಾಡಿ ಇವತ್ತು. In the event the complainant would not represent, appropriate orders would be passed. ಅವತ್ತು ನೋಡುವ. ನಾನು ಇದು 4th ಕ್ರೈಮೇ ಅನ್ಕೊಂಡೆ. ಅಲ್ಲ, ಅದು ನೀವು ಪ್ಯಾಕೇಜ್ ಇರ್ಬೇಕಾದ್ರೆ ಅವೆಲ್ಲ ಹೇಳ್ಬಾರ್ದು. 4 ಮಿನಿಮಮ್ ಕೇಸ್.
23.
Awaiting police report. Awaiting police.
Post immediately after service of notice.
Entry ಮಾಡಿ.
2 weeks ಒಂದು ಕೆಲಸ ಮಾಡಿ ಅಷ್ಟೇ. ಡೇಟ್ ಕೊಡಿ.
24.
Post after service immediately ಅಲ್ಲ. Yes, next.
Entry ಮಾಡಿದ್ರೆ maybe.
That'll extend, sir. Yes, Sachin.
24.
Food and Safety Act provisions is invoked.
Correct, sir. ಏನೇನು ರೀಸೈಕ್ಲಿಂಗ್ ಏನೇನ್ ಮಾಡಿದ್ರಿ ಅಂತ.
Yes, my lord, we have produced the material.
ಅವ್ರ ಪ್ರಕಾರ ಯೋಗರ್ಟ್ ಏನದು ಮೊಸರು ರೀಸೈಕಲ್ ಮಾಡ್ಬಿಟ್ಟಿದ್ದೀರಾ?
Plus, let me put it in this.
Yes, sir.
My lords, as per Sushil Kumar's case.
Sushil Kumar.
Sushil Kumar's case. My lords, there is complete bar to invoke the provisions under the Food and Safety Act, including the provisions of the food, the officer under Food and Safety Act. My lords, I cannot, there is a complete bar contained under section 89, my lords, which overrides all other the provisions of law.
ಇವರು ಸರಿಯಾಗಿ ಮಾಡೋದಿಲ್ಲ, ಮಾಡಬೇಕು ಅಂತ.
To just place on the judgment of the apex.
ಕೊಡಿ ಸರ್.
My lords, have a look at the Sushil Kumar case. On second page ali, the provisions invoked is the charges under section 272, 273, 420, read with section 120 of IPC, so and so, so and so. Has quashed the proceedings, but insofar as IPC, my lords, the court has not quashed. That is the reason, my lords, the appeal was filed before the apex court. Kindly have a note of para number 10, my lords.
Yes, sir.
Yes, my lords, para 9. The issue raised in the present appeal are no longer res integra after the decision of this court in Ramnath versus State of UP. This court took the view that very exhaustive and substantive and procedural provision in 2006 Act have been provided for dealing with the offence concerned unsafe food. Court looked into the section 89 of the Act 2006, which provides for overriding effect of the Act 2006 overall other food related laws. The court also looked into section 59 of the Act 2006. The final conclusion drawn in Ramnath Supra is under. Thus, there are very exhaustive, substantive and procedural provisions in FSSA for dealing with the offence concerning unsafe food. In this context, we must consider the effect of section 89 of the Act, which reads as thus. Overriding effect of this Act overall all food related laws. The provisions of this Act shall have effect notwithstanding anything inconsistent therewith contained in any other law for time being in force or in any instrument having effect by virtue of law other than this Act. The title of the section indeed indicates that intention is to give an overriding effect to FSSA or all food related laws. However, in the main section there is no such restriction confined to food related laws. It is provided that provisions of FSSA shall have effect notwithstanding anything inconsistent therewith contained in any other law for time being in force. So the section indicates that overriding effect is given to the provisions of FSSA over any other law. The settled law is that if main section is unambiguous, the aid of the title of the section or marginal note cannot taken into interpret the same. Only if the ambiguous, the title of the section or marginal note can be looked into to understand the intention of the legislature. Therefore, main section clearly gives overriding effect to the provisions of FSSA or any other law insofar as law applies to the aspect of food in the field covered under FSSA. Next, 21. The decision of this court in so and so does not deal with this contingency at all. In the case of state of Maharashtra, the question effect of section 97 of FSSA did not arise for consideration of this court. The court dealt with simultaneous prosecution and concluded that there could be simultaneous prosecution, but conviction and sentence can be only one. The proposition is based on what is incorporated in section 26 of Act. We have no manner of the doubt that by virtue of section 89 of the Act, by section 59 will override the provisions of section 272 and 273 of the IPC. Therefore, there will not be any question of simultaneous prosecution under both statutes. Thus, the claim laid on in the Ramnath is that if an accused is charged of an offence so and so of an IPC, section 59 of the Act 2006 would be attracted. In fact, offence under section 59 of the Act 2006. Yes. Well, ultimately, my lords, this 420 and other offence was quashed by the apex court. That is my first submission. Insofar as, my lords, the authorized officer also issued notice, my lords, I have participated in the proceeding and it is posted for orders. That is my second submission. My lords, third submission is that, my lords, if my lords have a look at the complaint averments, my lords, he is not an affected party. Kindly have a look at the complaint averments. My lords, allegation is that he has received an information that selling expired product by an accused. My lords, insofar as my case is concerned, my lords, I have placed the memo. Kindly have a look at the memo, my lords. In this, my lords, we have been issued a license to purchase the damaged and expired products. How I have sell it, kindly have a look at the page number 2.
I have seen all the pages in the memo.
Yes. Kindly see, my lords, in this, rice flours, pulses, chips, biscuits.
ನನಗೆ ಎಲ್ಲೆಲ್ಲಿ ಡೌಟ್ ಇದೆ ನಾನೇ ಕೇಳಲ್ಲ ಎಲ್ಲ ಓದಿದ್ದೀನಿ.
Yes.
ಈ ಆಯಿಲ್ಸ್ ಅಂಡ್ ಫ್ಯಾಟ್ಸ್ ಅಂತ ಇದೆಯಲ್ಲ,
ಕರೆಕ್ಟ್.
ಈ ಎಕ್ಸ್ಪೈರ್ಡ್ ಆಯಿಲ್ ಅಂಡ್ ಫ್ಯಾಟ್ಸ್,
Yes.
ಕೋಕೋನಟ್ ಆಯಿಲ್, ಪಾಮ್ ಆಯಿಲ್,
Correct.
ಘೀ, ಬಟರ್ ಎಲ್ಲ ಎಕ್ಸ್ಪೈರ್ಡ್ ಪ್ರಾಡಕ್ಟ್ಸ್ ನೀವು ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
My lords, kindly see, my lords.
You are recycling that?
Correct. We are selling it, my lords. We are meant for that.
ಅಲ್ಲ, selling it to whom?
Yes, my lord. That is the reason, my lords. Kindly.
Selling it to ಒಂದು ಸೋಪ್ ಫ್ಯಾಕ್ಟರಿ, ಇನ್ನೊಂದು ಅಲ್ಲ, selling it ಯಾರ್ಯಾರಿಗೆ
My lords,
ಇನ್ವಾಯ್ಸ್?
kindly see 3, point number 3. 3 ಅಲ್ಲಿ ಮೆಮೊದಲ್ಲಿ
3 ಅಲ್ಲೇ ಇರೋದು.
ಕೋಕೋನಟ್ ಆಯಿಲ್, ಪಾಲ್ಮ್ ಆಯಿಲ್, ಘೀ, ಬಟರ್, ಎಕ್ಸೆಟ್ರಾ.
ಬಟರ್.
Yes, sir.
ಆಯ್ತಾ? ಇದನ್ನ you recycle it.
Correct.
Sell it to whom?
My lords, that is also indicated here. We are selling it to Brindavan Soap Factory. Kindly have a look at the page number 9. Page number 9, my lords.
For the purpose of?
ಡಿಟರ್ಜೆಂಟ್ ಗೆ ಅಂತೆ.
For the
Kindly see page number
purpose of
9.
detergent.
ಹೌದು.
ಹಾ.
Kindly see page 9,
ಆಯ್ತಾ?
sir. Page
ಆಯ್ತು.
9.
ಒಂದ್ ನಿಮಿಷ. Detergent.
Yes, sir.
So
Manufacturing.
ಒಂದ್ ನಿಮಿಷ ಸ್ವಲ್ಪ page 9 ಗೆ ಬನ್ನಿ.
Yes, sir.
Soap manufacturers.
Correct.
Brindavan soap factory is a soap manufacturer.
Correct.
It manufactures detergents, liquids,
Correct.
soaps.
Yeah.
Made out of what? Expired damage oil, expired detergent powder,
Correct.
scrapped detergent liquids and soaps. So this Brindavan soap factory, whoever it is supplying detergent liquids and soaps which will never wash the clothes because they're all scrap material. You are selling it to them, correct? So nimage only on technical point you are that complaint could not have been
Correct.
registered.
That is one
That will examine.
Yes. My lord, my submission is that
ಆಮೇಲೆ
there is an
ಈಗ
expert body.
ಒಂದ್ ನಿಮಿಷ
Yes, sir.
ಈಗ ಮೊಸರು ಕೋಕೋನಟ್ ಆಯಿಲ್ ಎಲ್ಲ ರೀಸೈಕಲ್ ಮಾಡಿ ಏನ್ ಮಾಡ್ತೀರಾ?
My lords, kindly have
How
a
do you
look.
recycle curds? I don't know.
Lords, we are not recycling it.
Then
Let me put it in this way.
ಅಲ್ಲ
We
butter,
segregate. We segregate.
coconut oil, palm oil, ghee, butter.
Correct.
What recycling of ghee you will do?
We are not recycling. Sir.
Then
We are not recycling. We segregate the products and we supply to these
ಆಮೇಲೆ
companies.
ಇಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ you have applied for to the ಯಾವ್ದಿದು food safety standards ಅಲ್ಲಿ give us permission to use scrapped material or best before dated products ಆಗೋಗಿರೋದ್ನ waste material for cattle feeding.
We are not doing it.
ಅಲ್ಲ ಅಂದ್ರೆ ಪರ್ಮಿಷನ್ ಕೇಳಿ.
My lords, no, not like that. My lords, we segregate. We segregate and when we sell it to the company, my lords, which manufactures cattle feeds. They, my lords, they, ಏನ್ ಮಾಡ್ತಾರೆ ಅವ್ರು? And they'll sell it, my lords.
You are in Chennai, is it?
Bengaluru.
ಮತ್ತೆ ಇದೇನ್ ಮೊಹಮ್ಮದ್ ದಾವೂದ್ ಚೆನ್ನೈ, what is that?
ಅವರಿಗೆ directors.
Oh, director of this company.
ಹೌದು. My lords, my submission before my lords is that there is an expert body for that. There is an authority which is contemplated under the provisions of the Act.
Correct. Only
They have
that
already
body should-
they made an
No,
inquiry.
technically you may be right in
Lords,
contending.
they made an inquiry. This is not the case where my lord, they have held an inquiry and they have posted the case for orders. Now I'll be
No, I'm
prosecuted.
on, the court is only concerned with the consumers. ನೀವು ಮೊಸರು ಘೀ ರೀಸೈಕಲ್ ಮಾಡ್ಬಿಟ್ಟು ಎಲ್ಲ ಬಡವರು ಕೊಟ್ಬಿಟ್ರೆ ಅವ್ರು ತಗೊಂತ ಕಡಿಮೆ ರೇಟ್ಗೆ ಅಂತ.
If my lords have a look at the complaint averments also, the complaint is not an affected party. What he says, he received an information. Kindly have a look at the complaint averments. Complaint averment says is that he has received the information selling expired product by the accused.
ಅಲ್ಲ ಅಂದ್ರೆ ಅನ್ಫಿಟ್ ಫಾರ್ ಹ್ಯೂಮನ್ ಕನ್ಸಂಪ್ಷನ್ ಪರ್ಮಿಷನ್ ಕೊಡಿ ಅಂತ ನೀವೇ ಕೇಳಿದ್ದೀರಾ?
My lords,
ಅಲ್ಲ,
there
ನಿಮ್ಗೆ
is,
ಯಾರೋ ಬರ್ದಿದ್ದಾರೆ, whoever is director,
Lords, if-
Mohammed something is your director.
my lords, if there is any violation of the law, I'll not be escaped from the liability.
Correct,
Because
you-
the law will take care under the special enactment, Food and Security Act. There is a specific provision for punishment also.
ಈಗ ಸ್ಪಾಟ್ ಒಂದ್ ನಿಮಿಷ ಅಲ್ಲ ಅಷ್ಟೇ, ಸ್ಪಾಟ್ ಮಾಸರ್ ಮಾಡಿದ್ರಲ್ಲ ಏನೇನು ಸಿಕ್ತು?
All these things which my learned friend speaking about.
ಎಲ್ಲ ಎಕ್ಸ್ಪೈರ್ಡ್ ಪ್ರಾಡಕ್ಟ್ಸ್.
ಎಲ್ಲ expired product and some of the things they removed the labels. The same product, they remove the label probably to refix a new label.
Relabeling.
Relabeling.
My lords, we meant for that. We always purchase
You meant
damaged.
for that?
Alla, my
ಅಂದ್ರೆ
lords,
consumers are getting expired products then?
we always purchase the damaged products, expired products, and we sell it to the concerned manufacturer company. We segregate it and we sell it. This is how it works.
Hot chips ಎಲ್ಲ ಇದೆನಾ?
ಅದು ಇದೆ.
Not for human consumption.
10 kinds of damaged oil into one can. Hot chips, very tasty.
My lords, this is not for
What should
human
happen to human beings?
My lords, this is not a case where, my lords, we have not sold the said product to the.
That we'll see.
Yes.
But why ನೀವು ಮಾಡ್ಬೇಕಾದ್ರೆ
Legal
ಸರಿಯಾಗಿ
point,
ಮಾಡಕ್ಕೇನೀಗ?
on the legal point.
ಹಾ.
It is on this judgment will not dealt with the issue of where charges have been framed. It's only investigation. Post investigation, we will ask the appropriate authority will file a complaint my lord if necessary.
Why do you do this? ಕರೆಕ್ಟ್ ಆಗಿ ಮಾಡಕ್ಕೆ ಏನು ಒಂದ್ಸರಿ ಮಾಡ್ಬೇಕಾರೆ?
I'll verify what.
ಅವ್ರಿಗೆ ಹೆಲ್ಪ್ ಆಗ್ಲಿ ಅಂತ ಪೊಲೀಸ್ನವರು ಮಾಡಿರ್ತಾರೆ ಅದನ್ನ. ಅಲ್ಲ, who's the ಮಾಜರ್ ಮಾಡಿದ್ಯಾರು?
ನಾವೇ ಮಾಡಿರೋದು.
ಪೊಲೀಸಾ?
ಹೌದು. Based on a subsequent registration of FIR, we conducted a spot inspection and recovered various articles my lord.
ವೆಟರ್ನರಿ ಡಿಸ್ಪೆನ್ಸರಿ ಯಾಕೆ?
ಎಲ್ಲವೂ ಇದೆ.
ಅಲ್ಲೇ ಇಟ್ಕೊಂಡಿದಾರ?
ಇದೆ. ಕೆಲವು ಪ್ರಾಡಕ್ಟ್ಸ್ ಗೆ ಬರೀ ಲೇಬಲ್ ನ ತೆಗೆದಾಕಿ ಪ್ರಾಡಕ್ಟ್ ಇಸ್ ಇಂಟ್ಯಾಕ್ಟ್ ಲೇಬಲ್ ಇಸ್ ನಾಟ್
And you sell it to Flipkart, is it?
No, no,
ಅಲ್ಲ
we
ಇಲ್ಲಿ
take it from.
ಇಲ್ಲಿ ಆಫೀಸ್ ಇದು ಆರ್ಡರ್ ಇದೆ ಇಲ್ಲಿ ಅದಕ್ಕೆ.
My lords, if my lords have a look
No,
at the
it is
special
technical,
enactment.
ಅಲ್ಲ technically you may be sound.
Correct.
But technicality is apart.
but I'll examine my lord. The only issue, my lord, I'll see whether the even in MMRD, my lord, and all other legislation, the police cannot file a charge sheet, but doesn't bar for registration of FIR and then conduct an investigation, file an appropriate complaint before a court.
ಆರೋಪಿ ಸ್ವಇಚ್ಛಾ ಹೇಳಿಕೆ ಏನಿದು? ಅಮೀರ್ ಅಹಮದ್ ಬಿನ್ so and so. You are the director, is it?
Yes.
Amir Ahmad.
Correct, Allah, director.
Right, let's see.
Yes.
But technically you can't
I'll
do
verify
this.
the technical.
No, well, pass orders, yes. Heard the learned counsel B.S. Sachin appearing for the petitioner and the learned additional SPP. Heard reserved. Yeah. Sorry, SPP, sorry sir. ಇದು ಯಾಕೋ sir. And the learned SPP is B.N. Jagdish. ಸ್ವಲ್ಪ ಅವಾಗ ರಿಮೈಂಡರ್ ಕೊಡ್ಬೇಕು.
My lords, I have annexed.
ಅದು
Ramnath-
7-8 ತಿಂಗಳಿಂದ ಹಂಗಂದು ರೂಢಿ.
I have annexed Ramnath case also, my lords.
All right, that shall be an interim order of stay of further proceedings, quay the petitioner till the next date of hearing. Reserved stay.
25.
For the petitioner, your lordship. Take further instruction.
Lordship, section 457 of Karnataka Prevention of Cow Slaughter Act, your lordship, and section 379. Lordship, the petitioner is accused number 7. Based on the confession statement of accused number 2.
Corroboration ಇದೆಯಾ ಅಂತ ಕೇಳಿದೆ.
No, nothing recorded.
I sought for further information regarding the
ಅವ್ರು ಹೇಳೋದನ್ನ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ
DDR.
ಮೇಡಮ್, ಏನಿದೆ? List the matter on Tuesday in the fresh matters finally. In the event, no instructions with regard to corroborative material against the present petitioner, accused number 1 would be projected before the court by the state. Accused number 7 would be projected before the court. This court would be constrained to stall further proceedings against the petitioner. Yes. Next.
26.
For petitioner, my lord. On 18/4/2026, the complainant has sold his vehicle to the uncle of the petitioner, my lord, by executed sale agreement and 2930 form, delivery note, everything, my lord. Thereafter that, on 5/5/2026, the FIR has been registered.
ಇದು ಅಷ್ಟೇ. Instructions. ಕೊಡಿ. Next Tuesday, the
Even they have
interim protection.
antecedents also, my lord.
Interim protection subsisting would continue till the next date of hearing. Wednesday fresh matters, next.
Point 1 is also. Next, connected.
Same order, both.
27.
Lordship, priest in the temple who was unnecessarily dragged into the proceedings of one CCTV camera line being cut.
For what?
Your Lordship, the learned SPP on the last occasion said, in fact, nothing much against the petitioner has been, nothing has surfaced as against this petitioner. Lordship,
Golka.
Please, Your Lordship.
Theft from,
They claim that there's a theft. They claim that the CCTV camera was cut. 5 months later, they file a
accused
complaint.
number 6.
Two people were found in the CCTV.
ಇವರಲ್ಲ.
Not us.
Anyway, that probably will not do anything, my lord. That's what I made a submission.
Heard the learned senior counsel Srimati Lakshmi Iyengar appearing for the petitioner. The petitioner is accused number.
First match, then it's for some time.
Close ಮಾಡ್ಲಿ ಬಿಡಿ. ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕ್ಲಿ, ಅವರೇ ಹಾಕ್ತಾರೆ. Protection ಕೊಟ್ಟಿದ್ದೀನಿ anyway.
Your Lordship, that protection given on 9th, unfortunately was not uploaded, if that could be.
ಇಲ್ಲೇ ಇದೆ,
just-
ಯಾಕೆ? ಏನಾಗಿದೆ?
It's uploaded, na? Next. please.
Accepted, my lord.
9/7 ಗೆ ಕೊಟ್ಟಿದ್ದೀನಿ. We'll repeat that anyway. Heard the learned senior counsel Srimati Lakshmi Iyengar appearing for the petitioner. The learned SPP on instructions would seek time to seek further instructions in the matter as according to the learned SPP, there is nothing directly found against the petitioner. He would require time to look into the records and make a submission. In the light of the learned senior counsel would submit that ಮತ್ತೆ ತೊಂದರೆ ಕೊಟ್ರ ಆಮೇಲೆ
ಇಲ್ಲ, ತೊಂದ್ರೆ ಕೊಡಿ.
that the interim protection so granted on 9/7/2026 must be continued This court on 9/7/2026 had passed the following order. Said order shall continue till the next date of hearing. List the matter on 20th.
Your Lordship, if that word directly is taken out, Your Lordship, nothing as against the petition, because he did say directly.
Directly take it. Yes. Avre we report ಆಗ್ತಾರೆ. Sorry.
Please.
Yes.
28.
Lord is, your lordship was pleased to grant.
Chartered accountant.
Yes, please. Lords, the stage at the trial court is, lords, the matter is reserved for judgment. It is at that stage the petitioner has come before this
Oh,
court.
my lord, subsequently what happened in this matter? Allegation is, my lord, the petitioner is a chartered accountant, is a non-public servant. As a public servant is a accused number one who allegedly demanded.
No,
of
no,
a-
ಆ stage ಅಲ್ಲಿ entertainment
No,
ಅಲ್ಲಿ
my lord,
Argued
only
the
one
same
submission.
contention in the trial
No,
court.
because why I drawing the attention of this honorable court, my lord? The very identical issue which they have contended before the trial court, where then the charge sheet said that it's an illegal gratification which has been allegedly paid by the complainant to the accused number two, my lord. Where the allegation that it is a.
Sir, judgment ರಿಸರ್ವ್ ಆಗಿದೆಯೋ ಇಲ್ವೋ?
No, my lord.
ಆಗಿದೆಯೋ ಇಲ್ವೋ ಹೇಳಿ?
Please, my lord, it is made. My lord,
Direct the court to pronounce the order.
No, my lord, this is only one humble submission.
Sir,
Annexure-
judgment reserve, what do you think?
No,
You
please,
did not
my
tell me on the earlier occasion. You
Please,
were
my
there.
lord.
you-
Please, my
ಇಲ್ಲ,
lord.
ಪ್ರಸನ್ನ ಕುಮಾರ್, directed.
Directed.
Please, my lord, page number
Time it is coming up.
214. This is a coordinate bench has quashed the proceedings entirely.
I will direct the court to look into that also.
My lord,
The
this
petitioner is
ma-
before the court
may I
seeking the
try it?
following prayer.
May I try it?
No, sir. ನಿಮ್ಗೊಬ್ರದ್ದು ಬೇರೆಯವ್ರಿಗೊಬ್ರು.
ಒಂದೇ document. It is
The
the
petitioner
CBI.
is before the court seeking the following prayer. This court, owing to the submission of the counsel for the petitioner on 13/7/2026, had granted the following order. The learned counsel Rahul Reddy representing the, please Prasanna Kumar, Rahul Reddy appearing for Prasanna Kumar representing the CBI would submit that the matter before the concerned court, which is of the year 2013, has now been concluded and reserved for its judgment. Reserved at that stage, the petitioner has approached this court in the subject petition. In the learned counsel for the petitioner submits that the coordinate bench, you know,
Coordinate page number 214, my lord, where the issue which has been already been covered and all the subject matter of the CBI charge sheet.
the same petitioner.
Same petitioner. my
ಏನಾಗಿದೆ
lord.
ಇದು?
That is the reason, my lord, I wanted to draw attention of this
That
honorable
is the
court, my
order
lord.
on departmental.
Kindly bear with me, only for 1 minute, my lord.
One ನಿಮಿಷ. The learned counsel would submit that concerning the same petitioner, the coordinate bench of this court in writ petition 19236 of 2018 has quashed the proceedings in terms of its order dated 18th December 2025. In the light of the quashment of the proceedings, the criminal case cannot be permitted to be continued, is his submission. The concerned court therefore shall now look into the order of the coordinate bench as well, while passing its order in a proceeding that is now reserved for its judgment. There is no warrant of interference once the proceedings are concluded and the matter is reserved for its judgment. It is needless to observe that the concerned court would apply its mind to the order passed by the coordinate bench and then pass necessary orders in accordance with law.
Please, my lord, one more document, my lord, with that is CBI itself, at the behest of the CBI, these proceedings have been initiated, the departmental inquiry. This has to be came into the light only when the proceedings have been concluded during the departmental inquiry, my lord.
That is 2025, sir. Concluded ಅಂದ್ರೆ quash ಆಗಿರೋದು.
Quash ಆಗಿದೆ.
Disciplinary proceedings have been quashed. My lords, on the ground that the allegation leveled by the CBI and the disciplinary inquiry are different. That is the submission.
ಆಯ್ತು ತೊಂದ್ರೆ ಇಲ್ಲ, ಅಲ್ಲಿ ನೋಡ್ಕೊಂಡು ಮಾಡ್ಲಿ ಅಲ್ಲಿ. Let that court decide.
Clarification, lordship may clarify. Lordship had said quashment of proceeding. Let that be clarified as disciplinary proceeding.
Quashment of proceedings hyphen disciplinary proceedings.
All the contention urged.
ಎಲ್ಲ left open, sir. All contentions urged in the present petition shall remain open to be reserve ಆಗಿದೆ already, remain open.
Further submission.
So it would remain open to be considered before the concerned court.
29.
appearing for petitioner, my lord. Allegation are under section 3192, cheating by personation. Idರಲ್ಲಿ entire complaint ಅಲ್ಲಿ there is no single allegation against accused number, petition number 2, with regards to cheating by personation, and it's a civil in nature, my lord. Civil in nature.
ಏನು
ಇದು
ಎಷ್ಟು ದುಡ್ಡು?
39 ಲಕ್ಷ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಬಟ್ ಪಿಟಿಷನ್ ನಂಬರ್ 1 and 2 ಆರ್ ನಾಟ್ ದಿ ಓನರ್ ಆಫ್ ರಾಘವೇಂದ್ರ ಸ್ಟೀಲ್. ಅಲ್ಲಿ ವರ್ಕ್ ಮಾಡ್ತಿದ್ರು.
Project yourself.
We have not projected as owners. ನಾವ್ ಯಾವ್ದು ಯಾರ ಹತ್ರನು ಓನರ್ಸ್ ಅಂತ ಹೇಳಿಲ್ಲ. ಆಮೇಲೆ ಇದ್ರಲ್ಲಿ 3 ಅಕೌಂಟ್ ನಂಬರ್ ಮೆನ್ಷನ್ ಮಾಡಿದ್ದಾರೆ. ಆ 3 ಅಕೌಂಟ್ ಇವ್ರದಲ್ಲ.
1 HCGP to emergent notice in the meantime. Next.
30.
Lordship, for the respondent in this matter.
Could you please delete the name of Ms. Anuparna Bardula?
Delete the name of Madhu?
No, of Anuparna Bardula, Your Lordship.
Anuparna so and so deleted.
Thank you.
Madhu retained. But where is Madhu?
Lordship, Lordship, I'm
Seniors on VC,
I'm on VC, Lordship.
Oh, I can't see. You are on AC anteli.
The daughter of A1, my lords, travel. My lords have granted permission on Friday.
ಏನೈತಿ? Travel ಆಯ್ತಾ?
ಇಲ್ಲ, travel ಆಯ್ತು. But
Washing.
ಇಲ್ಲ, we have only sought for relaxation of the condition. Condition imposed was not to leave the jurisdiction of the court. The special court, my lord, extends to Karnataka. My lords have granted to within India.
Within
Please.
India. You want to continue with this or what?
Please.
Close ಮಾಡ್ಲಾ?
Please. Reserving liberty, my lords, to
That's all.
approach the trial.
The petitioner heard the learned counsel Rajat appearing for the petitioner and learned counsel Madhu and Rao representing the enforcement directorate. This court, owing to the impending urgency or the right of the petitioner to travel beyond, travel beyond the jurisdiction being curtailed, this court had passed the following order. The learned counsel for the petitioner submits that he be reserved liberty to knock at the doors of this court in the event the petitioner is wanting to travel beyond the shores of the nation.
Or the trial court.
This court or the concerned court, if the petitioner is wanting to travel beyond the shores of the nation. In that light, the and would submit that petition be disposed with reserving such liberty.
May I request, my lords, on observation that she is neither an accused nor a witness and the
ಹಿಂಗ್ ಮಾಡ್ಕೊಳ್ಳಿ. The learned counsel Rajat would submit that the petitioner is neither an accused nor
a witness in the case.
neither
My
an
lords, may I
accused
submit, Lordship?
Our contention ಅಷ್ಟೇ sir. Neither an accused nor the witness. Therefore, the proceedings must not be permitted to be continued. Even the learned counsel Madhu and Rao submits that they would seriously dispute the said position. Be that as it may, the learned counsel Rajat would restrict his submission for preserving liberty to the petitioner to knock at the doors of the appropriate fora in the event he would want to travel beyond the shores of the nation. In that light, reserving such liberty, the petition stands disposed.
Publish.
Kindly add that.
He's not on
the
case.
investigation.
Huh?
That she'll be cooperative for the investigations.
No, she'll cooperate. Where is the non-cooperation?
Our condition is always there.
Huh?
Condition is
That
always
is already
there.
part of the bill.
That is there, yes.
Obliged.
31.
By special order.
Bail petition on special order.
Bail,
This is the third time it's coming before your lordship.
we'll close it today.
Yes, my lord.
Yes.
417 and 376.
64
Equivalent
to
to 300.
promise to marry.
Yes.
Promise to
Promise to marry illa.
Promise ಇಲ್ವಾ?
Illa.
ಸರಿ ಬಿಡಿ.
Consensual. She says it happened for 4 to 5 times after the first incident. And then this is money matter. Both of them have invested in the
Money matter?
ಹೌದೌದು ಸ್ಟಾಕ್ ಬಿಸ್ನೆಸ್ ಅಲ್ಲಿ ಹಾಕಿ ಇಬ್ರು ಒಟ್ಟಿಗೆ ಇನ್ವೆಸ್ಟ್ ಮಾಡಿದ್ದಾರೆ.
ಮನೆ ಮ್ಯಾಟರ್ ಅಲ್ಲ.
ಮನಿ
ಮ್ಯಾಟರ್. ಸರಿ ಆಯ್ತು.
ಇನ್ವೆಸ್ಟ್ಮೆಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಇದ್ರಲ್ಲಿ ಏನು
Lot of money has been taken.
Transactions are all based on investigation has to
1 crore 91 lakhs.
ಇಲ್ಲ 79 lakhs ಅಂತ ಹೇಳಿ.
ಅಷ್ಟೇ? Oh, 7950.
No, the thing is everything is made online, Google Pay, Phone Pay. So based on all documentary evidence.
ವಾಪಸ್ ಅದೇ ಟೈಪ್ ಹಂಗೆ ಕೊಡಿ.
Custodial intervention is not required and they have not sought for his.
No, you return it by Google Pay, Phone Pay, however you
That is
receive.
invested, my lord. Both of them are together invested. In share.
ಯಾವ್ದ್ರಲ್ಲಿ ಇನ್ವೆಸ್ಟ್
ಬರ್ಬೇಕಷ್ಟೇ.
ಮಾಡಿದ್ರಿ?
Stock business ಅಲ್ಲಿ, that is her case. She started with 2000.
2000?
Went on paying through online payments and then
How long do you know each other?
for the last 4 years.
2000 ಇಂದ ಹೆಂಗ್ ಮಾಡಿದ್ರಿ ಮತ್ತೆ?
No, 2000 ಇಂದಲೂ ಇದೆ. 2000 ಅಮೌಂಟ್ ಇಂದ ಸ್ಟಾರ್ಟ್ ಮಾಡಿರೋದು.
ಅಮೌಂಟ್ ಸರಿ ಆಯ್ತು.
And he has returned some amount also in between. Investment ಮಾಡಿದ್ರಲ್ಲಿ
ಲಕ್ಷ
ಬರ್ಬೇಕಷ್ಟೇ.
The petitioner, the sole accused is
he is-
before, accused number one, sorry, accused number one is before the court seeking enlargement on bail for it having been turned down by the concerned court in criminal miscellaneous 239 of 2026. Heard so and so. The facts enumerated are as follows. The petitioner and the respondent complainant are known to each other for close to 5 years. They are said to have indulged in relationship which was physical as well for all those years, apart from the fact that the two together have invested in the stock market. The allegation springs when the stock market falls. The allegation is that the desired amount is not handed over by the petitioner to the complainant. The investment of the complainant started on 5/9/2024 with an amount of rupees 2000 and grew up to reaching the amount of 79.5 lakhs. The allegation, as could be gathered from the complaint, is that the returns were not satisfactory. That is the complaint. Returns were not satisfactory. On the said allegation, it appears that the offense of repeated rape has sprung on consensual acts that has happened between the two for over 4 years of them knowing each other, or even 2 years of their consensual acts as is narrated in the complaint. Therefore, the petitioner is entitled to grant of bail in the case at hand, owing to the fact of the law laid down by the apex court in the case of Dhruvaram Mudalayar Sonar, 2019, 18 SCC, page 191, with following conditions. Hakya. Yes.
32.
I'm for the petitioner in this case, my lord. In this case, offense under 470, 419, 420, 465, that I have purchased the property from Ondode Gowda. That property was standing in his name, my lord, that is in annexure F.
Forgeries. One HCGP 2 emergent notice. Yes.
Remote one.
No. Yes, next.
33.
Appear for petitioner in this matter, my lord.
Intermodal.
Yes.
Post immediately after service of notice. I vote next.
Intermodal may be extended.
Sir, don't worry. Yes.
That's for the petitioner 1 and 2.
306.
Abatement is suicide.
108.
108. My lords, the death note doesn't name the petitioner 1 and 2. And also the allegations in the FIR and the PCR doesn't suggest proximate instigation or intentional aid.
Very good. Yes.
And this is an afterthought because the respondent number 2 and his family, that is the deceased husband's family, they don't want the petitioner number 1 wife to claim the death benefits of the husband.
The petitioners are accused 1, 2 and 3.
1 and 2.
Accused 1 and 2. The first petitioner is the wife of the brother either. Who is the complainant?
Brother of the deceased husband.
Is the brother of the complainant. The petitioner for accused number 1 and the brother of the complainant get married on 8/5/2025. After marriage, the first petitioner is off to Delhi for the purpose of coaching of the civil services examination. On 4/12/2025, from 2/12/2025, the accused number 1 continued to stay in Delhi. And on 16/12/2025, ಯಾವತ್ತಾಗಿದೆ ಇದು?
ಇದು
On 18/1/2026, what the first petitioner would receive a call from the police at Bangalore that the husband has committed suicide. If the first petitioner was away from 8/5/2025 up to 18/1/2026, the proximity, goading or instigation as is necessary under section 45 of the BNS for it to become an offense under section 108 of the BNS is prima facie not met. The learned HCGP also produced the records of investigation for a perusal at the hands of this court. Even the records of investigation would not advance the cause of the complainant in registering the crime, particularly for offences punishable under section 108 of the BNS. Therefore, the permitting further investigation, qua these petitioners in the case at hand, would become an investigation, huh?
Yes.
Investigation, qua the petitioners till the, would become an abuse of the process of the law and run foul of the judgment of the apex court in the case of Yadavinder Singh Yadav, 2025 SSC Online SC, page 2332. Yes. Therefore, there shall be an entry mode of stay of further proceedings qua the petitioners. Next.
35.
Oblige.
Petitioner in this matter. The trial court has rejected the application under 94 of BNSS, my lord. The prayer sought in the trial court, my lord, the preservation of the CDR and the CCTV footages.
It's a vacant land, my lordship. CCTV footages are not
Allah,
there in.
at the time of incident, the petitioner number 1 and 2 were
Offense
not in
in, sir?
302, my lord.
Murder. The
petitioner number 1 and 2 were not in the scene of occurrence at the time of incident.
The eyewitnesses are there.
Allah,
my lord.
eyewitness-
That's a matter of trial.
Allah, the IO has ought to have collected the CCTV and the
ಅದು vacant land ಅಲ್ಲ?
ಅಲ್ಲ ಅದ್ರಲ್ಲಿ ಇದೆ CCTV footages
ಇಲ್ಲ,
ಇದೆ.
vacant land ಅಲ್ಲೇ ಇನ್ಸಿಡೆಂಟ್ ಆಗಿರೋದು.
ಅದ್ರಲ್ಲಿ CCTV footage.
ಮನೆ ಪಕ್ಕದಲ್ಲಿ vacant land ಇದೆ.
Statement, my lord.
It will go on eyewitness statement.
ಅಲ್ಲ ಅದರಲ್ಲಿ they have not in the scene of occurrence. The petitioner number 1 is
plea of alibi ಅಲ್ಲೇನೆ. Yes.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಸ್ವಾಮಿ ಅಂದ್ರೆ ಅವರು petitioner number 1 is a maid servant and petitioner number 2 is also working in hospital. At the time of incident, they were not in the scene of occurrence.
No, maid servant or paid servant. I am not done that. Yes.
But I take instruction and
to withdraw the petition.
no, but,
Kali land and CCTV ಕೊಡಿ ಅಂತ ಇದು ಒಂದೇ rules to drag the proceedings.
no, my lord, the CCTV footage ಇದೆ. ಅವ್ರ ಮನೆ
ಇಲ್ಲ, it is not there, my lordship. I have taken instruction. It's a
ಅಲ್ಲ
vacant land.
ಅವ್ರ ಆ scene of occurrence ಅಲ್ಲಿ ಇಲ್ಲ ಅಂತ ಇಲ್ಲಿ ತೋರಿಸಕ್ಕೆ ಬೇರೆ ಕಡೆ
Scene of occurrence ಇಲ್ಲ ಅಂತ ತೋರ್ಸಕ್ಕೆ ಬೇರೆ ಮೆಥಡ್ ಇದ್ರೆ ಮಾಡಿ.
Even if Panchanama
In a vacant land, if there is no CCTV footage, where will I direct?
accident ಆಗಿದ್ದ ಜಾಗದಲ್ಲಿ ಇಲ್ಲ ಸ್ವಾಮಿ. ಬಟ್ ಇವರು ಆ ಟೈಮಲ್ಲಿ ಇರ್ಲಿಲ್ಲ ಅನ್ನೋದಕ್ಕೆ ನಮ್ಮ ಹತ್ರ
ನಿಮ್ಮ ಹತ್ರ ಇದೆಯಾ?
ಅಲ್ಲ ಅವರು ಮನೇಲಿ ಕೆಲಸ ಮಾಡೋ CCTV footage ಆ ದಿನದಲ್ಲಿ ಅವರು
ಅದು ಎಲ್ಲಿದೆ? ನಿಮ್ಮ ಹತ್ರ ಇದ್ರೆ ಕೊಡಿ. I'll ask them to produce it there.
petition number 2 working in a hospital ಅಲ್ಲಿ ಅವ್ರದ್ದು ಏನಾಗುತ್ತೆ ಅವ್ರ ಅಟೆಂಡೆನ್ಸ್ ಡೀಟೇಲ್ಸ್ ಎಲ್ಲ ಇದೆ.
ಅದು ಏನಾದರೂ ಆಗ್ಲಿ, I will direct them to produce it, place it before the court. If you have it, please give it. You are working somewhere else? ಹೌದಾ? ಅಲ್ಲಿ CCTV footage ಇದೆಯಾ?
ಆ ಮನೆಯದ್ದು CCTV footages ಇದೆ ಆ ಟೈಮ್ ಇಂದ.
ಆಯ್ತು. You can procure it. I'll direct them to procure it.
I'll direct them to procure it.
Yes, check which is the house they were asked
House and
investigating.
the hospital where the petition number 2 also
Check
working,
that.
my lord.
The learned counsel for the petitioner is before the court on a strange circumstance. According to the learned counsel,
Submit, my lord.
ಅವರೆಲ್ಲ
ಕೊಡಲ್ಲ ಸ್ವಾಮಿ ಅವರು.
ಅಲ್ಲ, you communicate to the hospital. The petition, ನೀವು ನರ್ಸಾ?
ಅಲ್ಲ ಅವರು ಅಲ್ಲಿ ಹೌಸ್ ಕೀಪಿಂಗ್ ಮಾಡ್ತಾರೆ, ಇನ್ನೊಬ್ರು
In the hospital.
in the hospital. ಅವ್ರ ಅಟೆಂಡೆನ್ಸ್
The petitioners are said to be the housekeeping staff in which hospital?
Lord, Shri Lakshmi Mother and Children's Hospital, KR Pura, Bengaluru.
Sorry, so and so. The issue is that on the date of alleged occurrence of the incident, the petitioners are said to be in the hospital, and the CCTV footage that they were working at that time at the hospital is available. Therefore, the investigating officer shall secure instructions with regard to the availability of CCTV footage of the said date and timestamp and observe and produce at the same before the court along with the
So,
transcript.
my lord, where the petitioner one is working, ಅವ್ರದ್ದು details ಹಾಕಿದೀನಿ ಸ್ವಾಮಿ ಅವ್ರು.
Hello, whatever petitioners, yes. Next.
36.
For the petitioner, my lords. The said incident, my lord, took place, my lords, in the road, my lord, with the presence of a police officials, my lords. The complainant, my lord, is the mother-in-law, my lord. Earlier occasion also, my lord, her daughter, my lord, filed the very same complaint that has been stayed by this honorable court.
My lord, every
ಏನ್
time
problem
madam,
ಮತ್ತೆ?
Notice is not
it's
issued.
a family dispute, my lord. Even he is not paying the maintenance also, my lord.
ಯಾರಿಗೆ?
ನಮ್ಗೆ, I am the,
Mother-ಇಗ?
ಅಂದ್ರೆ mother ಇಲ್ಲ ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಇನ್ನೂ ಒಂದಿದೆ complaint. Habitual, my lord, every time when he goes to the court, my lord, he makes galata and ಮನೆ ಹತ್ರ ಹೋಗೋದು, ಗಲಾಟೆ ಮಾಡೋದು,
Yes, my
ಹೊಡಿಯೋದು.
lord. The
ಇಬ್ರು ಮಕ್ಳಿದ್ದಾರೆ.
grandmother
ಹೆಣ್ಣು
went to
ಮಕ್ಳಿದ್ದಾರೆ.
see the child, my lord. At that time, my lord, they have called the police. This entire incident, my lord, took
Every
place with the
time, my
presence of the
lord.
police, my lord. I have produced the
She's
photographs may be
mother-in-law
seen,
is
my
a
lord.
teacher,
ಈಗ
my
ಯಾರು ಗಲಾಟೆ ಮಾಡ್ತಾ ಇರೋದು ಇಲ್ಲಿ?
Page number
Page
18, 19.
page
may be
20 ಅಲ್ಲಿ ಯಾರು ಮದರ್ ಕಂಪ್ಲೇಂಟ್ ಯಾರು?
complainant first lady, my lord. ಅವರು ಸೀರೆ ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ, ಅಲ್ಲಿ ಹಾಕಿರೋದು ಬೇರೆ.
mother-in-law, my lord.
74 section ಹಾಕಿದ್ದಾರೆ.
Mother-in-law of the
We
first
have filed
petitioner.
ಈ
complaint, my lord,
21
on
ಅಲ್ಲಿ who is the mother-in-law and who is the other-in-law?
first person, my lord.
ಹ.
She is raising hand, my lord. He is
Bhagyamma
the
is the
complainant, my lord.
ಫಸ್ಟ್ ಪೆಟಿಷನ್ ಕಂಪ್ಲೇನೆಂಟ್
ಹೌದು, ಎರಡನೇದು wife of the first petitioner, my lord.
ಇವ್ರಿಗೆ ಹೊಡಿಯಕ್ ಆಗುತ್ತಾ ಮೇಡಮ್ ಯಾರಾದ್ರೂ?
ಅದು ಬೇರೆ ಸೀರೆ ಎಳೆದಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ.
ಅಲ್ಲ,
my lord,
ಮನೆ
kindly see, my
ಓಕೆ
lord.
ಇಲ್ವಲ್ಲ ಅವರು?
ಇಲ್ಲ.
ಅಲ್ಲ ಮನೆ ಹತ್ರ
ಈಸ್ ಇನ್ ದ ನೈಟಿ, ವೇರ್ ಇಸ್ ದಿ ಸೀರೆ ಎಳೆಯೋದು?
My lord, house trespass ಅಂತ ಹೇಳ್ತಾರೆ. This incident took place, my lord, in the road.
ಎಲ್ಲ ಸ್ವಾಮಿ,
ಇನ್ನೇನ್ ಮತ್ತೆ ಇದು?
ನೈಟಿ ಎಲ್ಲ
ಇದು ಬೇರೆ ಏನು ಅಂತ ಹೇಳ್ಬಿಡಿ ಮೇಡಮ್.
ಅಲ್ಲ, ನನ್ಗೆ ಕಾಪೀಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಕಾಪಿ ಕೊಟ್ಟು ಇದು
ನೋಟಿಸ್ ಆಗ್ಲಿಲ್ಲ
ಇದು
ಸ್ವಾಮಿ.
ಸ್ಯಾರಿನಾ ಇದು?
ನೋಟಿಸ್ ಆಗ್ಲಿಲ್ಲ ಸ್ವಾಮಿ.
ಇದು ಸ್ಯಾರಿನಾ?
ವೇಲ್ ಹಾಕೊಂಡಿದ್ರು ಅಂತ ಇದೆ.
ನೋಟಿಸ್
ಅದು ಎಳೆದ ಸೀರೆ ಎಳೆದಿರೋದು ಅಂತ ಅಲಿಗೇಷನ್ ಇರೋದು.
ಹೌದು,
ಎಲ್ಲಿದೆ ಸ್ಯಾರಿ?
74 ಹಾಕಿದೆ.
ಅಲ್ಲ, ಎವ್ರಿ ಟೈಮ್ my lord.
ಎವ್ರಿ ಟೈಮ್ ಇರ್ಲಿ,
ಅಲ್ಲ, ಇದು
ದೇರ್ ಶುಡ್ ಬಿ ಸಮ್
ಇನ್ನೂ
ಮೀನಿಂಗ್.
ಅಲ್ಲ my lord.
ಈಗ ನಿಮ್ ನೋಟಿಸ್ ಮಾಡಿಲ್ವಾ?
ಇಲ್ಲ ಆಗ್ಲಿಲ್ಲ.
ಇವಾಗ ಬಂದ್ರಿ ಮತ್ತೆ ಅಲ್ಲೇ ಇರಿ.
Lord,
ಎಸ್, ದಿ ಪೆಟಿಷನ್ 1 HCGP 2 emergent notice. The complainant alleges that complainant mother-in-law alleges that the son-in-law sanna
ಅಲ್ಲ,
ಇಲ್ಲ son-in-law,
son-in-law and the daughter,
brother and mother.
son-in-law, brother and mother have
ಬ್ರದರ್ ಅಲ್ಲ ಅದು.
ಹೌದು,
ನೀವು
son-in-law,
one ನಿಮಿಷ, son-in-law and others, yes, have attempted to outrage the modesty of her and have pulled her sari. The picture which led to the alleged outraging of the modesty is produced along with the petition. She is not even wearing a sari. Therefore, the complaint is said to have been orchestrated to achieve collateral purposes. Therefore, there shall be an interim order of stay of further investigation qua the petitioner till the next date of hearing. Okalat hakbidi.
My lord, I'll file.
Oh,
And
ಮಾಡಿ.
also it may be connected along with.
Tag
criminal
along with
petition
so and so.
15,
Yes,
18,
next.
my lord.
Please.
The date may be fixed, my lord.
ಬರ್ಲಿ
It's
ಬಿಡಿ, ತೊಂದ್ರೆ ಇಲ್ಲ.
investigation ಎಲ್ಲಾ ಇದ್ರಲ್ಲೂ they files and
ಕರೆಕ್ಟ್, ನೀವು ಹಿಂಗೆಲ್ಲ ಮಾಡಿದ್ರೆ ಮತ್ತೆ ಹಂಗೆ ಆಗದು.
my wife ಕೂಡ she has filed a petition, my lord.
Yes, next.
37.
For the respondent number 2, my lord.
Your lordship, the once 139 may be also taken together.
We'll take it at 139.
No, your
At 139 we'll take. Next.
serial number.
ಅದು ಬರಲ್ಲ. There is a direction by this court to dispose the matter.
ಓ,
So,
ಅದು ಆ ಮ್ಯಾಟರ್ ಅಲ್ವಾ? ಕೊಡಿ
direction
ಕೊಡಿ.
has been passed by this court in the month of January.
ಈಗ ಏನಾಗಿದೆ?
Yes, my learned friend is not allowing the trial court to dispose the matter. And there are 5 witnesses are there.
ಈಗ
Four-
Ramanand,
evidence of 4
Your lordship,
witnesses.
all the witnesses are, all the witnesses have been.
that is my direction, right?
Yes.
Your lordship, all the witnesses have been examined. And even your lordship may kindly turn to page.
Is that my direction to
Your
dispose the
lordship, yes, your lordship.
then what is the problem now?
Your lordship, I cooperated with the direction. I went to day-to-day trial. I completed the trial on 4/4 only I have completed. Then I filed the application. The application.
What
was
applications?
for summoning the witness and.
Which witness?
Your lordship, for that reason, your lordship.
Which witness?
They are involved. They had earlier filed a complaint against the same petitioner, and the complaint was withdrawn. as settled out of court. Your lordship may kindly
To
turn
argue
to.
that matter, not calling of witnesses, there should be some
Your lordship may kindly
no,
turn to
sir,
page
I will not
270.
permit.
Your lordship
Yes.
may kindly turn to page 270.
270.
70. Yes.
ನೀವು ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ತೊಂದರೆ ಕೊಟ್ರೆ ಅದೆಲ್ಲ ಸರಿ
ಇಲ್ಲ ಇಲ್ಲ ನಾನು ಒಂದ್ ದಿವಸನೂ ನಾನು ತಗೊಳ್ಳಿಲ್ಲ, ಒಂದೇ ದಿವಸದಲ್ಲಿ ಮುಗಿಸ್ಬಿಡ್ತೀನಿ ನಾನು. ಐ ವಿಲ್ ಕನ್ಕ್ಲೂಡ್ ಐ ಆಮ್ ರಿಲೈಯಿಂಗ್ ಆನ್ ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಜಡ್ಜ್ಮೆಂಟ್, ಟೂ ಜಡ್ಜ್ಮೆಂಟ್ಸ್ ಆಫ್ ದಿಸ್.
ಒಂದ್ ನಿಮಿಷ ಸರ್. ಅಡಿಷನಲ್ ಸಬ್ಮಿಷನ್ಸ್ ಟು ಅಪ್ಲಿಕೇಶನ್ ಏನಿದೆ ಪೇಜ್ 271 ಏನದು?
270
70
ಹಿಂದೆ
ಏನದು?
ಸೇಮ್ ಕಂಪ್ಲೇಂಟ್, ಸೇಮ್ ಪಿಟಿಷನ್.
ಒಂದ್ ನಿಮಿಷ. ಕೇಸ್ ಅಡ್ವಾನ್ಸ್ ಕಂಪ್ಲೇಂಟ್ ಅಂಡ್ ಪ್ರೆಸೆಂಟ್ ಮೆಮೋ ಫಾರ್ ವಿಡ್ರಾವಲ್ ಅಂಡ್ ಕೇಸ್ ಇಸ್ ಸೆಟಲ್ಡ್ court amicably. Yaar, who is that complainant?
That witness only I have asked to summon.
Which witness is that?
That one person by name Mirlal Kumar Singh, who was the earlier MD of the Noble Software Company. He had filed a private complaint on same petitioners on the same documents. Here the documents are all which are produced as Xerox copies. The original were in this private complaint, and the CW1 has deposed contrary.
I will grant him 1 day's time.
One day sak nan avattu.
Now 3 more applications came to be filed by my learned friend.
Yeah, 3 more.
Three more after.
And the CW1.
You don't press upon those 3 more applications. I'll permit this.
Your lordship.
And CW1.
You say you will not press upon those 3 more applications.
One application, 340 application for perjury.
ಅದೆಲ್ಲ ಆಮೇಲೆ.
ಅದನ್ನ after conclusion it may be considered. 340 application is
340 application la ಆಮೇಲೆ wherever you want.
CW1 for record time 19 times he was cross-examined, which is a Guinness record. 19 times. He is not allowing the trial court to dispute the matter.
ಈಗ ಲಿಮ್ಕಾಗ್ ಹೋಗ್ಲಿ ಬಿಡಿ.
ಅಲ್ಲ ಇದ್ರಲ್ಲಿ ನಾನು ಹೇಳ್ಬೇಕಂದ್ರೆ ಒಂದೇ ದಿವಸದಲ್ಲಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕಂಪ್ಲೀಟ್ ಮಾಡಿದ್ದಾರೆ. ಒಂದ್ ವರ್ಷ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಪ್ರೋಗ್ರೆಸ್ ಮಾಡಿಲ್ಲ.
ಅಲ್ಲೂ ಹಿಂಗೆ ಮಾಡ್ತೀರಾ ಅನ್ಸುತ್ತೆ, ಅದಕ್ಕೆ ಹಿಂಗಾಗಿರೋದು.
ಅಲ್ಲ ಐ ವಿಲ್
ಕರೆಕ್ಟ್ ಆಗಿ ಫ್ಯಾಕ್ಟ್ಸ್ ಹೇಳಿ. ಈಗ ಯಾವ ವಿಟ್ನೆಸ್ ನ ಬೇಕು ನಿಮ್ಗೆ ರೀಕಾಲಿಂಗ್?
ಮುರ್ಲಾಲ್ ಕುಮಾರ್ ಸಿಂಗ್.
ಅಯ್ಯೋ ಅದ್ ಯಾರು ನನಗೆ ಗೊತ್ತಿಲ್ಲ. ವಿಟ್ನೆಸ್ ನಂಬರ್ ಹೇಳಿ ಸರ್.
ದಿ ನ್ಯೂ ವಿಟ್ನೆಸ್ ಹೂ ಇಸ್ ನಾಟ್ ಬಿನ್ ನೇಮ್ಡ್ ಇನ್ ದಿ ಚಾರ್ಜ್ ಶೀಟ್.
ಸರಿ. ಆಮೇಲೆ
ಅದೊಂದೇ ಓನರ್ ಆಫ್ ದಿ ಕಂಪನಿ. ಓನರ್ ಆಫ್ ದಿ ಕಂಪನಿ ಅವರು ಈಸ್ ನಾಟ್ ಎ ವಿಟ್ನೆಸ್ ಟು ದಿ.
So I will record that you are not insisting on any other witnesses to be examined except these two.
CW1 and CW2.
CW1.
Sorry, these two witnesses, Mullal Kumar and.
That's all. On the very day you will finish it.
Yes, sir.
And no further application will be filed.
And regarding only the Xerox copies have been.
ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ. No further application will be filed by you.
Yes, your lordship, there is one more petition. That is 139. There I have summoned the original documents which is the part of charge sheet.
That we will see separately. Now this will close it on that day. You are going to complete it.
Yes, yes.
And prosecution is not relying upon those witnesses. Those are the not relevant to the case, my lord. And this FIR registered in the year 2015. Only 5 witnesses are there.
1 minute.
4 witnesses.
Balkrishna,
Yes,
1 minute. See, if he says the same complainant, same charge on the same allegation is there.
No, it is a reverse application, my lord.
On the same charge idre, if that has been withdrawn on the ground that it has been settled and the second crime is registered, that would become a relevant document.
Yes, only that point.
The only document I am going to.
Only I am relying only on that issue because this was discovered only at the last moment of the.
Kindly see, that is admitted by the PW1. And out of 5 witnesses, evidence of 4 which has already been completed.
I think stay ಮಾಡ್ತೀನಿ ಬಿಡಿ. ಆ ಗ್ರೌಂಡ್
ಎಲ್ಲ ವಿಟ್ನೆಸಸ್ ಆಗೋಗಿದೆ ಈಗ.
ಸ್ಟೇ ಮಾಡಿ ಇನ್ನೊಂದು 6 ತಿಂಗಳು ಬಿಟ್ಟು ತಗೊಂಡ್ರೆ ಆಯ್ತು.
ಅಲ್ಲ ಎಲ್ಲ ವಿಟ್ನೆಸಸ್ ಆಗೋಗಿದೆ. ಐ ವಿಲ್ ನಾಟ್ ಐ ಹ್ಯಾವ್ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನ್ ಆಲ್ ದಿ ವಿಟ್ನೆಸಸ್.
ಅದಕ್ಕೆ ನಾನು that's why I also said I'll reason out and state, not a problem at all why it is necessary. The petitioner is before the court calling in question
139 connected matters.
The calling in question the rejection of an application filed under section 348 of the BNSS, the 311 of the earlier regime CRPC. The petitioner is before the court. Adele nan order ಇದೆ page. The petitioner was before the court 284. So
281.
This court directed conclusion of the proceedings within an outer limit of 4 months.
6 months.
Outer limit of 6 months. The petitioner has filed applications or after applications seeking on one pretext or the other is the allegation of the counsel Balakrishna MR. The learned counsel for the petitioner at this juncture would restrict his claim only to an application filed seeking summoning of two witnesses, which rejection of which is impugned in the subject petition. The reason so rendered by the reason for filing of the application is that the very complainant had registered a complaint which is closed before the concerned court and is withdrawn pursuant to a settlement arrived at between the parties. Therefore, summoning of those two witnesses would become imperative only to demonstrate that this is a repetition of the earlier proceeding which had stood closed on settlement arrived at between the parties. The learned counsel, in the light of the said circumstance, the concerned court ought to have permitted fixing a particular day for examination of both the witnesses. Therefore, in that light, I deem it, despite the vehement opposition of the learned counsel Balakrishna, I deem it appropriate to permit examination of those two witnesses. The next date,
13th.
13/8.
The next date is said to be, next date of listing of the matter before the concerned court is said to be 13/8/2026. The petitioner shall examine those witnesses on the said date, and conclude the examination on the said date itself. It is made clear the concerned court shall not adjourn the matter on any ground whatsoever, and further petition of this kind before this court seeking another consideration of another application would not be entertained at the hands of the petitioner. In the light of the said circumstance, the order of dated 27/6/2026 stands quashed. The application so filed, the subject application stands allowed with the aforesaid observations. In the event the petitioner would not conclude the examination or cross-examination as the case would be on the said date, the concerned court shall proceed to pass necessary orders in accordance with.
Your Lordship, in the event if the witness also does not turn up, I may be permitted to, if the witness does not come on that day.
You have to see to that witness comes on that. Yes, next.
139 also be.
Same order.
Documents,
Right.
other
Yes.
only because copies are being marked.
Those documents are.
I
not
139
relevant.
separate consider ಮಾಡಬಹುದು. Yes, next.
It may be adjourned.
ಅದರಲ್ಲಿ ಇದೆ,
We'll
not to-
see.
not to
ಅದ್ರಲ್ಲಿ
pronounce
stay
the-
ಇದೆಯಾ?
Not to
ಇಲ್ಲ,
pronounce the
stay
judgment.
ಕೇಳಿಲ್ಲ ನಾನು.
Not to?
Pronounce the judgment.
Wait.
Yes.
ಇರ್ಲಿ.
Same connected matter.
ಇದ್ರಲ್ಲಿ ಅದ್ ಬರ್ದು ಅದ್ರಲ್ಲಿ ಅದ್ ಬರೆಯಕ್ಕಾಗಲ್ಲ, ಅದನ್ನು ಕ್ಲೋಸ್ ಮಾಡೋಣ. Yes. Next.
38.
Here for petitioners. Bail matter, my lord, MPML special court.
ಇದೆಯಾ ಇವತ್ತು ಯಾಕೆ ಬಂತು?
He is in custody from 48 days.
ಎಲ್ಲಿ SPP?
Objection has been already filed.
Pass over.
Please.
Next.
39.
Eleven volumes of charge sheet.
And in 1 minute, he would say, I have perused and taken cognizance. Before I take your Lordship to certain important legal issues which arise from a Lord's kind consideration.
Arising out of a JDA?
JDA and arbitration ಇದೆ, NCLT ಇದೆ, 3 former learned judges of this court are appointed as arbitrators. He doesn't get any relief.
Where is the order of taking cognizance?
Yes, my lord, may I just request your Lordship to kindly straight away turn to page 58.
58.
The latest judgment of the Supreme Court is in the Jharkhand
Cognizance
case.
is take perusta.
Saldo. Number 1. Number 2, my lord, ಇದರಲ್ಲಿ he would take cognizance under the IPC, for offense under the IPC. The order of cognizance is on 11/6/2026. Your Lordship may kindly recall to your Lordship's memory, I had the occasion to make submissions, my lord, on this while placing reliance on the full bench judgment of the Allahabad High Court as well as a coordinate bench, Justice Natarajan. Now, subsequently, my lord, the whole controversy has been set at naught by an authoritative pronouncement of the Supreme Court that as on the date of taking of cognizance, when this BNSS has come into force, he has got to take cognizance under BNSS and certainly not under.
Pavinder Singh.
Yes, yes.
Hmm.
That is the latest law on the point.
Hmm.
That is number 2. But number 3, 406 and 420, they do not go together, is the law laid down by the Supreme Court.
Cognizance ತಗೊಂಡಿದಾರಲ್ಲ ಅದಕ್ಕೆ.
406 and 420, ಎರಡಕ್ಕೂ ಮಾಡ್ಲಿಕ್ಕೆ ಬರೋದಿಲ್ಲ. Any number of judgments of the Supreme Court, commencing from Delhi Race Club.
Which is the latest ಅದರಲ್ಲಿ?
Yes, madam. The latest is madam, that is in Arshad Niyaz Khan.
ಅದೇನಾ? the answer ಯಾರಿಗೆ? ಅರ್ಷದ್ ನಿಯಾಸ್ ಖಾನ್ ಯಾವಾಗಿನ?
Madam, this is in 2025.
Old ಆಯ್ತು.
ಅಲ್ಲ ಅಲ್ಲ. Your lordship, wait a minute.
They heard the learned.
And ಜೊತೆಗೆ ಒಂದೇ ಒಂದು ಸೆಂಟೆನ್ಸ್, ಜಾಸ್ತಿ ಹೇಳೋದಿಲ್ಲ. May I just request your lordship to kindly turn to page, my lord, 105. No, I'm sorry, 113. ನಾನು accused 3 to 7 now.
ಅಲ್ಲ, you accused 3 to 7.
3 to 7 now, ಇಲ್ಲಿ petitioners. Now kindly turn to page 113. Only just 1 minute, madam. Paragraph 23. ಯಾರ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್, ಯಾರ ಮೇಲೆ ಗ್ರೀವೆನ್ಸ್? That the fact that the loan was not utilized for the agreed upon construction in defiance of the loan agreement indicates that accused number 2 aimed to siphon off the money by mortgaging the complainant's property. This has been a systematic deception by accused number 2 since the beginning. Therefore, he has committed an offense. Para 24. That once a portion of the complainant's property was mortgaged by accused number 2 to secure the loan, the borrowing money took in, etc., the nature of property as defined under section 405. This property was entrusted to accused number 2 by the complainant for the explicit purpose. Number 20, para 25. When the borrowed funds were diverted for the purpose of other than the agreed upon the project, it constitutes a breach of trust. Our ಮೇಲ್ ಮಾಡೋದು ನಾವು ಮಾಡಿದ್ದೇನು ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಂತ 2 ಮೇಲೆ ಎಲ್ಲಾನು. And the arbitration proceedings are as against 2. NCLT proceedings as against 2.
We'll see. You have anything to say? Heard the learned senior counsel C.V. Nagesh and Dhyan Chinnappa appearing for the petitioners in the case at hand. The order, apart from the merit of the matter, which should be considered on the appearance of the counsel appearing for the respondent, appearance of the respondent, what merits entertainment of the petition at this juncture is twin illegalities found in the order of taking of cognizance. The order of taking of cognizance reads as follows. ಯಾವುದು ಪೇಜ್ ಹೇಳಿದ್ರಲ್ಲ ಅದು? 358. Page 58 marked portion. A perusal at the order of taking of cognizance would on the face of it depict blatant non-application of mind on the part of the concerned court. The learned senior counsel, Shri C.V. Nagesh, would submit that the cognizance is taken on 11/6/2026.
Yes, madam.
Correct, huh? 11/6/2026. And the cognizance is taken for offences punishable under the earlier regime, the IPC, and not the BNS. The second submission is, as observed herein above, blatant non-application of mind. The third, the third intertwined illegality in the other antamadi. The other intertwined illegality in the case at hand is the cognizance being taken for both the offences under section 406 and 420, which the apex court, if it is for at stage of investigation, I would have permitted. Cognizance. Cognizance is taken for offences punishable under section 406 or 420. It is by now too well settled a principle of law, as is laid down by the apex court in the case of Delhi Race Club, so and so.
It is a commercial transaction.
Followed. Adamel
Your lordship has ruled, my lord, in while following.
That is, it's covered by not one.
Yes.
Vijay Kumar Gai, Nitesh Kumar Jay Shah.
The first case and
all that we'll see. Amal man.
Please.
Delhi Race Club ಲೇಟೆಸ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಡಿ.
ಕೇಸ್ ಕೊಡ್ತಾ ಇದೆ.
ಡೆಲ್ಲಿ ರೇಸ್ ಕ್ಲಬ್ ಫಾಲೋ ಆಗಿರೋದು.
ಹೌದು. ಅರ್ಷದ್ ನಿಯಾಸ್ 2025 SEC
ಅದು ಹಳೆ-
online.
that's also old.
2058.
That's also old.
2025.
The latest judgment of the apex court in the case of Saminathan, SAMI. Saminathan versus State of Tamil Nadu rendered on 31st July 2026, reported in 2026 INSC 7226. Therefore, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing. Update.
We lost. Remember it. No, we lost sight of it. Honestly.
ಅದು old. 25 ಆಗೋಯ್ತು. If you
As
see paragraphs, just
Nagathan.
Nagathan ಅವ್ರದ್ದು, if you see the paragraphs from 33 to 40, elaborate discussion about how both cannot go hand in hand. And how commercial transactions are projected to become a crime. I think this is an answer to yours. Swaminathan was, it's not Swami, SAMI.
Swaminath. Deeply.
Yes. 31st July, about last week, I guess.
40.
The only allegation in the FIR that Khata has not been placed in page number 9.
Forgery, sir, bari adu onde alla.
Second complaint lodged by the complainant. The first complaint made in page number 56.
Correct.
But this is a second
Complaint
FIR.
becomes page 60 complaint, FIR in 380 of 2026.
But this is the second complaint lodged by the complaint. The same set fact. This is second complaint.
What happened to the first one?
But the same has been stated by my lordships.
Amate adike.
But this is my lord, based on the
Which is the
application
criminal petition kodi? Number
7641 my lord.
Kodi kodi.
76 I tagged
It's a
in page
case
number
of forgery,
64.
sir.
One submission. I have filed an impleading application.
He is no way connected to the matter.
Who are you?
Why? I am the complainant to the sub-registrar, my lord, stating that my documents were forged.
Will
My lord, I
permit-
bring it to the
This
notice
is
of the
a
sub-registrar.
classic case of forgery, sir. Where is the question of stay? Kodi ile. Yav criminal petition kodi?
7641 of 2026 in page number 64.
Page?
64 my lord. But the only allegation Khata has not been placed. Kindly see the complaint my lord.
My lord,
And the second FIR my lord. Second
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ.
he is not a complainant my lord. The complaint is the sub-registrar herein.
ಸಬ್ ರಿಜಿಸ್ಟರ್ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ಯಾರು?
none.
The complaint by the sub-registrar herein only.
ಕಂಪ್ಲೇಂಟ್ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಕೊಟ್ಟಿದ್ಯಾರು?
But in the FIR only complainant is the sub-registrar.
ಕ್ವಶನ್ ಆನ್ಸರ್ ಹೇಳಿ ಸರ್. ಸಬ್ ರಿಜಿಸ್ಟರ್ ಕೊಟ್ಟಿದ್ಯಾರು?
86/2026 as given by Satish Kumar on Satish
Who
Kumar.
is Satish Kumar?
Yatish Kumar.
Yatish Kumar.
Yatish sir. Who is Yatish Kumar?
He is filed a suit for declaration.
Correct. Yatish Kumar complaint ಮೇಲೆ ಸಬ್ ರಿಜಿಸ್ಟರ್ ಕಂಪ್ಲೇಂಟ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಿದ್ರು ಅಲ್ವಾ? Yatish
That is
Kumar
not
party.
a complainant my lord. That
ಅಯ್ಯೋ,
is the
ಪರವಾಗಿಲ್ಲ
application.
ಸರ್.
That is
I
the
will permit him to come on record. Anything else you have?
This is second complaint by the
No problem, sir.
complainant and
No,
second FIR my lord. Second that is not.
ಆಯ್ತು ನೋಡೋಣ. ಯಾವ್ದಾರು ಒಂದಾರು ಉಳಿಬೇಕಲ್ಲ?
ಅಲ್ಲ ಒಂದು my
ಒಂದ್
lord.
ನಿಮಿಷ ಒಂದು ಸ್ಟೇ ಮಾಡಿಸ್ಕೊಂಡ್ಬಿಟ್ರೆ ಇನ್ನೊಂದು ಒಂದನ್ ಕ್ವಾಶ್ ಮಾಡೋಣ, ಒಂದನ್ ಪರ್ಮಿಟ್ ಮಾಡೋಣ.
My lord,
ನೀವು ಒಂದ್ ನಿಮಿಷ ಸರ್. ಪ್ರೈಮಾ ಫೇಸ್
ಜಡ್ಜ್ಮೆಂಟ್ ತಮ್ಮದು ಒಂದಿದೆ, ಮಲ್ಟಿಪಲ್ FIR ಒಂದಿದೆ.
ಕರೆಕ್ಟ್ ಸರ್. ನೋಡೋಣ ಬೆಲ್ಸಿ.
ಮತ್ತೆ ಇದೊಂದು ಸೆಕೆಂಡ್ ಕಂಪ್ಲೇಂಟ್ is not met same allegation.
ನಂಬರ್ ಕೊಡಿ.
7641 my lord. In page
Tag
number
this
64.
petition along with so and so. Implementing application ಅಲ್ಲಿ
my lord, it's present on record, my lord. I
ಇದೆಯಾ?
number
ಬಂದಿದೆಯಾ ಅಲ್ಲಿ?
2 of 2026.
Well, they no way consent to this.
I have
They
filed.
the complaint it is 7641 or complainant.
ಆಯ್ತು. ಸೊ ಅಲ್ಲಿ
Complainant ಇದೆ
ಪಾರ್ಟಿ ಇದೀರಾ ಅದರಲ್ಲಿ?
ಅಲ್ಲಿ ಇದೆ, ಇದೆ.
My lord,
Tag this petition along with so and so, list it on Wednesday in fresh matters list.
ಅಲ್ಲಿವರೆಗೂ
ಅಲ್ಲಿವರೆಗೂ
ಸೆಕೆಂಡ್ ಕಂಪ್ಲೇಂಟ್ my lord. The second not to
ಅವತ್
precipitate.
ಅವತ್ ನೋಡುವ ಸರ್.
Not to precipitate.
ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ? ಬೇಲ್ ತಗೊಂಡಿಲ್ವಾ?
Not to precipitate. ಅದು ಫಸ್ಟ್ ಅಲ್ಲಿ stay.
ಇಲ್ಲ,
Not to
ಪೊಲೀಸರ ಹತ್ರ ಹೋಗ್ಬಿಟ್ಟು ಇಲ್ಲಿ ನಾನು ಕೋರ್ಟ್ ಅಲ್ಲಿ ಒಂದು ಕ್ರಿಮಿನಲ್ ಪಿಟಿಷನ್ ಫೈಲ್ ಮಾಡಿದೀನಿ, ಅದು ಡಿಸೈಡ್ ಆಗೋವರೆಗೂ ನೀವು ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡ್ಬಿಡಿ
ಅಲ್ಲ,
ಅಂತ
outcome you know
ರಿಕ್ವೆಸ್ಟ್
that.
ಮಾಡಿದ್ದಾರೆ.
No, we are
He
not
knows
stating-
everything because he is the complainant.
We are not stating anything my lord. The ಪೊಲೀಸರು ಹೋದ್ರೆ ಅವ್ರು ನಮ್ಮನ್ನ ಅರೆಸ್ಟ್ ಮಾಡ್ತಾರೆ. But until the next date.
My lord, he has
Not to
also given
precipitate
a
any
statement
matter.
that
Not to
ನಮ್ಮ
precipitate.
Precipitate ಇಲ್ಲ sir.
But stay at least.
List the matter on Wednesday so and so. No coercive steps will be taken against the petitioner. It would not mean that the petitioner would not cooperate for investigation.
Great.
Wednesday will close it.
yes my lord, I'll file a detailed objection also. my
ಅಷ್ಟ್ರಲ್ಲಿ
lord.
ಹಾಕ್ಬೇಕು ಹಾಕೊಂಗಿದೆ.
ಹಾಕ್ತೀನಿ, ರೆಡಿ ಇದೆ ಆಲ್ರೆಡಿ my lord. In that I will file. My lord,
File.
yes, I will.
Prima facie I feel it is forgery. We'll see.
Yes my lord. ಇದರಲ್ಲಿ my lord ಎರಡು GPAಗಳಿದೆ. ಒಂದು GPA ಸೇಲ್ ಡೀಡ್ ರಿಜಿಸ್ಟರ್ ಮಾಡಕ್ ಕೊಡ್ತಾರೆ, ಇನ್ನೊಂದು GPA ಇವಾಗ OS ಅಲ್ಲಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
Civil suit
Two
already
different,
filed. Until
two
unless the
different
civil
GPAs,
suit
my
has to
lord.
be
Both
decided.
GPAs are, both GPAs are fraud. Never GPA. we
ಅಲ್ಲ
grant
ಅವರೇ
anybody,
ಕೇಸ್
my lord.
ಹಾಕಿದ್ದಾರೆ ಸಿವಿಲ್ ಸೂಟ್. ಸಿವಿಲ್ ಸೂಟ್ ಇಸ್ ಪೆಂಡಿಂಗ್.
Civil suit is for.
We'll see.
ಸಬ್ಸಿಕ್ವೆಂಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಮೇಲೆ
Wednesday.
ರಹೀಮ್ ವರ್ಸಸ್ ಯುಪಿ ಉತ್ತರ ಪ್ರದೇಶ್.
ಎಲ್ಲ ಕೇಸಲ್ಲೂ ಆಗಲ್ಲ ಸರ್ ಅದು. ಅದರಲ್ಲಿ that is restricted to certain facts.
Right.
Yes.
41.
My lord, FIR filed under section 3 and 7 of EC Act, my lord. These petitioners are
Essential Commodities Act, my lord.
drivers.
The meantime, yes, next.
42.
Appearing for petitioner. Lord, annexure G, H and J, petitioner had attended the case on a very same day, my lord. The complaint alleged against the petitioner on that day, she came and entered the house illegally. Lord, alleged sections.
Trespass,
Yes, my lord.
ಎರಡು ಕೇಸ್ ಯಾಕೆ?
351, ಅದು FIR ಅಲ್ಲಿ ಹಾಕಿದೆ. Within 20 days, they have filed charge sheet, my lord.
ಸರ್ ಯಾವ್ದು ವಿಡ್ರಾ ಮಾಡ್ತೀರಿ?
Earlier, my lord, first one, my lord. I'm sorry. Lord, I may be permitted to file memo for withdrawal.
ಯಾವ್ದು?
My lord, 8354, my lord.
42.1 disposed as withdrawn as the charge sheet is filed and charge sheet is called in question in the companion petition. One HCGP to emergent notice in the meantime. Next.
43.
Lordship, offense under 498A, Lordship, against in-laws. Lordship, all the co-accused already grant stay by this honorable
Number,
court, Lordship.
tag.
10274 and 10284 of 26.
ಬರ್ಕೊಡಿ. Yes. ಇದರಲ್ಲಿ ಯಾರ್ಯಾರು ಇದ್ದಾರೆ?
Accused
Husband
number-
ಇಲ್ವಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ. Accused number 3 and accused number 6, your Lordship.
Same tag, same order. Next.
Oblige, your Lordship.
44.
For petition, successive petition notes. The crime stage notes, I filed the petition. In the meantime, note they filed charge sheet notes. Page number 30 is not the alleged post note. This is the notes basis for filing the complaint.
One HCGP to emergent notice.
Notes, sir. Meantime, notes.
354D, yes. Next.
Kindly see notes the post
Oh,
notes.
no, sir, nothing. Next.
45.
For non-transfer of shares, my lord, the 420 has been invoked. And moreover, my lord, the amount has been transferred to accused number 2. Accused number 2, my lord, promises, my lord, transfer of certain shares to complainant. My lord, for the failure of the same, my lord, I and accused number 2, my lord, I have been arraigned as accused. Section 420, 504 and 506 of IPC.
Total amount of 60 lakhs, my lords, received.
ಅದು accused number 1.
Accused number 2 has received, my lord, in his account.
ಅಲ್ಲ, accused transaction between?
Accused number 2 and complainant. And moreover, my lord, there is a delay of
Who are
2
you?
years. My lord, I am accused number 1.
ಅಲ್ಲ, accused number 1 ಗೊತ್ತು. What is the relation, sir?
My lord, they are known to each other, my lord, the accused number 1 and 2. No, accused number 2, my lord, promises, my lord, certain shares.
Whose account the amount is
My
transferred?
lord, accused number 2, your lordship may kindly see, my lord.
2 ಕೋಟಿ ಹಣ ಅವಶ್ಯಕತೆ ಇದೆ. So on.
Page number 26, my lord, he transferred, my lord, rupees 50 lakhs to the account of accused number 2.
The entire amount?
Entire amount, my lord, rupees 50 lakhs, my lord, 2 accounts has been transferred.
The petitioner is accused number 1. The counsel for the petitioner takes this court through the summary of the charge sheet to contend that the entire amount is received by accused number 2. The accused number 1 is only known to accused number 2, and therefore the petitioner has been drawn into the web of proceedings. In the event the complainant would project even the slightest of the amount received by the present petitioner, accused number 1, at a later point in time, the interim order now granted would stand automatically vacated. Therefore, till the appearance of the complainant, there shall be an interim order of stay. 1 HCGP, 2 emergent notice returnable by the 24th, list on 24th. Yes, next.
45.
Adarsh.
Sorry, 46.
46, correct.
46.
My lords, the petitioner,
ಎರಡು ಯಾಕೆ?
my lords, the first one challenging FIR, my lords, in that there was.
ಯಾವ್ದು ವಿಡ್ರಾ ಮಾಡ್ತಾ ಇದ್ದೀರಿ?
In that entry order is there, my lords, in the first petition, my lords.
ಆಯ್ತು, ಈಗ
Pursuant to the entry order, my lord, charge sheet is filed after 1 month, my lords.
ಒಂದು ನಿಮಿಷ.
Your lordship has observed to file the second petition.
Correct. Trespass ತಾನೆ.
Trespass, my lords, between brother.
ಯಾವ್ದು ವಿಡ್ರಾ ಮಾಡಕ್ ಕೊಡಿ ಈಗ. FIR ವಿಡ್ರಾ
First
ಮಾಡಿ.
petition, my lords, 896, my lords.
The learned counsel for the petitioner submits that memo ಹಾಕಿ.
Please.
He would, in terms of the memo withdrawn, in the meantime, in the next petition. Yes, next.
Great.
47.
Yes, sir.
Matter, my lords, where paramour gives a complaint. Wife, my lords, was taken into custody for the offence under 69. The lordship, my lords, enlarged her on bail. My lords, she has been suspended, my lords, from the company because of the impugned crime being registered against her.
Survey ಆಗಿಲ್ವಾ?
ಅಲ್ಲ, notice ಆಗಿಲ್ಲ.
Notice ಆಗ್ಲಿಲ್ವಾ?
Only she was enlarged and bail.
ಅಲ್ಲ, it should be quashed, no doubt, but ಬರ್ಬೇಕಲ್ಲ.
Please, now, my lords,
Complainant
because
you servant.
investigation is not stayed, my lords, because of
I
that.
will state, yes.
Now, my lords, she has been suspended from her company.
ಅದನ್ನ ಹೆಂಗ್ ಮಾಡ್ಲಿ ನಾನು?
That will not come in the way.
Then, yes.
The private company, she works as a legal advisor.
Can't help. How can I direct private companies? I will observe anyway.
Please.
This court on 21/7/2026 had passed the following order. The petitioner was released from prison in terms of the said order. The learned counsel for the petitioner submits that since the investigation is not stayed, the petitioner has lost her employment and therefore would submit that an observation to that effect should be made. The investigation is not stayed. Therefore, it appears that the petitioner has lost the employment. In the light of the order so passed, which encapsulates the whole episode of the role of the petitioner, there shall be an interim order of stay of all investigation in crime number 185 of 2026. It is needless to observe that this would not cause an impediment for continuance of employment of the petitioner. That should be all right.
One more request. The name of the complainant, my lords, is not disclosed in the FIR. Even if I take steps, my lords, it may not be served. Police may have to serve, my lords, to the complainant.
The respondent, ಯಾರನ್ನ ಮಾಡಿದ್ದೀರಾ ಮತ್ತೆ ಇಲ್ಲಿ?
ಅಲ್ಲಿ XX ಅಂತ ತೋರಿಸಿದ್ರು, ABCD ಅಂತ ನಾವು ಹಂಗೆ ತೋರಿಸಿದ್ವಿ. They may have to serve, my lords, to the complainant. They have not disclosed in the
whom,
FIR.
my lords, if it is X.
ಆಯ್ತು, ನಂಬರ್ ಅವ್ರ ಕಂಪ್ಲೇಂಟ್ ಹೆಸರು ಸರ್ವ್ ಹೆಂಗ್ ಮಾಡ್ತಾರ ಅವರು?
Police may have to serve.
The respondent, the de facto complainant be served through the jurisdictional police.
Please.
Yes, list the matter on 25th.
The fresh matters.
25th. Next.
48.
The matters which are listed are not false, wrongly connected. The connected matters which filed by the
46
48
48 ಒಂದೇ ಇರೋದು 48 ಅಲ್ಲಿ ಕನೆಕ್ಟೆಡ್ ಯಾವ್ದಿದೆ?
The pending matter, it's filed by the husband. It
48
challenging the same order.
48 is Kalyan.
Please,
ಏನಾಗಿದೆ ಈಗ?
ಅದು maintainability
ED files
please.
ಎದಕ್ಕಾಗಿದೆ ಮೇಡಮ್? ನೀವೇ ಕೊಟ್ಟಿದ್ದ?
Please, it is wrong.
ಕೊಡ್ಬೇಕಾದ್ರೆ ಕರೆಕ್ಟ್ ಆಗಿ ಕೊಡ್ಬೇಕಲ್ಲ. ಕರೆಕ್ಟ್ ನಂಬರ್ ಕೊಡಿ.
1180.
ಬರ್ತ್ ಕೊಡಿ. Detag the disposed files that are indicated in the cause list and tag the petition along with so and so. What have we challenged now?
The wife, had
criminal appeal alla agide. Then you will have to file revision.
The husband has filed a similar petition.
Kodi, tag along with so and so. Kodi. Correct number kodi. Tag along with so and so. List the matter on 20th. Yes, next.
49.
ಯಾವ್ದು withdraw ಇಲ್ಲ?
4897.
48, 49.
4897 of 2026.
4897, 49.1 withdrawn.
Section 85 of BNS, my lord. This petition is made against the stranger also, my lord. That's accused number 3.
Correct. 2 and 3 we will stay. Yes. To husband, one is husband. 2 and 3. 84. Next.
Okay.
50.
For the petition in this case, so actually the real fact 13,50,000 ಈ ಪೆಟಿಷನ್ ಹ್ಯಾಂಡ್ ಓವರ್ ಮಾಡಿದೆ ಬ್ಯಾಂಕ್ ಲೋನ್ ಅಂತೇಳಿ. ಸೊ ಅದನ್ನ ರಿಕವರಿಗೆ 34 lakhs ಗೆ ಅಂತೇಳಿ ರಿಕವರಿ ಮಾಡ್ಲಿಕ್ಕೆ ಕೊಟ್ಟಿದ್ದಾರೆ.
So ಅದಕ್ಕೆ he has created the story and has filed the complaint. ಅದರಲ್ಲಿ ನೆಲಮಂಗಲ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಕಂಪ್ಲೇಂಟ್ ಅವ್ರಿಗೆ ಜ್ಯೂರಿಸ್ಟಿಕ್ಷನ್ ಕೊಟ್ಕೊಳ್ತಾರೆ. ಅವ್ರು ಅದರಲ್ಲಿ ಇನ್ನು ಏನು ಇನ್ಫಾರ್ಮೇಶನ್ ಏನ್
ಆರ್
ಹೇಳ್ತಾರೆ?
ಕೋಟಿ
ಎಸ್
ಸೆಕ್ಯೂರ್ ಇನ್ಸ್ಟ್ರಕ್ಷನ್ಸ್ ಹೇಳಿದ್ನಲ್ಲ, ಎಲ್ಲಿದೆ ನೋಡಿ. Accept notice secure with regard to the role of the present petitioner by the next tomorrow in the
Otherwise.
fresh matters. ಇವತ್ತು ಕೊಡೋದು ನಾಳೆ ಕೊಡೋಣ. Yes. 51.1 ಏನು?
Well, it's all are connected, my lords. With regard to issuance of notice
Yes.
by another agency who is not IO. This is my lord's case where, if your lordship remember, the transfer of investigation agency happens at the level of DGP and not by the court or any judicial order. My lords,
I
now
granted an interim order.
Even
No,
may make one submission, my lord.
I have
51.1, my lord, has
I
to
have
be.
challenged the notice.
Yes.
51.1, my lord, has to be set aside and remanded back to the jurisdiction as per your lordship judgment, my lord.
ಏನದು? Which judgment?
This is Gubbi matter, my lord. Your lordship may recall that various lands have been granted to the people, that your lordship has set aside on the ground that the cognizance is taken without there being.
Oh, this matter. Yes, yes.
Yes, my lord. So
Not appearing in that
51.1 has
matter.
to be set aside, my lord. Your lordship has remanded
51
back.
we will set aside and send it back.
Yes, my lord. With respect to
51 ಆಮೇಲೆ after effect is the other petitions.
Yes, my lord. After effect.
After effect, what happens, my lords? Further
Last time ಕೇಳಿದ್ನಲ್ಲ, CID ಹೆಂಗೆ, where is the
Yes,
order of
in
transfer?
fact, I am ready with a judgment, my lord. I'll place those judgment, my lord. Supreme Court answer these issues, my lord.
ಆಯ್ತು, we'll take it on, take it.
My lords, now, my lords, in that light.
Take it tomorrow. Yes.
My lords, in that light, further investigation may be stayed, my lords,
No,
by
sir,
CID.
tomorrow, yes, sir. Tomorrow.
The 51.1
51.1 covered and disposed. Yes, same order. You are not appearing.
No, my lords.
To restore the dismiss order for non-prosecution.
138.
Plus one, maintenance petition. Suit for maintenance.
The petitioner is before the court seeking the following prayer. The petitioner is the wife of the respondent and the second petitioner, the child born from the wedlock of respondent, petitioner and the respondent. The petitioner institutes proceedings invoking the provisions of the Domestic Violence Act 2005 in Criminal Miscellaneous 916 of 2024. Owing to the continuous absence of the petitioner, the concerned court has dismissed the petition for its non-prosecution. It is this that is called in question in the case at hand. The learned counsel for the petitioner has taken this court through the averments in the petition to demonstrate that the petitioner, who is at that point in time having a 3-year-old child, could not attend the proceedings on a day-to-day basis, and what is sought before the concerned court is shared residence or the maintenance, as the case would be, and the concerned court could not have rejected the petition for its non-prosecution. The submission of the learned counsel for the petition would merit acceptance on the plain perusal. That is averred in the subject petition. The petitioner, therefore, on those circumstances, the order stands recalled. The petition is restored to file in Criminal Miscellaneous 916 of 2024. The concerned court shall now take the proceeding to its logical conclusion. It is needless to observe that the petitioner shall appear and cooperate with the proceedings. Ordered accordingly. Next.
53. Petitioner, my lord. My lord, this is the 125 proceedings, my lord. Maintenance. The marriage itself is dispute, my lord.
ಅದೆಲ್ಲರೂ dispute ಮಾಡ್ತಾರೆ. ಆಮೇಲೆ
My lord, while cross-examining the petitioner before the trial court, my lord.
ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
My lord.
ಮೇಂಟೆನೆನ್ಸ್ ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ?
My lord, maintenance.
ಎಸ್ ಸರ್.
My lord, maintenance ಅದು ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಕೇಳಬೇಕು, my lord.
ಕೇಳ್ಬಿಟ್ಟು.
My lord,
next Monday fresh ಮಾಡಿ.
my lord, it is a 311 application rejected, my lord.
Maintenance ಎಷ್ಟು ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ ಹೇಳಿ. Yes.
Wait for
Next.
54.
Petitioner, the sole accused in the case, charge sheet is filed, committed to the Court of Sessions.
Yes, sir.
Let's the allegation is that for 3 days, where the act of rape was committed over and over again and again.
Rape is not the allegation. Charge sheet ಅಲ್ಲಿ ಏನಿದೆ? 64 ಇದೆ.
ಇದೆ ಇದೆ, ಸ್ಟಾಕಿಂಗ್ ಇದೆ. So everything is 354D ಇದೆ. Everything is there. This is from 23 to 25th of October.
Then caution ಕೇಳ್ತಾ ಇದ್ದೀರಾ ಈಗ?
Stake. I will invite Lordship's attention to one
For statement, let's medical. Let's say corroborate.
I'll make submission.
Yes, sir.
146, page number 146. 146 she has written a message to me on 30th October, which is 5 days after the alleged assault. She writes this message.
Date of the alleged incident ಏನು?
23 to 25th of October.
1 ನಿಮಿಷ. 23/10/25. Correct. 23rd to
25th of October.
3 ದಿನ. Complaint is 6 months later.
6 months, 6 days.
ಆಯ್ತು. ಎಲ್ಲ 6 ಹೇಳಿ.
6 months, 6 days. So the message at page number 146 is sent on 30th October 2025.
I will continue at 2:30.
Yes, ma'am.
Yes.
My lords directed me to.
Serial number 56, my lord.
50?
56. I am withdrawing my petition in view of filing of the charge sheet.
ಯಾವುದು 56.1 ನಾ?
16177 of 20.
Withdrawn.
I am withdrawing. Filing no.
Serial number 43, but I was not there, my lord. Only one submission, my lord. Private complaint, 173(3), my lord. Police are not heard without.
ಅದು ಹೇಳಲೇ ಇಲ್ವಲ್ಲ ಮತ್ತೆ ಯಾರು?
Without, my lord, hearing the police, my lord, they have referred. Private complaint.
We'll see.
Yes. ಅಲ್ಲ ನಾಡಿದ್ದಿಗೆ appearance ಇದೆ. I'm sorry, my
lord.
lord. I could not
43.
appear.
We'll see. Wait. If that is the case, then we'll have to send it back.
Lord, this is covered by my lord's decision in my lord.
ಅದಕ್ಕೆ ಮಧ್ಯಾಹ್ನ ವಾಪಸ್ ಕಳಿಸ್ಬಿಡೋಣ.
Yes, my lord.
ಜಡ್ಜ್ಮೆಂಟ್ ಕೊಟ್ಟಿರಿ.
Lord, may I request ಮಧ್ಯಾಹ್ನ, my lord.
ಏನು ಸ್ಪೆಸಿಫಿಕ್ ಟೈಮ್ ಎಲ್ಲ ಬೇಕಾ? ಇಲ್ಲ ತಾನೆ?
It is my mistake, my lord. I did not appear.
ಬನ್ನಿ. Yes.
Lord, with the leave of court.
If I'm.
Wait. Yes.
Complainant evidence has been discarded and the matter is posted for judgment, my lord.
When?
Next Thursday, my lord.
ಬೆಳಗ್ಗೆ ಏನ್ ಮಾಡ್ತಾ ಇದ್ರಿ?
ಮಧ್ಯಾಹ್ನ ಸಬ್ಮಿಷನ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರಿ.
ಕೊಡಿ. Yes.
Tomorrow.
Friday.
Highly obliged.
My lords, in this plus the date was fixed in the past, but the matter was not posted, and 7 accused the FIR has been quashed. And my lords, I'm covered by the judgment. My lords.
Tomorrow.
Please.
My lords, we moved the memo in the morning. The parties are ready to settle, my lords. It was posted for.
What's the offense?
Section 74 and 75.
All right. It will be posted. Don't worry.
My lord, item number 145, my lord, a second list. I'm seeking adjournment. I'm aware for the respondent number 2 in this case.
Madam, ಯಾರಿಗಾರ adjournment ಬೇಕಾದ್ರೆ you can mention to the court. Tell the court.
Yes, my lord.
Yes.
ಈಗ ಯಾರಾದ್ರೂ ಕೇಳಿದ್ರೆ ಕೊಡಿ ಅಂತ ಹೇಳಿದ್ರು. And 145. 5.
So mention ಮಾಡಿದ್ದೀವಿ.
ಯಾವ್ದು ಮೇಡಮ್ ಡೇಟ್?
ಮಾರ್ಕ್ ಮಾಡ್ಕೊಂಡ್ರಿ. ಮಾರ್ಕ್ ಮಾಡ್ಕೊಳ್ಳೋಕೆ ಅಷ್ಟೇ ನಾನು.
ಹೌದಾ?
ಫಾಲೋ ಔಟ್ ಆದಾಗ ಹೇಳೋದು.
ಮೇಡಮ್
1056. ಹಾ ಸರ್ ಮಾಡಿ. 4 ಗಂಟೆ ಆಗಿದೆ.
ಮ್ಯಾಮ್ 56.1 ಮಾತ್ರ ವಿಚಾರ ಆಗಿದೆ. 56
ಇದೆ ಫಾಲೋ ಔಟ್. ಮೇಡಮ್ ಬೆಳಗ್ಗೆ ಮೆಮೊ ಮೂವ್ ಮಾಡಿದ್ವಿ. ಇವಾಗ ಮೆನ್ಷನ್ ಮಾಡಿದ್ವಿ ಮಧ್ಯಾಹ್ನ 2:30 ಗ. ಪಾರ್ಟೀಸ್ ಬರ್ತಾರೆ. ಬೆಳಗ್ಗೆ ಮೂವ್ ಮಾಡಿ ಕಳ್ಸಿದ್ದೀನಲ್ಲ. ಬಂದಿಲ್ಲ ಅಂತ. ಹೌದಾ?
ಮ್ಯಾಮ್ ಇದು ಮೆಮೊ ಇನ್ನೂ ಬಂದಿಲ್ಲ ಮ್ಯಾಮ್. 1053.
ಏನದು ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಹೋಗಲ್ಲ
ಫ್ರೆಶ್ ಮೇಡಮ್
ಹೋಗಲ್ಲ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್.
ಮಂಡೇ ಬರುತ್ತೆ ಅಂತ ಹೇಳಿ.
ಕಂಪ್ಲೈ ಆಗಿ ಸೀನಿಯರಿಟಿ
ಇನ್ನೊಂದು ಪಿಟಿಷನ್ ಬೆಳಿಗ್ಗೆ ಮೆಮೊ ಫೈಲ್ ಮಾಡಿದ್ದು, ಡೇಟ್ ಅಲರ್ಟ್ ಆಗಿಲ್ಲ, ಡೇಟ್ ಅಲರ್ಟ್ ಆಗಿಲ್ಲ ಯಾವಾಗ ಅಂತ ನೆಕ್ಸ್ಟ್
ಡೇಟ್ ಹಾಕೋಕ್ಕಾಗಿಲ್ಲ ಅಂದ್ರೆ
ಡೇಟ್ ಇಂದ ಮೆನ್ಷನ್ ಆಗಿಲ್ಲ ಬುಕ್ಕಲ್ಲಿ ಏನು.
ಚೆಕ್ ಮಾಡ್ರಿ ಯಾವ್ದು ಆಗಲ್ಲ. ಇನ್ನ ಬರೆಯಕ್ ಟೈಮ್ ಅದು ಸಂಜೆಗಾದ್ರೂ ಪರವಾಗಿಲ್ಲ, ಅದು ಇವತ್ತಾಗುತ್ತೆ. ಕಂಟಿನ್ಯೂನೇ. ಪುಣ್ಯನ ಅಖಿಲ್ ಸರ್ ಎಲ್ಲಿ?
ಸರ್ 230 ಲಿಸ್ಟ್ಗಿಂತ ಮುಂಚೆ ಇದು ಕಂಟಿನ್ಯೂ ಮಾಡ್ತಾರೆ. ಅಂತೆ ನಾನು 230 ತಗೋತಾರೋ ಇಲ್ಲ.
ಇದೊಂದು ಕೊಟ್ಬಿಡ್ತೀರಾ?
ಹಲೋ
ಇದೊಂದು ಕೊಟ್ಬಿಡಿ. ಇದೆರಡು ಬರ್ದ್ಮೇಲೆ ಕೊಟ್ಬಿಟ್ಟು ಡಿಸ್ಪಿಟಿಷನ್ ಬ್ರಾಂಚ್ ಆ ಕಡೆ ಅಂತ. ತಿರ್ಗಾ ಅದೊಂದು ನಾಳೆ ನೋಡೋಣ, ಆಗಿಲ್ಲ ಎಲ್ಲ ಹಾಗೆ ಆಗುತ್ತಲ್ಲ ಆರ್ಡರ್ನ.
ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ 230 ಮತ್ತೆ
ಮುಂಚೆ ನಾನು
ಮೇಡಮ್ ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ತಾನೆ ಮೇಡಮ್?
ଦଉଛନ୍ ଭାଇ ସାବୁତି ଦଉଛୁ ମାନସି ଖବର ಹಲೋ ఎట్లా તારો મોબાઈલ લઈ લે ને નહીં મારા મોબાઈલ થી બધું થાય છે હવે મારા મોબાઈલ થી કશું નહીં તું તારો મોબાઈલ જો હા હા ચાલી જ રહ્યું છે ને
યાર મુસ્તફાને ફોન કરો છો મને તો કંઈક હર્ટ થયું લાગ્યું સેટલમેન્ટની કોર્ટ જજ તો ઊભા થઈને જતા રહ્યા.
hello.
On the submission, my lord,
Yes,
many
madam.
days are given, but the registry has not listed, my lord.
What?
Tomorrow, maybe.
Dates are not given.
It was given, but registry has not listed before your lordship.
Why?
I'm moving another memo, my lord.
ಎಷ್ಟು ಮ್ಯಾಟ್ರ್ ಇದೆ ಮೇಡಮ್ ಇವ್ರದ್ದು? How many cases you have filed?
Um, 5, my lord,
Only
all
5?
connected matters.
All
My
5 you
lord,
want?
child has not even gone to school. She's still at home. And we went to deliver SMS. We were illegally detained, my lord.
All right. We'll take all the 5 in on one day.
My lord, tomorrow, my lord, kindly.
Tomorrow come in the evening. ಅದು ಹಾಕಿ ಮೇಡಮ್ ಎಲ್ಲ ಒಂದೇ ಸರಿ ಹಾಕಿ.
Deeply
And
obliged.
we'll adjourn everything on to a particular day.
No, my lord,
No,
for
after hearing
schooling.
you, after hearing you,
An interim order, maybe.
we'll see. Yes.
Deeply.
Madam, I have only 482. Don't move. Education matters also before me.
That is also connected with the 482.
Education ಯಾರು madam? How can education matters be taken in a 482 bench, madam?
Dealing to my lord.
Then that is why the registry is not posting.
Then it can be.
You want every case to come before this court? Not happening. Yes. Pronouncement.
List number 4, pronouncement of order. Serial number 1.
Finding no merit to interfere, quay the prayer for quashment in crime number 117 of 2024, the challenge is repelled. The petition stands rejected insofar as the challenge is concerned. Interim bail was granted for a period of 2 weeks, subject to certain conditions. The same was extended from time to time. For the aforesaid reasons, I deem it appropriate to make the said interim bail absolute, subject to the condition that the petitioner shall cooperate with the investigation.
Number 2.
ಇದು ನಿಮ್ದೆ ಅಸ್ಮತ್ ಪಾಷಾ ಅವ್ರದ್ದೇ ಅಲ್ವಾ? ಅದು ನಿಮ್ದೆ. Dismissed. Yes.
Number 3.
Dismissed.
Number 4.
Shampoo. Allowed cost.
Five.
I appear for petitioners in this case, madam.
Allowed cost.
Grateful, madam.
Number 6.
The criminal petition is allowed. The order dated 3/5/2025 passed in crime number 26 stands quashed. The B report filed in crime number 26 stands rejected. The Commissioner of Police, competent authority, SPP, the competent authority is directed to entrust the matter to a different investigating officer of a different jurisdictional police to conduct investigation into the matter, monitor the said investigation, and place the report of investigation before the concerned court within 3 months from the date of its entrustment in crime number 26 of 2023. ಇದೆ ಅಬೆಟ್ಮೆಂಟ್ ಸೂಸೈಡ್ ಅಲ್ಲಿ ಬಿ ರಿಪೋರ್ಟ್ ಹಾಕಿದ್ದು. Yes.
7.
Allowed cost.
Obliged.
8.
Petitioner.
One amendment also now has come, my lords. Now, if your lordship permit me.
ಹೇಳ್ಬೇಕಾಗಿತ್ತು ಅದನ್ನ.
ಅಲ್ಲ ಈಗ ಬಂದಿದೆ, ಮೊನ್ನೆ. but it's not been approved by the Rajya Sabha, my lords.
What amendment?
The amendment is, my lord, that 13(3),
Hmm.
earlier it provided, my lord, that it should be only
Could
by
you
the.
not place it
No, no,
before?
it has not been still, my lords. Two
Because
days
the
ago.
matter, apex court is, my matter is pending before the apex court. I had to do this.
2 days ago, my lords, Parliament has passed it, Rajya Sabha has not passed. It's now there's a proposal that it should go before the MFC after 2 years. What they've done is, my lord, up to 2 years, it is the district magistrate, executive magistrate will deal with it. If it's delay of more than 2 years, my lord, now they have proposed that it should be before the JMFC courts. Now the bill has been, my lords.
Then pronounce madadenge.
That I just wanted to bring to my lords because 2 days ago this has been passed by the Parliament, but not by the Rajya Sabha, had not become a law. But there's an amendment.
Defer it to Friday, file it along with the memo.
Please, this is a small. I will file the memo, my lord.
All big memo.
I will, my lords. Not yet become a law.
It's all right.
I
Let
will.
me, for
Yes,
information at least.
Please, I will.
The matter was listed for its pronouncement. The learned senior counsel PP Hegde now seeks to place a memo on record enclosing a copy of certain proceedings which wherein the
Bill number 140 of
where
2026.
so and so bill, wherein it is the opinion that post the filing of the application under the under section 13(3) for wanting the 13(3), after the expiry of 2 years, the matter has to be placed before the JMFC. In that light, the learned senior counsel submits, would want to make certain submissions. List on Friday. Yes.
Would it be? I have some inconvenience on Friday, Monday.
Monday, na?
Monday.
All
Please,
right.
great. The interim
Monday for
order.
further hearing of that case.
Interim order subsisting.
Interim order subsisting will continue. Yes.
Please.
9.
ಏನು ನಿಮ್ದೇನಾ 9?
No, 8 is over.
8 is over. Might is over. Yes.
Number 9.
Biggest.
Serious offense.
Serious.
Very, very serious offense.
Most dangerous.
Huh?
Most dangerous.
All threaten ಮಾಡೋದಂದ್ರೆ ಅದು advocate. Yes. Allowed cost. Yes. Same reasons, the other crime also.
10.
Same.
11.
Eleven is the ECIR challenge.
Yes, my lord.
Zoeb sir is there? Yes.
Yes, my lord.
This court therefore holds without the slightest hesitation that a writ petition invoking Article 226 of the Constitution of India read with 48 of the CRPC is maintainable to examine the legality of an ECIR and every consequential action founded thereon. The preliminary objection raised by the Directorate of Enforcement is accordingly rejected. The writ petition will now be heard on its merit. At 3:30, I'll take it. This will be uploaded in 10 minutes.
Very well. Grateful, my lords.
Next one, yes. A search undertaken under section 17A of the PMLA is not an independent civil exercise. It is in consequence of an ECIR, a continuation of the investigative process, and is a statutory measure adopted to secure the proceeds of crime during the pendency of the investigation into an offense of money laundering. Once viewed in that perspective, the argument that the search retains an exclusively civil character loses all its force. This court therefore holds that the petition under Article 226 of the Constitution of India read with 4 to CRPC, challenging search and seizure proceedings that emanate from an ECIR is perfectly maintainable. The preliminary objection consequently fails. The issue is answered accordingly. Matter would be heard on its merit. This also at 3:30, I will take it.
3:30.
Obliged. My lord, may I make one request, my lord?
Yes,
My
sir.
lord, my lord, today I am on my legs in another matter. My lord, may hear my learned friends. For me, if it can be either tomorrow or another day.
No problem, sir.
I am obliged.
Whenever you want, we'll post it because the councils have already come. I will hear them.
No, of course, my lord,
Yes.
they can be heard. I don't want to inconvenience.
Yes. These orders will be uploaded in 10-15 minutes. Yes.
Please, my lord, deeply obliged.
Which other matter? Zoeb sir.
That also my learned friend wanted to reopen the issue of locusts, so he had to argue. Otherwise, I was ready on the last day to respond.
Correct. He was still now only on hocus pocus. Now he's
Yes,
on
my lord.
locus.
Yes, my lord. Yes, my lord.
Yes.
Obliged.
I'll take everything. Let sir finish in those matters. Zoeb sir will wait for you later. Or you
Please,
want
my
it
lord.
another day? No, the other matter that
The other
locus.
matter also, my learned senior had to argue, my lord. So if he can conclude today, both matters, my lord, can accommodate me on maybe the coming week itself.
All right. Yes.
Obliged.
Yes. I get that up. Those two uploaded.
Matter pertaining to Dharwad bench, pronouncement of order, seal number 1.
Dismissed.
Lord, I was a beneficiary of an interim order, Lord, could it be stayed for a while?
No, sir. After dismissing, how will I, sir?
Making a request.
I'll have it uploaded by the end of the day. So you can challenge it immediately.
Because I was a beneficiary of.
Correct, sir. But whatever, I've reasoned it out. Yes.
Grateful.
But I'm thrown.
Serial number 2 is Harvard.
For the hearing.
Please, my lords.
Karbudi madam. You are here.
Number 2.
Please, lords. I appear for the respondent number 1 minute.
Ah.
Can sir's name may be deleted.
Ah.
Is this sir will be arguing the matter minutes?
All right. Yaru?
Arvind Kamath.
Arvind Kamath sir.
Any date may be fixed. We'll file our written synopsis on a very short compass. We'll file our written.
Dharwadadalva?
Harvard.
I'll take it there only.
Very
List the matter on 7th September. File your
Yes, we'll file
interim order.
interim order to be extended.
7th September. Don't come here. Yes.
This may be extended.
Interim order stands extended to the next date of hearing.
Great. Convisor's name may be deleted.
Register, delete the name of MB Convey and print the name of?
Girish.
Yes, Girish Hulimat.
Please.
7-9.
7, of course, 7-9.
Very good. Great.
Please.
ಕಳಿಸಿದ್ರ ಅದು
List number 2 continued, 54.
ಇಲ್ಲ yes sir.
Yes, sir. So
Serial number
54.
Offense is 64.
69.
Yes sir. Tell
69.
me.
Let's post the alleged offense. They have exchanged messages subsequent to the crime for about 1.5 months. There is no mention of the sexual assault, and the messages that they have exchanged reflects
charge sheet ಆಗಿದೆಯಾ?
charge sheet ಆಗಿದೆ, commit ಕೂಡ ಆಗಿದೆ. There is a complaint that I have lodged before the SSP.
ಅದು ಅವ್ರದ್ದು ಆದ್ಮೇಲೆ
ನಂದು ಫಸ್ಟ್ ಫೈಲ್ ಆಯ್ತು ಸರ್ 15th. This is at
page 49.
Yes, my lords. This is the complaint that I have filed before the SSP, wherein I have reported that the respondent number 2's father and uncle has called me and threatened me. That is on 15th April. 29th April, the subject FIR is registered. Even after 6 months, 6 days, the samples of the respondent number 2 is collected by the doctor. Adu yake anta kedre, it is answered at page number 140. The father of the respondent number 2 is the Assistant Commissioner of Police. This is a counterblast. After 6 months, 6
ನೀವು ನೋಡ್ಕೊಂಡು ರಿಲೇಶನ್ಶಿಪ್ ಮಾಡ್ಕೋಬೇಕಲ್ವಾ?
ಇದು marital relationship started arranged marriage violence. ಆಕೆ ಹೇಳ್ತಾರೆ ಅಂಡರ್ ಫಾಲ್ಸ್ ಪ್ರಿಟೆಕ್ಸ್ಟ್ ದಿ ಪಿಟಿಷನರ್ ಕೇಮ್ ಟು ಬ್ಯಾಂಗ್ಳೂರ್ ಟು ಮೀಟ್ ಮೀ ಅಂತ. The biodata.
You got married?
We never got married.
ಮತ್ತೆ marital?
No. False. It was a arranged marriage proposal.
Live in relationship 498 ಬರುತ್ತೆ.
ಹೌದು.
ಮತ್ತೆ
this ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ, that the allegation against me is that under false pretext I came to Bangalore to meet her and I have committed the sexual offense. False pretext ಅಂತ ಹೇಳ್ತಾರೆ. Page number 140. Rashesh, may kindly see. Page number 140. This is the biodata which was provided to me at the initiation of the matrimonial alliance. Illi, after the name, my lords, date of birth ಅನ್ನೋ ಒಂದು
ಇದೇನಿದು ಬಯೋಡೇಟಾ ಇದ್ದಂಗಿದೆ?
biodata. Fourth line, my lords, date of birth 24th October. It was her birthday. He was here to celebrate birthday. Adana, she has concealed. She has not come out with clean hands.
Both of you knew each other for how long?
Prior to this incident, 2 months, my lords.
Prior to 2 months?
We were not noticed. We were introduced through family, my lords.
Yes, sir.
Let's kindly see the column number 17, my lord's charge sheet.
ಬೇರೆ ಕಾಲಮ್ ನೋಡಿ. ACP daughter.
Yes.
One more submission, last submission. 164 statement was not provided to me in the certified copy that I have obtained, but it was read out loud by the prosecutor during the bail proceedings. Ali Ake, she makes an allegation.
Bail is granted?
It was granted. He was in custody, then he was released. In the 164 statement, she goes on and states 23rd, she was abused. 24th, they go to certain restaurant to have food. 24th, again, the abuse happened. 25th, they again went to a restaurant. This is the narrative. I don't have access to it, but ಆದರೆ prosecutor ಅವರು ನೋಡಿದಾಗ further ಅಲ್ಲಿ, this is what it is.
64 is not produced. I can produce it, my lords. It is not.
ಅವರು ಕೊಡ್ಬೇಕು ಅಂತಿಲ್ವಾ ಕಾನೂನು?
ಅಲ್ಲ, he can apply for certified copy, my lords. He will obtain it.
ಆಯ್ತು ನೋಡಿ.
Medical report, my lords, at page 170.
ಮೆಡಿಕಲ್ ರಿಪೋರ್ಟ್ ಏನು ಸರ್ 6 months ಆದ್ಮೇಲೆ?
The doctor says, my lord, the sexual violence cannot be rolled out.
No, we'll see. Let the complainant come. The petitioner is before the court calling in question proceedings in SC 979 of 2026, registered for offences punishable under so and so. The complainant and the petitioner become acquaintances. The acquaintance grows into physical relationship. The alleged acts of sexual abuse by the petitioner, as alleged in the complaint by the complainant, happens on 3 dates: 23/10/2025, 24/10/2025, and 25/10/2025. It is the allegation in the complaint that on 23/10/2025, the petitioner is said to have abused the complainant physically. And notwithstanding the said abuse, again goes out with the complainant on the next day and is alleged to have got abused for the second time on the second day. Again goes out with the same accused on the third day. The allegation is the third abuse on the third day of their consensual acts. The complaint is not registered immediately. It takes 6 months and 6 days for the complainant to register the complaint alleging the aforesaid offences. The learned counsel for the petitioner takes this court through the communication between the two on WhatsApp to demonstrate that there is no sexual abuse happened at all in the case at hand, as they were consensual acts between the two. The learned counsel would further submit that none of the statements nor the 164 statement of the complainant is even shown to the petitioner, all for the reason that the complainant's father is said to be in the police department. Be that as it may, finding no allegation that would touch upon the ingredients of the offences so alleged, there shall be an interim order of stay of further proceedings qua the petitioner till the next date of hearing, list the matter on 25th in the fresh matters list. 1 HCGP to emergent notice returnable by 25th. Next.
55.
Apologies, Lord. The second petition, I'll withdraw it.
ಯಾವ್ದದು?
First one, I'll withdraw it.
55.1 withdraw ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
No. 55, I'll withdraw it.
10936 disposed as withdrawn.
Lord, this is.
ಕಾರಣ?
Lord, by oversight, I filed 2 petitions.
ನೀವೇ ಓವರ್ಸೈಟ್ ಅಲ್ಲಿ 2 petitions ಅವ್ರೊಂದು ಹಾಕಿದ್ರೆ ನೀವೊಂದು ಹಾಕಿದ್ರ?
No.
ಅದು ನಿಮ್ ಕೊಲೀಗ್.
Lord, this is a case, Lord, only on the confession statement.
Corroborative material ಕೇಳಿದೆ ನಿಮ್ಗೆ ಲಾಸ್ಟ್ ಟೈಮ್. ನಾಳೆಯಿಂದ ಎಲ್ಲ ಸ್ಟೇ ಕೊಡ್ತಾ ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬಿಡ್ತೀನಿ. If corroborative material,
That's the petitioner.
if there is no coordination between all of you and no corroborative material is produced,
The
I'll
allegation,
record that and stay.
the allegations against this petitioner is that Miller, she is the seller of methamphetamine to accused number 1.
ಕರೆಕ್ಟ್, ಅದಕ್ಕೇನ್ ಬೇಕಲ್ಲ, ಎಲ್ಲಿದೆ?
Millers in the charge sheet, Millers.
ಆ ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಬಿಟ್ಟು ಬೇರೆ ಏನೂ ಇಲ್ಲ ಅಂತ ಅದನ್ನ ಹೇಳ್ತಾರೆ, ನೀವು ಅದನ್ನ ಹೇಳಿದ್ರೆ.
That's, there is no, Millers, his name does not find a place in FIR. Millers a Nigerian citizen, Millers.
ಇವ್ರು ನೈಜೀರಿಯನ್?
Yes, yes, ma'am.
ಇದೇ ಆದ್ಮೇಲೆ ಅದೆಟ್ಟು ಅನ್ನು ಏನಾದ್ಮೇಲೆ ಇದಾದ್ಮೇಲೆ ಅದೇ ಬಂದಿರೋದ್ ಪ್ರಾಬ್ಲಮ್.
Apart from this,
But in the.
ಯುವರ್ ನೇಮ್ ಇಸ್ ದಿ ಪ್ರಾಬ್ಲಮ್.
entire
ಎಲ್ಲ
charge
ಆದ್ಮೇಲೆ ಇಲ್ಲಿ
sheet-
ಬಂದಿದ್ದೀರಾ ಈಗ.
In entire charge sheet, not even there is no conversation details, plot or the amount transactions. And even only on the confession statement of co-accused has been implicated.
Millers, apart
ಅದನ್ನೇ
from this, Millers, she is involved in another 3 cases. Apart from
ಅದೆಲ್ಲ
this,
ಕೊಡಿ ಸರ್,
All
ಅದೆಲ್ಲ
three
ಹೇಳ್ಬೇಕು
have-
ತಾನೆ.
same
All
offenses.
4 petitions are filed, Lord. All the
ಎಲ್ಲಿದೆ
cases-
ಎಲ್ಲ?
No, it was not listed. In
Yeah,
all
ಇನ್ನೊಂದು-
cases, only on the confession statement she has been implicated.
ಮಂಜಪ್ಪ ಅಂತ ಯಾವ್ದು ಇದೆ ಇಲ್ಲಿ? ಅದು ಇಂಡಿಯನ್ ಸಿಟಿಸನ್.
Really.
ಹಾ,
It was not listed.
56.2 ಕನೆಕ್ಟ್ ಆಗಿದೆ.
No, no, other 4 cases were registered.
ಎಲ್ಲಿದೆ ನಂಬರ್ಸ್ ಕೊಡಿ ಎಲ್ಲ. ಚಾಲೆಂಜ್ ಮಾಡಿದ್ದೀರಾ ಎಲ್ಲ?
1 or 2 have filed. I'll.
Anyway, list day after tomorrow. If no corroborative material is produced, I'm going to stay everything. Yes.
Fresh
Next.
matters.
Friday, sir.
Please, fresh matters.
Here, appear for the petitioner, your lordship, the petitioner purchased that your lordship.
Purchases your lordship.
No, on 29/9/2025.
Correct ಆಗಿ ಹೇಳಿ ಸರ್.
The petitioner purchased on 29/9/2025 from one Channamma.
ಪೂರ್ತಿ ಹೇಳ್ಬೇಕು.
From
Purchases
Channamma.
your lordship ಅಂದ್ರೆ.
Channamma, your lordship. Then after, the allegation is that your lordship, her brother filed a complaint holding that
your lordship ಬಿಟ್ಬಿಟ್ಟು ಹೇಳಿ ಪರವಾಗಿಲ್ಲ.
is a natural guardian of the said Channamma. Now that your lordship. Yes, sir. He is also filed the suit for cancellation of the sale deed. And also another suit has been filed, your lordship, same by her sister, co-sister state. She is also the same. Now Channamma is a 60 years old, your lordship. She was married. She was only executed the sale deed and collected the sale consideration amount.
ನೀವು ಚೆನ್ನಮ್ಮ ಅಲ್ವಲ್ಲ?
ಅಲ್ಲ,
ನೀಲಮ್ಮ.
I am the purchaser of the from that Channamma.
ಪರ್ಚೇಸರ್ ಆಫ್ ಚೆನ್ನಮ್ಮ.
No,
ನೀವು
purchaser
ಫಸ್ಟ್
from the
ಕರೆಕ್ಟ್ ಆಗಿ
Channamma.
ಹೇಳ್ಬಿಡಿ.
From the
ಯಾರು
Channamma.
ಯಾರನ್ನ ಪರ್ಚೇಸ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
Neelamma was purchased the site.
ಯು ಆರ್ ಪರ್ಚೇಸರ್ ಆಫ್ ಚೆನ್ನಮ್ಮ ಅನ್ಬಿಟ್ರೆ ಹೆಂಗೆ?
29 guntas from Channam. Sale deed is page 85. Wala.
ಆಮೇಲೆ
And also they prefer the suit. Suit is at 114, your lordship. Page number 129 of 25.
ಯಾರು ಹಾಕಿರೋದು ಸೂಟ್?
Suit is also filed by the very complainant.
ಫಾರ್ ವಾಟ್?
The cancellation of suit for cancellation of the sale deed.
ಯು ಆರ್ ದಿ ಪರ್ಚೇಸರ್.
They are the witness, and on connected matter, they are the witness of the.
ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಯಾವ್ದಿದೆ? ಓ ಇದು ಇಬ್ರು ವಿಟ್ನೆಸಸ್.
Witnesses.
4 members. One is the car driver, another one is the.
ಕಾರ್ ಡ್ರೈವರ್ನು ವಿಟ್ನೆಸ್ ಮಾಡಿದ್ದೀರಾ? ಯಾರು ಬೇಕಾದ್ರೆ ಮಾಡ್ಬೋದು ಬಿಟ್ಟು.
Made as a accused. Who took the.
ಕಾರಲ್ಲಿ ಕರ್ಕೊಂಡು ಹೋದವ್ರನ್ನ accused, ಮಾತಾಡಿಸಿದವರು accused.
ಓ, ಊಬರ್ ಓಲಾನಾ?
ಊರಲ್ಲಿ ಯಾರೋ.
ಊರಲ್ಲ, ಸರಿ ಆಯ್ತು. ಇನ್ ದ ಮೇನ್ ಟೈಮ್. ಎಸ್, ಗೊತ್ತಾ ಮೇಡಮ್? ಇವರು ಅಲ್ಲ, ಗೊತ್ತಾ?
Offense 108 Millers, 306. Both Millers decision the petitioner are friends Millers.
Friends
Millers, they were studying architect Millers. Architecture Millers. They created one group Millers. It is name called as Architecture Nasha.
Nasha?
Yes Millers. That is the group name Millers.
ಅದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಆಗಿರೋದು.
Both were staying in one room.
ಆರ್ಕಿಟೆಕ್ಚರ್ ಬಿಟ್ಬಿಟ್ಟು ಬೇರೆ ಎಲ್ಲ ಆಗಿದೆ.
Millers, he committed the suicide Millers because of Millers. He was in.
Over Nasha?
maybe my lords. He was fallen in love with one girl, my lords.
In the group.
Not in group, all are friends, my lords. This group is with respect to my lords, the students, friends, my lords. And this petitioner and accused of the deceased were staying in one room, my lords. The issue with respect to the non-payment of rent, my lords, he forwarded some message, my lord. Petitioner forwarded some message.
What
messages.
message, sir?
Message regarding payment of rent, my lords. Then, my lords, he committed the suicide, my lords, and in page number 126.
ಕೇಳಿದ್ದಕ್ಕೆ suicide.
Yes, my lords. He asked some rent, ನನಗೆ ನಿನ್ನ ರೆಂಟ್ ಕೊಡು, ಆಮೇಲೆ ವಾಷಿಂಗ್ ಮಿಷಿನ್ ಇಬ್ರು ಶೇರ್ ಮಾಡಿ ತಗೊಂಡಿದೀವಿ, ಅದ್ರ ದುಡ್ಡು ವಾಪಸ್ ಕೊಡು ಅಂತ.
Washing machine.
Washing machine. Then, my lords, next day he goes and committed the suicide, my lords. And
For washing machine, somebody will commit suicide.
Yes, that is the case of the prosecution.
Odd,
That is not
sir.
the case of the defense. That is the case of the prosecution. And my lords, initially, my lords, the FIR was registered against 3 persons. Then subsequently, my lords, investigation was conducted. The IO has dropped 2 persons and they have retained me as accused number 1.
ನೀವು admin
Not admin, my lords. Close friend and ಅಷ್ಟೇ.
live-in partner.
Living partner, not.
Yes, sir.
Abusing my lords in front of all the my lords.
Abused in front of?
My lords, the persons my lords who are present and my lords, that made the my lords the petitioner.
Make what?
Abated the deceased.
Abet. ಅದು ಅಬೆಟ್ ಆಗೋಗಿದೆ. ಅಬೆಟ್ ಆಗಿದೆಯಾ ಹೇಳಿ.
Insulting my lords in front of all the persons my lords. Column number 7.
Charge sheet ಆಗಿದೆಯಾ?
Charge sheet
Yes,
is
page 33.
And my lords, previous day, my lords, he sent message to the message in the group saying that, my lords, this is all I am hearing because of you left me. I hate you, Nidhi. I really do.
Left me?
Left me. I hate you, Nidhi. Nidhi is
message ಕಳಿಸಿದ್ರಾ?
Message ಕಳಿಸಿರೋದು. And my lords, the entire story is changed now because my son is committed the suicide because the message received by the accused number, the petitioner.
ಈಗ ಸತ್ತಿರೋದು ಯಾರು ಸರ್?
ಸತ್ತಿರೋದು one Arun Kumar, my lords, is the friend of the petitioner.
Oh, you are the girl who was in love?
Not girl, my lords, I am the friend.
ನೀವು ಅಲ್ಲ?
ನಾನು ಅಲ್ಲ, my lords.
ಮತ್ತೆ ರಿಲೇಷನ್ ಲಿವ್ ಇನ್ ಯಾರ ಜೊತೆ ಇದ್ರಿ?
Live in, my lords, he was with the petitioner.
Involving 2 men now.
2 men. The reason for committing him suicide, my lords, because of the girl, my lords. The prosecution has successfully suppressed the story.
Where is girl is not the accused?
No, girl is not the accused, my lords.
ಇವರಿಬ್ಬರನ್ನೇ ನೀವು ಲಿವ್ ಇನ್ ರಿಲೇಶನ್ಶಿಪ್ ಅಲ್ಲಿ ಇಟ್ರಿ.
And though they changed the story because of I asked the rent and the payment of washing machine, and they have registered the FIR under 108 against 3 persons. Subsequently, they dropped 2 persons.
Allegations are my lords.
ತುಂಬಾ ಗ್ರೇವ್ ಅಲ್ಲ? ಇವ್ರು ಏನ್ ಮಾಡಿದ್ರು ಸರ್? ವಾಷಿಂಗ್ ಮಿಷಿನ್ ಕೇಳಿದ್ರು. ನಿಮ್ ಕಾಲಮ್ 17 ಬಂದು ನೋಡಿ ಸ್ವಲ್ಪ ಏನ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮಾಡಿದೀರಾ ಗೊತ್ತಾಗುತ್ತೆ. ಪೇಜ್ 33 ಏನ್ ಬರ್ದ್ಬಿಟ್ಟಿದೀರಾ ನೋಡಿ.
ಬಾಡಿಗೆ ಹಣ ಕೊಟ್ಟಿಲ್ಲವೆಂದು ವಾಟ್ಸ್ಆಪ್ ನಲ್ಲಿ ಕೆಟ್ಟದಾಗಿ ಮೆಸೇಜ್ ಗಳನ್ನು ಮಾಡಿ
ಮೃತ ಅರುಣ್ ಅವರ ಮನಸ್ಸಿಗೆ ನೋವುಂಟು ಮಾಡಿ
ಎಲ್ಲರ ಮುಂದೆ ಅವಮಾನ ಆಗುವಂತೆ ಮಾತನಾಡಿ
ವಾಟ್ಸ್ಆಪ್ ಅಲ್ಲಿ ಎಲ್ಲರ ಮುಂದೆ ಏನ್ ಬಂತು? ಅದ್ ನಿಮ್ ಗ್ರೂಪ್ ಟೈಟ್ಲೇ ತಪ್ಪು, ಅದಕ್ಕೆ ಆಗಿರೋದು ಇದೆಲ್ಲ.
The messages in the personal number, my lords.
DM
direct messages and not direct messages, my lords. I sent the messages to the another friend, accused number 3. He forwarded it to the deceased. All, my lords, it is a part and parcel of the charge sheet charts, and it is showing, my lords, the forwarded messages.
ನೀವು ಒಬ್ಬರೇ ಅಕ್ಯೂಸ್ಡ್ ಈಗ?
Sole accused, my lords.
Yes. Will not permit you to become solo accused. Kannada solo. Yes. The petitioner, the sole accused remaining in the fray in SC 149 of 2026 is before the court calling in question registration of the calling in question the proceedings registered for offences punishable under section 108 of the BNS stroke 306 of the IPC, the earlier regime. The petitioner and the brother of the deceased, complainant yaro? Son of the complainant. Son of the complainant along with several others were students of architecture. If they had remained students, nothing would have perhaps come about. They form a group, a WhatsApp group by name Architecture Nasha. In the said group, messages are sent between the members of the group. A girl yaradu? A particular lady who was also drawn as an accused earlier, who is now Madlelva. A particular lady who was the reason for a squabble between the son of the petitioner and the complainant is though not made an accused. The reason is discernible from the complaint. It transpires that the said lady and the petitioner were live-in partners for some time. The fight between the two, Idra ilva, live-in irlilva, were friends and ಈಗ ತಾನೇ ಹೇಳಿದ್ರಿ ಒಟ್ಟಿಗೆ ಇದ್ರು ಅಂತ.
ಲವ್ ಮಾಡ್ತಾ ಇದ್ರು ಅಂತ.
Love ಮಾಡ್ತಾರೆ ಸರ್. They were in love for some time. The fight between the two was with regard to payment of rent and the EMI to be paid on the washing machine that they had together purchased. The petitioner is said to have denied that and transmitted certain messages on WhatsApp group. The son of the complainant, finding the messages to be abusive, commits suicide. The acts of the abetment has fallen upon the petitioner. The perusal at the complaint or the summary of the charge sheet would not indicate even an iota of ingredient that is necessary to be present as obtaining under section 45 of the BNS for it to become an offence under section 108 - abetment to suicide. Permitting further proceedings against the petitioner in SC so and so would run foul of the judgment of the apex court in the case of Yadavinder Singh Yadav, 2025 SSC online SC page 2332. Therefore, there shall be an interim order of stay of further proceedings, square the petitioner to the next date of hearing. Yes, next.
For petition, subsequent filing of charge sheet, this present petition.
58, madam.
58-1.
Yav the withdrawal, memo for withdrawal in 58.1 in terms of the memo disposed. Yes, sir.
I'm for petition number 1 to 6 on. Where petition number 1 is the husband, petition number 2 is the father-in-law.
Madam, the petitioners are accused number 1 to 6. Finding no allegations that would touch upon the ingredients of the offences under section 85 of the BNS, qua the other accused 2 to 6, there shall be an interim order of stay. It is made clear no stay is granted qua the accused number 1, the husband, 1 HCGP 2 emergent notice. Next.
59.
My lord, this lordship has stayed the matter, my lord. Other offense, my lord, in fact, my lord.
Not 7.
Not 7.
ಮತ್ತೆ ಇನ್ಯಾವುದು ಬೇರೆ offense?
126, my lord, 126, 352, 115, 324, my lord. My lord, my complaint, my lord, I have, my lord, given a first.
ಅದೊಂದೇ 74, 76 ಬಿಟ್ಬಿಟ್ರಿ.
ಅಲ್ಲ, my lord, see.
ಅದೇನಾರು ಇರ್ಲಿ 74, 76 ಇದೆಯೋ ಇಲ್ವೋ ಇಲ್ಲಿ?
They have alleged, my lord. Kindly see, my lord, I have the messages with received message with regard to 112, my lord.
ಏನಂತ?
ಅಲ್ಲ, that my 134, my lord, my complaint was registered, my lord, in the 1112.
ಏನಿದು ಪ್ರಾಪರ್ಟಿ ಡಿಸ್ಪ್ಯೂಟ್?
Property dispute. They are the neighbors, my lord. ಅದು he has made a galata with the gas agency people. ಅದಕ್ಕೆ ಇವರು ಹೋಗಿದ್ದಕ್ಕೆ ಮಿಡ್ಲಿ he has
gas agency.
Gas person, gas agency person, he came for to deliver the gas to the petitioner's house, my lord. After going back, my lord, the bike of the complainant brother, my lord, kept in front of the lorry, my lord, one Sagar, and he was shouting with him. Then the petitioner was called to the place, my lord, when he requested him to remove the bike, my lord. At that time, galata was happened, my lord. I immediately called the N112. He knows that they will make some galata. 134, my lord, I called they received a message from 112, my lord. Then, my lord, my complaint was registered as an NCR in 5:30, my lord. Their complaint is registered in 9:40 in the night, my lord, as an FIR was registered against the petitioner in the whole house, my lord.
Using in public mallards.
I have produced the photos as well, my lord.
In gas problem, sorry, cylinder problem.
It is not stated in the complaint mallards. Allegations of abusing mallards in by taking.
ಏನು ಡ್ರಾ ಮಾಡಿರೋದು ಅಲಿಗೇಷನ್ ನೋಡಿದ್ರೆ ಪ್ರಾಬ್ಲಮ್ ಸ್ಟ್ರೈಟ್ ಆಫ್ ಹೊರ್ಮೋಸ್ ತರ ಆಗಿದೆ. ಎಸ್ ತೊಗೊಳ್ಳಿ. ಇನ್ ದ ಮೇನ್ ಟೈಮ್ ನೆಕ್ಸ್ಟ್.
60.
Challenging the order passed under section 91 of the CRPC, your lordships, I made an application to play a video.
Why, sir?
Please, Your Lordship.
2016 proceedings ಅಲ್ಲಿ 2026 ಅಲ್ಲಿ ಯಾವ ವಿಡಿಯೋ ಪ್ಲೇ ಮಾಡ್ಬೇಕು ಅನ್ಕೊಂಡ್ರೆ?
What was taken in 2015, CW10 is the investigating officer. Your
ಏನ್
Lordship.
ವಿಡಿಯೋ ಸರ್ ಅದು?
He had stated that we will continue to file criminal complaints against you continuously. In fact, Your Lordship.
ಯಾವಾಗ ಹೇಳಿದ್ರು ಸರ್ ಅದು?
2015 ಅಲ್ಲಿ, and after that he has in total 8 complaints he has filed against us. I have made a list in paragraph number 4, Your Lordships.
ಆ ವಿಡಿಯೋ ಯಾರ ಹತ್ರ ಇದೆ?
It is with the accused, Your Lordships.
Why you did not place it before the court 10 years ಇಂದ?
Evidence started now, Your Lordship. CW10 was being examination.
ಯಾರಿದು ಇನ್ವೆಸ್ಟಿಗೇಟಿಂಗ್ ಆಫೀಸರ್? ಅವರ ಹೆಸರು?
Avinash. One Avinash, Your Lordship. Paragraph number 4, I have stated the.
The learned HCGP secure instructions as to how the then investigating officer 10 years ago had indicated that he would register complaints after complaints against the petitioner, which is said to be shot on the video and which is available with the petitioner. And the apprehension turned out to be true when the complainant, when 8 cases are registered against the petitioner. The instructions be sought and submissions be made by the next date, lest the matter next Wednesday. Further proceedings before the concerned court shall remain stayed till the next date.
Much
Yes, next.
61. I seek for hand delivery. 10th is the.
ನಾಳೆ ಇನ್ನೊಂದು ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್ ಆಗ್ತಾ ಇದೆಯಾ?
10th is the matter, Your Lordship.
ಇರ್ಲಿ ಬಿಡಿ, ಕೊಡಿ. 10th ತುಂಬಾ ಟೈಮ್ ಇದೆ ಬರತ್ ಸಿಗಿ. ಎಲ್ಲದಕ್ಕೂ ಹ್ಯಾಂಡ್ ಡೆಲಿವರಿ ಕೇಳೋದಿಲ್ಲ. ನೀವ್ ಯಾರು? ನೋಟಿಸ್ ಮಾಡಿದ್ದೀನ? ಮತ್ತೆ ಯಾಕೆ ಕೂತ್ಕೊಂತ ಇದ್ದೀರಾ? ಹಿಂದೆ ಇರಿ. ಎಸ್, ಆಮೇಲೆ ವೆಕೇಟಿಂಗ್ ಸ್ಟೇ ಹಾಕೊಳ್ಳಿ. ಸ್ಟೇ ಕೊಟ್ರೆ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸುಮ್ನೆ ಇರಿ. ಎಸ್, ದೇರ್ ಇಸ್ ನೋ ಕಾನ್ಸೆಪ್ಟ್ ಆಫ್ K-8 in 482. ಅದೇನ್ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಇದ್ದಂಗ? ಎಸ್.
Lords, there is a dispute pertaining to a property, and there is a document which is alleged to have been fabricated in relation to survey numbers 122/13 and 123/14. Lords, I am a government official.
You are a government servant?
Yes, I am a government servant.
ಇದೆಲ್ಲ ತಾನೆ?
No.
ಆರೋಗ್ಯ ಸ್ವಾಮಿ ಎಲ್ಲ ತಾನೆ?
No. Lords, now it is like I am a government servant. I am a government servant in this matter. The allegation is there was a first FIR registered in crime number 130 of 2026 alleging that there was a trespass. During the course of investigation, some documents are produced by the accused number 1 Sridhar. Those documents are fabricated. Now he makes a casual statement saying that these documents is fabricated by so and so, including my name. That's all. Where he gets the information? How does he? On no basis.
Come to page 20, paragraph 2.
Please, my lords.
ಅಲ್ಲೇ ನಿಮ್ಗೆ ಹೆಂಗ್ ಮೀಟ್ ಮಾಡಿದ್ರು ಏನು?
I'm here.
You are a clerk in the taluk office.
Yes.
Yes.
Lords, kindly see, my lords, the.
No, let me see the investigation papers.
Very well.
Get the papers. Heard the learned senior counsel D.R. Ravi Shankar appearing for the petitioner. The petitioner is said to be a public servant working as a clerk in which taluk office?
Bangalore South Taluk.
Bangalore South Taluk, and is alleged of offences including the ones of forgery. Therefore, the learned HCGP to secure the investigation papers and place it before the court on the next date, Tuesday, fresh matters.
Lords, let there be no coercive steps till there. I am not saying that. Lords, if your lords were to see page 16, my lords, what is the allegation? It is just the inclusion of my name without there being anything against me.
I thought till Tuesday, till you produce, don't do anything.
Yes.
In model.
62.
Your lords were to pass a specific order. No coercive steps, only till next date of hearing.
SPP.
Not my instruction is because afternoon also he said the investigating officer takes him not to the police station, to Woodlands Hotel, and makes him sit there up to 11 o'clock and then.
Woodlands ellide?
Absolutely, they will not arrest me.
Woodlands ellide?
So that is what they have done.
To my place, they take to the nearest hotel.
They will not. No, don't go to drink coffee with them. Wait. Yes. Henry, hotel?
ಅವ್ರದೆಲ್ಲ ಅಲ್ಲ ನಡೆಯೋದು ಇವಾಗ ಹೆಚ್ಚಿಗೆ ವ್ಯವಹಾರ. ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಏನಿಲ್ಲ,
CCTV ಇರುತ್ತಲ್ಲ.
CCTV ರೂಲ್ ಬಂದ್ಮೇಲೆ ಎಲ್ಲ ಹೋಟ್ಲಿಗೆ, ಅದು ಎಲ್ಲಿ ಅಂದ್ರೆ ಎಲ್ಲಿ CCTV ಇರಲ್ಲ ಆ ಹೋಟ್ಲ್ ಹುಡ್ಕೊಂಡು ಹೋಗ್ತಾರೆ ಈಗೆಲ್ಲ.
The respondent shall not take any coercive steps against the petitioner till the next date of hearing. ಹಿಂಗೆ ಸ್ಟೇಗಳಾಗೋದು ಎಲ್ಲ ಆಗೋದು ಹಿಂಗೇನೆ. ಇಂಟೆಲಿಜೆನ್ಸ್ ಓಕೆ, ಓವರ್ ಇಂಟೆಲಿಜೆನ್ಸ್ ಇದೆ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು.
ಗ್ರೇಟ್ಫುಲ್.
ಏನ್ ವುಡ್ಲ್ಯಾಂಡ್ಸ್ ಚೆನ್ನಾಗಿರುತ್ತಾ? Yes.
62.
My lords, a group of BEMEL employees, my lords, would form an association.
Group of
BEMEL employees.
ML employees.
BEMEL
Nangena
employees.
yes.
BEMEL employees would form an association for the purpose of purchasing a site.
A site.
A site, my lords, a single site.
All
for the
right.
purpose of establishing a trust and a temple. Accordingly, they purchased the said site in the name of the de facto complainant's father in the year 1991, my lords. A trust is established. Simultaneously, the father of the de facto complainant would also execute a deed of self-declaration to state the site was
Now the
purchased.
son is the complainant.
Now, son is a complainant. He, after the change of kata to the name of the trust and the temple,
The main time.
deeply obliged.
63.
Enactor?
NI Act.
NA?
Petition for quashing the compromise order.
NI Act.
Yes.
Hmm.
I have received 3 lakhs rupees from the complainant and repaid with interest 4 lakhs to him, to her only. And,
ಚೆಕ್ ವಾಪಸ್ ಕೊಡ್ಲಿಲ್ವಾ?
ಚೆಕ್ ವಾಪಸ್ ಕೊಟ್ಟಿಲ್ಲ.
ಯಾಕೆ ಇಸ್ಕೊಳ್ಳಿಲ್ಲ ನೀವು?
ಅದು ಇಸ್ಕೊಂಡೆಲ್ಲ ಕೇಳ್ತಾ ಇದೀವಿ, ಕೊಡ್ತಾ ಇಲ್ಲ.
ಕೇಳ್ತಾ ಇದ್ದೀರಾ, ಕೊಡ್ತಾ ಇಲ್ಲ.
ಕೊಡ್ತಾ ಇಲ್ಲ.
ಅದಕ್ಕೆ ನೀವೀಗ ಎಂಟ್ರಿ ಮಾಡಿ ಕೇಳ್ತಾ ಇರ್ತೀರಾ, ನಾ ಕೊಡಲ್ಲ.
ರೆವಿನ್ಯೂ ಎಂಪ್ಲಾಯ್ ಸರ್, ರೆವಿನ್ಯೂ ಎಂಪ್ಲಾಯ್.
ರೆವಿನ್ಯೂ ಎಂಪ್ಲಾಯ್.
Yes.
ಓ, ಇದೆ ರೆವಿನ್ಯೂ ಸೆಕ್ರೆಟರಿ. ಓ,
ದಪ್ತರ್ತಿ ಸೆಕ್ರೆಟರಿ.
ರೆವಿನ್ಯೂ ಸೆಕ್ರೆಟರಿ.
ದಪ್ತರ್ತಿ ರೆವಿನ್ಯೂ ಸೆಕ್ರೆಟರಿ. That means 4th class employee, I think.
ಕ್ಲಾಸ್ 4 ಅಲ್ಲಿ 4th ಕ್ಲಾಸ್ ಅಂತ ಯಾವುದು ಇಲ್ಲ.
Already, without knowledge of the complainant has filed memo, compromise memo for 3 lakhs and if not paying the within 3 months, 6 lakhs may be paid like that without knowledge of the accused.
ಹೆಂಗೆ?
ಗೊತ್ತಿಲ್ಲ.
Oh.
The already that compromise memo also filed, compromise order also is there.
If 4 lakhs you have paid.
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 Last payment also.
Paid, not paid.
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 Last payment also 45,000 paid.
In the meantime. Yes.
64.
Huh? ಅದೇ ಕೊಟ್ಟಿದ್ದು.
Yes.
Yes. 60? Yes, there is.
Lord, provisions of SC Act was invoked. Lord, petitioner and his elder brother, my lord, there was civil disputes were pending before him. The person who worked in this land.
Only that.
Lord, page 40, my lord.
ಒಂದು ನಿಮಿಷ. 126 in the meantime. Next.
Grateful.
See, offense is non-cognizable. Offense is non-cognizable in nature, my lords. 318 subsection 2. IO Millers, instead of approaching magistrate, he has.
3182 is not non-cognizable.
It is a non-cognizable.
Cheating ತಾನೇ ಅದು?
Yes, my lord, cheating. Even earlier regime Millers 417, it is also non-cognizable.
417.
417 IPC, 3182 BNS.
Meantime, yes. 3184 is not non-cognizable.
3184 is.
4 is cognizable.
3184 is cognizable. And my lords, your lordship judgment, my lords, in Ratnakar, lordship is from the.
ಈಗಲೇ ಕ್ವಾಶ್ ಮಾಡೋದು ಬೇಡ, ಬರ್ಲಿ ಅವರು. Yes. 1 HCGB to emergent notice in the meantime. Yes, next.
Appearing for the petitioner, my lords. My lords, crime is of the year 2016, my lords. Till date, my lords, charges have not been framed. Therefore, my lords have sought for expedited.
ಅಲ್ಲ, ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ಯಾ ಅವಾಗ?
Charge sheet 2019, my lords.
The petitioner is before this court seeking the following prayer. The petitioner accused, complainant.
A complainant, my lords.
The petitioner is the complainant who sets the criminal law into motion, and the police conduct investigation and file a charge sheet before the concerned court in CC 686 of 2019. Despite for the offence punishable under section 419 and 420 of the IPC. Despite passage of close to 10 years, the concerned court has not, close to 6 years, 7 years, the concerned court has not framed the charges despite the charge sheet being filed before it and the arguments before charge also getting concluded. Therefore, the petitioner has sought a expeditious disposal of the same. The offences being the ones punishable under section 419 and 420 and the order sheet depicting adjournments being granted by the concerned court without any rhyme or reason. The concerned court shall now endeavour to conclude the proceedings with an outer limit of 6 months from the date of receipt of the copy of the order, if not earlier. Ordered accordingly. Next.
67.
How the Atrocity Act has been used for extraction.
Used, abused?
Lord,
that has been misused.
Misused.
Lord, the hack, Lord, the complaint says, my Lord, she has entered into a lease agreement. Lord,
Same
kindly say-
74 ಅಷ್ಟೇ ಒಂದು added. Meantime, next. Please ನೋಡೋಣ ಆಮೇಲೆ ಬರ್ಲಿ.
Fresh investigation. Petition for re-investigation, my lord.
Reinvestigation ಬೇಕಾ? Why?
The petitioner was lodged a complaint before the police, my lord, against the R6 and R7, my lord, for 307 and other offences, my lord. They registered the case. They have not conduct the investigation on the sidelines, my lord. Then they filed the charge sheet against, they recorded the statements of the witness. After 6 months, my lord, they filed the charge sheet against.
6 months ಅಲ್ಲಿ charge sheet ಹಾಕ್ಬಾರ್ದು ಅಂತಿದೆ.
ಅಲ್ಲ, statements recorded,
Get
the
the
eyewitnesses
instructions.
statements. As
The
well as the
petitioner is
accused
before the court
statements.
seeking further investigation into the matter. The learned
Notice last, Sumar sir
learned HCGP is directed to secure the complete records of investigation and project on the lacunae that is urged by the present petitioner, barged by the petitioner by the next date of hearing, Tuesday, fresh matters. Next date ಏನು ಅಲ್ಲಿ?
ಅಲ್ಲಿ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ, ಸೊ ನಮ್ಮ ಮೇಲೆ ಚಾರ್ಜ್ ಶೀಟ್ ಹಾಕಿದ್ದಾರೆ ಈಗ 304 ಹೇಗೆ ಹಾಕಿದ್ದಾರೆ.
ನಿಮಗೆ ಹಾಕಿದಾರಲ್ಲ, ಇರ್ಲಿ. ಎಸ್, ಟ್ಯೂಸ್ಡೇ. ಎಸ್, ನೆಕ್ಸ್ಟ್.
ನೆಕ್ಸ್ಟ್ ವೀಕ್
ಟ್ಯೂಸ್ಡೇ. ಇದ್ಯಾವುದು ಕನೆಕ್ಟೆಡ್ ಮ್ಯಾಟರ್ ಏನು?
Same set of facts already granted interim stay.
ಇದೆಯಾ?
ಇಲ್ಲ, different crime number. Same set of facts, different time, same police station, already stayed.
ಅಲ್ಲ, ಸ್ಟೇ ಇದೆಯಾ?
ಇದ್ರಲ್ಲಿ ಸ್ಟೇ ಕೊಡ್ಲಿ, ಇನ್ ತಗೊಂಡಿಲ್ಲ, ಈಗ ಬಂದಿದೆ. Same.
ಏನು NDPS?
ಇಲ್ಲ, EC Act ಸ್ವಾಮಿ, essential complaint section 11, private complaint.
1 HCGP 2 emergent notice in the meantime. Next, yes.
ಬಚ್ಚೋಬಿಡಿ.
70.
First respondent, my lord.
This is a case between the mother and the sons, my lords. Non-DV Act. DV
Who are you?
Act.
Oh, that,
14%, my lord.
My lords, here
I
the,
stayed the matter.
no, my lords.
You
Notice
served the
issued.
respondent by hand summons?
I'm for R1, my lord.
Appearing for R1.
My lordship, I placed time to file my objection. ಇದರಲ್ಲಿ ಆರ್ಡರ್ ಸೆಟ್ ಅಸೈಡ್ ಕೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಸೊ ಅದರಿಂದ ದಯವಿಟ್ಟು ನನಗೆ ಒಂದು ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕೋದಕ್ಕೆ.
ಆಯ್ತು, ಹಾಕಿ.
My lords, ಇದ್ರಲ್ಲಿ
Yes. Of objections. List the matter on 17th in the fresh matters list. 17th in the fresh matters list. Till such time further proceedings before the concerned court shall remain stayed.
my lords, I have not asked for the
Then
further
leave it.
proceedings.
17th, yes. Next.
Much obliged.
71.
Please, my lord. Section 34 application under Arbitration Conciliation Act, that is dismissed for non-prosecution.
Special order.
This before Justice Suraj,
Ah.
the special order. Well, on the last occasion, my lords had directed the objections to be filed by the respondent.
I don't have any objections, my lords, but there is a very short question involved, my lords. Lordship, have a look at the dates. Lords, they filed, my lords, a claim, and the claim, my lords, comes to be dismissed on 7/4/2011. Thereafter, my lords, they file an arbitration suit on 25/6/2011. For 14 years, my lords, they don't contest the AS. They don't prosecute the AS. 11/11/2025, the AS, my lords, comes to be dismissed for non-prosecution. 4 months later, my lords, a writ is filed seeking restoration of that dismissal. Now, my lords, the legal issue here is, my lords, whether in a 34 proceeding, the provisions of CPC will apply or not. Now, my lords, your lordship may have a look at 3 sections of the Arbitration Act. It is my submission, my lords, that this provisions of CPC in 34, my lords, is strictly applicable. Your lordship may have a look at 3 sections, my lords. The Arbitration Act.
Arbitration Act ಕೊಡಿ madam.
Going on merit, my lord, then I.
What else,
Hello,
sir?
because they were direct to file their objections. I was
And
not.
don't worry about it, sir. You see, you tell me how it is maintainable
Then,
now.
my lord, I'll produce judgments to that effect.
Oh,
also,
please,
because
sir.
what happens
Give
here,
it.
my lord, as far as section 34 is concerned, what my learned friend is saying factually it may not be right because it was transferred for some time, then brought back to this.
ಆಯ್ತು, ಎಲ್ಲ ಹಾಕಿ. Whatever, where is
Now
your,
that 14 years
you
was
cleared
waiting
everything?
Everything, sir.
Then produce judgments, whatever you want.
Lords, there are no judgments, Lords.
Let him produce.
Lords,
He
let
says
him produce
yes.
whatever, no,
As
let him
far
produce
as-
whatever he wants, Lords, but Lordship may see three sections. It clearly says CPC, Lords, is applicable to proceedings under 34. There can't be a judgment, Lords, to say CPC is not applicable to 34.
Let him produce. He
Allah
wants to
Kodangidre
produce.
That is not my submission at all. I am only saying, my lord, initially, section 34 applications, my lord, were categorized as suits, arbitration suits. Thereafter, my lord, it became arbitration petitions because this is an application, not a suit. Here, my lord, this is being treated like a suit and then it was dismissed for non-prosecution. Why it was dismissed for non-prosecution? Because we're trying to settle the matter. I was also waiting for, my lord, confirmation by the Honorable Supreme Court to see whether or not a order could be modified, to what extent. Here, my lord, it was what my claim was for specific performance. I said, see, please execute a JD in my favor. I had paid an advance of about 50 lakhs in 2005. All I'm saying, my lord, we tried to settle the matter out by saying, at least you refund that amount. I don't want the land. Give me the amount back. We were trying to work that out. That, my lord, did not fructify into anything else. So, which is why, my lord, dismissed for non-prosecution, because we were still trying to settle the matter. That is it, my lord. So, which is why, my lord, this is not an appealable order under section 37, because 37 will come only if it is set aside.
You produce whatever you want. Friday, Monday,
Next week sometime, my lord.
Monday.
Monday,
but,
Tuesday.
13th, my lord, may I?
Tuesday,
13th, because it may-
13th, all right.
13th.
13th. No
Please.
problem. Yes.
Publish.
72.
What are these matters now? Yen ಆಗ್ಲಿಲ್ವಾ? Yes, sir. We'll dismiss it then. Right away.
With regard to the 482 petitions, my lord.
Interim order I'll vacate because I had granted it only to, for settlement
No, my lord,
purposes.
that is the
No,
wrong.
no, no, no.
These interim orders were granted a couple of years back, my lord. Only in the ED matter, the interim order is granted this year, my lord. Because there was a stay in the predicate offense. So at that point of time, this ED has.
ED matter ಯಾವ್ದು ಇದ್ರಲ್ಲಿ?
The first 72.
The stay was only for facilitating the settlement.
ED matter, he will vacate that interim order in the ED matter.
My lord, even the ED matter, that is only point.
Nothing, yes.
Any date.
ಇದೆಲ್ಲ ಸ್ಟೇ ತಗೊಂಡ್ಬಿಟ್ಟು ಆಟ ಆಡೋದಾಗಲ್ಲ ಇಲ್ಲಿ.
No, my lord, these stays were granted on a different occasion, in a different.
No, that is in the predicate.
Yes,
We'll
my lord.
vacate it in the ED matter.
It was 11/6/2026 order.
The only point on which the ED petition was filed, my lord, is that when there is in a predicate offense, there was a stay at that point of time. They
That
filed a
law
charge
is
sheet.
no longer good, sir.
Yes, my lord, that I concede to that fact, my lord. So with regard to other petitions, my lord, I have a separate merits on the matter, my lord, because.
Other petition we will hear.
Yes, my lord.
Yes. The ED matter will vacate the interim order.
Yes, my lord.
This court on 11/6/2026.
Otherwise, I may be permitted to withdraw these two petitions, my lord, where the
ED is there.
ED is, my lord.
We'll
Yeah, with
permit
regard to
you.
other matters, I will proceed with the
No problem.
merits.
Learned counsel for the petitioner, ಯಾವ್ಯಾವ್ದು ಆನಂದ್ ಅದು?
My lord,
ED ಇರೋದು ಯಾವ್ದು?
72 and 72.6.
72 and
72.6.
72 and 72.6. ಅಲ್ಲಿ heard so and so ಅಂತ ಹೇಳಿ, the learned counsel Anand would seek to withdraw the petitions to avail of such remedy as is available in law at the appropriate time before the appropriate fora. Reserving such liberty, the petition stands disposed. Insofar as the others are concerned, we'll post for admission on next Wednesday.
72.77.
Don't withdraw somebody else's case.
So 72.
72.7, sorry madam, 72 and 72.7.
I will give the list. I will give the
Yes,
both
yes,
petitions.
no problem. Next.
73.
Till then interim order may be.
Interim orders in the, madam, Mikidral interim orders there, continue. Yes, next.
Lord, 73 appearing for petitioner in this matter, my lord. My lord, PMLA proceedings, my lordship. Default by the builder, my lordship. They have attached my property. No reason has been mentioned in the.
Who are you?
I am the landlord, my lordship. Landlord share has been attached, my lordship. 5 apartments which has been.
Yes.
My
Who
lord,
appears in this?
My lord, it's the same matter.
Same matter.
My lord, same transaction.
Same
she's-
transaction.
Same transaction.
I'll explain, my lordship, what is the fact. My lord, builder herein
Please see, my
receives of.
Same transaction. She's landowner's property has been attached.
That's what.
Those are the developers.
Yes.
Developers.
Yes.
Developer
The developer
defaulted.
has not developed the property. What's the?
My lords,
please,
my
ma'am.
lords, there is a connection to it because during the same period, we have taken it as a value thereof. May kindly see the provisional attachment order. My lords, I file my objections. I take notice.
Fine,
I'll file.
Learned counsel Anuparna, representing the enforcement directorates, accept notice to notice and seeks weeks
Already
time.
they have
10
accepted, my lordship,
My lord,
long
they are
back,
appearing
and they have
before-
accepted.
10
FIR
days,
has been
10 days
filed.
time to file statement of objections.
Yes, sir.
List the matter on 14th,
Meanwhile, my lord.
14th, list the matter on 18th, objections if any by.
My lord, in the meanwhile, my lord, because my lordship kindly see the reasoning, what they have mentioned, my lord.
Parallel.
Because
Yeah.
the crimes of proceeds are not available, not traceable, they
Attach-
wanted to attach my
No,
property.
don't confirm the attachment.
No,
Please, my lord,
they have,
it may be.
They have appearing before the adjudicator.
The adjudicating authority shall not finalize the proceedings without the leave of the court. Next.
Please, ma'am.
74.
I appear for petition. Not seeking, my lord.
Seeking
Your lordships have
transfer
directed
the
them to,
investigation to CID.
in the previous date of hearing, my lord, your lordship directed to secure the investigation papers. Because, my lord, the accused person, my lord, till now, my lord, continues to, my lord, send obscene materials to the.
Even now.
Even now, my lord,
CID
even now.
ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ. What are you doing? The learned HCGP to secure instructions as to why action should not be taken against the investigating officer. List this matter on Tuesday in fresh matters list. ಬರ್ಕೊಳ್ಳಿ ನಾಗೇಶ್ವರಪ್ಪ ಅಂತ ಬರ್ಕೊಳ್ಳಿ HCGP. ಯಾಕಂದ್ರೆ ಮಾರನೇ ದಿನ ಅವ್ರಿಗೆ ಕೊಟ್ಬಿಟ್ಟು ಆಮೇಲೆ ನೀವು ಅಲ್ಲೆಲ್ಲೋ ಇದ್ದ ಕಷ್ಟ ಆಗುತ್ತೆ.
75.
For the petitions. Based on the statement of the co-accused, I have been arraigned as an accused for the NDPS.
Learned HCGP Nageswarappa to secure instructions with regard to the corroborative
already.
material
That has
that is available against the petitioner, as the contention is that he is drawn into the web of proceedings and continued therein only on the voluntary statement of the co-accused. Like a specific notice.
one more aspect. Lay upon judgment of the Honorable Supreme Court.
ಅಯ್ಯೋ ಜಾವೇದ್ ಗೊತ್ತಾಯ್ತು.
ಅಲ್ಲ ಜಾವೇದ್ ಅಲ್ಲ ಸ್ವಾಮಿ ಇನ್ನೊಂದಿದೆ. That is in concern of the compliance of section 42 my lord, that is not followed. Which is
ಅವ್ರಿಗೆ ಮುಂಚೆನೆ ಜಡ್ಮೆಂಟ್ ಕೊಡೋಂಗಿದ್ದು ಕೊಟ್ಬಿಡಿ. ಎಲ್ಲಿಟ್ರಿ?
Judgment he has not given.
ಯಾರಿಗೆ ಕೊಟ್ರಿ ಸರ್?
Junaid ಕೊಟ್ಟಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಜೂನಿಯರ್ಗ?
On the last occasion SPP has appeared. This is coming for 5th time my lord.
ನೆಕ್ಸ್ಟ್ ಟೈಮ್ ಸ್ಟೇ ಕೊಟ್ಬಿಡ್ತೀನಿ ಎಲ್ಲಾದ್ರಲ್ಲೂ.
There's one more aspect my lord. That is serious procedural breach my lord, since so far as section 42 is
We'll hear it if it is so we'll finish it. Yes. Tuesday.
ಚಾರ್ಜ್ ಗಿದೆ ಸ್ವಾಮಿ.
ಯಾವತ್ತಿದೆ?
25th.
ಅಯ್ಯೋ ತುಂಬಾ ಟೈಮ್ ಇದೆ.
Petitioner was working as a PDO, but in a meeting he had brought the wife of the present complainant had quarrel. In that connection, she had filed a complaint, and that complaint before Lokayukta was concluded, and ultimately it was closed by Lokayukta.
17A challenge ಮಾಡಿರೋದು.
ಹೌದು.
So what?
But not at issued. My contention is, if your lordship kindly turn to page 92, the same complaint filed by the wife was closed after proper inquiry.
Was withdrawn.
Closed. Now that your lordship will find on page 92. Lokayukta concluded the case on the basis of the warning given by the officer concerned to the petitioner herein. But again, same.
Heard the learned cynical CH Jadhav ಅಂತ ಹಾಕ್ಬಿಟ್ಟು ಆಮೇಲೆ. Next.
77.
ಏನಿದು?
Attica gold case.
Attica ಎಲ್ಲಿ SPP?
I appear for responding to lordship in 77.123 lordship.
This is for the non-compliance of the lower court.
This one, instead of hearing, you are asked to file a memo. So there are multiple freezing orders and there are multiple judicial orders and also.
Directing freezement of the account?
Yes, Mills. That's right. Henceforth, I'm placing the memo on record, Mills.
All right, serve a copy on him.
Alright.
The learned counsel representing the Axis Bank would place a memo along with documents on record to demonstrate or in justification of the freezing orders that are passed. The same is taken on record, the learned counsel to the petitioner to secure instructions on the memo and make submissions on the next date. List on next Wednesday.
Lords, kindly be taken in fresh matter.
In the
At
Honorable
this point, it
Magistrate
is
Court
getting
also
dragged
matter.
on, my lords.
Produce this memo minutes. In the magistrate court as well.
I don't know, we'll see. Yes, list the matter on Thursday, Wednesday next.
Much obliged, my lord.
The fresh matters list next.
79. Appearing for the petitioners, my lords. My lords, the petitioner herein has been falsely roped into this crime. It's a case of cricket betting, my lords. And he's been issued a police notice under section 35
79 KT Act, my lord.
of the Karnataka Police Act. my
Covered
lords.
Kodi, give me the judgment.
It's already, it's
No, that's
spelled
not on
out, my
that
lords.
cricket betting Vidya Kodi. Page 28 covered, closed. Yes, next.
Wait 2 minutes.
Is that the one?
I have one here, my lords.
I
It's-
thought whatever you have, give it, yes.
Please, my lords.
Adane tagoli madam. Yes, next. Yes, Sunil.
108, abatement to suicide. Wife has committed suicide. Husband was separate. She was suffering from chronic depression. Now the
You are the
complainant-
husband.
I'm the husband. Not sir. I think the complainant is also online. He doesn't want to prosecute the matter also because it was a case of suicide. She was suffering from bipolar disorder and chronic depression. And apart from that,
How long were you married?
because we were married around 8 years because it was her second marriage and my first marriage. And she had a kid from the second, her first marriage who was with us. And because of the alcoholism, it aggravated.
Alcohol?
The alcoholism aggravated the depression in her case. So she did not want it to be institutionalized despite attempts made by the father as well as the husband. That has led to.
All right.
The reports are there along with the.
It's here anyway.
Pradesh, my lords,
Wait,
last
list
there.
the matter on 20th. Further investigation or charge sheet?
Investigation.
Further investigation where the petitioners shall remain state till the next date. All documents illide.
last time.
Yes.
81.
Order of the respondent, my lords.
Invocation of COCA,
Kotpa.
control of organized crime act.
Oh, Coca.
My lords, order of sanctioning. My lords, to prosecute the accused, my lords, is.
Yes, Pepe Barakali, sir.
Yes,
Pass over.
please.
82.
For petitioner. The petitioner is a senior citizen who is a.
Where's your file?
Petitioner is a senior citizen who is taking care of his own son, which is.
Mike.
The petitioner is a senior citizen,
Ah.
who is taking care of his only son.
So?
No, he is injured actually. He's a head offside.
ಆಯ್ತು ಏನ್ ಬೇಕು ಈಗ?
NPW issue ಮಾಡಿದ್ದಾರೆ. ಅದಕ್ಕೆ ಬಂದು
ನೆಕ್ಸ್ಟ್ ಡೇಟ್ ಏನು?
next date is 12th December is
12 ಡಿಸೆಂಬರ್.
December. So NPW
ಯಾಕೆ ಅಪಿಯರ್ ಆಗಿಲ್ಲ?
ಅದೇ ಇಂಪ್ಲಾಂಟ್ ಮಾಡಿದ್ದಾರೆ.
ಹ್ಮ್.
So ಆ ಇಂಪ್ಲಾಂಟ್ ಇಂದ ಅವ್ರಿಂದ
Where have you produced all that?
wounded certificate we have produced.
Wounded ಅಲ್ಲ, wound certificate.
Wound certificate, sorry. Wound certificate we have produced Annexure D.
Hmm.
And current certificate we have produced.
Current
wound certificate.
Oh. Hmm.
Current wound certificate we have produced as Annexure B.
He suffered from serious injury, yes.
It is a compoundable offense.
Correct, but anyway, he's not in a position. Court bidalwala NBW. The sword of NBW hanging on the head of the petitioner shall remain state till the next date. No date, yes.
83.
It's a victim's petition.
case where petitioners are victims of mob violence.
Victims of mob violence.
Yes, yes.
Accused ಗೂ ನೀವೇ ಅಪಿಯರ್ ಎಕ್ಸ್ಟ್ರಾ ತಗೊಂಡಿದ್ದೀರಾ?
ಅಲ್ಲ ಇವರು petitioners ಅಕ್ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಕೌಂಟರ್ ಕೇಸ್ ಕೊಟ್ಟು. That is the other case. That's also listed. ಇದರಲ್ಲಿ last time your lordship that is CLM 113 on.
Tag along with that in the meantime. Next.
Your Lordships, if you may,
That was
ಇದು monitoring investigation ಹಾಕಿರೋದು. This is a victim's petition.
ಆಯ್ತು ಅದು ಟ್ಯಾಗ್ ಮಾಡಿ. What no investigation you want to monitor?
ಅಲ್ಲ ಇದು POCSO Act invoke ಮಾಡಬೇಕಾಗಿತ್ತು, ಮಾಡಿಲ್ಲ. That last letter of hearing, Your Lordships, that directed the HCGP to verify POCSO Act invoke because it is
Which
clear
HCGP
allegation.
of the four? ಗೊತ್ತಿಲ್ಲ.
That's a question.
That's the question that can't be answered. List the matter on Tuesday in the fresh matters list. Learned HCGP Deepthi Alva to secure instructions as to the allegations made in the petition with regard to shoddy investigation. Tuesday.
Yes.
Yes.
Great.
84. For the petitioner, my lord, this is a dispute between husband and wife. The matter is almost
As
settled.
always.
The matter is almost settled, my lord.
Almost andre?
They have proceeded to settle the matter. Kindly
Where is
have
the settlement? Are the parties here?
No, my lord.
They want time, is it? When do you want?
4 weeks.
4 weeks, all right. The learned counsel for the petitioner submits that there is settlement is almost concluding. Therefore, the counsel seeks time to almost 4 weeks. Yes, 4 weeks adjourned.
85.
For the petitioner, 223(1) violation, my lords. There's an interim order operating. I've paid the PF as well, my lords.
Dina dispose madu.
Please, my lords.
Yes. Wednesday, fresh matters.
Please, my lords.
Interim order continues. We'll dispose it on that.
Obliged.
Next Wednesday.
Application 497 and 503 application kept in abeyance. I'm seeking for mandamus to pass order because I had obtained the stay from this.
The petitioner is before this court seeking the following prayer. The stay ಈ court ಅಲ್ಲಿ ಇದೆಯಾ?
Please.
ಮತ್ತೆ ಅಬಯನ್ಸ್ ಹಿಡಿದು ಇನ್ನೇನ್ ಮಾಡ್ತಾರಲ್ಲ?
What had happened?
No, whatever may have happened. Which is that order?
My lords had granted stay. I am the petitioner. I have got the
Granted stay in what, sir?
Stay of crime number, my lords.
ಮತ್ತೆ ಅಲ್ಲಿ how will you
What had
proceed
happened?
to
I
pass
sought the
orders?
interim. What had happened, my lords? When the FIR was registered, police immediately freeze all the bank accounts. I sought the interim order stay along with the, my lords, defreezing,
Defreezement.
please, my lord, defreezing of the bank account.
Learned counsel of the petitioner seeks the following prayer. The learned counsel submits that notwithstanding the pendency of the proceedings by the accused, the concerned court ought to have answered the application under section 497 and 503 of the BNSS and would seek a direction for disposal of the said application. In the light of the prayer being innocuous, I deem it appropriate to direct the concerned court to answer the application in accordance with law and pass necessary orders thereon within an outer limit of 4 weeks from the date of receipt of the copy of the order. Ordered according. Next.
Obliged.
87, there is some settlement talk is going on between Kumar and myself. Next week it may be taken.
Settlement.
Meanwhile, will try to settle it.
The learned counsel appearing for the petition, the respondent would in unison submit the talks of settlement between the parties are afoot. AFOT. Therefore, list the matter on 18th or 24th, 25th.
18th release.
18th, all right, yes. Next.
88.
Writ for mandamus, my lordship. The direction to the
Direction
petitioner.
to what?
The secretary of the Lokayukta, my lordship. The petitioner has filed the complaint before the.
Latif ಎಲ್ಲಿ? May not filed. ಬರ್ಲಿ ಬಿಡಿ, ಏನ್ ತೊಂದ್ರೆ ಇಲ್ಲ. ಏನ್ frivolous complaint ಕೊಟ್ಟಿರ್ತೀರಾ ಒಂದು?
No,
So, you have some acts to grind against the accused, so on complaint before Lokayukta. ಅದಕ್ಕೊಂದು mandamus.
No, my lordship.
We'll dismiss it with cause. You're an RTA activist, huh?
No, my lordship. He is the doctor, my lordship.
We'll see, yes.
Date may be fixed, my lordship.
List next Friday, Akiman.
Fresh matter, my lordship.
Fresh matters, yes.
89.
279-304A. Respondent number 6 is the actual driver.
ನೀವು ಯಾರು?
My lord, I'm the person who's nowhere connected. I'll say how, please, my lord. Now what?
You are accused number 1, sir.
Yes, please, my lord. That is what is more surprising to the petitioner. My lord, I'll narrate the, my lord,
ಅಲ್ಲ,
fact history.
ಯಾರನ್ನಾರು accused, if somebody is drawn as accused, it will surprise the accused,
Yes,
no
please,
doubt
my lord,
about it.
definitely, my lord, I'll complete the narration itself.
Yes.
Now, please, my lord, kindly, my lord, for a moment, my synopsis is concerned. 5/6/22 is the date of accident, my lord. Within 1 month, please, my lord, they file a charge sheet as against the petitioner. My lord, in the charge sheet, please, my lord, they say that, please, my lord, this petitioner, he has obtained, my lord, a station bail is concerned. My lord, in fact, I was not the person who had not been to the station at all.
You're out of station.
ನಾನು ಸ್ಟೇಷನ್ ಬೇಲೆ ತಗೊಂಡಿಲ್ಲ ನಾನು.
ಅಲ್ಲ, were you out of station?
My lord, I was in the station itself, but my lord, the thing is, I have not even went to the station and I have not taken the station bail at all. My lord, what happens, please, my lord, they file a charge sheet within 1 month. My lord, CC, my lord, is registered in there 2022. 2025, my lord, I got a, my lord, NBW warrant from a call from a, my lord, one police called Madhu.
Warrant call.
Warrant call, my lord, stating that there is an NBW hanging against me. Thereafter, please.
You phone ಮಾಡಿ ಹೇಳ್ತೀರಾ ವಾರಂಟ್ ಕಾಲ್ ಇದೆ?
Allah, that is what, please, my lord, where, my lord, I got and I execute the bail is concerned. Therefore, I give a complaint to the SP and also, please, my lord, to the police complaints authority. My lord, my complaint came to be transferred in view of the jurisdiction is concerned. Now, what happens, please, my lord, thereafter, please, my lord, I produces one particular endorsement at annexure H1.
You driver?
Non-driver, respondent number 6 is the actual driver.
You factual driver?
Allah, not factual, Allah, I have been falsely implicated is what my submission would be to overcome the liability is concerned. My lord, kindly peruse annexure H1 page 99.
1 HCGP to emergent notice, there shall be an interim order of stay of further proceedings by the petitioner, making it clear that this interim order will not be used by the petitioner in the event of any claim before the motor vehicle.
Already ಕೊಟ್ಬಿಟ್ಟಿದ್ದಾರೆ.
ಗೊತ್ತಿಲ್ಲವಲ್ಲ.
Allah, I produced the judgment also.
Yes, next.
Compensation ಕೇಳಿದ್ದೀನಿ.
ಅದೇ ತೊಂದ್ರೆ ಆಮೇಲೆ.
Please.
90. For the petition in this matter, my lord, last occasion, the salary certificate of the petitioner is on.
You are the wife?
Husband, my lord. Wife is produced, my lord.
Wife is produced where?
It is in document, in page.
How much are you earning, sir?
12,000 with accommodation and available.
12,000 with accommodation of 75,000?
Accommodation provided by the employer.
The employer, 75,000 worth accommodation. Don't give me all these bottom documents here.
No, my lord, it is 12,000 rupees per month. He is provided.
You are working in Iyengar bakery?
Bakery, my lord. That is bakery. I was working and that is my pleading, my lord. It is in page.
Alla, you are paid salary with food,
Food.
Bakery ಇರೋದೆಲ್ಲ.
Bakery. He is working in a bakery.
Everything in the bakery you are permitted to eat.
No, my lord. This is the food they have provided, my lord. A salary certificate, my lord, it is in page number 61.
How much is she earning?
He is earning 13,000.
1,000 ಜಾಸ್ತಿ.
Yes, per month, my lord.
ನಿಮ್ per day
ನಮ್ಕಿಂತ 1,000 ಜಾಸ್ತಿ. Then, my lord, the trial court has awarded 5,000 rupees, my lord.
For whom?
For child 2,000 and wife 3,000. In the appeal, it has been enhanced to 10,000 rupees, my lord. That is
let the wife come and tell her story. All right. Yes. Emergent notice to the respondent, returnable by 25th. Petitioner is at liberty to serve the respondent by way of hand summons.
In the meanwhile, my lord, their filed an FLW has been issued, my lord.
Correct, sir. ಏನು ಕೊಡದೆ ಹೋದ್ರೆ
ಕೊಟ್ಟಿದ್ದೀನಿ. ಅದು ಆರ್ಡರ್ ಶೀಟ್ ಹಾಕಿ.
ಬೇಕರಿ ಪ್ರಾಡಕ್ಟ್ಸ್ ಆದ್ರೂ ಕೊಡಬೇಕು.
No, my lord, it is in the order sheet we have mentioned. It is we are paying the money.
Next.
For the petitioners, my lords, challenging the issuance of NBW, my lords, at crime stage. Your lordship was pleased to stay the NBW against other accused, my lords.
Put it, tag along with so and so same order.
My lords, there are 2 other petitions, my lords, which has to be tagged.
Put it, sir. Yes.
92.
Great.
ಅಲ್ಲಿಂದ ಹೇಳಿದ್ರೆ ಕೇಳಿಸಲ್ಲ, ಇಲ್ಲಿ ಬನ್ನಿ.
Does it matter pertaining to compoundable offences under the compounding of the offences, my lords?
NBW stay ಮಾಡಿದ್ನಲ್ಲ ಅದ ಇದು.
Please, madam. We needed a short accommodation.
MMDR. ಆಯ್ತು, list them at next Friday. 14th, yes. Next. Interim order continues. Interim order continue ಆಗದ್ ಬೇಡವಾ?
93.
Case is registered under the PMLA Act. After cognizance is taken, we contended that before framing of charges, section 244 and 245 has to be complied with. That has now been rejected. Even this Parvinder Singh blood, Supreme Court has held that 200 to 205 would apply. Similarly, in a case which is registered otherwise than by a police report, 244 and 45 also apply. That is the only limited point.
Yeah, well, heard the learned senior counsel Ashok Harnalli appearing. Who?
Madhu and Ram.
Learned counsel Madhu N. Rao is directed to accept notice for the respondent enforcement directorate. Registry to print the name of so and so is appearing for the respondent. List the matter on Wednesday in the fresh matters list. Yes.
Oblations.
Copy petitioner to copy. You have a copy?
Please, my lords, we have.
Yes. All right.
Oblations.
Yes.
94.
My lords, petitioner is a police sub-inspector and a constable, my lords.
Ibridara?
94.
Ibridara.
Ibridara, my lords. My lords, a road rage which takes place. Petitioner number 1 is assaulted. He takes treatment, has an FIR registered, which ultimately results in a charge sheet. Now, respondent number 2 gave a private complaint, my lords. Cognizance is taken by one court without having pre-cognizance proceedings. It goes to another court. Again, cognizance taken for the second time. 223 not followed, my lords. And then the cognizance which has been taken is challenged now, my lords. So far as my complaint, which has resulted in a charge sheet, they have approached this court. There is a stay. My lords, it is a page.
Page
Next year-
93.
next year J, my lords.
Page 93.
96.
93, sir.
Yes.
93, 96, sir.
93, please.
93. In the meantime, they tag this petition along with so and so. We'll dismiss that and allow this.
Oblige.
State.
95.
Next. Nimda, oh, petition, council, yes.
Grateful.
Yes, sir.
This is a matter of 2016. FIR comes to be filed in 2016, charge sheet in 2018. It's an election offense, Malaz, basically. So,
covered matter.
Malad, here this might not be directly covered, Malad. However, your lordship's judgment on the point is covering it, Malad. Because it's a part of the petition itself.
Page.
Malad, page number 13 onwards, Malad. Page number 13 onwards, each offense is extracted, Malad. Judgments in pertaining to each offense.
Which page is my judgment, sir?
Malad, all of them are your judgments.
Howda? Malad,
page number 13 onwards, Malad. Mohammed Adil, Malad.
You made the petition compilation, is it?
Malad, the offenses are so ludicrous.
There,
Malad.
this is Jokat is covered. That's what I'm asking. Where is that judgment?
It's already extracted.
Madam, ಇದು page 12 ಅಲ್ಲಿ on judgment criminal petition 6797 of 2022 ಅದರಲ್ಲಿ ಏನಿದೆ quote that and close it. Yes.
Oblige, Malad.
96.
For petitioner, Your Honor, and this under section 418 and 82 of Registration Act, it has been filed, Your Honor.
Yes, sir.
And Your Honor, in
Complainant is a sub-registrar.
sub-register, Your Honor, please. As in this, they have been in charge sheet, they have been kindly for page number 147, Your Honor.
SPP, you have to appear in this. Yes. The learned HGP is directed to accept notice. The SPP is directed to appear in the matter Tuesday, fresh matters.
Please, Your Lordship.
97.
For the petitioner, my lord. The petitioner was not arraigned as an accused in the petitioner was not arraigned as an accused in the schedule offense, my lord. Provisional attachment order was issued that was not issued against this particular petitioner, my lord. And adjudicating authority complaint was filed, my lord. I was not named. Then after the expiry of 30 days time, my lord, addendum has been issued and my name is attempted to be included, my lord. Now complaint has been filed. The private complaint under section 4445. Now my name has been shown, my lord.
Prosecution complaint.
Prosecution complaint. So my submission
Private complaint.
Sorry, the prosecution complaint. Sorry. My submission is that, my lord, I was not the party to any of these proceedings. Only in the before the adjudicating authority by way of an addendum, even after the expiry of 30 days, and also in the prosecution complaint. In with respect of other two persons, my lord, already this honorable court has stayed the proceedings.
Court
Yes,
ಮಾಡಿ
my
ಅದನ್ನ.
lord. So and my submission is that, my lord, now the
ಕೊಡಿ ಅದು.
yes, my lord.
Tag along with so and so. Take notice.
I'll take notice.
Same, ಅದ್ರಲ್ಲಿ same order. Learned counsel file vacating stay. Learned Counsel
But
Anupama.
I'll not file vacating stay. Let it come together. I'll file
We'll tag
objections.
along with so and so, file objections.
Yes, my lord.
Tag along with so and so, same order, list the matter on 25th.
My lord, only thing is that now prosecution complaint has been filed and now they will proceed with that matter. Unless this
Adral
is-
stay madilva.
No, at that point of time, the prosecution complaint was not filed, my lord. Now they have filed a prosecution complaint.
My lords.
That has to be deferred, my lord, the
Will file objections. My lords, once it have it on Tuesday, I will argue on that aspect of the matter.
All right,
So file,
yes.
please, my lords.
Don't proceed with that complaint till then.
My lords, I am not aware of the status of that.
Now with that you have become aware.
Please, my lords.
Yes. All right. Watch.
Maintainability matter, Sampreet V.
Yes, sir. Vikram sir.
I'll just make one mention. Serial number 118, my lord. It's a DA matter. Other DA matters, my lord, I'm told are listed on Monday.
Howದು?
This matter may be clubbed.
ಅದನ್ನ ಹಾಕ್ತೀನಿ ತೊಂದ್ರೆ.
Serial number 118.
Serial number 38, bail matter.
ಬೇಲ್ ಮ್ಯಾಟ್ರಾ? ಎಸ್ ಪಿ ಪಿ ಅವರೇ, ಅದು ಬೇಲ್ ಬಗೈರ್ ಹುಕುಂ ಆಯ್ತು ತಗೊಳ್ಳೋಣ. ವೈಟ್. End of the day.
Date given, my please.
We'll hear it today, definitely.
We went through your lordship's orders, my lords.
Yes, sir.
It's so lucid, I must say.
So I think that issue is now steered clear completely.
Absolutely.
That's why I said before you start this, I would have got it uploaded.
Correct. That was very helpful.
Sorry, one request. 230 being spoken to us.
Huh?
230 matter being spoken to us regarding the CC.
ರಾಧಾ ಆಯ್ತು ಒಂದು ನಿಮಿಷ ಕೇಳೋಣ. ವೆಯ್ಟ್ ಮಾಡಿ 7 o'clock ವರೆಗೂ ವೆಯ್ಟ್ ಮಾಡಿ. ವೆಯ್ಟ್ till 7 o'clock. Yes. Yes, sir.
Well, so I'll start with the 1668, first ECIR.
Whichever you want to start,
Well, it's
because you
petition
complete your
1668.
submissions today.
Yes.
The Zoeb sir will answer it on the next day, whatever I fix.
Well, as I've just, your lordships don't require this because it's
Other
still
councils can take a coffee break and come. Yes. Yes.
Well, so Genesis is 2021, when an FIR was registered in Bangalore. And
Now
there's a closure.
you're arguing the defreezing matter.
No, well, it's the first one, ECIR.
CIR challenge, yes.
So there were two closure reports, Bullets. One is in the FIR 47 of 2021 against the CFO and two directors of Gamescraft. And the second was 722, which your lordships have noted in 2024, again a closure report. So by the time they even registered the first ECIR on 11/11/2025, which your lordships have noted, there was actually no predicate offense at all. Not even the instance of some other police station, now we found that something is pending. No, absolutely nothing. So on a clean slate with no predicate offense, how do you even register an ECIR? Well, that's the basic question here. If the genesis itself,
That's why life and blood.
please,
Yes.
so without any soil, without a seed, you can't have a crop. So this is
That's
what
why
has happened.
I've said it is anatomically impossible.
Impossible.
For the crime to continue. Yes.
And there's an umbilical cord, my lords. Once we say proceeds of crime, without
No,
that,
that the Madras High Court had said the umbilical cord will not break even if the predicate offense goes. But Apex Court has reversed it.
reversed. That's right. So the central point here is, my lords, if the first ECIR itself is flawed, legally flawed, then anything that follows from that first ECIR will have to suffer the same fate. This is the broad proposition, my lords, because we can't keep building on an edifice which has no foundation. It is bound to collapse. So, my lords, when they come to register on 11/11/2025, the first ECIR, we have two closure reports which have been accepted, which have not been challenged.
Yes.
The second important fact is when there is a legislation in August 2025,
Closure.
we have
Banning online
completely
games.
seized our operations. So all we are doing now, ED is doing now, is to look back at what I was doing prior to August 2025. That's point number one, my lords. Second is we then come to your lordship's court because the search starts on 18th to 25th November 2025. And I know I've read it earlier, but just to refresh your lordship's memory, the lordship sees that interim order again.
Yes.
If your lordship sees your 1668 order sheet, it's interesting because once they are faced with this eventuality that there is no predicate offense, the ASG then says that it is entitled to update its ECIR for any crime that is pending preceding the subject crime.
I have quoted that paragraph 11
Please
in the
follow us.
earlier order.
So this words preceding the subject crime is very important. It has to precede. So there is no crime because they now in the reply in para 9.
No, there was no crime preceding,
Clear,
but they did proceed to register crime later.
That's right.
Yes.
So what they made a statement before your lordship and said that we are entitled to update our ECIR for any crime that is pending preceding the subject crime. So it was not just any pending crime, but it had to precede. On that basis, he submitted that there are several other FIRs which are pending prior to the registration of 722. So Malas, both these statements have to be carefully seen. The registration of other crimes had to be prior to 722. But what we find from the reply file to the writ petition is something quite different. If your lordship sees para 9 of the reply,
to this petition,
please, Malas, to 1668, para 8 first.
para 8 is it?
No, first para 8.
Of the reply?
Reply means. During the course of further investigation, well, actually, this is a wrong phrase. For people in criminal law, like your lordships is seeing it day in and day out, 173.8, the phrase further investigation is misplaced here.
No, misplaced alike. Not only in this, it is loosely used everywhere.
Everywhere.
It has some serious meaning.
Absolutely.
Yes.
Absolutely. During the course of further investigation, it was learned that another FIR bearing 0029 of 2026 dated 21/1/26. This is very important. So this is not a crime that preceded 722. That was the only limited liberty. Even if you read your lordship's order as giving them liberty to do it, they could have only added addendums vis-a-vis crimes that preceded 722. So, Malas, this Gomti Nagar police station crime, which is what they refer to in para 8, they say in para 9, accordingly, FIR number 29 of 26 was lawfully incorporated into the existing ECIR. With the greatest respect, this could not have been incorporated because this was not a crime preceding the crime in 722 of 2024. If this goes, Malas, there is today no predicate offense. The only other predicate offense which they're seeking to incorporate is an offense that is after the 722 of 2024
That's
offense.
Hyderabad.
No, Hyderabad comes even later, Malas. That's the better part. Now, the Hyderabad offenses, they don't seek to add by way of an addendum.
That's
They
independent.
register a fresh
They register
ECIR.
a fresh ECIR.
Because now they realize that what they had told your lordship was something.
Which is the predicate offense in this now?
In this,
After
there's
the grant of interim order,
after the
there
grant,
is a crime
it's only
registered.
para 9 months. It's only para 9 with the Gomti Nagar FIR. No other FIR.
That is on 18/2/2026, is
They
it?
have, yes, the addendum dated 18/2. There is no other FIR as far as the first ECIR is concerned. So first ECIR is literally floating in limbo without any roots, and it can't be a standalone ECIR without any predicate offense. So Malats, that with the greatest respect, Malats, I say, the lordships should have no difficulty in saying that any steps taken pursuant to the ECIR should go. ECIR itself should go. This is as far as the first ECIR is concerned, because the only way they're hanging on to it is because of this Gomti Nagar FIR, which I submit, Malats, cannot come to give life to a dead ECIR. Malats, then we come to the search and seizures that starts in November 2020 in the 3 FIRs in Telangana. Your lordship sees that for a minute, Malats, in the list of dates.
Yes. Yes, sir.
If your lordship now
97, 10 and 330.
Correct. These three now figure in the second writ petition we have filed. And well, all three relate to events succeeding the 722 of 2024, not preceding. So once your lordships granted a stay, so we go back to the stay order against the same parties without leave of this court, they could not have proceeded to act on these three FIRs. This is the second point, Malats. So once these
No,
three
I had
FIRs,
stayed only crime number 72 of 24.
Yes.
ECIR emanating from that. Now, where is the bar for them to register other crime, register a fresh ECIR if there are fresh crimes registered?
No, because
elsewhere?
your lordship granted a stay. What I'm saying is,
No, stay of what?
Stay of any further proceedings vis-a-vis.
Pursuant to 722.
No. Well, it's that
26/1/2026 is my order.
Yes. Let's read that, Malats.
Yes. Investigation in the said ECIR on the basis the closure report in the predicate offense has been accepted.
Correct.
That is in 722 B report had been accepted.
Correct.
Correct. Now, where is the bar for them to file another or register another ECIR if there are predicate offenses later registered,
Well,
which has no connection with 722?
Very well, I'll take your lordship's point, but the point I wish to develop is this. If your lordships find that the three FIRs in Telangana have actually not proceeded at all, apart from just registering the three FIRs,
that's on the merit. Yes.
They have done nothing. So they have no indication there are any proceeds of crime. They don't know if there's a crime, much less do they know if there are proceeds of crime, because it has not even picked up for issuing notices. Nothing has happened in the three FIRs. So unless there are proceeds, that first of all, there has to be a crime, then we talk of proceeds of crime. They just randomly pick up three FIRs, and the dates of those FIRs are very significant. One is dated 24th January 2026, which is just 1 day,
2 days,
2 days
prior,
after
yes.
your lordship's interim order.
It can't be 26/1/26. 22/1/26.
24/1, Malats.
No. My interim
Lordship's
order is
22/1.
22/1.
Correct. 2 days later, the first FIR of Telangana is registered. Then the second one on 10th February, third one on 12th February. Nothing has happened, Malats. The local police has actually not taken even the first step. So there is no way that ED can form reasons to believe that there is a crime and that there will be proceeds of this crime from Telangana. So relevant for the freezing matter, Malats, if your lordship sees the amounts involved in the three FIRs, one is 53,080.
1.85 crore and 40 lakhs.
Well, this works out to roughly around 2.26 crores, 2.6 CR. Now the ECIR is registered on this basis on 23rd February 2026. So one question is, if they were so confident of addendum to an existing ECIR,
no fresh need be raised.
They need not have been. So this was done only, and your lordships have noted that in the order holding the arrest to be legal. This was done mala fide only so that they could have a fresh search and seizure and they could have an arrest. And that your lordships has actually held was a mala fide action, abuse of the powers. Your lordships have held the arrest to be completely illegal. And the allegations in both cases are identical, Malats. That is, people were cheated by bots and lost money when they were gambling. Well, it's on 7th May 2026, summons are issued. Your lordships have seen all that in the order of arrest. And the freezing order, my lord sees now, of 13th May 2026. That's in the second writ petition. Page 117A. The allegations here are identical. I'm sorry, this is page 117 of the defreezing writ, which is Well, the defreezing rate is 18285.
No, I'm at page 117.
Page 117. The order of freezing, if I may read it.
Yes, sir.
Whereas I, so and so, Assistant Director, Directorate of Enforcement, Bangalore Zonal Office, authorized by so and so to conduct search seizure for freezing under so and so. During the course of search, it is revealed that Messrs. Gamecraft Technologies Private Limited is engaged in criminal activities associated with schedule offence. In the case of wherein proceeds of crime is derived, that is the users of online rummy game across all brands of the online rummy game who made to play with bots automated program without being made aware of the fact that they were playing with bots automated program. The proceeds of crime is derived by Messrs. Gamecraft in the form of bet amounts placed and lost by real customers, and also in the form of commission on these gameplays in a dishonest manner by using bots automated program, which are received by the entity in its bank accounts and its subsidiary associated entities' bank accounts. Such proceeds of crime are being further routed, layered within the company through routine financial transactions and are parked in the bank accounts, bonds, investments in the subsidiaries and other entities and other financial instruments.
I've seen.
In order to obfuscate the true nature of the origin. Very good. Then your lordship sees the account holder names.
Yes.
So
Even the
there is
last
no
paragraph I've
reason
seen.
here, hence I hereby make an order. There is no application of mind. There are no reasons given. So the very genesis, if your lordship sees section 17 of
Mere
the PMLA.
suspicion. Account is frozen on mere suspicion.
Absolutely.
Where is the Delhi High Court judgment that is affirmed by Supreme Court day before yesterday?
Poonam Malik, it's in the binder, I think.
Yes.
Yes. The lordship sees the
Delhi
binder.
High Court's judgment is affirmed by Apex Court.
Yes.
Poonam Malik.
Yes. Where's the binder? He has the binder.
Yes. That's day before yesterday or last week, I guess.
Correct.
We have it in the magistrate court, we have the extract.
Oh, fine. Yes. Yes, yes, yes. You have not seen Anuparna?
Yes, 2025 SEC online, 8397, page 229 Malas of the binder.
Yes, sir. SEC online Delhi.
Please, Malas. 8397.
It's reported in SEC.
Yes,
Poonam Malik.
online version, Malas.
Online version, correct.
Version has all the high courts.
No, Poonam Malik, I saw only one judgment, which is, I think, authored by you in 2009.
This is Justice Hari Shankar's.
Yes. Now, this I know.
Yes.
But when I searched for it, I found what was authored by Sir. Yes. This I have seen.
Yes, yes. Para 56 is what is relevant.
Yes, that also. Delhi High Court.
Yes, Malas.
Delhi High Court I've seen. Yes.
This has been upheld by the Supreme Court.
Yes, yes.
So the freezing order on the face of it, Malas, does not conform to section 17, 1 capital A. If your lordship has that section for a minute.
ED, PMLA kodu.
Yeah.
Yes, sir.
So first 17.1 has to be read, where the director or any other officer not below the rank of deputy director authorized by him for the purpose of this section, on the basis of information in his possession, has reason to believe.
Yes.
The reason for such belief to be recorded right. So let's that the greatest aspect is completely absent here. And so it straightaway vitiates the freezing order, which is dated 13th May 2026.
This Delhi High Court is reported in SEC?
Yes, Manoj. SEC online.
You have it?
Page 229 of the lordship binder has.
Compilation. All right. Yes, yes.
So there is a. Well, you also have the judgment of this court in Dr. Natesha, DV Natesha. versus
Yes,
Director of
yes.
Enforcement.
That's pending in appeal.
Justice Chandana orders. So the 17.1A order was set aside because reasons were not adequate. Now, Malas, which is why we filed the amendment application, while this writ was pending, this order was freezing was passed and the retention order also has been passed on 3rd June 2026. That your lordships will find in our amendment application.
I think I've made observations with regard to that in the maintainability thing.
Correct, correct. But your lordships are not formally allowed it, but your lordship said you will deal with it.
No, correct. No, in the that will consider
Correct,
it. Yes.
correct. Well, so that retention order your lordship finds in page 8 of that amendment application.
Now the retention order is passed under what provision?
Section 20 and
Retention
21.
of property.
20 and 21.
Hmm.
So there again, well, it's the genesis.
That should precede 17.
Please, Malad.
Reasons to believe under 17.
Correct. That's the genesis. So if you don't follow the law in 17, you can't make up for
There
it
is
in
no
20
there are
and
no
21.
reasons to believe recorded as obtaining in 17.
Absolutely.
20 would get vitiated.
Correct. So Malad, these procedural irregularities, if I have to go to the adjudicating authority and then go to the appellate tribunal and so on, well, I'll be minus. So what has happened? It's nearly 500 crores have been seized in 106 accounts. If your lordship sees the freezing order for a minute.
Where
If
do I
may-
get that?
Lordship's account,
Oh, that's the order that I saw now.
correct. 106 accounts. And Malus, it's interesting that if your lordship sees the classification of
that
those
I-
106
yes.
accounts,
Hmm.
you will find 23 escrow accounts,
Hmm.
10 mutual funds,
Fixed deposits.
77 fixed deposits, one bond. So, Melons, how are mutual funds, fixed deposits, escrow accounts all supposed to be subject matter of any freezing, which means non-application of mind again? And this is CSR accounts where the company is supposed to have 10% of its earnings given to CSR, and they have done that. Well, and I have instructions to say they've been disclosing all these income to the income tax authorities, taxes being regularly paid. It is nobody's case that this is some, money that's been hidden away. They were in the accounts, they remain in the accounts. I have just ceased my operations. So to say that this is laundered money that is illegally gained has to have some basis. So merely reproducing the contents of the 3 FIRs will not amount to application of mind and will not lead to reasons to believe. There has to be some initial step taken. Well, the second important aspect is no notice under section 50. Well, already they have made a mistake in 722 of 2024. Had they issued a notice to me under 50, I would have told them there are closure reports. I would have showed them the closure reports. They could not have registered the ECIR. At least this time around, better discretion should have prevailed. They could have easily asked me questions. They could have first given me a notice under section 50, asked me, can you explain the genesis of all these monies lying in your accounts? Well, as it turns out that these are not bots, are already established in the closure reports that were filed. We have scientific reports to show that these are not bots. And this is the report of Indian Technology, Delhi. The Lordship sees that for a minute. Yeah. Where is it? Give me the page. There is a. Malas, we are just handing you over that report to your Lordships. It is IIT Banaras Hindu University.
Banaras?
Yes, BHU, IIT BHU. It has given a concrete conclusion that there was no bot used.
Anyway, that's what you have sought for. From
They've
them.
accepted it, and the closure report has
Who
been
has
filed.
accepted it?
The Bangalore police, Malas.
Oh,
And the closure report.
closure report is based upon that report.
Not this one.
There was another FIR earlier in Bangalore in 2021.
No, B report I think is accepted and closed because the complainant was satisfied that he has received back his money.
No, there was another, Malas. There's a 2021 report closure, which was not based on the complainant's satisfaction.
No, that is 2021, which ended in closure by filing a B report is based upon this report that there were no bots in that.
Correct.
So that chapter is over.
Yes.
Now the second chapter commences on 722 of 2024.
Correct.
722 is closed on account of the complainant coming and saying, I'm satisfied, I've got my money back.
Absolutely.
That's closed.
That's also.
Yes.
Nothing on merits unsatisfied.
Correct. Whatever. It is closed. Closure has become final. 6 months thereafter, the first ECIR springs. After my interim order, the second ECIR springs.
Well, is this annexure, these two annexure? All right. The Lordship sees this report because this is a 2021 report.
Copy. Confidential document.
Just to say that, well, it's easy to make an allegation of bot without any scientific basis. And mere suspicion, well, it only adds to this more and more suspicion. And because the figures are large, well, there's an argument of prejudice always. 500 crore fraud, 2000 crore fraud. But when you actually, go deeper into it, you find it's all based on nothing.
Arguments in terrorism.
Exactly. Yes. So, Malas, in the first round, that is in the first ECIR, when the freezing order was passed, if your lordship sees that in the list of dates, 11th, sorry, not 11th, no, 21st November 2025, there is a first freezing order in the first ECIR, where 8 escrow accounts were in fact seized. And that we have referred to, Malots, in page 21, para 28
No,
of our
you mean to say first freezing order 2021?
Yes. No, there were, in 21st November 2025, they froze 8 escrow accounts. So all these 106 accounts were very much there.
Post the search and seizure pursuant to 722.
Correct. Malas.
And the first ECI.
Please, Malas. So that freezing order goes, Malas, it is like they're waking up every time to try and find something new, so that something more can be foisted, because there are no consequences. Well, it's like we've lost liberty for almost a month in the jail. So.
Oh, that's not challenged?
Well, it's
that you're out now.
Well, we are out. That's not been challenged. But there are no consequences, therefore. Well, nobody's held accountable for our wrongful arrest. And now with the account freezing, well, the way it is hurting us, we've set it out in our writ petition. If your lordship sees that for a minute. Para 31 of our writ petition.
I'm holding 18285.
Yes, Malats, that writ petition. Para 31, we say how many employees are continuing to work.
That is, the last time you told me that.
And the annual cost is 105 crores. So I'm not paying salaries. I'm not able to disburse salaries to any of these employees. And my activities have completely come to a standstill.
All right.
Malats, when they have filed this complaint, last time your lordships asked them, and I think the ED was good enough to tell your lordships the complaint has been filed.
Prosecution complaint.
That complaint makes no reference to any of these 106 accounts. It's very strange.
Prosecution complaint in the ECIR.
No. Yes, Malats. In the second ECIR, there's a prosecution complaint. That complaint we've placed on record. Yeah, we are handing it over actually.
What is identified? They've identified the POC.
The proceeds of crime that they identify here.
Copy.
Yes.
Not given. Why copies are not given to the other side?
It's their complaint, Malats.
Correct, but in the form that you present it is needed to them.
Very well. We'll do that. We'll do it straight away.
Yes.
So, Malats, if your lordship sees.
Layering, concealment and proceeds of crime.
So they now come up with a huge figure of 19,000 crores.
19,000 crores?
Well, they just roped in all the ex-employees.
No, what is frozen is 560 crores.
No, in the second, Malats, the freezing order in the attachment order in section 5, that works out to 1129 crores. And these 106 accounts don't figure in that. So they come up with a press release totaling everything and saying 2,500 crores. That's why Lordships would have found a headline in many newspapers. Gamescraft, 2,500 crores. So this is the press release that they've issued. 2401 crores attachment. So it makes for good optics that we have a strong enforcement directorate, but it requires courts to unveil the truth of the legality of such actions. So if your lordship sees the last paragraph, they acknowledge earlier during the course of search, movable assets valued at approximately 495 crores were frozen. That is what we are here before. Along with cash amounting to 11 lakh gold diamond jewelry. Accordingly, the total value of proceeds, because this is now the next attachment that they have done. of 1906 crores in the beginning of the first paragraph, the first page. Directorate of Enforcement has provisionally attached movable and immovable properties valued at 1906 crores. So, Malas, this is therefore apart from the 106 accounts that they have frozen. Well, let's see if that this is proceeds of crime. There's no reason why no complaint is filed for this. If that is proceeds of crime, there's no reason why they could not have attached it first. So we're not clear what is proceeds of crime.
No, I'll adjourn it to next week. By then you may get it.
Please, for us. Your Lordships, in one sentence, have summarized what this whole thing is about. So if we do not know what the crime is, we can keep, having imaginary figures of proceeds of crime and justify all actions. So, Malas, the long and short of the submissions is this: the very genesis is illegal. There is no basis in law for registering the first ECIR. So the freezing order in the first ECIR goes. If the first ECIR goes, well, it explains the background to the second ECIR, because it's the same set of persons, the same activities, and the second ECIR pertains to all activities prior to August 2025, because it's nobody's case that these activities continued after August 2025. The only reason they needed to register a fresh ECIR is only because they knew the first ECIR had no legs to stand, therefore you need a second one. On the same set of facts, another search, another seizure, another attachment, another freezing order. So, Malas, the entire action, if you see it in a totality, smacks of malafidis, and it's an abuse of the process of court, and which is why we are here before your Lordship.
Yes, Vikram sir.
Quickly, my Lord, I think my learned Lord senior friend has very well elaborated. And not just wanted to show to your Lordships my first argument, my Lord, that as Dr. Muralidharan said, my Lord, it's a dead body and nothing can be built on it, my Lord. It's a dead body, and for that, my Lord, I wish to refer to the ECIR itself. I've just culled out the ECIR, therefore this note.
Yes.
Just culled out the ECIR. Give them copy. See, my Lord, serial number 5. 11th November 25. Your Lordships knows, my Lord, that the closure report is accepted since July 25. Now, my Lord, what is the content of the ECIR? Source from which, my Lord, I'm reading page 2. Source from which the information has been received, FIR number so and so registered at so. Lord, I ask a simple question as a student of law. If a closure report is accepted, where is this FIR? It has extinguished in thin air. There's nothing survives. You are saying I have this source. Then, my Lord, please see serial number 8. Details of prima facie case for investigation. The next one, I'm reading just after the source. Details of prima facie case for investigation of offense of money laundering. And the first line is as per FIR 722 of 24.
They were not aware of the closure at all.
Not aware, my Lord. Not considered. A dead body is taken as FIR.
They were not aware that it was closed.
They did not bother to, my Lord, do that exercise. They just culled out the allegations in the FIR and they think that they've done their job. Now that investigation has started, I have every jurisdiction. I am an ED officer to subsume, merge, consolidate every other FIR on this earth and continue with my investigations, irrelevant if I started on a dead note. So, my Lord, just one more line I wanted to show, my Lord. It quotes, my Lord, in the body of the ECIR, complainant has observed consistent pattern. Complainant experienced numerous glitches. And then, my Lord, the last line, the offense under section so and so 318 invoked in the FIR is scheduled offense under PMLA. Therefore, prima facie, it is proceeds of crime and I am approaching. So, my Lord, if this was the starting point, I need not labor except, my Lord, citing one constitution bench, my Lord, Baldev Singh, where, my Lord, that NDPS Act case, the argument was that you are saying section 50, no search, no offer given prior to search will vitiate the proceedings. What happens to there's a truckload of recovery of a narcotic? The answer was, my Lord, that the remedy cannot be worse than the disease itself. If they have, my Lord, violated a basic procedure, a basic norm, as my Lord Dr. Muralidharan put it, my Lord, umbilical cord connection. There cannot be better than that, my Lord. You did not have the basis to commence investigation. Where is the question of, my Lord, any kind of action being taken pursuant to that would justify. So it's a dead body, my lord. I'll rest my case on first ECIR today, which is the subject matter of caution, that, my lord, it cannot proceed further. One paragraph, my lord, of Bhajan Lal, I do not know, my lord, I've read it before or not. Para 60 of Bhajan Lal, my lord. Though we read it for, my lord, that 102, para 102 for exceptions. But, my lord, I wish to read that para 60. This was the language used by, my lord Justice Pandian, if I'm correct.
No, he has made me read all paragraphs.
All right, my lord. Then, my lord, it's a divine power if, my lord, your lordships were to condone the lapses and, my lord, say that, my lord, even if there is a procedural transgression, but still we will condone it, it will amount to clothe an authority with a divine power which no one can on earth can enjoy. That's actually the language used. It is beyond cosmos. Just 5-6 lines of para 60, my lord.
Yes, yes.
It is, my lord, page 364 of the judgment, page 32 of the compilation.
Yes, sir.
Para 60, my lord.
Yes.
The sum and substance of the above deliberation results in conclusion that the investigation of an offence is the field exclusively reserved for the officers whose powers in that field are unfettered, so long as the power to investigate into offences is legitimately exercised in strict compliance with the provisions falling under chapters 1 of the code, and the courts are not justified in obliterating the track of investigation when the agencies are well within their legal bounds, as aforementioned. Indeed, a noticeable feature of the scheme under chapter 14 is that a magistrate is kept in the picture, but he is not authorized to interfere with the investigation or to direct police how that investigation is to be conducted. But, my lord, these 6-7 lines, if a police officer transgresses the circumscribed limits and improperly and illegally exercises his investigatory powers in breach of any statutory provision causing serious prejudice to the liberty and property of a citizen, then the court, on being approached by the person aggrieved for the redress of any grievance, has to consider the nature and extent of the breach and pass appropriate orders as may be called for, without leaving the citizens to the mercy of police echelons, since human dignity is a clear value of our constitution. It needs no emphasis that no one can demand absolute immunity even if he is wrong and claim unquestionable right and unlimited powers exercisable up to unfathomable cosmos. Any recognition of such power will tantamount to recognition of divine power, which no authority on earth can enjoy. Precisely this is the issue before your lordships today. If the commencement is wrong, my lord, so, my lord, Devinder Pal Singh Bhullar, if initial action is not in consonance with law, all consequential or subsequent actions will fail. They have to be, my lord. So that's, my lord, the starting point. And I can tell your lordship, my lord, one thing with greatest responsibility, with the limited resources that I have, my lord, that, my lord, there is no judgment. Even Vijay Madan Lal Chaudhary, my lord, settled the position of law to that extent that if the predicate offence goes, my lord, the PMLA offence goes. But today, my lord, we are on a much higher wicket. There is no predicate offence existing. And you commence an investigation on a dead body. This is clear, my lord, with utmost respect. And, my lord, it's just an argument, and I leave it to your lordships. My lord, it will attract the vice of section 62 of the Act.
You mean to say they're flogging a dead horse?
Oh, absolutely. They were, my lord, not flogging. There was no horse existing, I would say. It's finished, over, done. My lord, a person, my lord, a closure is equivalent to, my lord, acquittal. Your lordship's judgment, my lord, recently in another case, my lord, your lordship said closure amounts to, my lord, if acquittal and discharge all are recognized by, my lord, the Supreme Court. Article 141, it is binding on all, much less on the Enforcement Directorate, which was a party to that petition.
I think in B report cases I've
Yes.
written something.
Yes, the latest one.
ನಿಮ್ದೇ ಬರ್ತಿದ್ದೀನಿ ನಿಮ್ದ್ರಲ್ಲೇನ
Two latest ones, my lord, I'll just pass on your lordship's judgment. Two views taken by your lordship. What I'm, my lord, in the first case, I would, my lord, only say that nothing that can be done, data can, my lord, can cure this, my lord, incurable illegality. It is not an irregularity which is curable, but an incurable illegality. And that's where we stand in the first, my lord. About the second aspect, my lord, I have 3 things to add. And that's, my lord, very dear to, my lord, what my lord, I have been so far, my lord, looking at it as a student of law. So, my lord, the action is being taken under section 17. Now, if your lordships would see 3 sections, my lord, in PMLA, 5, 17, and 19. They are, my lord, absolutely, I would say, almost perimaterial in, my lord, the phraseology, Even if information is used in 17.1, it is actually the material which has to be sent under 17.2. So, my lord, they have to record reasons to believe in writing. For my lord, whatever 5 contemplates, whatever 17 contemplates, and whatever 19 contemplates. Those reasons to be recorded in writing must pertain, my lord, must have a live and proximate nexus to the contingencies mentioned in that particular section. 2, my lord, the reasons to believe recorded in writing, settled position of law, my lord, that they have to be furnished to the affected person.
Correct.
So now 17.2, my lord, or 5.2 or 19.2, my lord, casts another obligation, because, my lord, property is considered equal to, my lord, liberty here. It's a human right. It's a constitutional right under Article 300A of the Constitution. Therefore, my lord, there is an additional burden cast that immediately, now, my lord, the word immediately is of utmost importance, 17.2, you will send the entire material in your possession on the basis of which you have recorded those reasons under 17.1 to, my lord, the adjudicating authority. And number 3, my lord, when you take action under 17.1 capital A, which was inserted later by way of an amendment, my lord, where you can freeze something, you will even pass a special order for that and cause that order to be served on the person whose accounts, etc., or whose property is being frozen on the affected person. Now, my lord, in this case, all 3 have been breached in totality. 17.1, no reasons to believe recorded in writing have ever been furnished to me. It has not been even furnished to the adjudicating authority. They have filed an application under 17.4 within 30 days. It doesn't contain any reason, my lord. I'm sorry to say.
In the file.
In the file of the OA, I am going to demonstrate that. Reasons are for section 21, 20, where, my lord, they seek retention. There also they have to seek.
Not for 17.
Not for 17.1. No reasons are, at least I have not seen them. So, and not served on me. Why it has to be served? The answer lies in 2 judgments, one under PMLA itself, Arvind Kejriwal. 19.1, though the Supreme Court was looking at, but it said the reasons have to be furnished. Otherwise, there is no purpose. We can't deny judicial review. If the person doesn't have reasons, how will he challenge it? And, my lord, the other judgment is CB Gautam, Constitution Bench, and a judgment by Delhi High Court, whose author is sitting next to me at that time, my lord, who said that, my lord, CB Gautam's ratio, my lord, applies to PMLA, and, my lord, you have to, reasons to believe recorded in writing must be, my lord, served. So, my lord, there is no reason to believe under 17.1. Second breach, my lord, second breach, that order of freezing under 17.1A, Opto Circuit, Supreme Court direct judgment. Darsh Minerals, Punjab High Court judgment, my lord, I happen to be part of it. The judgment said that yes, there is a breach of 17.1A, but I will still not open the accounts because it was a case under the mining, my lord, provisions. I will import article, my lord, 39A of the Constitution. It's a, my lord, directive principle. It's a very valuable asset. I'll continue with that. The Supreme Court set aside that order, my lord, and said that once you hold that there is a breach of statutory provision under 17.1 or A, you have no option but to direct defreezing of the accounts. So 17.1A, my lord, order not served on any of the affected persons. And I'm making this statement, even the copy which has been, my lord, there is a 17.1A order. They have, my lord, given, my lord, now in the part. But that 17.1A order also says copy to, my lord, 2 or 3 entities where there are more than 8 or 9 entities affected. So, my lord, how did they serve? Whom did they serve? $1 million question. Now, my lord, third breach. 17.2 immediately they had to send. Material is existing, my lord, prior to passing of that, my lord, order of freezing. That is prior, because 17.1 you had to record those reasons. But, my lord, the material has been sent. This action of freezing is of 13th May. Focus. The action of seizure is of 13th May. And, my lord, on 19th May, after 6 days, they have sent, my lord, the material by email. That's their reply. We are pointing out that word in my note. 19th May, they have sent the material to the adjudicating authority by email. I'm sorry, my lord. Number 1, immediately is violated, even if I consider email to be appropriate. But, my lord, and immediately word is interpreted by Punjab High Court, albeit again in section 19, the identical words of 19.2, 24 hours, because they were prior in existence. 24 hours, they challenged that order before the Supreme Court. Their SLP is dismissed against that. Now, this, my lord, last but not the least, there is no compliance with 17.2 at all, because, my lord, under 17.2, there are special rules framed, like arrest rules, my lord, under 19. We have, my lord, under 17, I call them, my lord, search, seizure, and, my lord, freezing rules. Those search, seizure, freezing rules contemplate a format. Those rules your lordships will find, my lord, in the any Bear Act. We'll point out, we are not circulating it separately. They point a format, my lord, that this is the form which you will fill. You will immediately hand over to the adjudicating authority. You will take a seal of the adjudicating authority, authentication, acknowledgement that it has been received by the adjudicating authority. Otherwise, my lord, it is a backdoor approach. You don't have reasons to believe on the day of when you pass an order. We do not know till date. Your lordships may note, even before your lordships, there is nothing on record that what are the reasons on the basis of which 17-month action is taken. Not produced before this court, not produced before adjudicating authority, not furnished to me. That's, my lord, the end of the entire breach. The rules are clear. This is the format to be followed. There is no other format. Even the arrest is made, my lord, under the form given under the arrest rules. Even they follow. It is for them to follow. If they have not followed that, my lord, they come today for the first time and tell your lordships that we have, my lord, complied with 17(2) by sending, my lord, that email, then, my lord, that itself is a breach. And on breach, as I said, my lord, all three judgments cover me. One that your lordships were pointing out, my lord, the Delhi High Court, the Punjab High Court, again, my lord, SLP dismissed, and, my lord, the Opto Circuit judgment. So this action of freezing, my lord, is totally contrary. And of course, my lord, that, my lord, Poonam Malik and all those judgments, my lord, Kejriwal itself, my lord, carves out that, my lord, reasons to believe are not reasons to suspect. The reasons to believe have to have a higher platform. They cite, my lord, cite right from Gifford's case in the, my lord, US. They've cited all those, my lord, precedents to say it is much higher platform.
To suspect, there need not be a reason.
A reason to suspect also require reasons, my lord, but reasons to believe are, my lord, of a much higher nature.
Should definitely need reason.
Need reason. Now, my lord, the second aspect is, my lord, the last aspect which I leave for your lordship's consideration is, my lord, there is nothing which, my lord, allows this, my lord, department to, my lord, if the first ECIR, though I am not challenging the second ECIR so far, but, my lord, if they could subsume and add, there was no question of recording another ECIR. Two, my lord, even if we see the total of the proceeds of crime by calculating, my lord, whatever has been said in those FIRs is around 2 crores, 2.6 crores. And you are talking everything to be proceeds of crime. I'm covered by those two latest judgments of Madras High Court, my lord, that RKM Powergen and K. Govindraj, my lord, V. Shanmugam, that, my lord, all their job is only to confine themselves to proceeds of crime and not to transcend beyond the confines, boundaries, and limits laid down by the, my lord, schedule. I rest my case here. Yes. We'll
Anything,
circulate the list.
anything in addition?
So far as WP 1668 is concerned, I
Right.
make some submissions on that.
Hmm.
The reason being, my lords, post my lord's order on 22/1, the interim order that was granted, till June, my lords, the matter went on under the caption of further hearing and various submissions had been done. Now, those submissions which have been done, my lords, we have been able to formulate it and put it in the form of a note.
All
I will
right.
just point out.
So what becomes of that?
I will just point out, my lords, because their contention. Compilation. Just notice this, my lords, it will put the sequence in order, what we're giving now. Kindly notice this, my lords.
1 minute. Sergeant sir, you also something to say?
No, my lords, Dr. Muralidhar, my lords, has concluded everything except I may have just one point on 17, which I will, my lords, take maybe 30 seconds at the end. My lords.
All right. How long do you take?
Well, it's about 5-10 minutes to point out this aspect because I have the judgment supporting it. My lords, would Mr. Sajjan?
No, you finish.
I'll complete it. My lords, kindly notice, my lords, the backdrop of the case at page 1, the date. The most relevant date here would be, my lords, the acceptance of the B report took place on 5/7/2025, page 1. The ECIR gets filed
18/11.
On 11/11, after about
11,
5
all right.
months from then, when there was nothing in existence. Now, my lords, post that, kindly have page 3 for a minute, my lords. What was the contention of the Enforcement Directorate? 4 contentions which they had. If my lords would notice that. Page 3. Their first contention was, my lords, ECIR is a progressive or subsuming investigation.
That's what Dr. Muralidhar has.
That was the first contention. Kindly notice the second one, my lords. There must be a distinction made with compoundable ones or the ones which have been dismissed on merits. That was the second submission, my lords. The third contention which they did was, they said, my lords, extreme contention, it can be initiated without there being registration of an predicate offense itself. That was the third contention. The fourth contentions being, my lords, the initiation of ECIR is not crime specific, but is dependent on proceeds of crime. These were the four contentions. If my lords now would have page 4, there's something called statutory dependent enactments, where my lords, one enactment would be completely dependent on what is mentioned in the schedule. My lords would notice that, my lords, page 4. We have given certain examples of the statutory dependent enactment, and even PMLA, my lords, would come under that category because you have a schedule, you have a predicate offense, only then, my lords, proceeds of crime, a process or activity in furtherance of thereof, then comes PMLA. So we have extracted, my lords, which are the enactments which are statutory dependent. Thereafter, my lords, please notice page 8, there are about 10 situations, my lords, where you can't have a PMLA proceedings. Page 8.
You carry on. Yes.
In that page 8, second one, if there's no crime registered for a schedule offense, there can be no proceedings initiated under PMLA. The first aspect, my lords. Second, there, if there's quashment, third is discharge, fourth is acquittal. Then, my lords, even in technical grounds, if FIR is quashed, even then you can't have a PMLA proceedings initiated. That's the fifth aspect. Sixth, if there is going to be a sole accused and it abates on his death, you can't have proceedings continued under PMLA. The seventh, my lords, if in case of compounding of a schedule offense or a predicate offense, you can't have PMLA proceedings. Now, my lords, B report or C report stands on the same footing, is how we put it across. And then, my lords, relevant portion in Vijay Madan Lal's case is extracted, where, my lords, it supports this view which we have taken. And, my lords, the relevant provisions under the PMLA I have extracted, my lords, which supports this view of it being a dependent statute. And finally, my lords, the judgments of my lords in 3 matters, my lord has taken this view. Can I just pass on the citations, my lords? In 3 judgments, this honorable court, 2 of which were cases where B report had been accepted. The first judgment, Richa Saxena, which had been given now, my lords would notice Richa Saxena. The relevant paragraph in Richa Saxena, paragraph 12, page 11.
That's the wife of the second
Yes,
case.
my lords. Yes, my lords. In that, in paragraph 12, the observation of my lords, the submission of the learned counsel for the respondent that the petitioner is not acquitted after a full-blown trial, as acceptance of B report will not amount to acquittal, is unacceptable, as the apex court also recognizes closure of proceedings on discharge of the accused. Even in the case of discharge, no trial is conducted against the accused. Therefore, closure of proceedings on acceptance of B report.
Yes, Nande order. I know.
That is followed by the coordinate bench at page 13, my lords, Kapil Mohan, who was a co-accused in this. And thereafter,
Husband
my
and
lords,
wife, sir.
the husband and wife. Thereafter, the other judgment is Lakshman Rao Peshwe. My lords took this view on 23rd April 2024, same view which was taken. And thereafter, my lords, page 34. My lords, in the case of Raghavendra Enterprises, the third of the matters where my lord took this view. Paragraph 7 and paragraph 8. Thereafter, my lords, we view Supreme Court rulings, no? The 3. My lords, thereafter, they extract in Vijay Madan Lal, then my lords in Pavana Dibbur, then in Yesh versus Union of India, and Senthil Balaji. The relevant portions we have extracted, we have marked that out, my lords. In view of all this, you could not have registered the ECIR after the acceptance of a B report. That too 5 months later. My lords, in so far as the defreezing part of it, my lords, I have nothing more to add than what has been stated.
5 minutes ಆಗ್ಲಿಲ್ಲ.
5 minutes.
Yes. ಅಷ್ಟು ಆಗ್ಲಿಲ್ಲ.
ಸ್ವಲ್ಪ.
Yes.
Malas, a
Sajan
few,
sir.
yes, Malas, a few sentences of the defreezing, apart to all that has been submitted before your lordships. And Malas, I'll not touch upon documents. Kindly see one other ignominy, Malas, in this scenario. The freezing order, Malas, was passed on 13/5/2026, freezing about 495 crores. Freezing obviously is under section 17, and 17 says, Malas, what is found as a result of a search must be seized. Now, these accounts in which there is 495 crores were not found as a result of the search, my lords, which was conducted under the new ECIR, because these accounts were disclosed, my lords, in the previous ECIR from 2025, my lords. This investigation is on. So it was always known to the authorities that these accounts existed. The icing on the cake, my lords, is although on 13/5/2026, this 495 crores is, my lords, frozen by virtue of a freezing order, ostensibly under section 17, on the basis that we have found as a result of the search. In 22/7/2026, there is a provisional attachment order under section 5, which is issued, my lords, to the same company, in which 1,900 crores is attached, which, my lords, belongs to completely different set of accounts. Therefore, an provisional attachment order being passed in 22/7/2026 does not touch upon these accounts, my lords, which are frozen, my lords, on 13/5/2026. Ostensibly, therefore, my lords, the test to say that these are therefore proceeds of crime is certainly not made out, because if it was, then, my lords, the provisional attachment order which is subsequently issued, my lords, would have actually captured this. The second scenario, my lords, in this overall context, statutorily, if you have an attachment order that you have applied your mind and, my lords, attached 1,900 crores for a predicate offense of 2.25 crores, then this freezing of 495 crores, ostensibly that it is found, my lords, as a result of search, my lords, is of no consequence. And that's the only factual aspect, my lords, I wanted to indicate. I think I've lost the court. Yeah. Hi, Zoeb. It's only you and me now.
Hi, sir.
I think
Very-
the court just dropped off. Sometimes they say, no, when the best point is being made, the worst things happen. You want to connect on another system?
I don't think it's a system issue.
Yeah, I think it's the connection issue from court.
That's right.
Which date do you want?
Tuesday, just check Tuesday. Yeah. Monday.
Colleagues, give the list of.
Plus, I think he joined it.
Yes.
Zoeb
My
sir.
lords, the court is now back.
When? My lord, does
No,
the
no,
Wednesday?
Sajan
so
sir,
sorry.
we have to complete. 1 minute. Yes, sir.
I'm so sorry, my lords. I lost the court on 1 minute. Your lordships are adjourning it for the 12th, my lords. Please give me, my lords, a minute on 12th.
No. That is because you are arguing the freezing matter. You froze.
Yes, my lords. I froze, my lords. In fact, the court froze, my lords. Zoeb and I were then talking to each other.
So the Zoeb had to come in, log in, and then only defreeze it.
Yes, my lords. No, my lords, that's all I
Yes.
wanted to say, my lords. Therefore, in the
Yes.
light of the subsequent attachment, this freezing order, my lords, really loses significance. That's all I have to say.
Yes. All right, sir. Zoeb sir.
My lord,
12th or 13th?
12th, if it's convenient, my lord.
12th, 4 p.m. It's convenient to me, not a problem. Yes.
4th.
12th.
4
I
p.m.
heard
I'm
all
very
this in your. Later on. Yes, Zoeb sir. If the amendments are allowed, I think tomorrow, if you want to file an appeal, or they want to file an
I
appeal.
could not hear Dr. Muralidhar, my lord. I could not hear. I'm sorry, I could not hear.
I was saying that the amendments should be
It is
formally
totally
allowed.
unintended.
No,
No, if anyone wants to file an appeal, then the amendment should not pose a problem.
With just exceptions, my lord, leaving all rights and contentions.
Of course, yes. The application seeking amendment of the petition stands allowed, subject to just exceptions, and also reserving liberty. Let them file whatever. That's enough. Just exceptions covers everything. Yes. So heard so and so. List the matter on 12th, Zoeb sir.
12th, my lord.
Fine.
12, yes.
Great for
12th for the hearing at 4 p.m.
Very good.
Record all the error appear agide. Yes.
Great for
The name may be added, my lords, 1668. My name is not shown.
Registry to print. ಆಮೇಲೆ ಅಲ್ಲೂ ಅಷ್ಟೇ ಹರ್ಡ್ Zoib Hussain, Leonard Senior Counsel appearing for the Enforcement Directorate along with Anuparna ಅಂತೆಲ್ಲ ಹಾಕಿ ಆಮೇಲೆ ಮಾಡಿ. Yes.
Obliged, deep.
Wherever interim orders are there, they'll continue.
Good.
Yes, sir. And the other one, Zoib sir.
Yes, my lord.
वो कब करेंगे?
Whenever my lord posted, because my learned friend had to argue on that locus issue.
No, I have some 2:30 mood matters. I'll finish that and get back to you if you're free.
Today, my lord? Today?
He lost the court again.
Yes. My lord will hear it today?
No, whatever. If you want it to be heard today, I'll take it today.
I entirely in my lord's hand, because my learned friend had to commence that argument that he wanted to.
Argument on locus, right?
On locus. But tomorrow 4 p.m, my lord, if it's
Tomorrow.
Chalega.
Tomorrow, my lord.
That's on Monday or 12th.
Why? What's your problem?
Tomorrow something.
Zoib sir is saying he's coming. What is your problem?
Tomorrow it's
Tomorrow, day after, whenever it's convenient.
Fine then. Tomorrow 4 p.m. we'll take it.
4 p.m.
So you need not wait for that. Any other matters, Zoib sir, you have?
No, my lord, I'm done.
Yes.
Thank you.
This matter on 12th.
Please.
Yes.
The interim order even this.
Interim orders will continue. 2:30 mood matters. Yeah. ಇದು ದಿಸ್ ಇಸ್ ಅದೇ ಇನ್ನೊಂದು ಮ್ಯಾಟ್ರ್ ಇತ್ತಲ್ಲ ಅದು 2:30 ಮೋಡ್ ಮ್ಯಾಟ್ರ್.
Mood matters. Fresh matter, Silam Bhavan, Venkatachalapati.
Petitioner in this case. The offense is 307, my lord.
307 ಏನ್ ಮೂವ್ ಮಾಡಿದ್ದು?
Morning move.
ಅದು ಯಾಕೆ ಅಂತ ಕೇಳಿ.
Not the own sister of the petitioner, lord, the complaint against the petitioner, my lord.
What do you mean own sister? Oh, own sister.
ನನ್ನ ತಂಗಿ. I would request your lordship to refer the complaint, page 20, annexure B.
ಈಗ ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ ಕ್ರೈಮ್ ಆಗ್ಲೇ ಬಂದ್ಬಿಟ್ಟಿದ್ದೀರಾ? 25/7 ಒಂದು ವಾರನೂ ಆಗಿಲ್ಲ.
Absolutely.
Because it's your sister, you have come early.
No, my lord, there is no proper allegations regarding to
that
this.
will see, sir.
307 attract ಆಗಲ್ಲ.
ಅಲ್ಲ ಅದಾಯ್ತು, ಇನ್ನು FIR.
Request your lord.
FIR.
Read out the complaint, my lord.
Long ಎಲ್ಲ ಯೂಸ್ ಮಾಡಿದ್ರು. Allegations are there.
Long.
No, it is that, my lord, release date ಮಾಡ್ಕೊಡ್ಲಿಲ್ಲ ಅನ್ನೋದು the allegation, my lord. Because of that, long use ಮಾಡಿದ್ದಾರೆ ಅನ್ನೋದು.
ಕ್ರಿಸ್ಟ ಕಾರಿಗೆ ಲಾಂಗ್ ಗಳಿಂದ ಹೊಡೆದು ಜಖಂಗೊಳಿಸಿರುತ್ತೆ.
ಕಾರಿಗೆ ಮಾತ್ರ ಅಲ್ಲ, ಕಾಲಿಗೂ ಹೊಡೆದು.
Just that, my lord, I'll just read out the complaint, my lord. Release date ಮಾಡ್ಕೊಡ್ಲಿಲ್ಲ ಅನ್ನೋ ಒಂದೇ ಕಾರಣಕ್ಕೆ false case came to be registered against him, my lord.
ಬೇಲ್ ತಗೊಂಡಿದ್ದೀರಾ? ಮತ್ತೆ ಫಸ್ಟ್ ಅದು ತಗೊಳ್ಳಿ. ಎಲ್ಲಿದ್ದೀರಾ ಈಗ?
Not yet filed, my lord.
ಒಂದು ವಾರನೂ ಆಗಿಲ್ಲ ಕ್ರೈಮ್ ರಿಜಿಸ್ಟರ್.
Just read out the complaint, my lord.
Sir, this cannot contain everything. Let the investigation happen. ನಿಜವಾಗ್ಲೂ ಹೊಡೆದಿದ್ರೆ ನೀವು?
Just that release date ಮಾಡ್ಕೊಡಿ
ಆಯ್ತು
ಅಂತ
ಸರಿ,
ಕೇಳೋದು.
ನಿಜವಾಗ್ಲೂ ಇಲ್ಲಿ ಲಾಂಗ್ ಇಂದ ಹೊಡೆದಿದ್ದಾರೆ ಅಂತಿದೆ. ಅದು ಹೊಡೆದಿದ್ರೆ
ನೋಡಿ, if at all she will not go to the police station and lodge the complaint against.
ಯಾಕೆ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ಗೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿರೋದು?
There is no serious injuries and all to her.
Still we have to collect their own certificate.
No. Without looking into investigation papers, no stay.
Ready to cooperate with the investigation.
Cooperate ಮಾಡಿ.
No cross system
No, no,
should
no,
be
no.
taken. my lord.
Secure. ಎಲ್ಲದ್ರಲ್ಲೂ
My
ಅದಾಗಲ್ಲ.
one sister-in-law, the
You have
complaint.
converted this court to bail court ಆಮೇಲೆ. No. Get the investigation papers. The learned HCGP Wahida is directed to accept notice for the respondent, secure the investigation papers and place it before the court on the next date. ಆಮೇಲೆ notice issue ಮಾಡೋಣ. List on Wednesday, fresh matters.
Seal number 2, 15B.
Please, my lords.
List
The SC/ST Act, my lords, after the complaint was lodged, my lords, by us on 11/7, my lords. 12th is this complaint lodged, my lords, stating that 8th is the incident, page 21. No, nothing in public view. Allegation is an abuse. That's all the allegation, my lords. Page 21.
ಇದು ಯಾವತ್ತು ರಿಜಿಸ್ಟರ್ ಆಗಿದೆ? 12/7 ಗೆ.
12/7 is
Only
that-
atrocities I will stay.
Please, my
Heard
lord.
the learned senior counsel,
ಇದು-
P.P. Hegde appearing for the petitioner, emergent 1 HCGP 2 emergent notice. There shall be an interim order of stay only insofar as the offences under the Atrocities Act are concerned till the next date of hearing, list on 25th in the fresh matters, returnable by 25th. Next.
Please, great.
Seal number 3, we know then.
307.
ಇದು crime. Charge sheet ಆಗಿದೆಯಾ? Settlement.
Settlement, husband and wife, my lordship. The 307, the injury is page number 39, my lordship.
Husband and wife.
Yes, my lordship. Reunion ಆಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
Reunion. They are living together, is it?
Yes, my lordship.
ಎಲ್ಲಿದೆ affidavit ಕೊಡಿ.
Page number 39 is the
But injury ಎಲ್ಲ ಆಗಿದೆ?
simple in nature, my lordship.
Simple.
Page number 39, my lordship.
Many injuries are there, my lordship.
ಎಲ್ಲ simple. But they are living together ಅಂತಲ್ಲ.
Yes.
The petitioners in the case at hand, the parties to the list in the case at hand are husband and wife, have brought the petition before the court seeking annulment of the proceedings on account of a settlement arrived at between the parties. Notwithstanding the offence being the one punishable under section 109 of the BNS stroke 307 of the early regime, the IPC. A perusal at the wound certificate would indicate that the injuries inflicted are all simple in nature. Apart from the said fact, the husband and the wife have now settled a dispute amongst themselves and are now living together. In that light, I deem it appropriate to accept the settlement between the two and close the proceedings against the husband for them to live happily ever after. Yes. Next.
Order sheets. Number 4, withdrawal.
In terms of.
Number 5, Balkrishna Emmer.
For the petitioner in this matter, my lord.
Ah.
The offences under section 69 and 351 subclass 2 of the BNS.
69.
Yes, my lord. The acquaintance for 5 years.
5 years.
Through Facebook, and physical relationship is for 2.5 years, my lord. Both are
ಅದನ್ನೆಲ್ಲ
matured adults.
ಬರ್ದಿಟ್ಟಿದ್ದೀರಾ?
As per the case of the complaint, my
ಸರಿ
lord.
ಸರ್. ಹಾ.
Both are matured adults, my lord.
Matured adults.
Yes.
Immature adults ಇದಾರಾ? Yes.
And he is in custody since 14/7/2026, my lord.
Very mature adult ಅದಕ್ಕೆ. Yes, madam. Madam.
Other than that, my
Take a
lordship,
minute.
ಖಾಸಗಿ ಫೋಟೋಗಳು
ಅದನ್ನ ಕಟ್ ಆಫ್ ಆಗ್ಬಿಡುತ್ತೆ. ಎಷ್ಟೊಂದು ಜನ ಎಸ್ ಫ್ಯಾನ್ ಜೋರ್ ಮಾಡಿ. ಎಸ್.
And complaint came to filed after lapse of more than 10 months, my lord.
10 months of what, sir?
From the date of last incident.
Last incident.
As per the case of the prosecution.
First incident ಯಾವಾಗ?
2023, my lord.
Last incident 25.
Yes, my lord.
You're in custody since 15 days.
Yeah, 14/7/2026.
ಯಾಕೆ ಬೇಲ್ ತಗೊಳ್ಳಿಲ್ಲ?
The bail application came to be rejected, my lord.
Coordinate bench.
some ಖಾಸಗಿ ಫೋಟೋಗಳು
Not coordinate bench, by the sessions court, my lord.
ಖಾಸಗಿ ಫೋಟೋ ಏನ್ ಮಾಡಿದ್ರಿ?
ಅಲ್ಲ, ಖಾಸಗಿ ಫೋಟೋ ಏನ್ ಮಾಡಿಲ್ಲ.
ಅದೇನ್ ಅಲಿಗೇಷನ್ ಇಲ್ಲ?
ಇದೆ.
Nothing.
ಎಲ್ಲಿದೆ? ಓ
Page number 19
Threatening.
ಇಲ್ಲ,
that.
351(2) ಅಷ್ಟೇ ಇರೋದು.
351 subclass 2, my lord.
Page number 19. Second paragraph.
That is the allegations, my lord.
ಈ ಅಲಿಗೇಷನ್ ನಾನು ಕೊಡಲ್ಲ ಅಷ್ಟೇ ಈಗ, ನೀವು ಅಲ್ಲೇ ಇರಿ.
And some amount also transferred to the account of the.
ಅಕೌಂಟ್ ಅಲ್ಲ, ವಾಟ್ ಇಸ್ ದಿಸ್? ಏರ್ ಕಂಡೀಷನ್ ಕೂಲಿಂಗ್ ನಲ್ಲಿಯೂ ಎಲ್ಲ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
ಅಲ್ಲ, even accepting.
ಏರ್ ಕಂಡೀಷನ್ ಕೂಲಿಂಗ್ ನಲ್ಲಿಯೂ ಸೋ ಅಂಡ್ ಸೋ ಸಾಲಿನಲ್ಲಿ
That is from 2000.
ಸೆಕ್ಷುವಲ್ ಅಸಾಲ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ.
From 2000.
ನೀವು ಎ ಸಿ ರಿಪೇರ್ ಮಾಡೋರ?
3.
ನೀವು ಎ ಸಿ ರಿಪೇರ್ ಮಾಡೋರ?
Not easy, my lord.
ಅದೇ ಎ ಸಿ ಇನ್ಸ್ಟಾಲ್ ಮಾಡೋರ?
Solar business.
ಸೋಲಾರ್ ಬಿಸ್ನೆಸ್.
Yes,
The petitioner is before the court calling in question registration of a crime in crime number 69 and 351-2 of the BNS registered for of the BNS. The fulcrum of the list is a relationship between the petitioner and the respondent complainant for over 5 years. The complaint alleges that from 1/2/2023 till the registration of the complaint, till the incident on 28/8/2025, the petitioner and the respondent have had physical relationship stroke consensual acts on the pretext of promise of marriage. The petitioner, having allegedly breached the promise of marriage, has led the complainant to register the complaint for the aforesaid offences. The complaint itself narrates that the petitioner and the complainant have had that relationship for over 5 years, for over 3 years on consensus, and such consensual acts as held by the apex court cannot become the offences even for the offences under section 376, which are all paraphrasable to the offences under section 69 of the BNS. In the light of the said circumstance, further investigation qua the petitioner shall remain stayed. The issue is, after the registration of the crime, notwithstanding it being registered after 8 months of the alleged incident, even according to the complaint, the petitioner is taken into custody and is now languishing in prison. In the light of the aforesaid interim order so granted, the inevitable conclusion, albeit prima facie, is the release of the petitioner from prison forthwith. The registry is directed to communicate this order electronically through electronically to the prison authorities to enable release of the petitioner. Yes, 1 HCGP to emergent notice further investigation. Stay madadalla further investigation. Yes, next.
Much obliged.
ಬಾಲಕೃಷ್ಣ ಅವ್ರು ನಾಳೆ ತಗೊಳ್ಳಿ ಆರ್ಡರ್.
ಆಯ್ತು, no problem.
ಬೆಳಿಗ್ಗೆ.
ಆಗ್ಬೋದು.
Till number 6. HSM.
Lord, these petitioners, my lord, were arrested on the basis of 74 of BNS.
74 ಅರೆಸ್ಟ್ ಮಾಡಿದಾರ?
Because what has happened? Accused number 1 and 2, my lord, against them FIR was registered. Accused number 1 to 4 and others. This petitioner number 2 is the mother of accused number 1.
Mother is arrested?
Mother is arrested.
What for?
74. ಯಾಕಂದ್ರೆ ಅವ್ರಿಗೆಲ್ಲ ಜೊತೆಲಿ ಇದ್ರು ಅಂತ ಹೇಳಿ ಇವಾಗ accused number 1 was not raised, my lord. After arrest of these petitioners, they were
ಯಾರು ಅರೆಸ್ಟ್ ಮಾಡಿದಾರೆ ಈಗ? ಸೆಕೆಂಡ್ petitioner? Accused number 6?
Yes, my lord.
She is arrested.
A5, 6, 7, both 3 are arrested.
All are arrested?
All are arrested.
Why?
My lord, this is a case of the allegation, my lord, as per the complaint. These accused number 1 and 2 have met the complainant near the school, my lord. At that time, my lord.
Pokso idea?
Pokso illa. She is also major. That was witnessed by the mother of the victim. She has slapped the accused one Akash. Thereafter, my lord, he informed the accused number 1 that they have taken my vehicle. Immediately, my lord, they went to accused number 1 2 along with Akash, went to that mother of the victim and requested to return the vehicle. At that time, my lord, she returned the vehicle.
Where is the SPP?
She returned the vehicle. She returned the vehicle. Thereafter, my lord, she assaulted the accused number 1 with slippers, for which, my lord, accused number 1 has informed to his mother.
There, my lordship.
Injured slipper?
Statement.
Statement.
Page number 20.
Madam, whatever it is, offense is what? 74. Out.
Thereafter, my lord, I go and, my lord, give all the documents that are available. And when I insist for a copy of FIR also, that is also not furnished. Now, my lord, in front of the informant who gives the complaint, inspector says you reverse 1.5 crores, only then we will release you. Kindly take to the complaint at page 120.
ನೀವು ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದೀರಾ?
ಎಲ್ಲಿ ನಮ್ಗೆ ಎಲ್ಲಿ ಅವಕಾಶನೇ ಇಲ್ಲ ಈಗ ನೀವು
ಅಲ್ಲ ಆಯ್ತು, ಈಗ ರಿವರ್ಸ್ ಮಾಡಕ್ ಹೇಳಿದ್ದು ಎಲ್ಲಿದೆ?
ಅದನ್ನ ನಾವು ಇದನ್ನ ಹಾಕಿದೀವಿ. The notices itself are available at annexure. ಅಲ್ಲ ಅಂದ್ರೆ when I go there, my lord, they took my phone, gave it to the informant. He had the access to my phone, my emails, and they, my lord, orally told me while the statements were being, allegedly recorded, that you will have to reverse the money, otherwise we will not let you go.
Which police station is this?
Peenya police station.
Who is the SHO?
Yes, this is by
ಯಾರಿದು this?
PSI, my lord, ಅವರ ಹೆಸರು ಬಸವಲಿಂಗಪ್ಪ.
The PSI of the Peenya police station shall be present before the court. SPP ಅವರ. One is the previous case. Accused number 1, 2 ಸಿಕ್ಕಿಲ್ಲ ಅಂತ 5, 6 ನ ಅರೆಸ್ಟ್ ಮಾಡಿದ್ದೀರಾ. This is being repeated by the police. This time, ನೀವು ಸುಮ್ಮನೆ ಇದ್ರೆ but last time ನಾನು ಏನು ಮಾಡಲಿಲ್ಲ. This time I am going to impose exemplary costs and direct departmental inquiry against that investigating officer. If this is going to be the practice of these policemen, we will not spare them. Accused number 5, 6, now how did you arrest them? Offense is 354, 118. And by accused number 1, 2, 3, 5 and 6 are taken into custody because ನಿಮ್ಮ ಮಗ ಸಿಗ್ತಾ ಇಲ್ಲ ಅಂತ. Tomorrow morning I'll take this and keep the IO present, whoever it is. And this case now, this case, bank manager is taken. 35(3) notice is served in the police station without the FIR. He is asked to reverse 1.53 crores because complainant is sitting there.
My mobile phones are taken and my email is also accessed.
Keep this station house officer present tomorrow of Peenya police station. ಬರ್ಕೊಳ್ಳಿ. ಅದರಲ್ಲಿ previous messages will release you tomorrow. You secure instructions. Tomorrow at 10:30 you take it top of the list. Both these matters, both the officers of the station house office in India police station, Chintamani town police station, and the officer in charge of the police station, the Peenya police station, shall be present before the court at 10:30 a.m. tomorrow. Both these cases tomorrow will take. Secure instruction at 2:30. 2:30, yes. Secure instructions will take it at 2:30. Yes, next.
Number 8. Can I read?
Lads, I'm filing a memo for withdrawal in this case.
Whoever it is, respondent, PSI, ಹೆಸರು ಬಸಲಿಂಗ, ಚಿಂತಾಮಣಿ ಟೌನ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಅವರ ಅಲ್ಲ, ಸಾರಿ, ಇದು ಪೀಣ್ಯ. ಗೆಟ್ ಹಿಮ್. ವಿನಯ್, ಏನಿದು?
My lads, filing a withdrawal application. Memo.
ಯಾವ್ದ್ರಲ್ಲಿ?
Withdrawal memo, sir.
ಮೇಡಮ್, ಇದ್ಯಾವ್ದು ಫಾರ್ ವಿಡ್ರಾಯಲ್ ಅಂತಿದೆ?
ಹನುಮಂತೇಗೌಡ ಪಿಟಿಷನ್.
ಅಲ್ಲ, ಇದ್ಯಾವ್ದು ಸರೋಜಿನಿ ಅಂತಿದೆ?
Serial number 8.
ನಿಮ್ದು 9 sir. It's not fine, ಇರಿ.
The petitioner in this matter, my lord. I moved it on the score that the petitioner is a patient of dementia.
Sorry?
I moved it on the score that the petitioner is a patient of dementia, my lord, and my FDs are frozen. Despite me, I'm the accused number 2. Crime was registered and the charge sheet have been dropped. And now, despite my application, what I'm calling in question here is, my lord, the rejection of 451 and 457 application that your lordships will find, my lord, at page 226. Now, my lord, in 2018, a crime comes to be registered for offences, my lord, 406 and 420. I'm accused number 2 in that. All the allegations are against my husband, my lord, saying that the complainant, this Ashok Kumar, who has registered the complaint, saying that for some investment in share capital, he's taken a lot of money and all the offences are against him. The allegations are against him. Now, my lord, if page 44, your lordships will see.
44.
The unnumbered paragraph, last one, my lord, A2 and A3, that's the petitioner and the son of the petitioner have been dropped.
You're no longer accused.
No longer accused.
When was this filed? 2000. 18 itself.
18 itself. And then a supplementary charge sheet is also filed, my lord. That
There
your
also you are not drawn as accused.
lordship- No, my lord. That, my lord, at page 222, your lordship.
All right.
Now, my lord, my only prayer is this, that, my lord, I am extremely unwell. My account, my FD, my accounts are frozen. Despite me being dropped as an accused, my lord, my funds are not, it continues to be frozen. And I need those funds immediately for medical treatment, my lord. And this is the second round of litigation.
48 lakhs is frozen, is it?
38 lakhs.
Yes,
38 lakhs. I've produced the schedule also in the
Yes.
prayer.
Heard the learned counsel, Srimati Kirti Reddy, appearing for the petitioner. The petitioner was initially drawn as accused number 2, but has been dropped while filing the charge sheet and has not again been drawn as an accused while filing the supplementary charge sheet. The charge sheet and the supplementary charge sheet were filed way back in the year 2021. The petitioner is said to be suffering from dementia and needs money for her treatment. The reason that she has knocked at the doors of this court now is for defreezing of the account of the petitioner. The defreezing, lien mark madidara, freeze madidara?
Freeze.
Defreezing of the account of the petitioner, which stands frozen, in which the amount of 38 lakhs is lying. The learned counsel submits that 38 lakhs is necessary for the treatment of dementia. The learned HCGP to secure instructions as to why, despite the petitioner not being drawn as an accused, and all the fixed deposits that are indicated in page 57, 57 andre indicated in ಏನಿದು?
40.
Indicated in the order. ಯಾವತ್ತಂದ್ರೆ ಮಾತಾಡೋದು ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಹಾಕಿದೀವ ಇಲ್ಲ
That's because also some petitions were disposed of, my lords.
ಬೈ ಮೀ
ನಾವು ಮೆಮೊ ಹಾಕಿದ್ವಿ.
Or they dropped certain
As
people
again,
from
we
the
did not
charge sheet.
proceed against some of the accused. Those writ petitions were.
Today it may not be possible. We'll take it on a supposedly free day. This will 14 ಆಗ್ಬೋದಾ?
14
ಬೇಡವಾ? ಆಯ್ತು, after 20th. 24
Much.
ಮಂಡೇ, ಬಟ್ ಸಾಯಂಕಾಲ ತಗೊಂತೀನಿ.
Much.
ಅದೇ 4 PM.
4 PM. Much.
ಮಂಡೇ 4 PM ಅಂತಾನೆ ಹಾಕಿರ್ತೀನಿ. ಸರಿ, ಹಾಗಾದ್ರೆ ಹಂಗೆ ಇರಲಿ. ಎಸ್
24.
ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ಸ್ ಏನಾದ್ರು ಇದೆಯಾ ಅಲ್ಲಿ? ಅಂಟಿಲ್ ಫರ್ದರ್ ಆರ್ಡರ್ಸ್ ಆಗಿದೆ, ತೊಂದರೆ ಇಲ್ಲ. ನೋ ಇಶ್ಯೂಸ್. ಎಸ್.
Order sheet signatures. Reporting settlement, Shri Akshay Huddar.
ಇಲ್ಲ ಅಂದ್ರೆ ಪಾಸ್ ಓವರ್ ಬರ್ಲಿ, ಪಾಸ್ ಓವರ್ ಮೂವ್ ಮಾಡಿದ್ರೆ ಬರ್ತಾರೆ, ಪಾಸ್ ಓವರ್ ಮಾಡಿ.
List number 2, reporting settlement. Bill number 159.
Dheeraj.
Petitioners in this case.
Offense.
The respondents, my lords.
Offense.
498A, my lords.
Yes.
The parties are present, my lords.
Next.
Order sheet signatures.
Madam,
Both matters are.
All 3 matters?
yes, my lords,
All
all
three.
3 matters.
2 matters. Second petition filed by the in-laws, my lords.
Whatever, all 3 matters. Next.
Much obliged, my lords.
Joint memo ಇಲ್ಲಿ?
My lords, ಜಾಯಿಂಟ್ ಮೆಮೋ ಆಗಿಲ್ಲ ಇದನ್ನ ಏನು MC ಕೇಸಲ್ಲಿ
ಅಲ್ಲಿ
settlement
ಆಗಿದ್ಯಾ?
agreement ಆಗಿದ್ದಾರೆ ಅದಕ್ಕೆ
ಎಲ್ಲಿ ಅದು ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದೆ
ಹಾ,
my lords.
ಸರಿ.
ಅದಿದೆ.
Yes, next.
160.
Ashwin.
On the last occasion, your lordships derailed this from reporting settlement, my lords, because it's.
69.
No, these are disputes between the husband and wife.
ಏನ್ ಸ್ವಾಮಿ?
ಅದು ಡಿಸ್ಕಷನ್ ಆಗ್ಲಿಲ್ಲ.
ಹಾ.
Husband has contributed substantially to acquire the properties. There is a dispute regarding that aspect.
ಈಗೇನ್ ಮಾಡ್ತೀರಾ? ಸೆಟ್ಲ್ ಆಗಲ್ವಾ?
ಅಲ್ಲ ಅವ್ರು ಕೂತ್ಕೊಂಡು ಮಾತಾಡಿದ್ರೆ ಆಗುತ್ತೆ.
ಕೂತ್ಕೊಂಡು ಮಾತಾಡ್ತಾ ಇಲ್ವಾ?
ಮಾತಾಡ್ತೇವೆ, my lords. Before your lordships, it was submitted that we will not ask any alimony, my lords, any.
But she has taken all my money, lordship. ಇಲ್ಲ.
ಅಲಿಮನಿ ಕೇಳಲ್ಲ ಅಂತ ಆಲ್ ಮನಿ
All
ಗಾನ್.
money she has taken.
Not taken anything, my lords.
I told
have
Ashwin
one-
also to come over there to have a discussion.
I have one property in.
Ask your client to sit and talk to the other counsel's husband.
It's not going anywhere, my lords. It's been it's been
No,
very long.
if you go somewhere, it will go somewhere.
I've been there, but then he's not present. If I go somewhere.
I'm always available. I only told him.
Let the party.
2 days ago also I told
No,
him.
no, the other day you were not there. She only told that it is.
Yes, my lord.
Hmm.
Asking property that is gifted by my grandfather, my mother, and earned by me.
No, not on that. We are not on that. There are other properties which are acquired
No other
out of my contribution, and even my father has contributed to acquire the property. So there are a lot of issues which requires to be discussed.
Lot of issues ಅಂದ್ರೆ no settlement.
ಅಲ್ಲ ಅದರಲ್ಲಿ ಅವ್ರು ಬಂದು
Merits ಮೇಲೆ I will
ಮಾತಾಡಿದ್ರೆ
write.
ಆಗುತ್ತೆ. I'm ready. ಆಗ್ಬೋದು.
Then we'll say that there is no settlement in this. We will answer the petition on its merit.
ಆಗ್ಬೋದು.
Yeah, that is also happening.
Child is also with
Lords, initially what has happened was
Who has the custody of the
that
child?
the father has, the father has.
Granted by a court?
It's not granted by a court, my lords. Initially, when it was talks were happening, the custody was handed over to the husband on the premise that he would settle the matter. Thereafter, it was not.
Lordship, she has thrown both son and the husband out of the house. She has replaced the lock.
I
She
want to
is
see
taking
this.
the possession of the entire property. I and my son cannot enter into the premises.
That
If
is
we
one
go
of-
there, she files an application seeking cancellation of bail, which is granted to the husband. This is this situation,
No,
please, your
then
lordship.
ಇದರಲ್ಲಿ settle ಆಗಲ್ಲ.
ಆಗಲ್ಲ, my lords.
I will answer it on merits.
Obliged, obliged, your lordship.
If you are holding the child and
Child is with me.
ಅದೇ asking
And there are other allegations
asking to
against
ransom on holding the child.
No, I'm not.
Mother will throw the child, sir.
No, your
What are you
lordship, there
talking?
there is evidence to that effect also, your lordship.
Anyway, yes.
Obliged, your lordship.
We'll take it on we'll take it next week.
Obliged.
On merits.
Date
Yes,
may be fixed.
list on 13th in the fresh matters
Obliged.
list. The parties to the list submit that there is no settlement in the case at hand. List on 13th in the fresh matters list. Yes, to be heard on merits. Next,
161.
For respondent, my lord.
offense.
85 BLS. 85 BLS.
ಎಲ್ಲಿ petitioner? ಆಗಿದೆಯಾ ಇಲ್ಲೋ settlement?
Settle ಆಗಿದೆ, ಒಂದಾಗಿದ್ದಾರೆ ಸ್ವಾಮಿ.
ಒಂದಾಗಿದ್ದಾರೆ.
Not for the petitioner.
ಹ್ಮ್.
May I request for a short accommodation on the petitioner.
ನೋಡಿ ಒಂದಾಗಿಲ್ಲ, short accommodation. Yes.
ಇಲ್ಲ ಒಂದಾಗಿದೆ ಸ್ವಾಮಿ. She is not feeling well, Lord, I'm told.
All right, yes.
I'm sorry.
ಅಲ್ಲ ಎಲ್ಲಿ ಸೆಟ್ಲ್ ಆಗಿದೆ?
Lord, but in this matter, there are matrimonial proceedings pending, my lord. Within this matter, my lord, they've settled.
No, no, no.
She's-
Is
they
it
have
settled
agreed
in
to
the
work.
MC or you want to settle here?
Here, my lord, before your lordship.
All right, then yes, keep the party present.
Please,
When do you
please.
want 12th?
Lord, may I request for week? Yeah, please, my lord, 12th, next Wednesday.
12th, 4 PM to report.
Please,
settlement.
good.
Yes, next.
163.
Parties absent ಇದ್ದಾರೆ. Have it on 18th, my lord.
Next week, yes.
Have it on 18th, my lord.
18th, 18th, yes.
164.
Mohit Kumar. Offense ಏನು?
380. ಚಿಕ್ಕಪ್ಪ ಅವನ ಅಣ್ಣನ ಮಗಳ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್.
ಚಿಕ್ಕಪ್ಪ?
ಅಣ್ಣನ ಮಗಳ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್. 46,000 ಅದೆಲ್ಲ ರಿಕವರಿ ಕೊಟ್ಟಿದ್ದಾವೆ.
380.
380.
Between family, yes. ಕೊಡಿ ರೆಸ್ಪಾಂಡ್ ಕೌನ್ಸಿಲ್ ಯಾರು? ಅಷ್ಟು ದೂರ ಯಾಕೆ? ಮುಂದೆ ಬನ್ನಿ.
ರೆಸ್ಪಾಂಡೆಂಟ್ ನಂಬರ್ 2
ಕೊಡಿ.
ಫೈಲ್ ಮಾಡಿ.
ಎಸ್.
ಪ್ಲೀಸ್.
ಇದೆ ಮೇಡಮ್.
Name ಕೊಡಿ. ಇದೆ.
ನೆಕ್ಸ್ಟ್.
Order sheet signatures. 165.
Lords, this is a matter wherein the section 6 of POCSO has been invoked, my lords. The petitioner is in
What
custody.
settlement?
The petitioner is custody, my lords. He's ready to marry the respondent number 2.
What's his age?
He's 23 years old.
We'll give interim bail. The petitioner is before the court seeking the following prayer. The petitioner is accused number one, who is alleged of offence punishable under the provisions of the POCSO Act hyphen section 6. The petitioner is now ready and willing to marry the marry the victim. Ready and willing to marry the victim, but is in prison. Therefore, only for the purpose, only on the score that the petitioner is wanting to marry the victim, I deem it appropriate to I deem it appropriate to grant the petitioner interim bail for the purpose of the said marriage. It is made clear in the event he would breach the undertaking of marriage that he is now indicated, the petitioner would be back to the prison. As the offences are heinous. Therefore, the registry is directed to communicate this order to the prison authorities to enable release of the petitioner to marry the victim and produce the registration. How old is the victim now?
She's 18.
To marry the victim and produce a certificate of registration of the said marriage before this court on the next date. List the matter on 2 weeks between date. List the matter on 25th in the fresh matters list.
166. Settlement.
ಯಾವುದು? ಇರ್ಲಿ. ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ ಸೆಟಲ್ಮೆಂಟ್. ಎಸ್ ಅಷ್ಟೇ. Yes.
498A, husband and wife are united.
Living together.
Oh, they have rejoined the.
Interim bail for a period of 2 weeks.
One is DV case and one is IPC.
ಆಯ್ತು ಕೊಡಿ. ಎಲ್ಲಾಗಿದೆ ಸೆಟಲ್ಮೆಂಟ್?
Before this court, parties are present.
ನೀವು ಯಾರು?
Respondent, man.
ಎಲ್ಲಿ ನಿಮ್ಮ ಪಾರ್ಟಿ? ಆಯ್ತು. ಎಸ್.
Order sheet.
Next.
167 also. Yeah, 168.
For the petitioner, my lord. Lord, I request my lord to kindly have it on 12th, my lord.
ಆಯ್ತು 12th to report settlement.
Your lordship.
ಇಲ್ಲ ಇದು settlement ಆಗಲ್ಲ.
Decoy
ಇದು no. This is police inspector.
Correct.
No. This I will not settle.
12th it may.
Last time I told Monica that I'm not going to settle this. How can he enter into a settlement? He's a public servant.
Yes, my lord.
There's no settlement. There can be no settlement in the case at hand. Post the matter in the fresh matters list on Tuesday. We'll hear it on merit. Yes.
My lord, on Wednesday, 12th, my lord.
Right, 12th. Next.
323, 324, my lord. Simple in nature injury, page number 40.
Yes. Kodi. Yes, next.
Order sheet signatures.
Yes, next.
Lord, serial number.
ಇದು next ಏನು?
170.
ಎರಡು ಸೇಮ್?
ಇಲ್ಲ ಬೇರೆ.
ಇದೇನು?
In this, my lord, I have provided DD, my lord. I have to, my lord, make further payment. Why, my lord, 3 months? Till then, my lord, my accounts are frozen. That may be, my lord.
Interim order, no objection.
Interim order?
For granting of interim order.
ಏನು interim order?
My lord, the matter was settled for 1.5 crores, my lord. Today they are paying 25 lakhs. Understanding is, my lord, as per the joint memo, another 50 lakhs, my lord, shall be paid
within 3 months.
Within 3 months from today. The remaining amount of 75 lakhs, my lord, 2 years. But
2 years.
2 years. It is agreed between the parties. Today, in so far as interim, considering the interim prayer is concerned, my lord.
What interim prayer? Defreezing. ಮತ್ತೆ ದುಡ್ಡು ಹೆಂಗ್ ಕೊಡ್ತಾರೆ ನಿಮ್ದು?
Only 25 lakhs they are paying today.
ಆಯ್ತು, ಬಟ್ ಮುಂದೆ ದುಡ್ಡು ಕೊಡೋದು?
After within 3 months, my lord, for granting interim order, no objection by the complaint, my lord. It may be taken up after
2 years.
No, after 3 months.
3 months.
ಆಯ್ತು. ಮತ್ತೇನ್ ಸೆಟಲ್ಮೆಂಟ್ ಕ್ಲೋಸ್ ಏನ್ ಆಗ್ಲಿಲ್ಲ ಇದು?
Stay on the other defreezing of account. No.
Defreezing of account, and I'm paying, my lord, today 25 lakhs.
ಅದು ಕೊಡಿ.
And proceedings may be also put to, my lord.
This is not in settlement, then we will take it separately.
I understand.
List the matter after 4 weeks, right? 12 weeks.
12 weeks, my lord, but till then, my lord, there will be.
One ನಿಮಿಷ. List the matter after 12 weeks. The parties to the list have arrived at a settlement and the terms of settlement are as follows. In the light of the settlement arrived at, the petitioner hands over a demand draft of rupees 25 lakhs to the complainant and undertakes to adhere to the terms of the settlement, which would be 3 months ಆದ್ಮೇಲೆ ಎಷ್ಟು 50 lakhs,
50
which would be payment of 50 lakhs after 3 months.
After all, within 3 months.
ಆಯ್ತು, within 3 months. Therefore, 3 months ಗೊಂದು ಡೇಟ್ ಕೊಡಿ, ಕೊಟ್ಬಿಟ್ಟು list the matter on so and so. In the event there is breach of undertaking, this court would view it seriously and permit further proceedings against the petitioner. Yes.
My lord, on the last date of hearing, I filed for cause for respondent number 2. But it's
Registered to print the name of Chandrasekhar is appearing for respondent number 2. Yes.
What should I say about defreezing as well, my lord, on my
Defreezing.
Oh, no objection.
In the light of the settlement arrived at as observed here and above, the accounts that are frozen off the petitioner shall be defrozen immediately. However, with an observation that in the event there is breach of undertaking, it would be the defreezing of the account will lead to refreezing of the account. Yes.
Oblige, please.
Date.
ನಾನೆಲ್ಲಿರ್ತೀನಿ, ಬರುತ್ತೆ ಬಿಡಿ.
Madam, date.
ನವೆಂಬರ್ ಅಲ್ಲಿ ಕೊಡಿ ಅಂತ.
Please.
November.
Oblige, please.
Serial number 174, my lord.
ಒಂದ್ ನಿಮಿಷ ಸರ್, ಸೆಟಲ್ಮೆಂಟ್ ನಿಮ್ದುನು ಮತ್ತೆ ವೇಟ್ ಇನ್ನೊಂದು ಇವ್ರದಿದೆ, SPP ಅವರೇ, ಬಗೇರ್ ಹುಕುಮ್ದಿದೆ. ಇವತ್ತಿದ್ಯಾ ಅದು ಯಾವತ್ತು? ವೇಟ್ ನಾವು ಕರ್ದು ಬಿಡಿ ಮೇಡಮ್ ಲಿಸ್ಟ್. ಸೆಟಲ್ಮೆಂಟ್ ಯಾವ್ದಿದೆ ಇನ್ನ? ಏನದು ಮೇಡಮ್? ಒಫೆನ್ಸ್ ಏನು? Pokso and who is going to settle it?
The victim girl is aged about 22 years and victim girl is present before the
so
court. They are
child
feeling
marriage
the
act ಅಂತೂ ಸೆಟಲ್ ಮಾಡೋದೇ ಇಲ್ಲ.
like the POCSO case, my lords. And you know,
ಅದು
the
ಬರ್ಲಿ ಬಿಡಿ.
parents were not involved in the sense. They themselves had married and after that, because she was convinced.
ಈಗ ಕಸ್ಟಡಿ ಇಲ್ಲ ತಾನೆ?
ಇಲ್ಲ, bail ಇದೆ.
ತೊಂದ್ರೆ ಇಲ್ಲ, ಫ್ರೈಡೆ ಆಗ್ತೇನೆ. ಫ್ರೈಡೆ
That's-
ಫರ್ದರ್ ಹಿಯರಿಂಗ್ ಅದು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಲಾಸ್ಟ್ ಟೈಮ್ ಕೂಡ ನಾವು ಹೇಳಿದ್ವಿ, but
ಲಿಸ್ಟ್
further
3 ಅಲ್ಲ,
list
ಏರಿ ಒಂದ್ ನಿಮಿಷ ಆಗಾದ್ರೆ. ಎಸ್, ಲಿಸ್ಟ್ 3 ಕಾಲ್ ಔಟ್ ಮಾಡಿ.
List number 3, further hearing, serial number 1.
ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ ಸ್ಟೀಲ್ ಹೈಪರ್ ಮಾರ್ಟ್, ಇದು ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಇಂದ ವಾಪಸ್ ಬಂದಿರೋದಲ್ಲ ಮೇಡಮ್. All these release these matters from all these matters from the status of being part heard and post the matters in the regular list for admission. Yes, interim orders wherever are there, continue ಮಾಡ್ಬಿಡಿ. Yes, next.
Serial number 10.
ಅದ್ಯಾವ್ದು ಇವ್ರದೇನಾ? ಇದೇನಾ?
This case, my lord, for the respondent.
ಅದಿರ್ಲಿ. ಎಸ್
Please.
ಅದಿರ್ಲಿ ಬಿಡಿ, ನೀವು ಕೊಡ್ತಾ ಇದ್ದೀರಲ್ಲ ಈಗ.
ಹೌದು.
ಈಗ ಪೇಮೆಂಟ್ ಬರ್ತಾ ಇದೆಯಾ?
ಬರ್ತಾ ಇದೆ.
75,000 ಬರ್ತಾ ಇದೆಯಾ ಇಲ್ವಾ?
ಕರೆಕ್ಟ್ ಟೈಮಲ್ಲಿ ಹೋಗ್ತದೆ, 1ನೇ ತಾರೀಕು.
ಕರೆಕ್ಟ್ ಟೈಮಲ್ಲಿ ಬರ್ತಾ ಇದೆಯಾ? ಸರಿ.
ಮೊದಲು 3ನೇ ತಾರೀಕು ಇತ್ತು, ಮತ್ತೆ 2 ಆಯ್ತು, 1ನೇ ತಾರೀಕು ಆಗಿತ್ತು.
ಆಯ್ತು, ಈಗ ಬರ್ಲಿ, ತಗೊಳ್ಳುವ ಅದನ್ನ.
ಹೆಗ್ಡೆ ಅವ್ರು ಹೇಳಿದ್ಮೇಲೆ ಬರುತ್ತೆ.
PP ಹೆಗ್ಡೆ ಅವ್ರು ಹೇಳಿದ್ಮೇಲೆ ಆಯ್ತು. ಈಗ ನಂತರ ತಗೊಳ್ಳುವ. ಯಾವಾಗ ಒಂದು 2 ವೀಕ್ಸ್ ಬಿಟ್ಟು, ಒಂದು 2-3 ವೀಕ್ಸ್ ಬಿಟ್ಟು ನೋಡು. ಇರ್ಲಿ,
ತಾವ್ ಹೆಂಗ್ ಹೇಳ್ತೀರ ಹಾಗೆ ಸುಮೇಶ್.
ಅದು ಬರ್ತಾ ಇರ್ಲಿ, ಅದು ನೋಡುವ.
ನೆಕ್ಸ್ಟ್ ಮಂತ್ ಫಸ್ಟ್ ವೀಕ್ ಅಲ್ಲ.
We'll take it on 11th September. 11th September.
11 is a good number.
9/11 na?
9/11.
Oh, 11. No. Yes. Not a good number. Yes, anyway. A date which has lived in infamy. Yes. Idu list on 11th September. For further hearing, all the conditions and the orders that are passed in the interregnum shall continue.
Great.
ಹೆಂಗೋ ಕ್ರೈಮ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ,
ಎಲ್ಲ ಚಾರ್ಜ್ ಶೀಟ್ ಆಗಿ.
ಚಾರ್ಜ್ ಶೀಟ್ ಸ್ಟೇ ಮಾಡಿದೀವಲ್ಲ, 75 ಹೋಗೋವರೆಗೂ ಅದಿರುತ್ತೆ. ಎಸ್.
No, no, I understand. Your lordship is trying to balance the equities, my lord.
Just
That's what the honorable High
Social
Court, my lord, sitting in
Hmm.
jurisdiction.
The matter of social justice.
Yes,
No, it is justice, not social need not be added to justice.
Matter of
whatever, according to you, according to him, master.
No, my learned friend Jagdish will always.
You
pick
may
up
not
social.
agree social justice, but he may say, so what?
No, I feel justice includes everything, that's all. And justice includes for this, both sides.
ಅದಕ್ಕೆ
The only
ಎರಡು
player is my lord.
ಬ್ಯಾಲೆನ್ಸ್
Your lordship
ಮಾಡಿರೋದು.
may-
75 75 ಯಾವತ್ ನಿಲ್ಲಿಸ್ತೀರಾ ಅವತ್ತು ಟ್ರಯಲ್
Your lordship may kindly grant justice for both, that's all, my lord.
ಟೆಸ್ಟ್. Yes, yes. September 11th
Please.
at 4 p.m. for
I
the
do
hearing.
Justice will met, my lord,
Huh?
if he marries, then only the justice.
ಏನು?
Justice will.
No, you should say,
ಅದು
you
ಆಮೇಲೆ.
should marry means.
That we'll see.
Yes, fine.
We'll see what happens.
The marriage, my lord, is always a continuation of the love. When the love stops, marriage stops, my lord.
Which is
Love
incorrect,
stops,
my lord.
marriage
What-
stops. Marriage starts, love stops.
Love stops.
Don't make dangerous statements here.
The
No, no, it's the
What is he saying? Marriage starts and love stops.
Because
Ah.
he wanted, he
How
says
long are you
they should
married?
marry.
How long are you
So your
married?
lordship is asking for the client or me? my-
ನಿಮಗೆ ಸರ್.
No, no, my words are only for the.
Only
But
for
he has
that.
given the child now. Now he is telling that love stops, marriage stops. Marriage stops, love stops. After giving the child.
ಏನ್?
We have seen, my lord, divorce starts when there is no love.
Without marriage.
No love.
No love.
Then the divorce starts, usually, my lords. And if the marriage has not happened, my lords, love should continue at least when the
After-
marriage happens.
After
And in
giving
the
the child.
loveology. Yes.
The practicology, my lord. Please, please.
ಆಯ್ತಾಯ್ತು ಸರಿ.
We hope love can prop up any time, my lord, because broken marriage.
We'll discuss about that.
No, no, my
Yes.
blooded friends' words, my lord, that there should be marriage. I'm all for it, my lords. But the conducive atmosphere must be there in both of them.
Oh, no, they will,
We
they will
provide
create,
it. We are ready.
Allah, they will create all conducive atmosphere. What do you want?
Tell
No
my lord.
objection.
Let let him
there
submit
can
before the
be-
court what he needs.
That can,
Conducive atmosphere court ಅಲ್ಲ.
Allala. Let him tell us. We will provide. my lord.
ನೀವು ಬಿಟ್ರೆ ನೀವು conducive my lord provider.
because everybody expects all sorts of relief from my lord.
Okay.
Order relief.
Yes, yes.
We are grateful.
Let it come on 11th at 4 p.m.
Please.
Yes, for the hearing.
By that time, all negativity be vanished. So
There is no negativity. If you marriage, all positivity. If you marry, rather.
I think my learned friend Xavier only, of course, he said it in a different tone, but intended to say, let love cultivate. That's all even.
That's all.
Satyavachan, yes. 11th.
Please properly summarize, my
Right,
lords. All of us say the same thing.
11th, yes, sir.
Much. Great. Great.
Continue.
Yes.
Orders 98, complaints.
For a short accommodation, they given me the application just now to stay the investigation.
ಯಾವುದು ಸರ್? ಒಂದ್ ನಿಮಿಷ. Number?
98 ಅಲ್ಲಿ ಅದೇನಾಗಿದೆ ಅಂದ್ರೆ ಇಬ್ರು ಪಾರ್ಟ್ನರ್ಸ್ ಪಟಿಷನರ್ ಅಂಡ್ ರೆಸ್ಪಾಂಡ್ ಟು ದ ಪಾರ್ಟ್ನರ್ಸ್ ನಂಬರ್ she has forged the documents and she has created 98 sale deeds and even there is a
DA for stay of investigation 2 years ಹಿಂದೆ ಇದು.
2 years ಈಗ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ್ರು ಸ್ವಾಮಿ.
ಈಗ ಎಷ್ಟು ಚೌಟ ಸರ್ ಈಗ ಹಾಕಿರೋದು ಅಪ್ಲಿಕೇಶನ್?
My lords, there was an interim order not to take coercive steps, which was 2 years back. Now, 3 events that have happened, my lords. There was an MOU between the parties settling all the disputes.
No instructions.
One day, sir, can I just explain? After the MOU was entered into, they disputed the MOU. That went before the arbitrator, my lords. The arbitrator held the MOU to be valid. Sale deeds are entered into. Now, despite that, my lords, we still now get notices from the police when the matter is seized by the arbitrator.
ಅದಕ್ಕೆ ಸ್ಟೇ ಕೇಳಿದ್ದೀರಾ?
Now we have asked for stay of proceedings and the complaint which I gave on the basis of which FIR is registered, there's a stay.
Your lordship posed me a
I
question
have to
last at a hearing. How many notices have been issued? We have issued 3 notices, my lord. Not responded, therefore we have issued first, second, third notices. I have all the notices.
My lords,
I get the instruction.
3 occasions.
Not to take course steps ಇತ್ತಲ್ಲ?
My lords, not to take coercive steps was there, my lords. Can I give the 3 aspects, my lords, which has arisen now for us to seek the present stay? 8, how many applications before the arbitrator? 13 applications before the arbitrator, my lords. All the 13 applications are held against them. The MOU
That's
was,
all right.
my lords, MOU was sent to forensic science.
You were not there earlier. Lakshminarayan was there, senior counsel. I had directed him to appear before the jurisdictional police. He has not appeared. Is the allegation?
No, my lords, the appearances that I've taken before the jurisdictional police three in number. I can give the dates when the appearance has taken place by the three accused. 3 times appearance has taken place. In the meanwhile, the matter is before the arbitrator.
That is a different thing.
And
When
there's
this order is passed, if there is a breach of this order, we will not entertain
Let's
it.
could I give the dates when we appeared before the
So
jurisdictional
we'll
police?
take it. Yes.
Let's could it be tomorrow or day
No, no, sir. We'll take it on Wednesday.
Wednesday?
Let them cooperate. I have a third notice.
On 29/7.
We're not cooperating with the investigation, no
Kindly
intelligence.
notice on 29/7 also we were before them.
The, list the matter,
And the Sen police station transferred this matter.
list the matter on Wednesday, in the same stage. The learned SPP would, however, submit that the petitioners are not, petitioner, Obraibra,
The three of them.
petitioners are not cooperating with the investigation in the, notwithstanding the order that is passed by this court on so and so. The learned learned senior counsel of the petitioner submits that they have in fact cooperated with the investigation. Therefore, list this matter on Wednesday. Cooperation to the investigation shall continue by the petitioners. We'll hear it on that.
On Wednesday.
On Wednesday, yes.
Would it be in hearing on
Same-
IA, my lord?
same
Because
stage.
It's in order, Siga.
ಅಲ್ಲ ಇರ್ಲಿ ಸೇಮ್ ಸ್ಟೇಜ್ ಎಸ್ ಐ
Hearing on-
ಆಮೇಲೆ ಬರುತ್ತೆ ಪರವಾಗಿಲ್ವಾ
ಇಲ್ಲ.
99 withdrawal.
ಇನ್ ಟರ್ಮ್ಸ್ ಆಫ್
100.
My lord, 99, I am appearing for the petitioner, my lord.
ಯು ವಿಡ್ರಾನ್
Yes, yes, yes. Grateful, my lord.
ಥ್ಯಾಂಕ್ ಯು ಎಸ್
100.
2 weeks I
Number
won't
100,
next.
my lord. I appeal for the petitioner in this case, my lord.
Yes, next
101.
withdrawal
102.
withdrawal
103.
ಮಂಜುನಾಥ್ ಗೌಡ್ರೆ ಎಂಟ್ರಿ ಮಾಡ್ರಿ ಇದೆಯಲ್ಲ
ಇದ್ರಲ್ಲಿ ಒಂದ್ರಲ್ಲಿ ಕೊಟ್ಟಿದೆ ಇನ್ನೊಂದ್ರಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಇದ್ರಲ್ಲಿ ಎಂಟ್ರಿ ಮಾಡ್ರು ಕೊಡ್ಬೇಕು
ಕೊಡ್ಬೇಕಾ ಕೊಟ್ಬಿಡೋಣ ಎಸ್ ಕೊಡಿ ಅವ್ರಿಗೆ ಎಂಟ್ರಿ ಮಾಡಿ ಕೊಡ್ಬೇಕಂತ
Lords, an inquiry under section 45A is still pending. Now on the premise that the stamp duty which is proportionate to the converted land having not been paid, criminal
Heard
prosecution
the
is
learned
initiated.
senior counsel, D.R. Ravi Shankar appearing for the petitioner. In the light of the interim order subsisting in criminal petition 2838 of 2026 stroke the companion petition, there shall be an interim order stay in the case at hand as well.
Please, Miller.
Yes, next.
104.
Post immediate, idira, learned counsel so and so undertakes to enter appear, hakidira okala.
Filed yesterday.
Submits that is entered appearance for the second respondent registry to print the name of so and so as appearing for the second respondent. Entry ಮಾಡಿದ್ಯಾ?
Yes, ma'am.
2 weeks IO. Next, objections if any, the next 2 weeks. Next.
105.
Lordship, in PCR is pending in 2025, 25 up 2019.
Entry ಮಾಡಿದ್ಯಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ ಏನು
No, notice ನಾನೇ ಮಾಡಿರೋದಾ?
ಹೌದು ಸ್ವಾಮಿ.
ಅಂದರೆ ಏನೋ ಪ್ರಾಬ್ಲಮ್ ಇದೆ. Yes.
It is my lordship, in the meanwhile is another petition is filed, complaint filed, my lord.
Post immediately after service of notice upon the second respondent. Yes.
Lordship, interim order.
ಅವತ್ ಬರ್ಲಿ. Yes, next.
Any date, my lord, one date.
Immediately, yes.
My lords, I
Post
appear for
immediately after
petitioner.
service of notice upon the respondent. Next.
Interim order may be extended.
Interim order ಇದ್ರೆ continue ಆಗುತ್ತೆ sir. Yes.
107.
Tomorrow I'll take steps.
Furnishing of.
ಏನಿದು?
That's for furnishing of steps, my lord. 64 is the appeal.
64 BNS.
BNS, please.
Stay ಇಲ್ವಾ?
Stay ಇಲ್ಲ.
List them at, charge sheet ಆಗಿದೆ.
ಇಲ್ಲ.
Your lordship, charge sheet is filed in this.
My instruction is not charge sheet.
ನಂದೇ ಆರ್ಡರ್.
Please.
ಚಾರ್ಜ್ ಶೀಟ್ ಚಾಲೆಂಜ್ ಮಾಡಿ.
Please.
ಚಾರ್ಜ್ ಶೀಟ್ ಫಾರ್ಮ್ಯಾಟ್. ನಂಬರ್ ಇದೆಯಾ ಮೇಡಮ್?
Yes, yes, sir.
CC ನಂಬರ್ ಕೊಡಿ ಅವ್ರು. Yes. Yes, next.
108.
Post immediately after service of notice. ನಿಮ್ದ?
Please.
ಎಂಟ್ರಿ ಮಾಡಿ ಉಂಟಾ?
Entry ಮಾಡಿ, sir.
ಅದಕ್ಕೆ ಸೈಲೆಂಟ್ ಆಗಿದೆ. Yes.
Please.
'Next, yes, next.
Await
notice. Post immediately service of notice upon the respondent.
Date might be given.
Same immediately. 110 also same order.
110 entry order ಇದೆ. It may be
ಇದೆಯಾ?
entry order ಇದೆ, my lords.
ವಿಕೆಟ್ ಮಾಡ್ಬೇಕಾ?
No, my lords.
ಮತ್ತೆ ಎಕ್ಸ್ಟೆಂಡ್ ಮಾಡ್ತೀನಿ ಬಿಡಿ ಸರ್. Yes.
Submission.
Huh?
111.1 notice had not been issued for the locate.
First matter, my lord.
And copy as.
ಏನ್ matter ಏನು?
First matter.
Proceedings under 13 has been initiated.
Huh?
Proceedings under section 13 of the Prevention of Corruption Act.
PC Act.
Please,
ಹಾ.
madam.
This is
There is a stay of.
SLO order, my lord, this.
Oh, that
Land
SLA
acquisition,
matter.
acquired matter.
List the matter on 13th, madam. 13th, alla? 13th, 10th. List the matter on 10th.
Copy may be served to me.
Petitioner, ಯಾರ ಹೆಸರು ತೋರಿಸ್ಬೇಕು ರೆಸ್ಪಾಂಡಿಗೆ?
Second matter will Binu.
That's for
First
R
matter
two.
ಸೆಕೆಂಡ್ ಮ್ಯಾಟ್ರಲ್ಲಿ
Binu is the same.
ಕೇನ್ ಸುಬ್ಬಾರೆಡ್ಡಿ ಇಲ್ವಾ?
ಇಲ್ಲ,
I appear for case.
No, for respondents.
ರೆಸ್ಪಾಂಡೆಂಟ್ ಬಿನು ಇಸ್ ಆಲ್ರೆಡಿ ದೇರ್.
First matter we will file ವಕಾಲತ್.
ಯಾವ್ದು ಲತೀಫ್ ಬದಲು?
ಇಲ್ಲ. Latiff ಬದಲು defecto
My lords,
complaint.
for de facto complaint.
Complainant.
We are for the.
Registered to print the name of Binu M as appearing for the complainant.
Yes.
In 111. In 111.1 is already, Binu is already.
My lords,
Copy serve ಮಾಡಿ.
Please.
Yes.
our name has not been
Stay-
shown.
stay me-
Our name has not been shown in 111.1, my lords.
Registered to print the name of B Latif as appearing for the Lokayukta in 111.1.
Copy to be served.
Petitioner to serve set of papers upon the council. Next,
Please.
Monday.
Please.
Next.
Stay may be continued.
ಇದೆಯಾ?
ಇದು last granted my lord.
ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ.
Please.
ಇಲ್ಲ ಅಂದ್ರೆ ಅದು
ಇಲ್ಲ
ಕಂಟಿನ್ಯೂ.
ಎರಡರಲ್ಲಿ ಇದೆ. Both matters.
Yes. ಮಾಡಿದ್ರೆ ಕಂಟಿನ್ಯೂ. Yes, next.
My lords, 112, can it be taken up after 10 days,
Pardon?
my lords? 10, 112.
ಹಾ.
The IT department is before my lords seeking relaxation of a condition imposed, my lords.
ಈ ಡಿಪಾರ್ಟ್ಮೆಂಟ್ ಕಂಡೀಷನ್ ಯಾರು ಇಂಪೋಸ್
ಅಲ್ಲ,
ಮಾಡಿಲ್ಲ?
release of cash ಗೆ without seized amount.
ವಿತೌಟ್ ಎನಿಥಿಂಗ್ ರಿಲೀಸ್ ಮಾಡ್ಬಿಟ್ಟಿದಾರಾ?
My lords, we are seeking a modification of the,
ಆಯ್ತು, ವಿಲ್ ಸಿ. ಯಾರು who should be heard? Nobody.
my lords, accused number,
Then serve on them.
yes,
The petitioner furnish PFS ಕಟ್ಟಿಲ್ಲ.
ಹೇಳಿ.
A week's time is granted to do the needful. List the matter on 24th in the fresh matters list. In the event needful is done.
Very well.
Yes. Ayappa.
113. Should matter has been connected with serial number 83.
Serial number?
83.
83 is over already.
This matter has
Yes,
been
tag
connected.
along with 83.
May the
Yes.
interim order be extended.
Interim order will continue, madam.
Great.
Is that matter?
ಅಲ್ಲ, ಅವ್ರಿಗೆ ಅಲ್ಲೇನ್ ಸ್ಟೇ ಕೊಟ್ಟು ಫರ್ದರ್ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಕೇಳಿದ್ದಾರೆ.
This is that matter, my lord. There is an objection saying that we issued a 126 notice
ಹೌದು,
to the
correct.
minor.
ಹಾ.
And if their own complaint, my lord, they don't say that this particular.
No, that ಇನ್ನೊಂದು ಪೆಟಿಷನ್ ಹಾಕಿದ್ದಾರೆ 83 ಅಲ್ಲಿ, ಬೆಳಗ್ಗೆ ನೀವು ಇರ್ಲಿಲ್ಲ ಅದ್ರಲ್ಲಿ.
Their own
ಅದಕ್ಕೆ
petition, they don't say. this
ಎರಡು
particular
ಟ್ಯಾಗ್
victim-
ಮಾಡಿ ಒಂದಿನ ಹಾಕ್ತೀನಿ. Tag with 83 list on 25th. Yes. ಅಲ್ಲ, ಅವತ್ತೇ ಹಾಕಿ 11th ಹಾಕಿ. ಹಾ, ಸೇಮ್. Yes. Next. 114.
114.
ಹ್ಮ್.
115.
114 ಅರ್ಜನ್ ಆಗಿದೆಯಾ?
KSCM.
ಓ, ಅದೇನಾ ಅದು? ಆಲ್ ರೈಟ್. ಸ್ಟ್ಯಾಂಪೀಡ್ 115. Yes.
IO is there, my lords, this may be
Interim order will continue. Yes. 115.
interim order to be extended, my lords.
Interim order. Post immediately after 115, post immediately after service of notice upon the respondent, interim order continue ಮಾಡಿ.
116.
Same order, interim order continue ಮಾಡಿ.
Admission 117.
I am appearing for petitioner, my lord.
2022 ಯಾಕೆ ಇಲ್ಲಿ ಮೇಡಮ್? ಓ, ಕನೆಕ್ಟ್ ಆಗಿದೆಯಾ? ಏನ್ ಮ್ಯಾಟ್ರ್? 2 weeks IO. ಅರ್ಜೆನ್ಸಿ ಇದೆಯಾ? 2 weeks IO. Next.
118. Update item.
118 date ಆಯ್ತು. Yes. 19.
119.
For the petition. And the annexure A and D, that is the impugned FIR and charge sheet. The
Offense ಏನ್ ಸರ್?
SCST Act, offense under SCST.
ಸ್ಟೇ ಇಲ್ವಾ?
ಇಲ್ಲ, stay.
ಕೊಡಿ. Notice issued by me or what?
Not. The money dispute between the petition and petitioner are the contractor, house construction contractor.
Who is the contractor?
Petitioner, petition number 1 and 2.
ಅವ್ರೇನು?
Father and son.
No, no.
Complaint is the site owner.
In the meantime. Yes, next. State.
Please.
120.
For the respondent number 2, my lords, a short date may be granted for
I
leading
appear for the petitioner, my lord.
arguments.
Offense.
Offense of criminal breach of trust and deletion of the data. This is arising out of the arbitration petition.
Interim order ಇದೆಯಲ್ಲ?
Interim order is.
2 weeks IO. Next.
Date may be kindly be fixed.
Yes, yes. Next.
121.
ಏನಿದು 13 7
Section 7, madam. Section 13(1)D, 13(2) of PC Act.
13(1)D
D.
ಅಂದ್ರೆ Monday, yes. 13(1)D na?
Section 7, 13(1)D and 13(2).
7 ಇದೆ.
7 is.
Yes, all right. Monday.
122.
It's a matter where the allegation is of the husband that he pushed, the wife pushed the husband is the allegation.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
Stay ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮೈಲಾಡ್ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಫಾರ್ಮ್ 2 ಅಬ್ಜೆಕ್ಷನ್
ನೀವಿದ್ದೀರಾ?
ಹೌದು. ಸೊ ಅಬ್ಜೆಕ್ಷನ್ ಟು ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್ ಆಫ್ ಪ್ರೊಸೀಡಿಂಗ್ ಅಂತ ಹೇಳಿ ಫೈಲ್ ಮಾಡಿದ್ವಿ ಅಪ್ಲಿಕೇಶನ್.
ಅಬ್ಜೆಕ್ಷನ್ ಟು ಲೈವ್ ಸ್ಟ್ರೀಮಿಂಗ್?
ಹೌದು ಮೈಲಾಡ್. ಏನಾಗ್ತಿದೆ ಯೂಟ್ಯೂಬ್ ಅಲ್ಲಿ ಪಬ್ಲಿಷ್ ಆಗಿಂದ ಅದನ್ನ ಕಟ್ ಮಾಡ್ಬಿಟ್ಟು ಬೇರೆಯವರು ರೀಪಬ್ಲಿಷ್ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಬೇರೆ ಬೇರೆ ಇಮೇಜ್.
ನಿಮ್ಮ ಅಬ್ಜೆಕ್ಷನ್ ತಗೊಂಡು we will close live streaming, don't worry. Yes.
ಹೌದು. ಮತ್ತೆ ಏನಾದ್ರು ನ್ಯೂಸ್ ಪೇಪರ್
List after 2 weeks. List after 2 weeks. Next live streaming ಇಲ್ಲದೆ ಇರೋ ಜಡ್ಜ್ ಕೂತ್ಕೊಂತಾರಲ್ಲ ಅವ್ರ ಮುಂದೆ ಆರ್ಗ್ಯೂ ಮಾಡಿ. Yes. Next.
23.
That's for the petitioner, my lords. 125 BNS, my lords, Act endangering life or personal safety. Rash and negligent drive. The substratum of the complaint is that, my lords, I was driving rash in negligent manner. However, my lords, accused number 2, who is also the complainant, he has pleaded guilty, wherein he has stated that
accident caused by the negligence in the driver. Offense or charge in the
ಅಲ್ಲಿ ಇನ್ನೊಬ್ರಾಗ್ಲೇ ಪ್ಲೀಡ್ ಗಿಲ್ಟಿ ಮಾಡ್ಕೊಂಡಾಗಿದೆ ಮತ್ತೇನ್ ಸರ್? ಅಲೋಡ್ ಕಾಸ್ಟ್. Next.
Machu.
Next.
124.
Lordship, this matter covered by your Lordship's judgment of Lofty Khanna. Lordship, where mediation has
Lofty
taken.
judgment?
Lofty's judgment covered by your Lordship. It's a very similar case.
Who is the respondent?
Respondents here, your Lordship.
Who is the counsel?
So counsel left for the day.
Left for the day. Why judge is sitting, counsel left, is it? Who is that counsel?
They were there, last 3 occasions they were there, your Lordship. She just left this. Lordship, post mediation, when mediation fails after that.
Stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ.
Say only as against the father and sister, your Lordship, as against husbands not there. Even Supreme Court judgment squarely on this, it falls, your Lordship.
We'll see. Heard the learned senior counsel Srimati Lakshmi Iyengar appearing for the petitioner. List the matter on, we'll close this on the next date. List the matter on 20th. And the same stage, interim order subsisting will continue to the next date of hearing.
Admission won't reach, your Lordship.
ಅಲ್ಲ ಈಗ ಅದು ಉಲ್ಟಾ ಆಗಿರುತ್ತೆ ಅವಾಗ ಅಡ್ಮಿಷನ್ ಮೇಲೆ ಬರುತ್ತೆ.
Obliged.
125.
ಅದೇ ತಾನೇ ಇಷ್ಟು ಡಿಕ್ಟೇಟ್ ಮಾಡಿದ್ದು.
125.
For the petitioner, that's an intimate
ಇಲ್ವಾ? ಇಂಟಿಮೇಟರ್ ಇಲ್ವಾ?
ಅದರಲ್ಲಿ ಮೆಲೋಡ್ಸ್ ಫಿಂಗರ್ ಪ್ರಿಂಟ್ ಎಲ್ಲಾದ್ರ ಮೇಲೂ ಸಿಕ್ಕಿದೆ. ಅವ್ರ ಫಿಂಗರ್ ಪ್ರಿಂಟ್ಸ್ ಎಲ್ಲ ಗೋಲ್ಡ್ ಮೇಲೂ ಸಿಕ್ಕಿದೆ.
ಎಲ್ಲ ಗೋಲ್ಡ್ ಮೇಲೆ?
ಹೌದು ಮೇಲೋಡ್.
ಏನ್ ಸ್ಟೀಲಿಂಗ್ ಆಫ್ ಗೋಲ್ಡ್?
Receiving of stolen.
1.6
Receiving of stolen gold.
1.6 kgs ಮೇಲೋಡ್ಸ್ ಟೋಟಲ್.
ಏನ್ ಸೆಟಲ್ಮೆಂಟ್ ಮಾಡ್ಕೊಳ್ಳಿಲ್ವಾ?
I have to seek
ಮಾಡ್ಕೊಳ್ಳಿ, ತೊಂದ್ರೆ ಇಲ್ಲ. ಮಾಡ್ಕೊಳ್ಳಂಗಿದ್ರೆ ಲಿಸ್ಟ್ ಆಫ್ಟರ್ 2 weeks.
Much obliged, madam.
Yes, next.
126.
Offense of forgery and cheating, please, my lord. Complainant and accused are Australian citizens, husband and wife, please, my lord.
So?
He has, the court of Australian magistrate court had asked to file a report for valuing a particular property in Bangalore, please, my lord. That report, in compliance of the order, I have filed it.
Stay ಇದೆಯಲ್ಲ?
Stay A3 ಗೆ ಇದೆ, my lord, connected. A8 ನಮ್ಗೆ A2 is quashed also by your lordship.
ಕೊಡಿ. There shall be an interim order of stay of further proceedings square these petitioners till the next date of hearing.
Interpol warrant also is issued.
ಇದು ಸ್ಟೇ ಮಾಡಿದ್ದೀನಿ, ಅಡ್ವಾಂಟೇಜ್ ತಗೊಳ್ಳಿ. ಎಸ್.
127.
Let's ACST Act.
Report will be filed shortly.
ಬಿ ರಿಪೋರ್ಟ್ ಫಾರ್ಮ್ಯಾಟ್ ಕ್ಲೋಸ್ ಮಾಡಿರ್ತೀನಿ. ಕಮ್ ಬ್ಯಾಕ್ ಇಫ್ ದೇರ್ ಇಸ್ ಎನಿ ಪ್ರಾಬ್ಲಮ್.
DG ಗೆ ಹೋಗಿ ಅಲ್ಲಿಂದ ಪರ್ಮಿಷನ್ ತಗೊಂಡು ಅದು ಬರ್ಬೇಕು. ACST ಕೇಸ್ ಯೂಶಲಿ DG ಹೋಗಿ ಬರ್ಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ.
ನೀವು ಯಾಕೆ ಅದಕ್ಕೆ ನಿಮ್ ಚಿಂತೆ ಯಾಕೆ? ಅವ್ರು ಹೇಳಾಯ್ತಲ್ಲ ಬಿ ರಿಪೋರ್ಟ್ ಆಗ್ತೀವಿ ಅಂತ. ತುಮ್ ಫಲ್ ಕಾವ್ ಪೇಡ್ ಗಿನ್ನೆ ಕಿ ಜರೂರತ್ ನಹೀ. Yes. Both matters be report format. Yes.
Cancellation mail ಬಂದಿದ್ದಾರೆ. One will not survive.
ಯಾವ್ದದು? ಯಾವ್ದು?
One criminal petition, my lords.
Number ಹೇಳಿ ಸರ್.
6131 of 26.
6131 cancellation of bail.
Yes, my lords.
The petitioner is before the court seeking the following prayer in the light of the closure of the proceedings in WP 12038 of 2026, the petition calling in question the cancellation of bail would not survive for consideration. Therefore, the petition is disposed as having become infructuous. Second, 27.1 B report format. Yes. ಏನಾದ್ರು ತೊಂದ್ರೆ ಆದ್ರೆ ವಾಪಸ್ ಬನ್ನಿ.
Great.
Yes.
128.
For responding with two, my lords.
Offense under section 85 of BNS, my lords. That is an interim order.
2 weeks.
My lords, we filed an application for vacating of stay, my lords. The short accommodation may be granted, my lords.
Have you filed, madam?
Please, my lords, a short accommodation to argue on the same, my lords.
Learned counsel. No, if you have filed vacating stay, I'll post it.
Please, my lords, we have filed, my lords.
The registry is directed to put up the application said to have been filed seeking vacation of the interim order on the next date. List the matter on 20th under the caption.
Obliged.
Applications. Yes, next. Interim order continues.
Obliged.
Next.
129.
I pay for the second respondent, my lord.
ಏನಿದು?
ಇದರಲ್ಲಿ
interim order ಇದೆಯಾ?
No interim order.
There is no interim order?
No interim order.
No, my lord.
Malas, the thing is, Malas, on the day advocate appeared and taken time to file objection, Malas, I saw the copy also. Well, the thing is, Malas, he is not a student, he is not a parent, Malas, he is a third. He is alleging that I have received an amount of rupees 1 crore for 45 lakhs with respect to the medical seats are concerned, Malas.
Medical seat?
Yes, Malas. Malas, these allegations are made against accused number 1. I am accused number 2, Malas.
Who is, you are the wife of accused number 1.
The thing is, Malas, I have not single pay, Malas. He has said that, Malas, it will be transferred to the account, Malas. I have not received single pay from the accused. Moreover, Malas, those students are studying in the different colleges. They are all obtained the seats, Malas.
My lord, she is the chairman. Monies, she has also received a couple of. She is the chairwoman, of course, chairman of the Barkotidare. She is the chairman of the institution. She has also received the monies along with her husband, who is the first accused.
Oh, you mean to say she's the queen pin?
Absolutely, my lord.
Oh, exactly.
Malas, he has not put the document to show that I have received an amount, Malas. Moreover, he is not a student.
Husband and wife, sir.
Malas, 1 minute.
How can you give up your husband like this?
Malas, he is not a student.
You can't when you have.
Complaint is not a student, Malas. Complaint is not a parent of the students. He is not. Malas, no way connection to the.
Objection, Aki Mahesh.
Please, my lord.
Investigation papers.
Please.
ಇದೆಯಾ? ಕೊಡಿ. Yes. List the matter on 19th.
Obliged, my lord.
ಎಷ್ಟು ಸೀಟ್ ಕೊಡಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿದ್ರಿ?
Malas, I have not taken undertaken, Malas. I am just advised.
Your husband.
Wherever the seats are available, that is our duty, Malas.
Your duty.
It is my duty, Malas.
ಅಲ್ಲ ಜನರನ್ನ ಲೂಟಿ is your duty.
Malas, Malas, if the substantive, I have received a single pay from the list he has given, Malas.
ಆಯ್ತು ನೋಡುವ.
Obliged, my lord.
130.
ಇದು ಸ್ಟೇ ಆಗ್ಬಿಟ್ಟಿದ್ಯಾ?
Adalli, initially, based on initial input, I made a submission 39 lakhs she has to pay. But ultimately.
Correct, ಅವ್ರೇನೋ ಕೊಡ್ತೀನಿ ಅಂದ್ರಲ್ಲ.
They have to pay, ultimately now, 1.27 crores has been transferred to this petitioner.
ಸರಿ ಬಿಡಿ ಬರ್ಲಿ ಅವ್ರು. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಈಗ ಬೇಡ. ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ 6 ಗಂಟೆಲ್ಲ. Yes, list the matter after 2 weeks. Yes, next.
131.
131 appearing for the petitioners, my lordship. Case.
List on 19th.
My lordship, interim order may be granted.
ಯಾಕೆ next date ಏನು?
3 times.
Next date ಏನು? ಆಯ್ತು ಪರಲ್ಲ. 19th there shall be an interim order of stay for the proceedings quay the petitioner to the next date of hearing. 19th interest matters will dispose it. Next.
132.
Magazine.
Huh?
Magazine, already I have submitted.
Magazine. 132. List after 2 weeks, yes.
133.
Petitioner, my lord. For the respondent number 2 and 3, my lords. Section, BNS section 291, dog bite case, my lord.
2 weeks, I will. Next.
Interim order.
134.
134 ಅಲ್ಲಿ the matter has been settled before the family court Chikkaballapura, your lordship.
This is.
The other side is not cooperating. I have also.
Interim order, 2 weeks, I will. Next. Interim order ಇದೆಯಲ್ಲ?
Copy ಎಲ್ಲ ಹಾಕಿದ್ದೀನಿ.
Interim order ಇದೆಯಲ್ಲ sir? Yes.
135.
19th. ನಿಮ್ಗೂ interim order ಬೇಕಾ?
It is the third time it was leased.
ಆಯ್ತು. ಸೇಮ್ ಇಂಟರ್ಮ್ ಇವ್ರದ್ದು ಯಾವುದು ಸೀರಿಯಲ್ ನಂಬರ್ 131 ಗೆ ಏನ್ ಬರ್ದೆ ಅದೇನೆ. ನೆಕ್ಸ್ಟ್
Split up charge sheet.
ಸೇಮ್ ಆರ್ಡರ್. ಎಸ್.
Same order.
ಕೊಟ್ಟಾಯ್ತು. ನೆಕ್ಸ್ಟ್
137.
Appearance for the petitioners. A memo for withdrawal file matters.
Thank you, sir.
Police have filed the charge sheet. Liberty may given to
ಕೊಡಿ
challenge the charge sheet.
Yes.
138.
For petitioner, maybe release this matter on Tuesday in the fresh matters.
ಆಯ್ತು. ರಮಾನಂದ್.
I for the respondent to my lord. The entire charge sheet is only copies of documents. No original documents have been produced.
Again,
Ledger account, because there is an accusation, I have created a loss of
ಆಯ್ತು. ಇದು
50,000.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಫ್ರೆಶ್
All
ಮ್ಯಾಟರ್ಸ್.
those documents have been.
ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್ ಲಿಸ್ಟ್. ಎಸ್.
140.
The matter where delay has been condoned improperly, my lord, in an NI Act matter. There is also the issue.
Day after tomorrow will close. Well, have you served on the other side?
I've served, my lord, I filed the wakalat as well.
I 2 weeks I next.
My lord,
Intermod ಇದೆಯಲ್ಲ. Next.
141.
My lord, sir, 13A, connected matter, my lord, A1, my lord, has granted the interim order and reserved for the judgment.
ಹೌದಾ? ರಿಸರ್ವ್ಡ್ ಯಾವುದು?
My lord, sir, the writ petition number 17437 of 26.
ಆಯ್ತು. ಇದನ್ನ ಮಂಡೇ ತಗೊಂತೀನಿ. By then if it's possible. Yes. Same 142 ಅದೇನಾ?
ಹೌದು. Different crime number, but similar, same allegation.
All right. Yes.
Please.
Hearing on IA 143.
Petitioner, my lord, 4 weeks time, my lord. We have approached the bank.
Vacating stay ಇದೆ madam.
State
We had undertake to repay the deposit. I mean
No.
deposit.
Wait. List the matter on 20th in the same stage. Yes. No 4 weeks time in this. In the fresh matters ಹಾಕಿ. Yes. Interim order ಇದೆಯಾ? We'll continue to the next date. Yes.
144.
Same 20th.
145.
Status filed.
20th. Heard learned senior counsel as Sriranga appearing for the petitioner. 20th. ಈಗ 6 ಗಂಟೆ ಆಯ್ತು. Yes.
146.
20th.
147.
ಇದು 13 7 ಸತೀಶ್?
13.
ಮಂಡೇ.
For the respondent.
ಇದೇನು?
Interim order.
You filed an application for
Application, the matter is pending before the arbitrator. If I succeed, my lord, the writ petition deserves to be allowed. If he succeeds, writ petition will go.
Where?
The arbitration is pending before the.
So what do we do?
My lord, the interim order may be continued, my lord. The estate officer has no jurisdiction now.
Basically, the arbitrator has already passed an order under section 16. That, I mean, he does not have any jurisdiction under the public premises.
I will hear it then.
My lord, that must be, writ petition must be heard.
The writ petition will be heard. Yes. List the matter on 25th. List the matter on 25th in the fresh matter, since it's special or fresh matters list.
Very well.
Convenience compilation.
Interim order may be continued.
Heard the learned senior counsel ಅಂತ ಹಾಕಿ ಆಮೇಲೆ interim order will continue to the next day. Yes.
149.
Appear for petitioner, my lord. Next week, my lord.
20th. Yes. Next. That will continue. Sir, ಇದೇನು special order?
That's 150.1. I'm withdrawing the petition.
ಇದಾ?
150.1.
150.1. ಆಯ್ತು. Petition in terms of the memo. 150. 20th document.
My lords, I appear for the petitioners in this matter in 150.
Next.
My lords, there's been a bereavement in the petitioner's family, my lords. May 2 weeks be granted.
20th, sir. Yes.
151.
Same.
For the respondent, my lords.
20th.
152. Preliminary hearing.
All preliminary hearing matters on 20th. Yes. Interim order ಇದೆಯಾ? ಇದ್ರೆ 2 weeks. Yes. Interim order ಇರೋ ಕಡೆ 2 weeks ಆಯ್ಬೋ, ಇಲ್ಲದೆ ಇರೋ ಕಡೆ 20th.
My lords, vacating IA.
ಯಾವ್ದ್ರಲ್ಲಿ vacating ಇದೆ?
151.
That 20th date ಕೊಟ್ಟಾಯ್ತಲ್ಲ. Yes.
153 case and counter case.
Whatever it is.
They have settled the matter, my lords.
Settled.
Friday, ಹೌದು.
ಆಯ್ತು. Friday. 153 to report settlement on Friday.
My lord, 154 connected.
ಇದೆಲ್ಲ ಅದೇನಾ? 3 ಅದೇನೆ. 158 ತಗೊಳ್ಳಿ ಮೇಡಮ್. 155 ಮಂಡೇ.
156 also same.
156 ಮಂಡೇ.
157,
ಆಮೇಲೆ ಮಂಡೇ
158,
ಮಂಡೇ ಆಲ್ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ಸ್ ಏನಾದ್ರು ಇದ್ರೆ ಕಂಟಿನ್ಯೂ ಮಾಡಿರಿ. 152 ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದೆಯಲ್ಲ ಮೇಡಮ್? ನೋ ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಇದ್ರೆ ಮೇಡಮ್ 20th.
154 connected with 27, madam, 27 least 2, my lord, maybe joint.
ಸೆಟಲ್ಮೆಂಟಾ?
ಇಲ್ಲ sir, 27 ಎರಡು ಒಂದೇ ಮ್ಯಾಟರ್ ಇದೆ.
ಮೇಲ್ಕೋಟೆ ಟೆಂಪಲ್ ಥೆಫ್ಟ್.
ಎರಡು ಒಂದೇ ಇದೆ, 27 ಇದೆ.
ಆಯ್ತು, ಅವತ್ತೇ ಕೇಳುವ.
ಅಲ್ಲ ಸರ್, 27 ಸೀರಿಯಲ್ ನಂಬರ್ 27 ಲೀಸ್ಟ್
ಏನ್ ಬೇಕೀಗ?
ಕನೆಕ್ಟೆಡ್ ಮಾಡಿದ್ರೆ.
ಆಯ್ತು ಸರ್. ಎಸ್
171, my lords, for dictating.
List 3.
Serial number 6, my lords, settlement, my lords. The parties are present before the court, my lords.
Serial number 7, Karthik.
6.
Karthik. 7.
ಲಿಸ್ಟ್ ಅಕ್ಷಯ್ ಹುದ್ದಾರ್ಥ
ಅಲ್ಲ
ಮೇಡಮ್? ಮತ್ತೆ
ಕಾರ್ತಿಕ್
ಇದು ಅಲ್ಲ, ಅದಾಯ್ತು. ಅವರು ಜೈಲ್ ಇದಾರಂತಲ್ಲ, ಎಲ್ಲಿ ಅರುಣ್ ಶ್ಯಾಮ್. ಆಮೇಲೆ ಇವ್ರದ್ದು ಬೇಲ್
My lord.
174.
List 5, first matter.
10, my lord.
ಅಲ್ಲ ಆಯ್ತು, ಬಟ್ ಅದು ಅವ್ರಿಗೆ ಬೇಲ್ ಕೊಟ್ರೆ ಏನಾಗುತ್ತೆ? ಏನಾಗಲ್ಲ.
No, there is a legal point, my lord, that this will have an impact on, and I have seen your lordship judgment. Your lordship judgment does not deal with this issue. Your lordship judgment deals with the issue whether the day of arrest or day of remand should be calculated. There are coordinate bench judgments, my lord, and I'll place it, my lord. There is the legal point. I am not on this particular.
ಇದು ಕೊಟ್ಟರು ಕನ್ವಿಕ್ಟ್ ಆಗಿರೋದೆ.
Barala, but that will be tomorrow. Everybody will bring that judgment and say this is how the law has to be interpreted. So that will, it has a bearing impact on, because in this court has held, and Supreme Court has also held. In body warrant, we cannot keep them in custody. We cannot.
Anyway, ಆಯ್ತು, we'll see.
Yes, madam.
Because charge sheet is filed on 239th day. We'll see. List the matter Friday.
For settlement, my lord.
Fresh matter. We'll take it in fresh matter because it's a bail matter. We'll take it in fresh matter. ಅವ್ರದ್ದು ಅಷ್ಟೇ, ಅರುಣ್ ಶ್ಯಾಮ್ ಶುಕ್ರವಾರ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಈಗ
I can understand.
ಆರು ಕಾಲಲ್ಲಿ ಏನ್ ಮಾಡ್ಲಪ್ಪ?
He has got some medical issue.
ಆಯ್ತು, day after tomorrow fresh
hospital today.
Day after tomorrow I'm commencing the sitting at 10 o'clock. So we'll
Tomorrow, my lord.
tomorrow ಆಗಲ್ಲ, ಇವತ್ತು ಆಗದ, ಲಿಸ್ಟ್ ಮಾಡ್ಸಕ್ಕೂ ಆಗಲ್ಲ.
Friday I have some inconvenience also.
ಇರಿ, ಎಲ್ಲಿ ಹೋಗ್ತದೆ ಅವ್ರಿಗೆ ಬಿಡಿ. ಎಲ್ಲಿ ನಿಮ್ ಕೊಲಿಗೆ ಸುಯೋಗಿಲ್ವಾ? ಎಸ್,
I'll have tomorrow, my lord. I request. I take chance, I'll take chance.
ಲಿಸ್ಟ್ ಕ್ಲೋಸ್ ಆಗ್ಬಿಡಿದೆ. ದಟ್ಸ್ ದ ಹೋಲ್ ಪ್ರಾಬ್ಲಮ್. 6 o'clock ಆಗಲ್ಲ, 5 o'clock ಆಗಿದೆ.
Objections are already filed, my lord. Lordship
ಕರೆಕ್ಟ್. ಫ್ರೈಡೆ ಫ್ರೆಶ್ ಮ್ಯಾಟರ್ಸ್. ಇಲ್ಲ ನಿಮ್ಗೆ ಇನ್ಕನ್ವೀನಿಯನ್ಸ್ ಇದ್ರೆ ಮಂಡೇ.
ಬೇಡ, ಫ್ರೈಡೆ ನಿಮ್ಗೆ.
ಫ್ರೈಡೆ. ನೀವು ಊರಿಗೆ ಹೋಗ್ಲಿಕ್ಕೆ ಉಂಟಾ?
Passed out 43.
ಎಸ್. ನೀವೇನೋ ಹೇಳಿದ್ರಲ್ಲ, ಯಾರ 175(3) ವೈಲೇಷನ್ ಕೊಡಿ. List it on Monday in the fresh matters list till such time further proceedings before the concerned court shall remain stayed. Although it has to be sent back. Jagdish sir, 175(3) violation. No report is called from the IO.
It has to be.
Direct reference. ಎಲ್ಲ ಕೋರ್ಟ್ ಮುಗ್ದೋಯ್ತು, ಇದೊಂದು ಬಾಕಿ ಇದೆ ಅಂತನ? ಎಸ್, ಮಂಡೇ ಮತ್ತೆ
Passed out 77.
Yeah, appear for respond number 2, your lordship. In 77.123, your lordship.
Attica Gold SP pair.
Yes. Respondent is not there. Respondent.
ಇಲ್ಲ, ಇದಾರಲ್ಲ, ತಗೊಂತೀವಿ ನೋಟಿಸ್ ಅಂತ. ತಾಹಿರ್.
Please, lordship.
The learned counsel Mohammad Tahir accepts notice for the respondent complainant in all these cases. All right, list this matter on stay ಕೊಟ್ಟಿದ್ದೀನಲ್ಲ ಎಲ್ಲ.
Monday, my lord.
List this matter on Monday na?
Monday.
Tuesday. List the matter on Tuesday in the fresh matter. Wednesday in the fresh matters list.
Meanwhile, copy to be served, your lordship.
ಎಲ್ಲ ಕಾಪಿ ಕೊಟ್ಬಿಡ್ರ. ಗೋಲ್ಡ್ ಅಲ್ಲ, ಕಾಪಿ ಮಾತ್ರ.
Interim order to be extended in 77.4.
ಏನು?
Interim order to be extended. Interim order is there in 77.4, your lordship.
ಎಲ್ಲಿದ್ರು ಕಂಟಿನ್ಯೂ ಆಗುತ್ತೆ ಸರ್. ಎಸ್.
Please, lordship.
ನೆಕ್ಸ್ಟ್.
81.
In this case, my lord.
The invocation of the coca.
ಇದು ಕೋಕಾಯಿನ್ ಹೋಗ್ ಮಾಡಿರೋದು ಸ್ಟೇ ಮಾಡ್ಬೇಕಾ?
Objections are ready, madam.
ಹಾಕಿ ಕೊಡಿ ಮತ್ತೆ. The learned SPP submits that the objection should be filed in the next 24 hours. List the matter on 19th, fresh matters. ಏನು? ಇರ್ಲಿ ಪರವಾಗಿಲ್ಲ. 19th fresh matters. Next.
230 mood matter for reporting settlement. Hello. Shehudar.
Offense. 74 and?
25.
Where is the complainant? Where is the counsel for the complainant? Yes, Jagdishwar. 74, 75. Who is the accused? Huh? Counsel for respondent number 2 Bekala. You are the complainant? You are withdrawing the complaint. Yes, we'll close it. Yes, complainant is present and submits that not wish to pursue the proceedings, signature mark.
Order sheet signatures.
Yes, next.
Further hearing in serial number 7 and 10.
ಇದು ಪೇರೆಂಟ್ಸ್ ಗಿಲ್ಲ ಒಂದ್ ನಿಮಿಷ SPP ಅವರೇ ಪೋಕ್ಸೋ ಸೆಟಲ್ಮೆಂಟ್ ಮದುವೆ ಆಗಿದೆ, ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ಇದೆ.
ಮಕ್ಕಳು ಬೇರೆ ಇದ್ದಾರೆ. Let the child marriage continue with against the parents.
ಚೈಲ್ಡ್ ಮ್ಯಾರೇಜ್ ರೆಸ್ಟ್ರೆಂಟ್ ಆಕ್ಟ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ. ಈ ಕಸ್ಟಡಿಲಿ ಇಲ್ಲ ತಾನೆ? ಸರಿ ಪರವಾಗಿಲ್ಲ ಕೊಡಿ. ವಿಲ್ ಕ್ಲೋಸ್ ಇಟ್ ಆನ್ ಯುವರ್ ಮ್ಯಾರೇಜ್, ನಿಮ್ದು ಅವ್ರದ್ದು, ಬಟ್ ಪೇರೆಂಟ್ಸ್ ಮೇಲೆ ನಡೆಯುತ್ತೆ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 2 ಕೌನ್ಸಿಲ್ ಇಲ್ಲಿ, ಕಂಪ್ಲೇಂಟ್ ಕೌನ್ಸಿಲ್ ಇಲ್ಲಿ. Don't do all this. Get the counsel. 7th ಹಾಕಿ. Yes. Madam.
One more matter being spoken to.
ಕೊಡಿ, ಇಂಪಾರ್ಟೆಂಟ್. ಎಲ್ಲಿ ಅವರು? ರಾಧಾ ಬನ್ನಿ.
ಅದರಲ್ಲಿ ನಾವು we have filed a final report, madam.
ಗಿರೀಶ್ ಎಲ್ಲಿ? ಇದಾರಲ್ಲ ಅವ್ರು. ಎಸ್.
172.
ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಆಯ್ತು. ಸರಿ 13 ಆಯ್ತು. 13.
My lord, 171. Serial number 171, my lord. It's for dictating orders. Dictating orders ಇದೆ.
ಈಗ ಮಾಡ್ಲಾ ಸರ್?
ಇಲ್ಲ, any short date.
Date ಕೊಡ್ತೀನಿ. I'll give a date.
My lords kindly.
What is ಯಾವ dictating orders madam?
171 ನಲ್ಲಿ ಸ್ವಾಮಿ.
What is that?
Connected matter.
A short date maybe.
Give a date. Yes. Oh, this matter.
Yes.
All right. Yes. 498.
498.
We'll dictate it on 12th. 12th ಹಾಕಿರ್ತೀನಿ. We'll do something.
Short submission.
ಮತ್ತೆ again.
Put in length.
Just 2 minutes.
Lordship permitted me ಅಂದ್ರೆ?
Permitted me to make that submission.
ಹಂಗೆ. All right. Don't show like this.
Serial number 7.
Yes.
12. My lord, sir, the written synopsis is filed.
172.
Petitioner.
ಈಗ CCBಗೆ ಕೊಟ್ಬಿಟ್ಟಿದ್ದೀನಿ, ನಿಮ್ಗೆ ಹಿಯರ್ ಮಾಡಿಲ್ಲ. I'll recall it. I'll hear you and pass orders.
Now the entire investigation is over. We have filed a B report. As against we found the petitioner is also not a real Radha.
That's a very.
Another petition where your lordship has dismissed, she is also not real Radha. The 2 Radhas are not real.
Then which is the third one now?
Third one is the other petition against whom
Yesterday.
ನೀವ್ ಯಾರು?
he is appearing for them.
He is not a party in the present petition.
ರಿಯಲ್ ರಾಧಾ?
Real Radha ಕಡೆಯಿಂದ transaction ತಗೊಂಡಿದೀವಲ್ಲ. Alright, this
First
has
time
led to
I'm seeing
incomplete.
4 Radhas.
Alright.
4 Radhas?
4 Radhas in one. For the sake of property.
Alright, the investigation being completed is, due respect to my friend, is incorrect statement. What was told yesterday in the coordinate bench is something else, and what.
Coordinate bench.
Alright, the.
Coordinate bench ಯಾಕೆ?
One matter was pending.
ಇನ್ನೊಂದು ಪೆಂಡಿಂಗ್ ಇದೆಯಾ?
ಇತ್ತು. There SPP made a statement, learned SPP made a statement that few accused my lords, they are filing a B report. And we informed to the honorable judge saying that my lords, your lordships have already transferred and that is being listed for further hearing at the instance of the state. Recording the submission of SPP, learned SPP, with reference to few of the accused, he said, my lords, they will file a B report by the state government because it is already transferred. Much prior to the order being passed by the coordinate bench yesterday. My lord, since he wanted to be heard My lord, the matter is listed.
ಅದಕ್ಕೆ will hear this.
Place the entire investigation material, my lord.
ಶುಕ್ರವಾರ ತಗೊಂತೀನಿ. We'll recall it because he was not heard. ಆಮೇಲೆ we'll pass an order.
In fact, if I'm not out of place.
ಅಲ್ಲ ಈ ಸ್ಟೇಜ್ ಅಲ್ಲೇ ಬೇಕಾದ್ರೆ ಹಿಯರ್ ಮಾಡ್ಬೇಕು ಅಂದ್ರೆ ಮಾಡ್ತೀನಿ. ಆಯ್ತು.
I'll place the entire investigation.
ಅಲ್ಲ being spoken to ಅಂದ್ರೆ ಬರೀ ಟಾಕಿಂಗ್ ಆಗುತ್ತೆ, ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಲ್ಲ.
For example, placing synopsis.
ಕೊಡಿ. The subject petition was disposed, were directing the matter to be transferred to the CCB. The learned SPP submitted, learned SPP submitted that the state was not completely heard in the matter. Therefore, the order stands recalled post the matter on Friday at Friday agatala 4 p.m. to hear further. 3 p.m.
ಆಯ್ತು, Monday.
Monday 4 p.m. Yes, all right. ಅಷ್ಟರಲ್ಲಿ ಏನ್ ಹಾಕಿದಿರಿ ಇನ್ವೆಸ್ಟಿಗೇಷನ್ ಮುಗಿದ ಚರ್ಚೆ. Now we have.
In fact, I have not seen the full report, my lord. I have been given and then I placed it before the court. I have taken it back and I have not even opened it. I can place it.
Who is the real Radha now?
Lord, if I have to say something, in fact, the day when it was.
Property worth 200 crores.
ಇರ್ಬೋದು ಅಂತ ಮೋಸ್ಟ್. 60 ಕೋಟಿ ಇದೆ.
ಏರ್ಪೋರ್ಟ್ ಹತ್ರ.
ಅಲ್ಲ, ಹೊಸಕೋಟೆ.
In fact, the day when the matter was taken up, my friend said no objection for transferring. So
now, he was not properly instructed. Let's not put him into problem.
ಅದಕ್ಕೆ ಮೈಕ್ ಆಫ್ ಮಾಡ್ಕೊಂಡು.
ಆಯ್ತು.
Definitely not. In fact, I had not even read that file and that your lordship asked me, I said yes. Please.
And one submission. List 3 serial number 5. It's been remanded back from the Supreme Court. Kindly a date maybe.
ಯಾವುದು sir?
List 3 serial number 5.
ಗೊತ್ತು.
A date may kindly.
Krishna E campus.
Please.
ಅಲ್ವಾ? We'll fix a date. I've just released it from part heard for the reason that 23 is with me only. Let it come ಅಂತ ಅಷ್ಟೇ. Yes.
Please.